Struggle for the land. Native North American resistance to genocide, ecocide, and colonization. By Ward Churchill. For my mother. Forward. Buying time. With the money they made by stealing our land, they have bought themselves some time, air time, THIRD time, WAR time, and underground time. By that they believe that they have bought history. But when I look back, past the hundreds of years of history they claim to own, through our own thousands of years. And when I think of the millions of red flowers that opened each spring of those thousands of years, no matter how white the winters, I see ours like stars in the eyes of our children. Jimmy Durham. Preface. Succeeding into Native North America. A secessionist view. He map on the F.A. Singh page could be called the indigenous North American view of bi-original secession. Although the scale in which it is presented prevents the details from being clear, the treaty and land claim areas involved are not exactly how it was BC. They are instead the basic outlines of the legally defined land areas of native nations. 1. The map, even through its general contours, may help correct some of the basic miseducation with which most non-Indian residents of the continent have been afflicted. First, the map shows how North America's indigenous peoples lived in what amounted to natural, bi-original configurations. Second, it shows that North America's reigning nation-state governments, those of the United States and Canada, are, according to the indigenous host nations, on shaky grounds, both legally and environmentally. Very little land in North America should not rightly be under native jurisdiction, administered under indigenous rather than immigrant values. Back to the first point. When I was in grade school, I was taught there were Plains Indians, Oddland Indians, and Pueblo Indians, and that's about all. What was left out was that the treaty areas and treaty rights of indigenous people in North America are ongoing, and that they accrue to recognized nations, demonstrating distinct sociocultural and linguistic patterns. Also omitted from my education was the fact that these nations had lived quite well within these defined territories since time immemorial. There was least trade between each of the indigenous areas, but each was also essentially self-sufficient. Today, a lot of people question the necessity and utility of centralized nation-state governances and economics. Point 2. They find the status quo to be increasingly absurd and are seeking alternatives to the values and patterns of 11. Consumption presently dominating not only North America, but the rest of the planet as well. The living reality of native North America, and the bi-originally determined redefinition of polity it represents, offers the model for an alternative arrangement. Point 3. And, if Leopold Kohr and Thc Basque say such a naturally grounded structure could work in Europe, why not here? For it is obviously important that everyone learn as much as possible about American Indian realities, rather than the self-serving junk they usually teach in school. The second important aspect of the map is the legal basis for protecting the environment and its inhabitants. It points up. The native struggle in North America today can only be properly understood as a pursuit of the recovery of land rights which are guaranteed through treaties. What Indians ask, what we really expect from those who claim to be our friends and allies, is respect and support for these treaty rights. What does this mean? Well, it starts with advocating that Indians regain use of and jurisdiction over what the treaties define as being our lands. It means direct support to Indian efforts to recover these lands, but not governmental attempts to compensate us with money for lands we never agreed to sell. This, in turn, means that those indigenous governments which traditionally held regulatory and enforcement power within Indian country, not the more modern and otherwise non-traditional tribal councils imposed upon Indians by the federal government under the Indian Reorganization Act of 1934, should have the right to resume their activities now. By extension, this would mean that much land which is currently taxed, regulated, strip-mined, militarized, drowned by hydroelectric generation or over-irrigation, and nuked by the US and Canadian governments would no longer be under their control or jurisdiction any longer. Surely, this is a prospect which all progressive and socially conscious people can embrace. What is perhaps most important about Indian treaty rights is the power of the documents at issue to clarify matters which would otherwise be consigned by nation-state apologists to the realm of opinion and interpretation. The treaties lay things out clearly, and they are instruments of international law. Point 6 In this sense, the violation of the treaty rights of any given people represents a plain transgression against the rights of all people, everywhere. This can be a potent weapon in the organization of struggles for justice and sanity in every corner of the globe. And it should be appreciated as such by those who champion causes ranging from protection of the environment to universal human rights. 1-2. Native North America is struggling to break free of the colonialist, industrialist, militarist nation-state domination in which it is now engulfed. It is fighting to secede from the US and Canada. But, because of the broader implications of this, we refer to the results we seek not as sex Zion, but as success. This is true, not just for Indians, but for all living beings and the earth itself. WONTU help us succeed into a full scale re-emergence of our natural world. Wino Zaladuk. Introduction. The Indigenous Peoples of North America. A struggle against internal colonialism. The Europeans who began taking over the New World in the 16th and 17th centuries were not ecologists. Although they were compelled to realize that the Americas were not quite uninhabited, they were not prepared to recognize that these new lands were, in an ecological sense, much more than sparsely inhabited. This second hemisphere was, in fact, essentially full. William Catton Overshoot. The standard Euro-American depiction of pre-contact native North Americans has long been that the relative handful of us who existed wandered about perpetually in scattered bands, grubbing out the most marginal subsistence by hunting and gathering, never developing writing or serious appreciations of art, science, mathematics, governance, and so on. Aside from our utilization of furs and hides for clothing, the manufacture of stone implements, use of fire, and domestication of the dog, there is little in this view to distinguish us from the higher orders of mammalian life surrounding us in the American wilderness. The conclusions reached by those who claim to idealize Indianness are little different at base from the findings of those who openly denigrate it. Native people were able to inhabit the hemisphere for tens of thousands of years without causing appreciable ecological disruption only because we lacked the intellectual capacity to create social forms and technologies that would substantially alter our physical environment. In effect, a sort of socio-cultural retardation on the part of Indians is typically held to be responsible for the pristine quality of the Americas at the point of their discovery by Europeans. In contrast to this perspective, it has recently been demonstrated that 15. Far from living hand-to-mouth, Stone Age Indians adhered to an economic structure that not only met their immediate needs but provided considerable surpluses of both material goods and leisure time. 3. It has also been established that most traditional native economies were based in agriculture rather than hunting and gathering, a clear indication of a stationary, not nomadic, way of life until the European invasion dislocated the indigenous populations of North America. For it is also argued that native peoples' long-term coexistence with our environment was possible only because of our extremely low population density. Serious historians and demographers have lately documented how estimates of pre-contact indigenous population levels were deliberately lowered during the 19th and early 20th centuries in order to lessen the implications of genocide bound up in the policies of the US, Canada, and their colonial antecedents. 5. A noted ecologist has also recently determined that, rather than being dramatically underpopulated, North America was in fact saturated with people in 1500. The feasible carrying capacity of the continent was, moreover, outstripped the European influx by 1840, despite massive reductions of native populations and numerous species of large mammals. 6. Another myth is contained in the suggestion that indigenous forms of government were less refined than those of their European counterparts. The lie is put to this notion, however, when it is considered that the enlightened republicanism established by the United States during the late 1700s, usually considered an advance over then prevailing European norms, was lifted directly from the model of the currently still functioning Haudenosaunee Confederacy. 7 In many ways the Haudenosaunee were indicative of political arrangements throughout native North America. 8 American Indians evidenced similar achievements in preventative medicine, mathematics, astronomy, architecture, and engineering, all without engendering appreciable environmental disruption. 9 Such a juxtaposition of advanced socio-cultural matrices and sustained ecological equilibrium is inexplicable from the vantage point of conventional Euroderivative assumptions. Unlike Europeans, Native Americans long ago attained a profound intellectual apprehension that human progress must be measured as an integral aspect of the natural order rather than as something apart from and superior to it. Within this body of knowledge, elaborated and perfected through oral 1-6 tradition and codified as law in ceremonial/ritual forms, the indigenous peoples of this hemisphere lived comfortably and in harmony with the environment, the health of which was recognized as an absolute requirement for our continued existence. 10 In simplest terms, the American Indian worldview may be this: human beings are indeed encouraged to develop our innate capabilities, but only in ways that do not infringe upon other elements called relations, in the fullest dialectical sense of the word of nature. Any activity going beyond this is considered as imbalance, a transgression, and is strictly prohibited. Engineering, for example, was and is permissible, but only insofar as it does not permanently alter the earth itself. Similarly, agriculture was widespread, but only within parameters that did not supplant natural vegetation. 11 Key to the indigenous American outlook is a firm acknowledgement that the human population may expand only to the point, determined by natural geographic and environmental circumstances, where it begins to displace other animal species and requires the permanent substitution of cropland for normal vegetation in any area. North America's aboriginal populations never entered into a trajectory of excessive growth, and, even today, many native societies practice a self-regulation of population size that allows the substance of our traditional worldviews with their interactive environmental relationships to remain viable. 12. Cultural imperialism. They came for our land, for what grew or could be grown on it, for the resources in it, and for our clean air and pure water. They stole these things from us, and in the taking they also stole our ways and the best of our leaders, killed in battle or assassinated. And now, after all that, they've come for the very last of our possessions. Now they want our pride, our history, our spiritual traditions. They want to rewrite and remake these things, to claim them for themselves. The lies and thefts just never end. Margot Thunderbird, 988. Within the industrial wasteland of the late 20th century, such traditional perspectives are deformed right along with the physical dimensions of indigenous culture. Trivialized and co-opted, they have been reduced to the stuff of the settler society's self-serving pop mythology, commercialized. 17. And exploited endlessly by everyone from the Hollywood moguls and hippie filmmakers who over the past 75 years have produced literally thousands of celluloid parodies not merely of our histories, but of our most sacred beliefs, to New Age yuppie airheads like Lynn Andrews who pen lucrative feminist fables of our spirituality, to the flabbily over-privileged denizens of the men's movement indulging themselves in their Wildman weekends, to pseudo-academic frauds like Carlos Castaneda who fabricate our traditions out of whole cloth, to well-intentioned FREs like Gerrymander who simply appropriate the real thing for their own purposes. The list might easily be extended. For pages. 13 Representative of the mentality is an oft-televised public service announcement featuring an aging Indian, clad in beads and buckskins, aimed against a backdrop of smoking factory chimneys while picking his way carefully among the mounds of rusting junk along a well-polluted river. He concludes his walk through the modern world by shedding a tragic tear induced by the panorama of rampant devastation surrounding him. The use of an archaic Indian image in this connection is intended to stir the settler population's subliminal craving for absolution. Having obliterated native North America as a means of expropriating its land base, the subtext reads, Euro-America is now obliged to make things right by preserving and protecting what was stolen. Should it meet the challenge, presumably, not only will its forebears' unparalleled aggression at last be in some sense redeemed, but so too will the blood-drenched inheritance they bequeathed to their posterity be in that sense legitimate. The whole thing is of course a sham, a glib contrivance designed by the conquerors to promote their sense of psychic reconciliation with the facts and fruits of the conquest. 14 A primary purpose of this book is to disturb, better yet, to destroy altogether such self-serving and satisfied tranquility. In doing so, its aim is to participate in restoring things Indian to the realm of reality. My hope is that it helps in the process to heal the disjuncture between the past, present, and future of native North American peoples which has been imposed by nearly 4 centuries of unrelenting conquest, subjugation and dispossession on the part of Euro-America's multitudinous invaders. This does not make pleasant reading, nor should it. My message is that there can be no absolution, no redemption of past crimes unless the outcomes are changed. So long as the aggressor's posterity continue to reap the benefits of that aggrace. 1/8. Zion, the crimes are merely replicated in the present. In effect, the aggression remains ongoing and, in that, there can be no legitimacy. Not now, not ever. Contemporary circumstances. We are not ethnic groups. Ethnic groups run restaurants serving exotic foods. We are nations. Brooklyn Rivera, 1986. The current situation of the indigenous peoples of the United States and Canada is generally miscast as being that of ethnic/racial minorities. This is a fundamental misrepresentation in at least 2 ways. First, there is no given ethnicity which encompasses those who are indigenous to North America. Rather, there are several hundred distinctly different cultures, ethnicities, in anthropological parlance lumped together under the catch-all classification of Native Americans. Similarly, at least 3 noticeably different gene stocks, the nomenclature of race, are encompassed by such designators. Biologically, Amerinds like the Cherokees and Ojibwe's are as different from Inuits and such Athabascan types as the Apaches and Navajos as Mongolians are from Swedes or Bantus. 15. Secondly, all concepts of ethnic or racial minority status fail conspicuously to convey the sense of national identity by which most or all North American indigenous populations define ourselves. Nationality, not race or ethnicity, is the most important single factor in understanding the reality of native North America today. 16. It is the sense of ourselves as comprising coherent and viable nations which lends substance and logic to the forms of struggle in which we have engaged over the past third of a century and lore. 17. It is imperative when considering this point to realize that there is nothing rhetorical, metaphorical, or symbolic at issue. On the contrary, a concrete and precise meaning is intended. The indigenous peoples of North America, indeed, everywhere in the hemisphere, not only constituted but continue to constitute nations according to even the strictest definitions of the term. This can be asserted on the basis of 2 major legal premises, as well as a range of more material considerations. Let's take them in order. To begin with, there is a doctrine in modern international law known as the right of inherent sovereignty, holding that a people constitutes 19. A nation, and is thus entitled to exercise the rights of such, simply because it has done so since time immemorial. That is, from the moment of its earliest contact with other nations, the people in question have been known to possess a given territory, a means of providing their own subsistence, a common language, a structure of governance and corresponding form of legality, and a means of determining membership/social composition. As was to some extent shown above, there can be no question but that native North American peoples met each of these criteria at the point of initial contact with Europeans. 18. Second, it is a given of international law, custom, and convention that Treaty making and treaty relations are entered into only by nations. This principle is constitutionally enshrined in both U.S. and Canadian domestic law. Article 1 of the U.S. Constitution, for instance, clearly restricts treat-y-loch-ilg-el-heliugalivo to the, explicitly recognizes the fact that governments acknowledged the independent and national character of the Indian peoples with whom dealt 41. Insofar as recognition once given is irrevocable unless the recognized ceases to exist or ceases to have the elements of nationhood, it is accurate to observe that the effect of the treaties is as forceful and binding now as when they were signed. 42 Legally speaking, it is the treaties rather than settler state statutory codes which continue to define the nature of the relationship between most American Indian peoples, Canada, and the United States. 4.3 This is and will remain unequivocally the case, absent an ability on the part of the U.S. and/or Canada to demonstrate that the indigenous nations with which they entered into treaties have either undergone some legitimate diminishment in their status or gone out of existence altogether. To quote Attorney General again, so long as a tribe exists and remains in possession of its lands, its title and possession are sovereign and exclusive. We treat with them as separate sovereignties, and while an Indian nation continues to exist within its acknowledged limits, we have no more right to enter upon their territory than we have to enter upon the territory of notwithstanding whatever may have been or may be said to the contrary, the said Indians and all other peoples who may later be discovered by Christians, are by no means to be deprived of their liberty or the possession of their property, even though they may be outside the faith of Jesus Christ, and that they may and should, freely and legitimately, enjoy their liberty and the possession of their property, nor should they be in any way enslaved. Should the contrary happen, it shall be null and of no effect. 51. What the discovering power actually obtained was a monopolistic right vis-a-vis other European powers to acquire the property in question, should its native owners ever willingly consent to its alienation. 52. As John Marshall correctly observed in 1832. Discovery old not affect the rights of those already in possession, either as aboriginal occupants, or by virtue of a. 43. Discovery made before the memory of man. It gave the exclusive right to purchase, but did not found that right on a denial of the right of the possessor to se 1153. In substance, the doctrine was little more than an expedient to regulate relations among the European powers, intended to prevent them from squandering the old WORLD's limited assets by engaging in bidding wars or, worse, outright military conflicts among themselves over new WORLD territories. Were all in pursuit of nearly the same object, it necessary, in order to avoid conflicting settlements, and consequent war with each other, to establish a principle, which all should acknowledge as the law by which the right of acquisition, which they all asserted, should be regulated, as between themselves. This principle was, that discovery gave title to the government by whose subjects, or by whose authority, it was made, against other governments, which title might be consonanted by possession. The exclusion of all other Europeans, necessarily gave to the nation making the discovery the sole right of acquiring the soil from they could interfere. 54. That such understandings were hardly unique to Marshall, is witnessed in a 1792 missive from then Secretary of State Thomas Jefferson to the British Foreign Ministry, in which he acknowledged that the Treaty of Paris had left the U.S., not with clear title to lands west of the Appalachian Mountains, but rather with an ability to replace England in asserting what he called a right of preemption. 55. That is to say, the sole and exclusive right of purchasing from whenever they should be willing to sell. We consider it as established by the usage of different nations into a kind of jus j, cl1 tmfor America, that a white nation settling down and declaring such and such are their limits, makes an invasion of those limits by any other white nation an act of war, but gives no right of soil against the native possessors. 56. So plain was the pattern of law and historical precedent in Marshall's mind that he openly scoffed at N060 NS, prevalent among his countrymen, that the doctrine of one, discovery did, or could have done, more, The extravagant and absurd idea, that feeble settlements made along the seacoast acquired legitimate power to govern people, or occupy the lands from sea to sea, did not enter into the mind of any man. Were well understood to convey the title which, according to the common law of European sovereigns respecting America, they might rightly convey, and no more. This was the exclusive right of purchasing such lands as the natives were willing to sell. The Crown could not. 44. Undertake to grant what the Crown could not effect to claim, nor was it so understood. 57. The same problems afflicting arguments that title to unceded Indian land advocates claim was passed to the U.S. via the Treaty of Paris also besets other acquisitions from European/Euro-American POWs. This is most notably true with respect to the 1803 Louisiana Purchase and the 1848 cession of the northern half of Mexico under the Treaty of Guadalupe Hidalgo, but also pertains to the 1845 admission of Texas to the Union, the 1846 purchase of Oregon Territory from Russia, and so on. 58 As concerns the largest single annexation ever made by the U.S. encompassing the entire Trans-Mississippi West. What acquired FMM Napoleon in the Louisiana Purchase was not real estate, tore practically all of the ceded territory that was not privately owned by Spanish and French settlers was still owned by the Indians, and the property rights of all the inhabitants were safeguarded by the terms of the Treaty of Cession. What we did acquire from Napoleon was not the land, which was not his to sell, but simply the right. 59. Similarly, the Treaty of Guadalupe Hidalgo, by which the U.S. war against Mexico was concluded, made express provision that already existing property rights, including those of the region's indigenous peoples, be respected within the vast area ceded by the Mexican government. 60 In no instance is there evidence to support assertions that the U.S. obtained anything resembling valid title to its presently claimed continental territoriality through interaction with non-indigenous governments, whether European or Euro-American. Less, can such contentions be sustained with regard to Hawaii. 61 The matter is confirmed by the 1928 Island of Palmas case, in which the International Court of Justice found that title supposedly deriving from discovery cannot prevail over a title based in a prior and continuing display of sovereignty. 62. Territorium residential nullius. Although John Marshall himself, while readily conceding many of its implications, would ultimately pervert the doctrine of discovery in a relatively sophisticated fashion as he attempted to rationalize and legitimate his country's territorial ambitions, many of his peers operated much more crudely. Hence, in the 1842 Martin v. Vildel case, 45, decided only 7 years after Marshall's death, the Supreme Court set down the following opinion. The English possessions in America were not claimed by right of conquest, but by right of discovery. For, according to the principles of international law, as understood by the then civilized powers of Europe, the Indian tribes in the New World were regarded as mere temporary occupants of the soil, and the absolute rights of property and dominion were held to belong to the European nation by which any particular portion of the country was first discovered. Whatever forbearance may have been practiced towards the unfortunate aborigines, either from humanity or policy, yet the territory they occupied was disposed of by the governments of Europe, at their pleasure, as if it had been found without inhabitants. 3. In so thoroughly misconstruing extant law, ruining history in the process, what the good justices were about was devising a legal loophole. Through it, they intended to pour a veneer of false legitimacy over U.S. plans, by now openly and officially announced as the country's manifest destiny, of rapidly extending its reach from the Mississippi to the Pacific and beyond, ignoring indigenous rights, not only to land but to liberty and often life itself, at every step along the way. 64 The mechanism they seized upon for this purpose was the principle of territorium residential nullius, the element of discovery doctrine providing that Uninhabited territory might be claimed outright by whoever first found it. 65 It's not that the Supreme Court of the United States or anyone else ever really argued that North America was completely unoccupied at the time of the initial European arrivals. Instead, they fell back on the concept of the Norman Yok, an ancient doctrine particularly well developed in English legal philosophy, stipulating that to be truly owned it was necessary that land be improved. 66. Whomever failed within some reasonable period to build upon, cultivate or otherwise transform their property from its natural state of wilderness forfeited title to it. The land was then simply declared to be vacant and subject to claim by anyone professing a willingness to put it to use. 67. The Puritans of Plymouth Plantation and Massachusetts Bay Colony had experimented with the idea during the 1620s, arguing that while native property rights might well be vested in our town sites and fields, the remainder of our territories, since it was uncultivated, should be considered terra nullius and thus unowned, but their precedent never evolved into a 46. More generalized English practice. 68 Indeed, the Puritans themselves abandoned such presumption in 1629.69. Whatever theoretical disagreements existed concerning the nature of the respective ownership rights of Indians and Europeans to land in America, practical realities shaped legal relations between the Indians and colonists. The necessity of getting along with powerful Indian, who outnumbered the European settlers for several decades, dictated that as a matter of prudence, the settlers buy lands that the Indians were willing to sell, rather than displace them by other methods. The result was that the English and Dutch colonial governments obtained most of their lands by purchase. For all practical purposes, the Indians were treated as sovereigns possessing full ownership of the lands of America. 70. By the early 19th century, the demographic/military balance had shifted dramatically in favor of settler populations. 71 One result was that the potential of invoking the Norman Yok in combination with the broader principle of residential nullius began to be rethought. In terms of international law, the principle eventually found expression in the observation of Jurist Emmerich de Vietel that no nation holds a right to exclusively appropriate to themselves more land than they have occasion for, or more than they are able to settle and cultivate. 72. For all practical intents and purposes, John Marshall himself employed such reasoning in an 1810 opinion holding that portions of Indian country not literally occupied or cultivated by indigenous peoples might, at least in certain instances, be construed as unowned and therefore open to claims by settlers. 73 Over the next 75 years, the principle was brought to bear in the continuously evolving affirmation of U.S. Indian policy as well as judicial interpretation of indigenous property. Entitlements with the size of an ever greater number of the areas set aside for native use and occupancy demonstrating no relationship at all to the extent of aboriginal holdings or to more recent treaty guarantees of territoriality. Rather, federal policymakers, judges and bureaucrats alike increasingly took to multiplying the number of Indians believed to belong to any given people by the number of acres it was thought each individual might use productively. The aggregate figure arrived at would then be assigned as that people's reserved land base. 74 By the latter part of the 19th century, the process in Canada was much the same. 75 In the U.S. The trend culminated in passage of the 1887 General Allotment Act, a measure by which the government authorized itself to impose 47 such terms upon every indigenous nation encompassed within the country's claimed boundaries. 76 At the stroke of the congressional pen, traditional and native modes of collective land holding were unilaterally abolished in favor of the self-anointedly more advanced or civilized Euro-American system of individual ownership. 77 The methods by which the act was implemented began with the compilation of official rolls of the members of each tribe in accordance with criteria sanctioned by the Federal Bureau of Indian Affairs. 7 When this task was completed, each individual listed on a roll was allotted a parcel of land, according to the following formula. 1. To each head of a family, 1/4 section 1160 acres. 2. To each single person over 18 years of age, 1/8 section. 3. To each orphan child under 18 years of age, 1/8 section. 4. To each other single person under 18 years of age living, or who m. 1 YH Horn prior to th. 106. In reality, if the doctrine had ever embodied such a principle and no evidence has been produced to show that it did, it had not done so for some 900 years. 10. By the 16th century, Vittoria, Matthias de Pau and others had codified conquest rights as an adjunct or subset of discovery doctrine, constraining them within very tight limits. 108. Such rights might be invoked by a discovering power, they wrote, only on occasions where circumstances necessitated the waging of a just war. With respect to the new WORLD, the bases for the latter were delineated as falling into three categories. First, instances in which, without provocation, a native people physically attacked representatives of the discovering crown. Second, instances in which the natives arbitrarily refused to engage in trade with crown representatives, and, third, instances in which native people refused to admit Christian missionaries among them. Should any or all of 5.1. These circumstances be present, the jurists agreed, discoverers held the right to use whatever force was necessary to compel compliance with international law. 109. Having done so, they were then entitled to compensate themselves from the property of the vanquished for the costs of having waged the war. 110. In all other instances, however, legitimate acquisition of property could occur only by consent of its indigenous owners. The problem is that in the entire history of Indian-white relations in North America, there is not a single instance in which any of the three criteria can be documented. 112. Hence, contra the THIRD Court's all-encompassing declaration that Euro-American title to the continent derives from conquest, such a result does not obtain, legally at least, even with regard to the relatively few instances in which wars were actually fought. LL3 at FOL lows that the only valid land title presently held by either the U.S. or Canada is that accruing from bilateral and mutually consensual treaties through powers like England and France. 114. Earlier US jurists and legislators understood the law, even if the THIRD Court did not. One consequence was the 1787 Northwest Ordinance, in which the Congress swore all wars of conquest against native peoples and pledged the country to conducting its relations on the basis of treaties negotiated in utmost good faith. 115. As has been mentioned, John Marshall classified contentions that North America's indigenous nations had been conquered as extravagant and absurd. 116. Elsewhere, he observed that law which regulates, and ought to regulate in general, the relations between the conqueror and conquered, incapable of application to American Indians. 117. Even the Martin Court, hostile to native interests by any estimation, was at pains to state that English rights in America were claimed by right of conquest. 118. Probably the most definitive assessment was that offered High Indian Commissioner Thomas Jefferson Morgan in 1890, after the Indian wars had run their course. From the execution of the first treaty made between the United States and the Indian tribes residing within its limits, the United States has pursued a uniform course of extinguishing Indian title only with the comment of those tribes which were recognized as having claim to the soil high reason of occupancy, such consent being expressed by treaties. 19. In light of all this, it is fair to say that there is not a scintilla of validity attending the THIRD opinion, either legally or in any other way. The 52. Same holds true for the dominant society's academic and popular discourse of conquest, perhaps best represented by the 2000 Cowboys and Indians movies produced by Hollywood over the past 75 years. 120. To pretend otherwise, as the THIRD Court did, does nothing to legitimate Euro-American claims of primacy over native territories. Rather, it is to enter a tacit admission that, in the U.S. at least, much land has been acquired in the most illegitimate fashion of all the waging of aggressive war, and that a considerable part of the continent constitutes what one analyst has termed occupied America. 121. Extinction. Although both the United States and Canada officially maintain that genocide has never been perpetrated against the indigenous peoples within their borders, 122 both have been equally prone to claim validation of their title to native lands on the basis that group extinction has run its course in a number of cases. Where there are no survivors or descendants of pre-invasion populations, the argument goes, there can be no question of continuing Aboriginal title. Thus, in such instances, the land vacated by the literal die-off of its owners must surely have become open to legitimate claims by the settler states under even the most rigid constructions of Tritorium res nullius. 123. While the reasoning underpinning this position is essentially sound, and in conformity with accepted legal principles, the factual basis upon which it is asserted is not. With the exception of the Beothukes of New Foundland, whose total extermination was complete at some point in the 1820s, it has never been demonstrated that any of the peoples native to North America, circa 1500, has ever been completely eradicated. 124. Take the Pequots as a case in point. In 1637, they were so decimated by a war of extermination waged against them by English colonists that they were believed to have gone out of existence altogether. Even their name was abolished under colonial law. 125. For 3 centuries, Pequots were officially designated as being extinct. Yet, today, the federal government has been forced, grudgingly, to admit that several hundred people in Connecticut are directly descended from this extirpated nation. 126. Similar examples abound. The Wampanoags of Massachusetts were declared extinct in the aftermath of the 1675 King Philip's War, but managed. 53. To force recognition of their continuing existence during the 1970s. 127. More or less the same principle applies to a number of other peoples of the Northeast. 128. The Piscataways, Yamasees, Catawbas, and others of the Southeast, all of whom were reportedly extinct by 1800,129. The Wayuki, Yahi, and others of Northern California, largely annihilated through the cruelties of the original settlers prior to 1900,130, and so on around the country. James Fenimore Cooper's Last of the Mohicans wasn't, nor was Alfred Kroeber's Ishi really the last of his tribe. 131. In sum, the fa-bled vanishing red man, alternately bemoaned and celebrated with a great deal of glee in turn-of-the-century literature, didn't. 132. Bienurge, extinction is and has always been more a classification bestowed for the administrative convenience of the settler states than a description of physical or even cultural reality. The classic example occurred when, during the decade following the adoption of House Resolution 108 in 1QR, 1, THP 1 TSCNNR, FFSS systematically terminated its recognition of more than 100 indigenous peoples. 133. Some, like the Menominees of Wisconsin, were eventually able to obtain formal reinstatement. 134. The majority, however, like the Klamaths of Oregon and an array of smaller peoples in Southern California, have been unsuccessful in such efforts. They remain officially dissolved, whatever remained of their reserved territories absorbed by the surrounding settler state. 135. In other instances, the U.S. has simply refused ever to admit the existence of indigenous peoples. Notably, this pertains to the Abenakis of Vermont, who, having never signed a treaty of cession, actually hold title to very nearly the entire state. 136. Other examples include the Lumbees of North Carolina, perhaps the most populous indigenous people in all of North America, and a number of fragmentary groups like the Miamis of Ohio scattered across the Midwestern states. 137. While not following precisely the same pattern, Canada has also utilized policies of declining to acknowledge native status and or refusing to recognize the existence of entire groups as a means of manipulating or denying altogether indigenous rights to land and sovereign standing. 138. While neither such official subterfuges nor the popular misconceptions attending them have the least effect in terms of diminishing the actual rights of the peoples in question, they do place the settler states in positions of patent illegality. Among other things, it is readily arguable that official declarations that still viable human groups have gone out of existence, coupled to 54. Policies designed and intended to bring this about, constitute the crime of genocide, not only within the definition of the term as originally advanced by Raphael Lemkin during the Second World War, but as it is now codified in international law. 139. Merger with settler society. A final line of argument extended by the United States and Canada to justify their denials of indigenous rights to self-determination is that most native peoples have long since commingled with the settler societies of both countries to the point, in many if not most cases, of rendering our sovereignty self-nullifying. 140 Although it is true that international law recognizes the voluntary merger of one nation into another as the sole sure and acceptable means by which national identity and concomitant national rights can be extinguished, it is dubious whether the description actually applies to any but a handful of North America's indigenous nations. 141. In many instances there is simply no evidence of a voluntary merger by treaty agreements or in any manner. One will search the treaties of the Six Nations Confederacy and no doubt many other Indian nations in vain for such evidence. Very few treaties, perhaps none, include provisions even remotely suggesting voluntary merger or voluntary surrender of sovereignty. The settled doctrine of the law of nations is that a weaker power does not surrender its independence, its right of self-government, by associating with a stronger, and taking its protection. A weak state, in order to provide for its safety, may place itself under the protection of one more powerful, without stripping itself of the right of government, and ceasing to be a state. 144. That Marshall's 1832 opinion yields a continuing validity is amply borne out in the status accorded such tiny protectorates as Liechtenstein. 55. San Marino and Monaco in Europe itself, examples which, along with Luxembourg, Grenada, the Marshall Islands and a number of other small nations around the world whose right to sovereignty is not open to serious challenge, also preempt questions of scale. 145 As Onondaga leader Oren Lyons has aptly put it, nations are not according to size. Nations are according to culture. If there are 20 people left who are representing their nation, they are a nation. Who are we to say less? 146. Other mainstays of the merger argument are the facts that native peoples both north and south of the border have become increasingly assimilated into settler culture, accepted citizenship in both the US and Canada, adopted forms of governance explicitly subordinated to those of the settler states, and are now thoroughly encompassed by the statutory codes of the latter. 147 Even the most casual examination of the record reveals, however, that none of this has occurred in anything resembling a voluntary R011 THPPRT of the Insuinans nations involved. Indeed, native races tends to all for aspects of the process has been, and in many cases continues to be, substantial. For starters, the kind and degree of cultural assimilation among native people evident today in both countries results, not from any choice made by Indians to fit in, whether collectively or individually, but from extraordinarily draconian conditions imposed upon them by the settler state governments. From at least as early as the last quarter of the 19th century, the United States and Canada alike implemented policies of compulsory assimilation involving direct intervention in the domestic affairs of all indigenous nations within their respective spheres. 148 Among the techniques employed was the systematic subversion of traditional native governments through the creation, underwriting and other support for oppositional affiliations, and routine disruption of customary social/spiritual practices. 149 Most especially in the U.S., but also to a considerable extent in Canada, the early phases of such initiatives were coupled to the previously discussed program of land allotment and manipulation of tribal membership. 15 Meanwhile, the traditional economies of an ever-increasing number of native peoples throughout North America were undermined and in many cases obliterated altogether. 151 While all of this was obviously devastating to the ability of indigenous nations to maintain their cohesion and cultural integrity, the real linchpin of assimilation policy on both sides of the border was the imposition of university 56. Sal compulsory education upon native children. 152 Between 1880 and 1930, up to 80% of all American Indian youngsters were sent, almost always coercively, often forcibly, to remote boarding schools, FARFROM family, FRENS, community, nation, and culture. Thus isolated, shorn of their hair, compelled to dress in Euro-American attire, forbidden to speak their native languages or follow their spiritual beliefs, subjected to severe corporal punishment and or confinement for the slightest breach of discipline. The students were typically held for years, systematically indoctrinated all the while to accept Christianity, speak proper English and generally adopt Western values and perspectives. 153 The express objective of the boarding school system was, according to U.S. Superintendent of Indian Schools Richard H. Pratt, to kill the Indian in each pupil, converting them into psychological intellectual replications of non-Indians. 154 The broader goal, articulated repeatedly by the administrators of U.S. assimilation policy as a whole, was to bring about the functional disappearance of indigenous societies. As such, by some point in the mid-1930s. 155 The intent in Canada was no different, albeit geared to a somewhat slower pace. 156 While such a process of socio-cultural merger can by no conceivable definition be described as voluntary, it is glaringly genocidal under even the strictest legal definition of the term. 157 Citizenship a residential little better American Samoa a justification for statist presumption. Indians, as a rule, sought to become citizens of neither the U.S. nor Canada. On the contrary, the record demonstrates conclusively that in the latter country we began to be treated as subjects at a time when we were strongly and all but unanimously asserting the exact opposite. Consider, for example, the following observation, drawn from opinion of a 20th century Canadian court. It is well known that claims have been made from the time of Joseph Brant that the Indians were not really subjects of the king but an independent people, allies of His Majesty, and in a measure at least exempt from the civil laws governing the true subject. Treaties had been made in which they were called faithful allies and the like. As to the so-called treaties, John Beverley Robinson, Attorney General for Upper Canada, in an official letter to Robert Wilmot Horton, Under Secretary of State for War and Colonies, March 1, 1824, said, to talk of treaties with the Mohawk Indians, residing in the heart of one of the most populous districts of Upper Canada, is much the same, in my humble opinion, as to talk of making a treaty of alliance with the Jews of Duke Street. 58. 57. More formally, in the sense of enfranchisement and the like, citizenship was not extended to indigenous people until an act to encourage the gradual civilization of the Indian tribes was effected by the province of Canada in 1857.159. Since the law made acceptance voluntary, Indians had to apply, and were declared legally white upon acceptance. There were relatively few takers. 160 Hence, pursuant to the 1867 British North American Act, native citizenship in Canada was simply made declarative, irrespective of objections raised by its alleged beneficiaries. 161 As Prime Minister Sir John A. Macdonald put it in 1887, the great aim of our such legislation has been to do away with the tribal system and assimilate the Indian people in all respects with the other inhabitants of the Dominion, as speedily as they are fit for the change. 162. In the United States, citizenship was first imposed upon native people in a large-scale fashion during the 1805, as a quid pro quo in the release of IIL Jivy Judley Dlu LLC JLWJP LLC DS Phi 0111 Trusts to S. 163 in 1924. An act was passed unilaterally conferring citizenship upon all Indians who had been overlooked in earlier processes, or who had proven resistant to accepting it. L64 As in Canada, the grant of citizenship was not sought by the Indian population, and many Indian nations have consistently and vigorously denied United States citizenship. The Six Nations Confederacy, to use a now familiar example, has repeatedly gone on public record to reject United States citizenship and deny the federal government's power to make them citizens. 165. It has never been held by any court, national or international, that the unilateral conferral of citizenship upon a population deprives them of their separate nationhood. The ultimate question is, after all, whether Congress has the right or the legal power under international law to legislate over Indian nations without their consent. 66. As to the fact that indigenous governments are presently considered as parts of the settler state governmental hierarchies themselves, Native people no more chose the status than they did U.S/Canadian citizenship or any other aspect of assimilation. 167 Traditional forms of governance throughout the United States were systematically supplanted, nation by nation, under the 1934 Indian Reorganization Act with a constitutional structure designed by the BIA. 168 In the great majority of cases, the resulting tribal 58 councils were patterned more after corporate boards than actual governing bodies, while all of them derived their authority from and were underwritten by the U.S. rather than their own ostensible constituents. 169 Although superficially democratic in its implementation, referenda were conducted on each reservation prior to its being reorganized. The record is replete with instances in which federal officials misrepresented what was happening in order to convince Native voters to cast affirmative ballots. 170 In certain instances among the Lakota, for example, where a sufficient number of dead persons to swing the outcome were later shown to have voted outright, electoral audit prevailed. L7 Hopi provides another useful illustration. Collier reported to the Secretary of Interior in 1936 that the Hopis had accepted the IRA by a vote of 519 to 299, the total votes cast representing 45% of the eligible voters. According to the statistics contained in the ratified and Interior-approved Constitution itself, only 755 people voted in the constitutional referendum. This is 63 fewer people than voted in the 1935 referendum on the Indian Reorganization Act. How can 818 voters constitute 45% of the eligible voters in 1935 and, a year later, 755 voters constitute 50%? Clearly, Collier made up his own statistics, and perpetrated a good deal of deception in order to make it seem the Hopis always been considered as distinct, independent political communities, retaining their original natural rights. The very term nation, so generally applied to them, means a people distinct from others. The words treaty and nation are words of our own language, selected in our diplomatic and legislative proceedings, by ourselves, having a definite and well understood meaning. We have applied them to her nations of the earth. They are applied to all in the same sense. 185. The Marshall Innovation. It will undoubtedly be argued that there is yet another way out of the box of illegality in which the settler states would otherwise appear to be trapped, and that Marshall himself supplied it a year before he made the 60. above quoted statement. This is found in a formulation extended by the Chief Justice in an 1831 opinion, Cherokee v. Georgia, as he struggled with the impossible task of reconciling the legal realities of indigenous sovereignty to the insistence of his own country upon asserting its dominion over them. 186 After conceding that argumentation intended to prove the character of the Cherokees as a state, as a distinct political society, separated from others, capable of governing itself, has been completely successful. 187 He went on to observe, and other international adjudicating bodies that we have long experienced in U.S. Canadian courts. 225 In the alternative, if the all but unanimous Lilgenus refusal to countenance substantive alteration of the draft document they themselves endorsed proves inadequate to compel its eventual acceptance by the General Assembly, other options must be found. The most promising of these would appear to reside in a generalized native repudiation of any statist version of the proposed Declaration of Indigenous Rights, combined with a return to the strategy advocated by Durham and others during the late 1970s. 226 This, quite simply, devolves upon the devising of ways to force acknowledgement of indigenous rights under existing law rather than the creation of a new instrument. 227 There are numerous routes to this end, beginning with the seeking of advisory opinions on the broader applicability of its interpretations in the land of Palmas and Tvextern Sahara cases. 228 Perhaps more important are a range of possibilities by which the IC&/or appropriate UN organs might be compelled to advance concrete interpretations of the meaning inherent to assorted declarations, covenants, and conventions. The 1966 International Covenant on Economic, Social and Cultural Rights, FOR example, and the 1966 International Covenant on Civil and Political Rights vis-a-vis Indigenous Peoples. 229 Probably salient in this regard is the 1960 Declaration on the Granting of Independence to Colonial Countries and Peoples, the fifth point of which stipulates that 66. Immediate steps shall be taken, in trust and non-self-governing territories or all other territories which have not yet attained independence, to transfer all powers to the peoples of those territories, without conditions or reservations, in accordance with their freely expressed will or desire, without any distinction as to race, creed or color, to enable them to enjoy complete independence and freedom. 230. The nature of the immediate steps to be taken are neither mysterious nor left to the interpretive discretion of colonizing states. Rather, they are spelled out clearly in Articles 73 to 91 of the United Nations Charter. 231 In essence, all such territories/peoples must be inscribed by the colonizer on a list maintained by the UN Trusteeship Council, which then must approve a plan, including a timetable, by which complete decolonization will occur at the earliest feasible date. 232 The colonizer is then required to submit regular reports to the Council on progress made in fulfillment of the plan. 233 The process culminates in a referendum or comparable procedure, monitored by the UN and sometimes conducted under its direct supervision, by which the colonized people determine for themselves exactly what they wish their political status to be, and what, if any, relationship they wish to maintain with their former colonizers. 234 One significant hurdle which must be cleared in the course of bringing such elements of black-letter law to bear on the question of native rights are the provisions contained in Article 1 of the United Nations Charter and Point 7 of General Assembly Resolution 1514 guaranteeing the territorial integrity of all states. 235 By and large, the meaning of these clauses has been interpreted in accordance with the so-called Blue Water principle of the 1960s, a doctrine holding that in order to be eligible for decolonization, a territory must be physically separated from its colonizer by at least 30 miles of open ocean. 236 By the standard, most indigenous peoples are obviously not and will never be entitled to exercise genuine self-determining rights. There are, however, substantial problems attending the Blue Water formulation, not just for indigenous peoples but for everyone. It would not, for instance, admit to the fact that Germany colonized contiguous Poland during WORLDWAR2, or that the Poles possessed a legitimate right to decolonization. Plainly, then, a basic reformulation is in order, starting wraps from the basic premise that integrity is not so much a matter of geography as it is a question of whether a given territory can be shown to have been legitimately acquired in the first place. Thus, the definitional 67 obstacle at hand readily lends itself to being rendered far less insurmountable than it might now appear. 237 Ultimately, such issues can be resolved only on the basis of a logically consistent determination of whether indigenous peoples actually constitute peoples in a legal sense. While the deliberately obfuscatory arguments entered on the matter by the US, Canada, and several other settler states during the 1980s have by this point thoroughly muddied the situation with respect to a host of untreated peoples throughout the world, the same cannot be said of treated peoples in North America. As has been discussed in this essay, we have long since been formally recognized by our colonizers not only as peoples, but as nations, and are thereby entitled in existing law to exercise the rights of such regardless of our geographic disposition. 238 The path leading to an alternative destiny for indigenous peoples is thus just as clear as that the settler states would prescribe for us. By relentless Melnalevi, LTING assertion of the basic rights of treated peoples at all levels, through every available venue and excluding no conceivable means of doing so, we can begin to secure them, restoring to ourselves and our posterity their rightful status as sovereign and co-equal members of the community of nations, free of such pretense as IRA-style self-governance and subterfuges like the Self-Determination Act. In achieving success in this endeavor, we will eventually position ourselves to tangibly assist our relatives in other parts of the world, untreated and thus unrecognized as being imbued with the same self-determining rights as we, to overcome the juridical/diplomatic quandary in which this circumstance places them. Part 2, The Land. In struggle for the land. Entering amongst the opulence, wondering what not to touch, times not knowing, times getting bit, times of temptation, times of seduction. Entering in the poverty, touched by everything, knowing the bite, no time for temptation, only time for doing. Babylon in terror, world run over by machines, the economics of captured dreams. The rich are poorer while the poor are waiting, everyone pretending to live, calling exploitation progress, calling submission freedom, calling madness profit, calling earth a planet, plaguing her with civilization. Jon Trudel from living in reality. Struggle to regain a stolen homeland. Iroquois land rights in upstate New York. The inhabitants of your country districts regard wrongfully, it is true, Indians and forests as natural enemies which must be exterminated by fire and sword and brandy, in order that they may seize their territory. They regard themselves, and their posterity, as collateral heirs to all the magnificent portion of land which God has created from Cumberland and Ohio to the Pacific Ocean. Pierre Samuel Dupont de Nemours letter to Thomas Jefferson, December 1, 1801. One of the longest height and more complicated land rights struggles in the United States is that of the Haudenosaunee, or Iroquois Six Nations Confederacy. The 1783 Treaty of Paris ended hostilities between the British Crown and its secessionists sub-Jects in the 13 Colorado Nice. It had no direct effect upon the state of war existing between those sub-Jects and the various indigenous peoples allied with the Crown. Similarly, while by the treaty George III quit-claimed his own country's rights under the doctrine of discovery within the affected portion of North America, it was the opinion of Thomas Jefferson and others that this had done nothing to vest title to these lands in the newly born United States. 1 On both counts, the Continental Congress found it imperative to enter into treaty arrangements with indigenous nations as expeditiously as possible. 2 A very high priority in this regard was accorded. The Haudenosaunee, or members of which the Mohawks, Senecas, Cayugas, and Onondagas had height with the British. 3 Hence, during October of 1784, the U.S. conducted extensive negotiations with representatives of the Six Nations at Fort Stanwix, in the state of New York. 93. The result was a treaty, said with the second negotiated at Fort Harmar in 1789, by which the Indians relinquished their interest in lands lying west of a north-south line running from Niagara to the border of Pennsylvania, that is to say, their territory within the Ohio River Valley, as well as parcels on which certain military posts had been built. In exchange, the U.S. guaranteed 3 of the hostile nations the bulk of their traditional homelands. The Oneida and Tuscarora were also secured in the possession of the lands on which they are now settled. Altogether, the Haudenosaunee reserved some 6 million acres, about half of the present state of New York, as permanent homelands. For this arrangement, while meeting most of the Indians' needs, was also quite useful to the U.S. central government. As has been observed elsewhere. First, in order to sell and settle it, the Continental Congress needed to extinguish Indian title, including any claims by the Iroquois in it alonce Jotnew York. The commissioners wanted to punish the Senecas. Thus they forced the Senecas to surrender most of their land in New York to the United States. Third, the United States wanted to secure peace by confirming to their remaining lands. Fourth, the United States was anxious to protect its frontier from the British in Canada by securing land for forts and roads along Lakes Erie and Ontario. New York State, needless to say, was rather less enthusiastic about the terms of the treaty. Indeed, it had already attempted, unsuccessfully, to obtain additional land cessions from the Iroquois during meetings conducted prior to arrival of the federal delegation at Fort Stanwix. 6 Further such efforts were barred by Article 9 of the Articles of Confederation, and subsequently by Article I and the Commerce Clause of the Constitution, all of which combined to render treaty-making and outright purchases of Indian land by states illegal. New York therefore resorted to subterfuge, securing a series of 26 leases, many of them for 999 years, on almost all native territory within its purported boundaries. The Haudenosaunee initially agreed to these transactions because of Governor George Clinton's duplicitous assurances that the leases represented a way for them to keep their land, and for his government to extend its protection over their property against the dealings of unscrupulous white land speculators in the private sector. The first such arrangement was reached with the Oneidas in a meeting begun at Fort Schuyler on August 28, 1788. 94. New York. State. Iroquois Treaty. Lands in 1794. Mopo by WWDA, by, Lid, Elf Holland Uni y Liddy of Colundio la Jali du Jl Almd registered July 1992. The New York Commissioners. Led them to believe that they had lost all their land to the New York Genocide Company, and that the commissioners were there to restore title. The Oneidas expressed confusion over this since they had never signed any instruments to that effect, but Governor Clinton just waved that aside. Thus the Oneidas agreed to the lease arrangement with the state because it seemed the only way they could get back their land. The state received some 5 million acres for $2,000 in cash, $2,000 in clothing, $1,000 in provisions, and $600 in annual rental. So complete was the deception that good Peter thanked the governor for his efforts. 7. Leasing of the Tuscaroras land occurred the same day by a parallel instrument. 8 On September 12, the Onondagas leased almost all their land to New York under virtually identical conditions. 9 The Cayugas followed suit on February 2, 1789, in exchange for payment of $500 in silver, plus an additional $1,625 the next June and a $500 annuity. New York's flagrant circumvention of constitutional restrictions on non-federal acquisitions of Indian land was a major factor in passage of the first of the so-called Indian Trade and Intercourse Acts in 1790.11 Clinton. 95. However, simply shifted to a different ruse, avoiding such tightening in the of mechanisms of federal control over his state's manipulations by backdating them. In 1791, for example, he announced that New York would honor a 999-year lease negotiated in 1787 by a private speculator named John Livingston. The lease covered 800,000 acres of mainly Mohawk land, but had been declared null and void by the state legislature in 1788. 1-2 concerned that such maneuvers might push the Iroquois, the largely landless Senecas in particular, into joining Shawnee leader Tecumseh's Pan-Indian Alliance and physically resisting further U.S. expansion into the Ohio Valley. The federal government sent a new commission to lead with the Haudenosaunee leadership at the principal Seneca town of Canandaigua in 1794. In exchange FORA pledged FROM the Six Nations not to bear arms against the United States, their ownership of the lands guaranteed them at Fort Stanwix was reaffirmed, the state's leases notwithstanding, and the BULK. Nonetheless, New York officials, obviously undaunted by this turn of events, rapidly parceled out sections of the leased lands in subleases to the very unscrupulous whites it had pledged to guard against. On September 1, 1797, the Holland Land Company, in which Lanny members of the state government had invested, assumed control over all but 10 tracts of land, totaling 397 square miles, of the Fort Stanwix TRED area. The leasing instrument purportedly extinguished native title to the land, a process which would be repeated many times over in the coming years. 14. Expropriation. Given the diminishing military importance of the Six Nations after the Shawnees' 1794 defeat at Fa'alantimhurst and the eventual vanquishing of Tecumseh at Tippecanoe in 1814, federal authorities ultimately did little or nothing to correct the situation despite continuous Iroquois protests. New York, along with others of the individual states, was thus emboldened to proceed with wholesale appropriations of native territory. In 1810, for instance, the Ho Land Company sold some 200,000 acres of its holdings in Seneca and Tuscarora land to its own accountant, David A. Ogden, at a price of 50 cents per acre. Ogden then issued shares against development of this land, many of them to Albany politicians who already 96. New York. State. Ward OWD2C July 1992. Land grants, purchases and Indian reservations within the 1794 treaty area. Held stock in Holland. Thus capitalized, the Ogden Land Company was able to push through a deal in 1826 to buy a further 81000 acres of previously unleased reservation land at 53 cents per acre. A federal investigation into the affair was quashed in 1828 by Secretary of WAR Peter B. Porter, himself a major stockholder in Ogden. 16 Under such circumstances, most of the Oneidas requested in 1831 that what was left of their New York holdings, which they were sure they would lose anyway, be exchanged for a 500,000 acre parcel purchased from the Menominees in Wisconsin. President Andrew Jackson, at the time pursuing his policy of general Indian removal to points west of the Mississippi, readily agreed why in the climate created by Jackson's own posturing, an ever-increasing number of federal officials followed Porter's example, actively colluding with their state-level counterparts and private speculators, thereby erasing altogether whatever meager protection of native rights had previously emanated from Washington. D.Cis. One outcome was that on January 15, 1838, federal commissioners oversaw the signing of the Treaty of Buffalo Creek, wherein 102,069 acres of 97 Seneca land was ceded directly to the Ogden Company. The $202,000 purchase price was divided almost evenly between the government and individual non-Indians seeking to buy and improve plots in the Fo-Meta reservation area. At the same time, what was left of the Cayuga, Oneida, Onondaga, and Tuscarora holdings were wiped out, at an aggregate cost of $400,000 to Ogden. 19 The Haudenosaunee were told they should relocate en masse to Missouri. Although the Six Nations never consented to the treaty, and it was never properly ratified by the Senate, President Martin Van Buren proclaimed it to be the law of the land on April 4, 1840.20 by 1841. Iroquois complaints about the Buffalo Creek Treaty were being joined by increasing numbers of non-Indians outraged not so much by the loss of land to Indians it entailed as by the obvious corruption involved in its terms. Why consequently, in 1842, a second Treaty of Buffalo Creek was drawn up. UI1 JCL Tlis ILCVV and Better Instrument, THLT.S. Again acknowledged the Haudenosaunee right to reside in New York and restored small areas such as the Allegheny and Cattaraugus Seneca reservations. The Onondaga Reservation was also reconstituted on a 7,300-acre land base, the Tuscarora Reservation on a paltry 2,500 acres. The Ogden Company, for its part, was allowed to keep the rest. 22 Although the Tonawanda Band of Senecas immediately filed a formal protest of these terms with the Senate, all they received for their efforts was an 1857 award of $256,000 of their own money with which to buy back a minor portion of their former territory. 23 Ogden, of course, was thus perfectly positioned to reap an extraordinary profit against what it had originally paid the same unwilling sellers. And so it went, year after year. So rich were the rewards to be gleaned from peddling Indian land that, beginning in 1855, the Erie Railway Company entered the picture. While the state legislature quickly approved the company's bids to obtain long-term leases on significant portions of both the Cattaraugus and Allegheny reservations, the state judiciary sensed an even greater opportunity. Playing upon the depth of then prevailing federal enthusiasm for railroad construction, New York's High Court Justices engaged in a cynical and rather elaborate ploy meant to persuade Congress to open the door of legitimation to the full range of the state's illicit leasing initiatives. Though the railroad leases were ratified by New York, the state's Supreme Court in 1875 invalidated them. In recognition of this action, the New York legislature passed a 98 concurrent resolution that state action was not sufficient to ratify leases because Congress alone possesses the power to deal with and for the Indians. Instead of setting aside the leases, Congress in 1875 passed an act authorizing the state now made leases renewable for 12 years, and by an amendment in 1890 the years were extended to 99. Later the Supreme Court of New York deemed them perpetual 24. As a result, by 1889 80% of all Iroquois reservation land in New York was under lease to non-Indian interests and individuals. The same year, a commission was appointed by Albany to examine the state's Indian problem. Rather than suggesting that the appropriation of 4/5 of their land had deterred Indian welfare, the commission criticized the Indians for not growing enough to feed themselves, thereby placing an undue burden on those profiting from their land. Chancellor C. N. Sims of Syracuse University, a commission member, argued strongly that only obliteration of the tribes, conferral of citizenship, and allotment of lands would set things right. 25 Washington duly set out to undertake allotment, but was stunned to discover it was stymied by the underlying title to much of the reserved Haudenosaunee land it had allowed the Ogden Company to obtain over the years. In 1895, Congress passed a bill authorizing a buyout of Ogden's interest, again at taxpayer expense, but the company upped its asking price for the desired acreage from $50,000 to $270,000. 26 The plan thereupon collapsed, and the Six Nations were spared the individual/social/political trauma, and the potential of still further land loss, to which they would have been subjected in the allotment process. 27 Not that the state did not keep trying. In 1900, after uttering a string of bellicosities concerning backward savages, Governor Theodore Roosevelt created a commission to re-examine the matter. This led to the introduction in 1902 of another bill aimed at allotting the Seneca reservations with 50,000 acres in all. They were by far the largest remaining Iroquois land areas by paying Ogden $200,000 of the Indians' Trust funds to abandon its claims on Allegheny and Cattaraugus. 28 The Senecas retained attorney John V. A. N. Voorhis to argue that the Ogden claim was invalid because, for more than 100 years, the company had not been compelled to pay so much as a nickel of tax on the acreage it professed to own. By this, they contended, both Ogden and the government had all along admitted that, for purposes of federal law, the land 99 was really still the property of Indians not taxed. Roosevelt's bill was withdrawn in some confusion at this point, and allotment was again averted. 29 In 1905, the Senecas carried the tax issue into court in an attempt to clear their land title once and for all, but the case was dismissed on the premise that Indians held no legal standing upon which to sue non-Indians. 30 Yet thirdedum pt to allot the Six Nations reservations undered in 1914, as did a new York state constitutional amendment, proposed in 1915, to effectively abolish the reservations. Even worse, from New York's viewpoint, in 1919 the U.S. Justice Department for the first time acted in behalf of the Haudenosaunee, filing a suit which established a 32-acre reservation near Syracuse for the Oneidas. 31 The state legislature responded by creating yet another commission, this one headed by attorney Edward A. Everett, a political conservative, to conduct a comprehensive study of land title questions in New York and to make recommendations as to how LHCY might be cleared up across the board. Once and for all. 32 The fix again seemed to be in. After more than 2 years of hearings and intensive research, however, Everett arrived at a thoroughly unanticipated conclusion: the Six Nations still possessed legal title to all 6 million acres of the Fort Stanwix Treaty area. He cited international law to the effect that there are only 2 ways to take a country away from a people possessing it: purchase or conquest. The Europeans who came here did recognize that the Indians were in possession, and so, in his opinion, THM recognized their status as nations. If then, the Indians did hold fee to the land, how did they lose it? Recognized by George Washington as a nation at the Treaty of 1784. Hence, they were as of 1922 owners of all the LMD them in that treaty unless they had ceded it by a treaty equally valid and binding. In his final report, Everett reinforced his basic finding with references to the treaties of Forts Harmar and Canandaigua, discounted both Buffalo Creek treaties as fraudulent, and rejected not only the leases taken by entities such as the Holland and Ogden companies but those of New York itself as lacking any legal validity. At A11.34 the Albany government quickly shelved the document rather than publishing it, but could not prevent its implications from being discussed throughout the Six Nations. On August 2, 1922, a council meeting was held at Onondaga for purposes of retaining Mrs. Lulu G. Stillman, Everett's secretary, to do research on the exact boundaries of the Fort Stanwix Treaty Area. 35 The Iroquois Land. 100. Claim struggle had shifted from dogged resistance to dispossession to the offensive strategy of land recovery, and the first test case, James Deere v. St. Llij River Power Company, was filed on June 26, 1925, in an attempt to regain a portion of the St. Regis Mohawk Reservation taken by New York. The federal government declined to intervene on the Mohawks' behalf on behalf of the Allegheny Senecas. The suit, ostensibly aimed at eviction of an individual who had refused to pay his $4 per year rent to the Indians for 8 years, actually sought to enforce a resolution of the Seneca Nation canceling hundreds of low-cost, 99-year leases taken in the city of Salamanca on the reservation in 1892. Intervening for the defendants was the Salamanca Trust Corporation, a mortgage institution holding much of the paper at issue. Although the case was ultimately unsuccessful in its primary objective, it did force a judicial clarification of the fact that, in and of itself, New York law had no bearing on leasing arrangements pertaining to Indian land. 38 This was partly corrected, in the state view, on July 2, 1948, and September 13, 1950, when Congress passed bills placing the Six Nations under New York jurisdiction in TL.RST criminal and then civil matters. 39 Federal responsibility to assist IN. Dion's in pursuing treaty-based land claims was nonetheless explicitly preserved. 4 Washington, of course, elected to treat this obligation in its usual cavalier fashion, plunging ahead during the 1950s while the Indians were mired in efforts to prevent termination of their FED. 101. Aerial recognition altogether with the flooding of 130 acres of the St. Regis Reservation near Messina, American Samoa, part of the St. Lawrence Seaway Pro JECT 41. The government also proceeded with plans to flood more than 9,000 acres of the Allegheny Reservation as a byproduct of constructing the Kinzua Dam. Although studies revealed an alternative site for the dam that would not only spare the Seneca land from flooding but better serve the greater public good for which it was supposedly intended, Congress pushed ahead. 42 The Senecas protested the pro-JECT as a clear violation of the Fort Stanwix guarantees, a position with which lower federal courts agreed, but the Supreme Court ultimately declined to decide the question and the Army Corps of Engineers completed the dam in 1967.43. Meanwhile, the new YORK State Power Authority was attempting to seize more than half of the Tuscarora Reservation, near Buffalo, as a reservoir for the Niagara Power Pro-JECT. In April 1, 1958, the Tuscaroras physically blocked access by construction workers to the site, and several were arrested. A federal district judge entered a temporary restraining order against the state, but the appellate court ruled that congressional issuance of a license through the Federal Power Commission constituted sufficient grounds for the state to exercise eminent domain over native property. 44 The Supreme Court again refused to hear the resulting Haudenosaunee Appel. A compromise was then implemented in which the state flooded only 560 acres, or about 1/8 of the remaining Tuscarora land. 45. Ganique. By the early 1960s, it had become apparent that the Six Nations, because their territory fell within the boundaries of one of the original 13 states, would not be allowed to seek redress through the Indian Claims Commission. 46 The decade was largely devoted to a protracted series of discussions between state officials and various sectors of the Iroquois leadership. Agreements were reached in areas related to education, housing, and revenue sharing, but on the issues of land claims and jurisdiction, the position of Longhouse traditionals was unflinching. In their view, the state holds no rights over the Haudenosaunee in either sphere. The point was punctuated on May 1, 1974, when Mohawks from the St. Regis and Kaufnawega reservations occupied an area at Ganique. 102. In the Adirondack Mountains. They proclaimed the site to be sovereign Mohawk territory under the Fort Stanwix Treaty. Represent a clout of title not only to 6.127 acres in Herkimer County but to all of northeastern NY, set out to defend it, and themselves, by force of arms. 48 After a pair of local vigilantes engaged in shooting at the Indians were wounded by return gunfire in October, the state filed for eviction in federal court. The matter was bounced back on the premise that it was not a federal issue, and the new YORK Attorney General, undoubtedly discomfited at the publicity prospects entailed in an armed confrontation on the scale of the 1973 Wounded Knee siege, let the case die. 49 The state next dispatched a negotiating team headed by then Future, now ex-Governor Mario Cuomo. In May 1, 1977, partially as a result of Cuomo's efforts but more importantly because of the Indians' obvious willingness to slug it out with state authorities if need be, the Moss Lake Agreement was reached. Under its provisions, the Mohawks assumed permanent possession of a land parcel at Minor Lake, near the town of Altona, and another in the nearby Macomb reforestation area. 50 Mohawk possession of the sites remains ongoing in 1998, a circumstance which has prompted others among the Six Nations to pursue land recovery through a broader range of tactics and, perhaps, with greater vigor than they might otherwise have employed. 51. The Oneida land claims. As all this was going on, the Oneidas had, in 1970, filed the first of the really significant Iroquois land claim suits. The case, Oneida Indian Nation of New York v. County of Oneida, charged that the transfer of 100,000 acres of Oneida land to New York via a 1795 lease engineered by Governor Clinton was fraudulent and invalid on both constitutional grounds and because it violated the 1790 Trade and Intercourse Act. It was dismissed because of the usual Indians lack legal standing argument, but Reinstat ed by the Supreme Court in 1974.52 compelled to actually examine the merits of the case. For the first time, the U.S. District Court agreed with the Indians that title still rested with the Oneidas. The plaintiffs have established a claim for violation of the Non-Intercourse Act. Unless the act is to be considered nugatory, it must be concluded that the plaintiffs' right of occupancy and possession of the land in question was not alienated. By the deed of 1795, the state had no rights against the plaintiffs, consequently, its successors, the defendant counties, are in no better position. On point 53. Remaining the Oneidas a legal fiction, and the lower court's rulings racist, attorney Alan Van Gestel appealed on behalf of the defendants to the Supreme Court. 54 On October 1, 1984, the High Court ruled against Van Gestel and ordered his clients to work out an accommodation, indemnified by the state, including land restoration, compensation, and rent on unrecovered areas. 55 Van Gestel continued to howl that the common people of Oneida and Madison counties were being held hostage, but as the Oneida's attorney, Arlinda Locklear, put it in 1986. One final word about responsibility for the Oneida claims. It is true that the original sin here was committed by the United States and the state of New York. It is also no doubt true that there are a number of innocent landowners in the area, i.e., individuals who acquired their land with no knowledge of the Oneida claim to it. Those facts alone do not end the inquiry respecting ultimate responsibility. Whatever the knowledge of the claims buyer, then, the landowners have certainly been aware of the Oneida claims since 1970 when the first suit was filed. Since that time, the landowners have done nothing to seek a speedy and just resolution of the claims. Instead, they as a point of principle denied the validity of the claims and pursued the litigation, determined to prove the claims to be frivolous. Now that the landowners have failed in that effort, they loudly protest their innocence in the entire matter. The Oneidas, on the other hand, have since 1970 repeatedly expressed their persecution for an out-of-court resolution of their claims. Had the landowners joined with the Oneida 16 years ago in seeking a just resolution, the claims would no doubt be resolved today. For that reason, the landowners share in the responsibility for the situation in which they find themselves today. 6. Others would do well to heed these words because, as Locklear pointed out, the Oneida case paved the legal way for other Indian land claims. 57. Not least of these are other suits by the Oneidas themselves. In 1978, the New York Oneidas filed for adjudication of title to the entirety of their Fort Stanwix claim, about 4.5 million acres, in a case affecting not only Oneida and Madison counties, but Broome, Chenango, Cortland, Herkimer, Jefferson, Lewis, Onondaga, Oswego, St. Lawrence, and Tioga counties as well. 58 Then, in December 1, 1979, the Oneida Nation of Wisconsin and the Thames Land of South Gold, Ontario, joined in an action pursuing rights in the same claim area, BNT naming the state rather. 104. Then individual counties as defendant. 59 The Cayuga Nation, landless throughout the 20th century, has also filed suit against Cayuga and Seneca counties for recovery of 64,015 acres taken during Clinton's leasing FOA of 1789.60. The Cayuga land claims. The latter case, filed on November 1, 1980, resulted from attempts by the Cayugas to negotiate some sort of land base and compensation for themselves with federal, state and county officials from the mid-70s onward. By August 1, 1979, they had worked out a tentative agreement that would have provided them with the 1,852-acre Sampson Park in southern Seneca County, the 3,629-acre hectare land use area in the same county, and an $8 million trust account established by the Secretary of the Interior. Although not 1 square inch of their holdings was threatened by the arrangement, the response of the local non-Indian population was rabid. Paul D. Moonen, Sr., president of the local Monroe Title and Abstract Company, the Cayugas have no moral or legal justification for their claim. 62. Wisner Kin, a farmer near the town of Ovid, immediately founded the Seneca County Liberation Organization, a group defined by nothing so much as its propensity to express the most virulent anti-Indian sentiments. SCLO attracted several hundred highly vocal members from the sparsely populated county. 63 A bill to authorize the settlement subsequently failed due to this white backlash, and so the Cayugas went to court to obtain a much larger area, eviction of 7,000 county residents and $350 million in trespass damages. Attempts by attorneys FORSCLO to have the suit dismissed failed in 1982, as did a 1984 compromise offer initiated by Representative Frank Horton. The latter, which might well have been accepted by the Cayugas, would have provided them with the 200-acre Howland Game Management Reserve along the Seneca River, a 2,850-acre parcel on Lake Ontario possessed by the Rochester Gas and Electric Company, and a 2,000-acre parcel at J.O. Inning Sampson State Park. Additionally, the Cayugas would have received well in excess of the $8 million they had originally sought. 64 While SCLO appears by this point to have decided that acquiescence might well be the better part of valor, the proposal came under heavy attack. 105. Oneida. Land Claim. State of New York 1984. FROM non-Indian environmentalists and other supposed progressives concerned about the animals in the Howland Reserve. Ultimately, it was nixed by Ronald Reagan in 1987, not out of concern for local fauna, or even as part of some broader anti-Indian agenda, but because was he angry with Horton for voting against his own proposal to fund the Nicaraguan Contras low-intensity war against that country's Sandinista government. 65 The suit is therefore ongoing. Salamanca. In the town of Salamanca, to which the leases expired at the end of 1991, the Allegheny Senecas also undertook decisive action during the second half of the 1980s. Beginning as early as 1986, they stipulated their intent not only to not renew leasing instruments, but to begin eviction proceedings against non-Indian lease and mortgage holders in the area unless the terms of any new arrangement were considerably recast in their favor. In substance, they demanded clarification of underlying Seneca title to the township, a shorter leasing period, FAIR rates for property rental, and preeminent jurisdiction over both the land and income-derived FROM at. 66. 106. A further precondition to lease renewal was that compensation be made for all non-payment and underpayment of FAIR rental values of Seneca property accruing from the then existing lease. Although these demands unleashed a storm of protest from local whites, who, as usual, argued vociferously that the Indian owners of the land held no rights to it, the Senecas were successful both in court and in Congress. 67 With passage of the Seneca Nation Settlement Act in 1990, the more essential Seneca demands were met. These included an award of $60 million, with costs borne equally by the federal, state and local governments, to reimburse the Allegheny Band for rental monies they should have received in over the past 99 years, but did not. The road ahead. The limited but real gains posted thus far, in both the Oneida land claims and with regard to renegotiation of the Salamanca leases, point to a viable strategy for a gradual recovery of Haudenosaunee land and jurisdictional rights in upstate New York during the years ahead. As of this writing, the second Oneida suit remains in process, as does the Cayuga suit. Based against the sort of settlement achieved in the earlier Oneida win, these seem likely to generate, if not a truly FAIR resolution of the issues raised, then a marked improvement in the circumstances of both nations. Also at issue is a long-term lease of Onondaga land upon which the city of Syracuse has been built. Following the pattern evidenced at Salamanca, the Onondagas have been able to secure an agreement in principle with state, local, and federal authorities which would both compensate them for lost rental earnings over the past century and generate a much higher level of income in the future. These monies can, in turn, be invested in the restoration of rural areas adjoining the presently tiny Onondaga Reservation to the nation's use and control. Overall, it seems probable that such efforts at litigation and negotiation will continue over the next 10 to 20 years, and thereby serve to enhance the relative positions of the Tuscarora and Mohawk nations as well as their FOR confederates. The increasing scope of native jurisdiction in New York which such a process would necessarily entail may accomplish a changed sensibility among the state's non-Indian residents, as they discover firsthand that a genuine exercise of indigenous rights does not automatically 107 lead to their disenfranchisement or dispossession of personal property. Indeed, it may be that at least some sectors of New York's non-Indian population may learn that coming under Indian jurisdiction can he prefer able to remaining under the jurisdiction of the state. If so, it may be that the ongoing assertion of Haudenosaunee sovereignty within the 1794 treaty territory will develop peacefully and with a reasonably high degree of Indian/white cooperation over the long run, reversing the unrelenting manifestation of Euro-American avarice, duplicity, and racism which has marked this relationship over the past 2 centuries. In the alternative, when the methods of litigation and negotiation reach the limit of the state's willingness or ability to give ground as surely they must, absent a profound alteration in the attitudes of the interloping white populace, conflicts of the sort previewed at Ganike and Oka must be the inevitable result. Something of a crossroads is thus at hand in northern New York state. Things could go either way. And in the final analysis, the choice is one which resides with the state and its immigrant citizens. The Haudenosaunee own the land there by all conceivable legal, moral and ethical definitions. They always have, and will continue to until they decide otherwise. As a whole, they have demonstrated a remarkable patience with those who have presumed to take what was and is theirs. But such patience cannot last forever. The Black Hills are not for sale. The Lakota struggle for the 1868 treaty territory. One does not sell the earth upon which the people walk. Tisinki Whitco, 1875. The defining characteristic of Federal-Indian relations since the moment the United States was born has been an insatiable U.S. quest to expropriate native land by any and all means available to it. Prior to the American War of Independence, less than 10% of the aboriginal land base within what are now the 48 contiguous states of the United States had been occupied by the European powers. Between 1787 and 1930, working westward from the original 13 colonies area of the eastern seaboard, the federal government seized approximately 90% of all remaining Indian acreage. Much of this land was retained by the government in the form of a sprawling complex of national forests, parks, military bases, and other facilities. The rest was parceled out to a broad variety of corporate clients and the Euro-American public at large. By 1990, indigenous people inside the United States retained only about 2.5% of the aggregate land base we enjoy yet in 1600. On the basis of such internal conquest and ongoing occupation, the United States has projected itself into the posture of a world power. For our part, American Indians have suffered greatly and consistently in our efforts to hold onto our territories, not infrequently experiencing outright genocide in the process of confronting Euro-American invaders. Nonetheless, the survivors have persistently sought to recover our homelands, once taken. The pattern has been replicated in hundreds of different settings across the FACE of North America. Perhaps the best known, and Sir. 113. Tainly one of the more sustained, of these struggles is that of the Lakota Nation, otherwise known as the Western Sioux or Teton Dakota, composed of the Oglala, Sikongu, Hunkpapa, Minneconjo, Itasipko, Sihasapa and Bohinantsa bands for the Black Hills region over the past century. In many ways, the Black Hills land claim serves as a lens through which all such Indian government conflicts can be viewed and more readily understood. Its ultimate outcome will have a wide-ranging impact upon native rights to land and self-determination throughout the United States. The Treaties of Fort Laramie and the Great Sioux War. In 1851, the United States entered into the first Fort Laramie Treaty with the Lakota, Cheyenne, Arapaho, Crow, and other indigenous nations of the northern and central plains regions. In large part, the treaty was an attempt by the federal government to come to grips with the matter of Indian territoriality within the vast Louisiana Purchase area it had acquired from France earlier in the century. The Lakota were formally recognized in the 1851 treaty as being entitled to a huge tract centering upon their sacred lands, called Pahasepa, including virtually all of the present states of South Dakota and Nebraska, as well as appreciable portions of Kansas, North Dakota, Montana, and Wyoming, and a small portion of Colorado. In sum, the U.S. formally recognized Lakota sovereignty and national ownership of between 6 and 7% of the overall territory now comprising the lower 48 states. It was not long, however, before gold and silver were discovered in the Virginia City portion of Montana Territory, and a short route to these ore fields began to be considered essential to a U.S. economy beset by the demands of the Civil War. Hence, at least as early as 1864, the government entered into open violation of the 1851 Treaty, sending troops to construct a series of forts intended to secure what was called the Bozeman Trail, directly through the western portion of the Lakota homeland. The Lakota, under the political leadership of Red Cloud and Oglala, responded by forming an alliance with the Cheyenne and Arapaho, bringing their joint military forces to bear upon the trail during the winter of 1866–67. By early 1868, the United States, having suffered several defeats in the field, and finding its 114 troops trapped in their forts, sued for peace. This led, that same year, to a second Fort Laramie Treaty in which the federal government once again recognized Lakota sovereignty and national territoriality, this time establishing a Jesuit Sioux reservation encompassing all of contemporary South Dakota west of the east bank of the Missouri River, and acknowledging that the Jesuit Sioux Nation was entitled to permanent use of unceded Indian territory involving large portions of Nebraska, Wyoming, Montana, and North Dakota. 3 Further, the new treaty committed U.S. troops to prevent non-Indians from trespassing in the Lakota domain, specified that it did nothing to abrogate or annul Lakota land rights acknowledged in the 1851 Treaty 4, and provided that no treaty for cession of any portion of the reservation herein described which may be held in common shall be of any validity or force as against said Indians, unless executed and signed by at least 3/4 of all adult male Indians, occupying or interested in the same. Again, the United States was unwilling to honor the treaty for long. A Catholic priest, Jean de Smet, ventured illegally into the Black Hills and afterwards reported to the Sioux Falls Times that he had discovered gold therein. 6 In short order, this led to the government's reinforcing Lt. Colonel George Armstrong Custer's elite 7th Cavalry Regiment and violating both the 1851 and 1868 treaties by sending this heavy military force directly into the hills on a fact-finding mission. Custer's 1874 report that he too had found gold in the Pahasapa, much ballyhooed in the Eastern press, led to another military foray into the hills, the Jenny Expedition, during the summer of 1875. 7 The fact that there was gold in the heart of Lakota territory, in their most holy of places, was thus confirmed to the satisfaction of Washington officials. With that, the government sent yet another treaty commission to meet with the Lakota leadership, this time in an effort to negotiate purchase of the Black Hills. 8 When the Lakotas refused to sell, Washington responded by transferring its relations with them from the Bureau of Indian Affairs to the Department of War. All Lakotas were ordered to gather at their assigned agencies within the Great Sioux Reservation by no later than the end of January 1, 1876, although they plainly had every right to be anywhere they chose within their 115 treaty territory. Those who failed to comply with this utterly unlawful federal directive were informed that they would be viewed as having broken the peace and consequently treated as hostiles. Meanwhile, President Ulysses S. Grant completed the government's raft of treaty violations by secretly instructing his army commanders to disregard U.S. obligations to prevent the wholesale invasion of the Lakota heartland by non-Indian miners. 9 Rather than submitting to federal dictates, the Lakotas gathered in the remote Powder River County of southeastern Montana, a part of their unceded territory, to discuss how they should respond. In turn, the army used this gesture of hostility as a pretext for launching a massive assault upon them, with the express intent of crushing Sioux resistance completely, once and for all. The U.S. Objective in this was, of course, to simply obliterate any Lakota ability to effectively oppose federal expropriation of the Black Hills. The mechanism chosen to accomplish this task was a 3-PRON power over Indian affairs, placed more than two-thirds of the most productive reservation acreage in the hands of non-Indian ranchers, farmers, and corporate concerns. 27 completely dispossessed of their land and traditional economy, modern Lakotas confront a circumstance on their reservations in which unemployment for Indians has hovered in the 90th percentile throughout the past half-century and more. 28 The implications of this situation are both predictable and readily apparent. The poorest county in the United States every year since World War has been Shannon, on the Pine Ridge Reservation. Todd County, on the adjoining Rosebud Reservation, has kept PACE, consistently placing among the 10 poorest locales in the federal poverty index. 29. 119. The legal battle. Many Lakotas, of course, never accepted the fact or circumstances of their colonization. Realizing in the wake of the Wounded Knee massacre that any direct military response to U.S. transgressions would be at best self-defeating, they opted instead to utilize the colonizers' own legal codes and its pretense of being a humanitarian power, bound by the laws of civilized conduct as a means of recovering what had been stolen from them. 30. The first court case. In 1920, a federal law was passed which authorized the Lakotas to sue the government under treaties, or agreements, or laws of Congress, on the misappropriation of any funds or lands of said tribe or band or bands thereof. 31. The law was hardly altruistic. Realizing that there had been difficulties with the manner in which Lakota consent had been obtained for the 1877 LHIH's land cession, the government saw the bill a handy means to hui the now impoverished Indians off and at last quiet title to the hills. This was amply revealed in 1923 when the Lakotas entered their suit with the Federal Court of Claims seeking return of their stolen land rather than the monetary compensation the United States had anticipated would be at issue. Not knowing what to do in the face of this unexpected turn of events, the court stalled for 19 years, endlessly entertaining motions and counter-motions while professing to study the matter. Finally, in 1942, when it became absolutely clear the Lakotas would not accept cash in lieu of land, the court dismissed the case, claiming the situation was a moral issue rather than a constitutional question over which it held jurisdiction. 32 In 1943, the U.S. Supreme Court refused to even review the claims court decision. 33. The Claims Commission. The litigational route appeared to be stalemated. But on August 1, 1946, the Indian Claims Commission Act was passed by a Congress anxious to put the best possible face on the government's past dealings with American Indians. 34 Motivation for this accrued from the recently announced U.S. intention of sitting in judgment of the Nazi and Imperial Japanese leadership for having engaged in crimes against the peace, war crimes, and other crimes against humanity. 120. 35 Under such circumstances, the federal government wished to present an impeccably moral facade to the world. Section 2 of the new act defined the bases upon which Indians might sue for lands lost, including claims in law or equity arising under the Constitution, laws, and treaties of the United States. Claims based on fraud, duress, unconscionable consideration, mutual or unilateral mistake, whether of law or of fact, or any other ground recognizable by the Court of Inquiry. 36 Recognizing that such language might arguably cover U.S. acquisition of the Mac Hills, the Lakotas filed their original Court of Claims case with the Claims Commission in 1950. The Commission, however, opted to view the case as having been retired by the 1942 Court of Claims dismissal and subsequent Supreme Court denial of certiorari. It likewise dismissed the matter in 1954.37. The Court of Claims upheld the Commission's decision on appeal from the Lakotas during the same year. 38 Undeterred by this failure of due process, the Lakotas entered a second appeal, and in 1958 the Indian Claims Commission ordered by the Court of Claims to reopen the case on the grounds that the Sioux had previously been represented by inadequate counsel and as a consequence an inadequate record already been resolved. 48. In 1981, the U.S. Eighth Circuit Court of Appeals affirmed the district court's dismissal, and, in 1982, the Supreme Court once again declined to hear the resultant Lakota appeal. 49. These decisions opened the way in 1985 for the Court of Claims to finalize its award of monetary compensation as the exclusive available remedy for the Black Hills Land Claim. 50. In sum, their Lakota recourse in U.S. courts had been extinguished by those courts. The game had always been rigged, and the legal strategy had proven quite unsuccessful in terms of either achieving Lakota objectives or even holding the United States accountable to its own professed system of legality. On the other hand, the legal route did mark solid achievements in other areas. Pursuing it demonstrably kept alive a strong sense of hope, unity, and fighting spirit among many Lakotas that might otherwise have diminutived over time. Further, the more than 60 years of litigation had forced a range of admissions from the federal government concerning the real nature of the Black Hills expropriations. The Supreme Court, for example, termed the whole FLLR a ripe and rank case of dishonorable dealings and national disgrace. Such admissions went much further toward fostering broad public understanding of Lakota issues than a one-sided Indian recounting of the facts could ever have. Cumulatively then, the Lakota legal strategy set the stage for both an ongoing struggle and for public acceptance of a meaningful solution to the Black Hills claim. 1, 2, 3. The extra-legal battle. It is likely that the limited concessions obtained by the Lakotas from U.S. courts during the 1970s were related to the emergence of strong support for the American Indian movement on Pine Ridge and Rosebud reservations during the early part of the decade. At the outset, AIM's involvement on Pine Ridge concerned the provision of assistance to local traditional Oglalas attempting to block the illegal transfer of approximately 1/8 of the reservation to the U.S. Forest Service by a corrupt tribal administration headed by Richard Wilson. 51. AIM provided a marked stiffening of the Lakota resolve to pursue land rights by demonstrating a willingness to go toe-to-toe with federal forces on such matters, an attitude largely absent in Indian country since 1890. The virulence of the federal response to AIM's criminal arrogance in this regard led directly to the dramatic siege of the Wounded-Knee hamlet in 1973, a spectacle which riveted international attention on the Black Hills land issue for the first time. In turn, this scrutiny resulted in analysis and an increasingly comprehensive understanding of the vast economic interests underlying federal policy in the region. This process steadily raised the level of progressive criticism of the government and garnered further non-Indian support for the Lakota position. Anxious to reassert its customary juridical control over questions of Indian land rights, the government engaged in what amounted to a counterinsurgency war against AIM and its traditional Pine Ridge supporters from 1973 to 1976.52. By the latter year, however, it was a bit too late to effectively contain AIM's application of external pressure to the U.S. judicial system. In 1974, the Lakota elders had convened a treaty conference on the Standing Rock Reservation and charged Oglala Lakota AIM leader Russell Means with tacking the 1868 Fort Laramie Treaty before the Family of Nations 53. Means therefore met AIM's diplomatic arm, the International Indian Treaty Council, and set about achieving a presence within the United Nations, not only for the Lakotas, but for all the indigenous peoples of the Eastern Hemisphere. LITC accomplished this in 1977 largely on the basis of the work of its first director, a Cherokee named Jimmy Durham, when delegations from 98 American Indian nations were allowed to make presentations before a subcommission of the UN Commission on Human Rights. At the Palace of Nations in Geneva, Switzerland. 54. In 1981, the United Nations reacted to what it had heard by establishing a working group on indigenous population, lodged under the United Nations Economic and Social Council, holding the same legal and moral force as the Universal Declaration of Human Rights, the 1948 Convention on Prevention and Punishment of the Crime of Genocide, assorted Geneva Conventions, and other elements of international law. 58 The result of this international approach was to deny the United States the veil of secrecy behind which it had conducted its Indian affairs as a purely internal matter. Exposed to the light of concentrated international attention, the federal government was repeatedly embarrassed by the realities of its own Indian policies and court decisions. As a consequence, federal courts became somewhat more accommodating in the Black Hills case than they might otherwise have been. Still, when the Lakotas rejected monetary settlement of their land claim in 1979-80, AIM was instrumental in forging the popular slogan "The Black Hills are not for sale." This was again coupled with direct extra-legal action when Russell Means initiated an occupation in 1981 of an 880-acre site near Rapid City in the Black Hills. This was couched in terms of being the first step in the physical reoccupation of Pahasapa. The AIM action again caused broad public attention to be focused upon the Lakota land claim, and precipitated the potential for another major armed clash with federal forces. The latter possibility was averted at the last moment. 126. By a federal district judge who, reflecting the government's concern not to become engaged in another Wounded Knee-type confrontation, issued an order enjoining the FBI and U.S. Marshal Service FROM undertaking an assault upon the occupants of what was by then called Yellow Thunder CAMP. 59 Under these conditions, the government was actually placed in the position of having to sue the Indians in order to get them to leave what it claimed was U.S. Forest Service property. 60 AIM countersued on the basis that federal land use policies in the Black Hills violated not only the 1868 treaty, but also Lakota's spiritual freedom under the First Amendment to the U.S. Constitution and the American Indian Religious Freedom Act. 61 In 1986, the government was stunned when U.S. District Judge Robert O'Brien ruled in favor of AIM, finding that the Lakotas had every right to the Yellow Thunder site, and that the United States had clearly discriminated against them by suggesting otherwise. The Yellow Thunder ruling was a potential landmark, bearing broad implications for application in other Indian land claims cases in the United States. However, O'Brien's finding was severely undercut by the Supreme Court's Geo Road decision in 1988 and was consequently nullified by the Eighth Circuit Court. 6-2 Like the Lakota legal strategy, AIM's course of largely extra-legal action has proven insufficient in itself to resolve the Black Hills land claim. Nonetheless, it can be seen to have had a positive bearing on the evolution of litigation in the matter, and it has accomplished a great deal in terms of bringing public attention to an understanding of the real issues involved. In this sense, the legal and extra-legal battles fought by Lakota's for Pahasapa may be viewed as having been, perhaps inadvertently, mutually reinforcing. And, together, these two efforts may have finally created the context in which a genuine solution can finally be achieved. The Bradley Bill. By the mid-1980s, the image of the United States regarding its treatment of the Lakotas had suffered so badly that a liberal New Jersey senator, Bill Bradley, took an unprecedented step, introducing legislation to Congress which the Lakotas themselves had proposed. 63 With the goal of finally ending the Black Hills controversy, the draft bill, S1453, was proposed to reconvey title to 750,000 acres of the hills currently held by the federal. 127. Government, including subsurface rights, to the Lakotas. Further, it provided that certain spiritual sites in the area would be similarly retitled. These sites, along with some 50,000 of the reconveyed acres, would be designated as Park. The BA lands of the land returned would be designated as forest. Additionally, considerable water rights within the South Dakota portion of the 1,868 treaty territory would be reassigned to the Lakotas. A Sioux National Council, drawn from all existing Lakota reservations, holding increased jurisdiction within the whole 8.5 million acres of the 1,868 Great Sioux Reservation, would also be established. Timbering and grazing permits, mineral leasing, etc., in the Black Hills would be transferred to Lakota control 2 years after passage of the bill, thus establishing a viable Lakota economic base for the first time in nearly a century. The $1.22.5 million awarded by the court of claims, plus interest accrued since 1980. Lakota's historic loss of use of their land rather than as payment for the land itself. Finally, the draft bill posited that it would resolve the Black Hills claim only, having no effect on subsisting treaties. In other words, with satisfactory settlement of the Hills issue in hand, the Lakotas would remain free to pursue resolution of their claims to the 1,868 unceded Indian territory and the 185 one-treaty territory. 64 Although the Bradley Bill was obviously less than perfect, compensation remained very low, considering that the Hearst Corporation's Homestake mine alone has extracted more than $1.8 billion in gold from the Black Hills since 1877-65, and the United States and its citizens are left with considerable land and rights in the area to which they were never legally entitled. It represented a major potential breakthrough not only with regard to the Black Hills land claim, but to U.S. Indian relations far more generally. Although the FULL Lakota agenda was not met by the bill, it probably came close enough that the bulk of the people would have endorsed it. That, more than anything, was a testament to their own perseverance in struggle in the face of astronomical odds. The bill, however, foundered during the late 80s in the wake of a campaign to improve upon it advanced by a rather mysterious individual named Phil Stevens. Throughout his life, Stevens functioned as a non-Indian, fashioning for himself a highly profitable defense contracting corporation in Los Angeles. Deciding to retire in 1984, he sold his company for an estimated $60 million. 128. Lion. Thereupon, he claimed to have discovered he was a direct descendant of a noted Lakota leader and to be consumed with a belated passion to help his people. In 1986, he began to approach certain disaffected elements on the reservation, arguing that with his federal contacts and negotiating expertise, he could better not only the monetary compensation portions of the Bradley Bill, increasing reparations to $3.1 billion, but improve upon its jurisdictional provisions as WEL 1.66. He punctuated his points by spreading relatively small quantities of cash around destitute Lakota communities 67 and stipulated that all he needed was to be provided proper authority, that is, to be elevated to the non-existent position of G-Reat Chief of all the Sioux to get the job done. Resistance to Stevens' posturing was intense in many quarters, especially among those who had worked most unstintingly to bring Bradley's initiative into being. Nonetheless, interest in Stevens' ideas had reached sufficient proportions by early 1988 that Gerald Clifford, chief negotiator and chair of the steering committee opposing Stevens, was compelled to take him to Washington, D.C. to broach his proposals to various key congresspeople. 68 The timing was most inopportune, given that Bradley had, since introducing his bill for a second time on March 1, 1987, been able to secure support for the legislation even from such notoriously anti-Indian senators as Lloyd Meads. The chairs of both the House and Senate Interior Committees, Representative Morris Udall and Senator D. A. Neil Inouye, had also agreed to serve as co-sponsors. The baleful consequences of Stevens' Washington tour soon became evident. Bradley had no intention of amending his bill to include Stevens' $3.1 billion compensation package or getting caught in the crossfire between competing Sioux factions. With Clifford's reluctant concurrence, Bradley decided to hold his bill in abeyance until the Sioux settled their internal dispute. 69 With the first significant congressional land return initiative in U.S. history thoroughly in tatters, Stevens quickly quit the field, withdrawing his flow off UNDS to the Lakota communities as well. Meanwhile, liberal South Dakota Senator Tom Dashley capitalized on the situation, founding what he called the Open Hills Committee, designed to see counter the long-term campaign. by those who seek to replace the 1980 Supreme Court settlement with a massive land and even more massive money transfer 70. The committee is chaired by D. Achilles Close. 129. Friend David Miller, reactionary revisionist historian at Black Hills State University in Spearfish, South Dakota. The Open Hills Committee riled up what Miller himself described as South Dakota's considerable redneck population, people who would just as soon load up shotguns as return any portion of the hills to the Sioux. In a part of the country where many people thought of Indians either as dirty drunks or crazed militants, the Open Hills Committee had no difficulty recruiting .71. In a context of mounting tension between Indians and whites in South Dakota during 1989, Dashley easily teamed up with his FELO Senator from South Dakota, Larry Pressler, to secure an agreement from NU, by then chair of the Senate Select Committee on Indian Affairs, that there would be no hearings, mark UPS, or other action taken on any Black Hills legislation without the express consent of the South Dakota Senatorial Delegation 72. In 1990, Pressler sought to follow up by introducing a resolution which would have required yet another reserva people of the Southwest as a threat to ranching and mining concerns. The war FEA toured a scorched earth policy directed against such targets as the Dine sheep herds and the peach orchards which had been carefully established over several generations at the bottom of Canondashe, in northeastern Arizona. The plan was to starve the Indians into submission, and it worked very well. The whole ugly business culminated in 1864 with the FORCED march of virtually the entire Dine people to a concentration camp at Bosque Redondo, in eastern New Mexico, a desolate place where about half of them died of disease, exposure and starvation in barely 2 years. 135. Finally in 1868, intent upon avoiding a scandal concerning its own treatment of a vanquished FOE after having executed officers of the Confederate Army FOR engaging in comparable atrocities against U.S. troops at such prison camps as Andersonville, the government relented and entered into a treaty with the Dine. The instrument formally acknowledged, among other things, the Indians are allied to a huge chunk of relatively barren land, mostly in western New Mexico. 2 Over the next decade, however, it was discovered that much of the new reservation was usable for cattle grazing. Consequently, the government continually adjusted the boundaries westward into Arizona until the territory of the INE completely engulfed that of another people, the Hopi. Still, there was no particular problem in many ways. The Dine, whose economy was based on sheep herding, lived dispersed across the land, while the Hopi, agriculturalists, remained clustered in permanent villages. Conflict was minimal, the two peoples coexisted in a sort of natural balance, intermarrying frequently enough to create an inter-ethnic entity known as the Tobacco Clan. 3 This began to change in 1882, when President Chester A. Arthur set out to provide a jurisdictional basis for Indian agent J. H. Fleming to assist Mormon missionaries in kidnapping Hopi children. Quite literally at the stroke of a pen, Arthur carved out a Hopi reservation within the area already reserved for the Dine. Arbitrarily designated as being a rectangle of 1 degree longitude by 1 degree latitude, the new reservation left Moenkopi, a major Hopi village, outside the boundary. Conversely, much Dine pasturage and about 600 Dine were contained within the area, a matter supposedly accommodated high wording that it would henceforth be the territory of the Hopi and such other Indians as the President knew select for. For a generation equilibrium was maintained. Then, in 1919, the Standard Oil Company set out to negotiate mineral leases on Dine land. In 1920, the Dine Council of Elders, a traditional mechanism of governance drawn in equal proportions from each of the clans comprising the nation and holding undisputed power in such matters, unanimously rejected the idea. Standard lobbied, and in 1923 federal authorities unilaterally replaced the existing Dine government with a Grand Council composed of individuals of U.S. rather than Navajo choosing. Being made up of men compulsorily educated off the reservation rather than of traditionals, and 136. Owing their status to the U.S. rather than to the people they ostensibly represented, the new council promptly signed the leasing instruments. Thereafter, it was the only entity recognized by the United States as legitimately representing Dine interests. 5 This experiment was such a success that an idea was shortly hatched to replace all indigenous governing bodies with comparably modern and democratic ones, based for the most part on models of corporate management. In 1934, with passage of the so-called Indian Reorganization Act, this concept became law. Native resistance to the IRA varied from place to place, the rule of thumb being that the more acculturated the people, the greater the ease with which it was accepted. 6 At Hopi, where the traditional Kikmungwe form of government was and is still very much alive, 85% of all people eligible to vote on the question of reorganization simply refused to participate, boycotting entirely a referendum required to stir the illusion that they had accepted reorganization. As Bureau of Indian Affairs employee Oliver Lafarge observed at the time, here were only 13 people in the willing to go to the polls out of a potential voting population of 250, having announced he would have nothing to do with so unhopi a thing as a referendum. Here we also see the Hopi method of opposition. Abstention of almost the whole village should be interpreted as a heavy opposition vote. 7. Although much the same situation prevailed in each of the Hopi villages, Indian Commissioner John Collier, the primary architect of reorganization, overcame this difficulty by quietly ordering that all abstentions be considered yes votes. While such fraud provided an appearance to the press and general public that the Hopis had all but unanimously embraced implementation of the IRA, it did nothing to change the actual results. The fact is that despite their overwhelming rejection of Collier's script, the Hopi were nonetheless hurriedly reorganized, opening a deep schism within their society that has not only never healed, but is in some ways more acute today than it was 50 years ago. As was noted at the time by Lafarge and others, leadership of the 10 to 15% segment of Hopi society that had been assimilated into non-Hopi values via compulsory education and Mormon indoctrination. This group represented the totality of Hopi voter turnout during reorganization and in all subsequent Hopi elections had long been the station of the Sikakwaptwa Family. 9 The men of the Family, the brothers Abbott and Emery, later their sons Emery Jr. and Wan immediately attained political ascendancy within the new Hopi Tribal Council when it was established in 1936. As is usually the case where patently imposed forms of governance are utilized by a colonial power to administer a sub-ject people, the new council shortly learned to translate service to the oppressor into personal profit. Correspondingly, by 1938 the Sikakwaptuas had garnered something of a monopoly on incoming U.S. government contracts and concessions, business. 138. Starts, and the like. Their new wealth was duly invested in a system of patronage among the Mormon Hopis, and this most un-Hopi sector of Hopi society became far and away its richest and most powerful strata. In short order, what had by and large remained a remarkably homogeneous and egalitarian culture was thus saddled with the sorts of ideological polarization, class structure, and elitism marking Euro-American civilization low. Indian Commissioner Collier was meanwhile quite concerned that the concept of reorganization, upon which he had staked his political future and personal credibility, would work in terms of making IRA governments functional, successful reflections of mainstream corporate society. The Mormon Hopis were only too happy to oblige in moving Collier's grand scheme along, serving as something of a showpiece in exchange for a quid pro quo arrangement by which they became the only segment of Hopi society with which the U.S. would deal directly. By 1940, the Sikakwaptuas and their followers had converted their alignment with the federal government into control, not only of all Hopi political offices, appointed positions, and budgets, but of the sole Hopi newspaper, grazing interests, and externally generated cash flow as well. However, they had still bigger plans. These had emerged clearly by 1943, when the Council, in collaboration with the BIA and over strenuous objections from the Kikmungwe, Success FULLY consummated a lobbying effort for the creation of G-Raising District 6, a 650,013-acre area surrounding the main Hopi villages and marked off for exclusive Hopi use and occupancy. Since nothing in traditional Hopi lifeways had changed to cause them to disperse across the land, the only beneficiaries were the Secqueptuaclique, whose grazing revenues were considerably expanded as a result of the establishment of the district. Meanwhile, some 109 families who had lived on newly defined District 6 land for generations were forced to relocate beyond its boundaries into the remainder of the 1882 Executive Order Area Y. Enter John Bo Wyden. By the early 1950s, with their gains of the FORDs consolidated and digested, the Secqueptuas were once again casting about FOR ways to expand their clout and income. Following the consolidation of Grazing District 6, they had allowed their council activities to lapse FOR several years while they 139 pursued personal business enterprises. In 195-1, however, they appear to have decided that reconstitution of the IRA government would be an expedient means through which to advance their interests. Given their religious affiliation, it was perhaps natural that they should retain the services of a well-connected Salt Lake City Mormon lawyer named John Boyden to pursue this end in the name of HOPI Self-Governance 12. Undoubtedly sensing a potential FOR immense profitability both FOR himself and FOR his church in the move, Boyden accepted the position of Hopi tribal attorney. At the top of his list of priorities in doing so, by agreement with the Secqueptuas, was an initiative to claim all of the EOA in the name of the Hopi IRA government. This he pursued through a strategy of first authoring legislation allowing him to do so, and then pursuing lawsuits such as the Healing v. Jones cases, initially before the Indian Claims Commission and then in Federal District Court. 13. What was at issue was no longer merely the land, concomitant grazing rights, and the like. By 1955, the full extent of mineral deposits in the Four Corners region were being realized by the U.S. government and corporations. 1. For Anaconda, Kermagee, and other energy conglomerates were buying leases and opening uranium mining/milling operations, FEAing the guaranteed market established by the ore buying program of the Atomic Energy Commission. Standard, Phillips, Gulf, and Mobil were moving in on oil and natural gas properties. 15. The worthless desert into which the U.S. had shoved the Indians was suddenly emerging as a resource mecca, and it was felt that the EOA might be a particularly rich locale. Indications are that Boyden and the Secqueptuas originally hoped what might be argued in court as constituting Hopi territory would overlay a portion of the grant's uranium belt. This did not pan out, however, and royalties from the uranium boom continued to accrue only to neighboring peoples such as the Navajo and Laguna Pueblo. Still, oil exploration proved a more lucrative proposition, and Boyden opened sealed bidding for leasing rights with District 6 during the fall of 1964. The proceeds came to $2.2 million, of which $1 million in FEES and bonuses was paid to Boyden's Salt Lake City law firm. 16. The next move was rather more intricate. Enlisting the assistance of a pair of regional politicos, Secretary of the Interior Stuart Udall and Colorado Representative Wayne Aspinall, both of whom professed to believe that energy development would be good for the West, Boyden was able to set up a triangular mining arrangement between the Navajo and Hopi councils on the one hand, and the Peabody Coal Company on the other. Not coincidentally, a significant interest in Peabody was held at that time by the Mormon Church, for which he was also serving as legal counsel during the negotiations. Overall, Boyden's PE arsenal take on the deal, in which he represented all parties except the Navajos, is said to have again run into seven figures. Why for him, things were moving right along. The nature of the land dispute. The upshot of the Peabody contract was the company's launching of a massive coal stripping operation on Black Mesa, near the village of Kayenta, along the northern boundary of the EOA. With a long-term money-maker thus secured for himself and his clients, Boyden returned to his real agenda of locking up their undivided rights to both the remaining land and the fossil fuels underlying it. While opening moves in this gambit had been made during the 1950s, the serious campaign really got off the ground during the early 70s. In a major suit, Hamilton v. Nakai, he argued that an earlier judicial determination that both the Hopi and Dine were entitled to equal use and benefit from the EOA outside of grazing District 6 meant the Dine had no right to keep livestock in numbers exceeding their half of the federally established carrying capacity of the land. This held true, he claimed, even if it could be shown that no Hopis were keeping animals in this so-called joint use area OUA. Boyden was thereby able to obtain court orders requiring a 90% reduction in the number of Dine livestock within the JUA.18, any such diminishment being tantamount to starvation for a people like the traditional Dine, dependent for subsistence upon a sheep economy. Boyden and the Sikakwaptuas anticipated this courtroom victory would have the effect of driving them out of the area altogether. Then, with virtually no Dine living on the contested land, arguments concerning the exclusivity of Hopi interests and prerogatives would seem much more reasonable. Here, the Boyden/Sikakwaptwa combination seriously miscalculated the manner in which the Dine would defend themselves. When they simply 141 ignored the court-ordered stock reduction, Boyden was forced into a whole series of related suits, each of them generating additional judicial decrees against the Dine. A freeze was placed upon their right to build new homes, corrals, or other structures within the JUA, for example, but none of this in itself accomplished much in terms of forcing them to move. 19 Even more frustrating for Boyden, federal authorities were less than interested in deploying the level of force necessary to implement their court's various decisions. And then came the energy crisis of the 1970s. Overnight, energy self-sufficiency became a national obsession. Shale oil, coal gasification, and other esoteric terminology became household matters of discussion. Congress sat down to do a quick inventory of its known energy assets, and, suddenly, the Black Mesa coal, which had barely elicited a yawn from legislators AFEW months before, became a focus of attention. ARI7 on LL1 RFRH:R/K LICF SFNLT or R URI Associates. 20 There was only one hitch in the program: it was and is impossible to strip mine land so long as people are living on it. The solution, of course, FOR the federal government as well as FOR the Hopi Council and the Energy COR Port Ions, was to remove the people. Hence, as early as 1971, Boyden was successful in offering his services to draft a bill delineating a formal division of the JUA into halves for introduction in the House of Representatives. The plan called for all Hopis living on the Dine side of a partition line to be relocated into Hopi territory and vice versa. Given that virtually no Hopis actually lived in the JUA, the law would serve the purpose of emptying half of the desired acreage of population and thereby open it up for mining. 21 Several scientific studies already suggested that once strip mining and slurry operations began in a substantial portion of Black Mesa, the adjoining areas would be rendered uninhabitable in short order, forcing the Dine off their remaining portion of the EOA. 22 The Boyden/Steiger scheme was thus clearly to use the appearance of an equitable resolution of a property rights question as a means to totally dispossess the Dine, accomplishing at last what Boyden and his clients had been trying to do all along. Steiger dutifully introduced the bill in 1972, but it met with certain 142 public relations problems. After all, the sort of mass forced relocation of indigenous people proposed hadn't occurred in the U.S. since the 19th century. While it squeaked through the House by a narrow margin, the bill stalled in the Senate. 23 The FEAR seems to have been that, energy crisis notwithstanding, the American public might balk at such a policy, a prospect seeming quite likely in the context of the Black liberation, anti-war, and other dissident movements then in full flower. Democratic Party presidential nominee George McGovern came out publicly against the idea, and even Goldwater, the arch-conservative, expressed doubts about its wisdom under such circumstances. 24 A plausible humanitarian cover was needed under which to effect the desired legislation. Here, Boyden once again proved his mettle. Retaining David Evans and Associates, yet another Mormon-controlled SALT Lake City firm, to handle the public image of the Hopi tribe, he oversaw the creation of what was called the Navajo-Hopi Range dispute. Within this scenario, which the Evans public relations people packaged rather sensationally and then fed to the media in massive doses, the Hopis and Dine occupying the JUA were at irreconcilable odds over ownership of the land. The result was a virtual shooting war fueled not only by the property rights dispute, but by deep historical and intercultural animosities. No mention was made of mineral interests or that Evans was simultaneously representing West Associates, avid as that consortium was to mine and burn JUA coal. As Washin? Ton Post reporter Mark Panich co-unt in 1974. The relationship between the Hopi Council and the power companies became almost symbiotic. On the one hand, Hamilton's speeches written by Evans would be distributed through the public relations machinery of 23 major Eastern utilities. Viewpoint, the Hopi rapidly took on the aura of the underdog who just wanted to help his white brother. Some of the Navajo, on the other hand, were saying threatening things about closing down polluting power plants and requiring expensive reclamation of strip-mined land. 25. The image of range war-type violence was carefully reinforced with photographs of outbuildings and JUNK vehicles abandoned at various locations in the JUA. These were frequently used for target practice by teenaged. 143. Plinkers a common enough practice throughout rural America and therefore often riddled with bullet holes. The Evans spin doctors presented their photos to the media as evidence of periodic firefights between Hopis and Ines. During 1971-72, few newspapers escaped a Sunday feature on the range war about to break out between two hostile tribes. Photos of burned corrals and shot-up stock tanks and wells were printed. By calling Evans and Associates, a TV crew could arrange a roundup of trespassing Navajo stock. Occasionally, when a roundup was ill progress, Southwestern newsmen would be telephoned and notified of the event. 2s. What real violence there was carned mainly FROM thugs, including a non-Indian named Elmer Randolph, put on the payroll and designated as Hopi tribal rangers by the IRA regime. Their specialty was beating to a pulp and arresting for trespass any Dine who came to retrieve sheep that had strayed into grazing District 6.27 when a group of Dine attempted to erect a fence. They first called a television crew to the spot and then personally tore the fence down, demanding before the cameras that the Arizona National Guard be dispatched to restore order within the JUA. This, too, was passed along by straight-faced news commentators as an indication of the level of violence existing among the Indians. 28. The federal government was morally obligated, so the argument went, to physically separate the two warring groups before there were fatalities. Predictably, Representative Steiger gave this theme official voice. There is nothing funny about the violence which has already transpired, he claimed, pointing to livestock mutilations, corral burnings, fence destruction, water tank burnings, and at least one shooting incident. If we permit ourselves to be seduced into some kind of legal procrastination and someone is killed, I am sure we would assume the responsibility that is patently ours. Let us not wait for that kind of catalyst. 29. At this juncture, Goldwater, one of the more powerful political figures in the country, decided the time was ripe to weigh in along the Boydenel-Sequequiptwa/Steiger axis. I have not supported the Steiger approach mostly because it involved money. The senator announced, I do not think we have to pay money to relocate Indians, when in the case of the Navajo they have 16 million acres. He went on to assert with astonishing facility that the Dine had literally tens of thousands of acres that are not being used, and therefore available to absorb those displaced by the partition/relocation proposal, ostensibly without significantly altering their way of life. 30. For his part, Boyden seized the opportunity to draft a new bill, this one to be introduced by Goldwater and Arizona's other senator, Pat Fannin. It called for partition and the rapid, uncompensated, and compulsory relocation of all Dine residing within the Hopi portion of the JUA. By comparison, the Steiger draft bill, which had called for the federal government to underwrite all costs associated with relocation, including the acquisition of additional lands as needed to resettle those affected, seemed benign. 31. Relocation becomes law. Actually, the Goldwater/Fannin initiative was a PR ruse designed to allow liberal Democrats to counter the bill's harsh proposals with a gentler plan of their own. This assumed the form of House Resolution 10337, yet another proposal in which Boyden took a hand, this one introduced by Utah Representative Wayne Owens. It called not only for compensation to the victims of the partition, as the Steiger draft had already done, but a decade-long period during which relocation was to be phased in so that those to be moved would not be overly traumatized. Tellingly, when Owens offered his Propositio N, Steiger promptly abandoned his own and became an endorser of the Owens bill. This newly hatched liberal conservative coalition was destined to finally produce Boyden's intended result. Despite a letter sent by Arizona Representative Manuel Lujan that passage of H.R. 10337 might result in a bloodbath in northern Arizona that would make the My Lai massacre look like a Sunday school picnic, and that it would in any event be the most shameful act this government has perpetrated on its citizens since colonial days, the Owens/Boyden concept was approved by the House Interior Committee by voice vote in February 1, 974.32. It was then forwarded to the FULL House FOR. Passage. This was accomplished on May 29, 1974, by a vote of 290 to 38.33. On the same day, Judge James Walsh issued a contempt of court decree against Chairman Peter McDonald and the Navajo Tribal Council for having failed to comply with his order to reduce Dine livestock in the JUA. 34. The bill was passed by the Senate shortly thereafter by a vote of 72-0 and in a somewhat different form than it had been approved by the House. 145. Although this usually precipitates an ad hoc committee meeting involving representatives of both chambers in order to hammer out a mutually acceptable joint version of the legislation, in this instance the House took the extraordinary step of simply approving the Senate's rendering without further discussion. 35. The statute was then routed on an urgent basis to President Gerald R. Ford, who signed it without reading it while enjoying a ski vacation in Vail, Colorado. 36. Enacted as public Law 93-531, the statute required a 50-50 division of the JUA, with the actual partition boundary to be established by the Federal District Court in Arizona. It also established a 3-member Navajo Hopi Relocation Commission, to be appointed by the Secretary of the Interior. Within 2 years of the date the court's partition line was defined, the commission was charged with submitting a plan to Congress detailing how relocation was to be accomplished. 30 days after Congress LPP roved the Relocildian PHN, L5-LR period Vald begin during which relocation would be carried out. 37. A total of $37 million was initially budgeted, both to underwrite the Relocation Commission's functioning, and to pay incentive bonuses of $5,000 to the head of each Dine family who agreed to relocate voluntarily during the first operational year of the program. Bonuses of $4,000 were slated to be paid to those who agreed to go during the second year, $3,000 during the third, and $2,000 during the FOEarth. In addition, each family of 3 or FEWER individuals was deemed eligible to receive up to $1,700 with which to acquire replacement housing. Families of FOER or more could receive up to $25,000 FOR this purpose. Public Law 93-53-1 also contained several other important provisions. It directed the Secretary of the Interior to implement Judge Walsh's order for Dine livestock reduction by outright impoundment. It authorized the Secretary to sell the Navajo Nation up to 250,000 acres of land under jurisdiction of the Bureau of Land Management at fair market value, and provided the Navajo Tribal Council authority to acquire up to 150,000 additional acres of privately held land. 38 The law also authorized litigation to resolve Hopi claims to land surrounding the village of Moenkopi, left out of the original executive order area. 39. The first grid in poll 95 to 53 skiers appeared almost immediately, when it became apparent that virtually none of the targeted people were likely to relocate on anything resembling a voluntary basis. The second followed shortly thereafter when it was discovered that the number of Dine subject to relocation had been dramatically underestimated. This was due to language in the Act stipulating that the partition would include the higher density population areas of each tribe within the portion of the lands partitioned to each tribe to minimize and avoid undue social, economic, and cultural disruption insofar as possible. Congress had apparently accepted without question an assertion made by Boyden through Evans and Associates that if this principle were adhered to, the number of impacted Dine would be about 3,540. There was no reason to assume this information was accurate. More to the point, when the court's partition line was ultimately finalized on February 1, 1977, this is usually referred to as the Simkin line, after F.E. Darrell mediator William Simkin, who actually drew it conformed much more closely to coal deposits than to demography. 41 Those areas Peabody preferred to mine first, areas of the northern JUA furthest from the Hopi mesas but adjoining the company's Kayenta operation, were included within the Hopi territory. Consequently, estimates of the number of Dine to be relocated were quickly raised to 9,525 high 1980,42 and eventually reached 13,500 people over Ally. Only 109 Hopis were affected, and their relocation was completed in 1976.44. Correspondingly, the costs associated with the relocation program escalated wildly. While in 1974, Congress estimated the entire effort could be underwritten through allocation of $28 million in direct costs and another $9 million in administrative overhead. By 1985 the relocation alone was consuming $4 million per year. With the Dine population vastly larger and more resistant than originally projected, direct costs were by 1985 being projected at a level of at least $500 million. 45. Similarly, the original 1982 timetable for completing removal of all, INE from the HPL quickly proved impractical. Revised several times, as of 1985 the wrap-up date was being projected into 1993.46. As all this was coming out, the true magnitude of Goldwater's Prairie Cation about there being tens of thousands of idle acres in the Navajo Nation where relocates could move and continue their traditional life ways, began to emerge. Leaving aside the spiritual significance of specific JUA geography to its Dine residents, it turned out the government's own data indicated the entirety of the reservation, consisting exclusively of arid and semi-arid terrain, had been saturated with sheep, and thus with people, since at least as early as the mid-1930s. Meanwhile, the 400,000 acres of replacement lands authorized under PL 93-53-1 for acquisition by the Navajo Nation - new lands, as they are now called as a means of absorbing surplus relocates was blocked by a combination of conflicting congressional interests, a requirement in the law that such land be within 18 miles of the reservation's boundaries, non-Indian lobbying, and avarice on the part of the Navajo tribal government itself. 48 The result was that relocates were left with no possible destination other than urban areas representing the very antithesis of their way of life. Additionally, Congress was forced to concede the inaccuracy of both the range war hoax and notions that the Hopis were unified by a desire to see the Dine pushed from any part of the JUA. There was no excuse for its ever having believed otherwise. As early as 1972, Kikmungwimina Lansa had come before the House Interior Committee while the Steiger bill was being considered and made it clear that the traditional Hopi majority wished to see the Dine remain on the land, if for no other reason than because their presence prevented strip mining. She further informed the legislators that the almost 40% of those relocated to off-reservation communities no longer owned their government-provided house. In Flagstaff, Arizona, the community which received the largest number of relocates, nearly half the 120 families who had moved there no longer owned their homes. When county and tribal legal services offices discovered that a disproportionate of the houses had ended up in the hands of AFEW realtors, allegations of fraud began to surface. Lawsuits were filed by local attorneys, investigations were begun by the United States Attorney's Office, the Federal Bureau of Investigation, the Arizona Department of Real Estate, and the Relocation Commission, and the most in-depth review of the relocation program which has ever been undertaken by a body of Congress was prepared. A classic example of what was happening is that of Hostine Nez. In 1978, Nez, an 82-year-old relocatee, moved to Flagstaff from Sand Springs. Within a year, Nez suffered a heart attack, could not pay his property taxes or utility bills, lost his $60,000 ranch-style home, and moved back to the reservation 9. By the mid-80s, relocatee reports of increased physical illness, stress, alcoholism, and family breakup were endemic. At least one member of the Relocation Commission itself had publicly denounced the program as being as bad as the concentration camps in WORLD War II, and then resigned his position. 71 AFEW local editorialists had also begun to denounce the human consequences of PL 93-531 in the sharpest terms imaginable. Will grow 1,000-fold and more. The fact that it is a problem manufactured in Washington does not ease the pain and suffering, nor does it still the anger that fills too many hearts. 72. Use of the term genocide in this connection was by then not uncommon and neither rhetorical nor inaccurate, Scudder and others having already documented the reality of what was being called the deliberate, systematic, willful destruction of a people. 73. At least two careful legal studies had also arrived at the conclusion that U.S. policy vis-a-vis the Genocide violated a broad range of international laws, including the United Nations 1948 Convention on Prevention and Punishment of the Crime of Genocide. 74 But still the government moved forward. Resistance. Resistance to extermination, whether physical or cultural, is a natural and predictable human response. In the case of the Genocide, it was shot out in a 1953 statement to Indian Commissioner Filio Nash Hai Navajo Tribal Council member Carl Todashina, shortly after the Healing v. Jones decision. The only way the Navajo people are going to move, we know, is they have to have another Baton Death March. The United States government will have to do that. We're settled out there, and we're not going to advise our people to move, no matter who says. They probably got to chop off our heads. That's the only way we're going to move out there. 5. More than 2 decades later, on March 3, 1977, when Arizona Senator Dennis DeConcini, who had first taken Sam Steiger's seat in the House and then moved up to replace Wayne Owens, attended a meeting of DINE at White Cone, in the southeastern Navajo Partition area, he heard exactly the same thing. Livestock reduction means starvation to us, DeConcini was told by 84-year-old Emma Nelson. Washington has taken our livestock without replacing it with any other way of making a living. Another area DINE, Chester Morris, was more graphic. The enforcement of PL 93-531 means starvation, homelessness, mentally disturbed, alcoholism, family dislocation, crime, and even death for many. This is very emotional, Miller Nez, a local resident, went on, and at some point I think we're going to resist any further attempt by Washington to take away our only source of support. I think sooner or later there will be killing of individuals. 76. The DINE were, to be sure, already resisting, and had been for a quarter century, simply by their refusal to comply with the terms of Healing v. Jones, Hamilton v. Nakai and various other judicial decrees. Tension escalated on October 2, 1977, when an elder named Pauline Weitzinger faced down a crew hired by the BIA to erect a barbed wire fence. When the crew began to construct a section of FENCE bisecting Weitzinger's sheep graze, she told them to stop. When they didn't, she drove her pickup truck straight at them. 154. They left, but returned the next day and resumed work. This time, she chased them away by throwing handfuls of dirt into their FACES. Weitzinger was shortly arrested for assault charges, but later acquitted. 77 Often during the following year and a half, FENCE crews showed up for work in the morning only to find the wire and posts they'd laboriously installed the day before had been torn down during the night. During the midsummer of 1979 a crew set out to FENCE off the property of Elder Catherine Smith, only to find themselves staring into the muzzle of her .22 caliber rifle. She fired over their heads, and, when they scattered, she began dismantling the FENCE before their eyes. Smith was arrested on serious charges, only to receive a directed verdict of acquittal from a judge responsive to her argument that she had been beside herself with rage in confronting a law she knew to be not only wrong, but immoral. At about the time Smith was firing her rifle, the American Indian Movement was conducting its 5th International Indian Treaty Council at the sacred site of Big Mountain in the northern portion of the HBL. Convened in that location at the request of the Dine elders, the gathering was intended as a means of garnering outside support for what the targeted population expected to be a bitter battle for survival. In the course of the meeting, the elders prepared a statement which read in part, "We do hereby declare total resistance to any effort or influence to be removed from our homes and ancestral lands. We further declare our right to live in peace with our Hopi neighbors." 79. Traditional Hopi leaders David Monongai and Thomas Banyasaya attended the gathering, extending unity and support from the Kikmungwe to the Big Mountain resistance. IITC pledged itself to take the situation before the United Nations. 80 Dine AIM leader Larry Anderson then announced his organization was establishing a permanent survival camp at the council site, located on the property of AIM member Bahikade Nahe. Anderson also promised to establish a legal defense apparatus to support the resistors as rapidly as possible. This was accomplished by securing the services of Boston attorney Lou Gurwitz to head up what became known as the Big Mountain Legal Defense/Offense Committee. By 1982, BMDC, UTI Lising FUNDS provided by the National Lawyers Guild, had opened a headquarters in Flagstaff, the most proximate town of any size to the JUA. 81 Over the next 2 years, Gurwitz entered several suits on behalf of individual Dine people suffering the impact of stock impoundment, and began 155 to assemble a legal staff composed primarily of student interns underwritten by the NLG. 82 He also began to organize an external support network for the Big Mountain Resistance, which at its peak evidenced active chapters in 26 states and several foreign countries. 83 On a related front, BMLDOC put together an independent commission to study the international legal implications of federal relocation policy in the JUA, and collaborated with organizations such as the Washington, NC-based Indian Law Resource Center in making presentations to the UN. Working Group on Indigenous Populations. 84 The level of physical confrontation also mounted steadily. In 1980, Cade Nahe was arrested along with 20 others during a confrontation with L3IA police. Charged with several offenses, he was later acquitted on all counts. At about the same time, Elder Alice B. Nally and 3 of her daughters confronted a FENCE crew, were Macedonia arrested, and each charged with 8 federal crimes. They too were eventually acquitted on all counts. The spring of 1981 saw a large demonstration at the Keams Canyon BIA facility which caused Acting Commissioner of Indian Affairs Kenneth Payton to temporarily suspend livestock impoundment operations. In 1983, after livestock reduction had been resumed, Big Mountain elder Matso was severely beaten while physically resisting impoundment of her horses. Arrested and jailed, she suffered 2 heart attacks while incarcerated. She was ultimately acquitted of having engaged in any criminal offense. 85 Matters reached a peak during June 1, 986 as the resistors prepared for the federally established date July 7 of that year when outright FORCED relocation was supposed to begin. The anticipated process involved large units of heavily armed BLA police and U.S. Marshals moving into the HPL, physically removing all Dine who had failed to respond to less drastic forms of coercion. BMDC managed to bring some 2,000 outside supporters into the contested zone, and AIM made it known that its contribution to defense of the area would likely be other than pacifistic. The government backed away from the specter of what Gurwitz described as 70-year-old Dine grandmothers publicly engaged in armed combat with the forces of the United States of America. 86. Rather than suffering the international public relations debacle which would undoubtedly have accompanied an open resort to FORCE of arms, federal authorities opted to engage in a waiting game, utilizing the relentless 156 pressure of stock impoundment, financing, and the rest to simply wear down the resistors. Their reasoning also seems to have encompassed the likelihood that, absent the sort of head-on government/Indian confrontation implicit to imposition of an absolute deadline, the attention of non-Indian support would be difficult or impossible to hold. The defense coalition BMDC had so carefully nurtured was thus virtually guaranteed to atrophy over a relatively short term of apparent government inactivity, affording authorities a much greater latitude with which to proceed than they possessed in mid-86.87 in 1988. Big Mo Untamed defense attorney Lee Brooke Phillips, in collaboration with attorneys Roger Finzel and Bruce Ellison, filed a lawsuit, L. v. Lanny Beads v. United States government, in an attempt to take the pressure off the Dine by blocking relocation on the basis of the policy's abridgment of First Amendment guarantees of religious freedom. 88 Although it initially seemed promising, the suit was dismissed by Federal District Judge Earl Carroll on October 20. 1989, following the Supreme Court's adverse decision in Ling v. Northwest Cemetery Protective Association. 89 Resistance under these conditions adds up more than anything to a continuing refusal to leave the land. By the summer of 1990, approximately half of the Dine originally targeted FOR relocation under PL 93 to 531 remained where they were at the outset, stubbornly replenishing their flocks despite ongoing impoundments, repairing hogans and corrals in defiance of the building FREs, and conducting periodic FORs to dismantle sections of the hated partition line FENCE.90. Liberal obfuscation. Almost from the moment that it became evident Dine resistance would be a serious reality, the government began a campaign to mask the implications of PL 93 to 531. The first overt attempt along this line occurred in July 1, 978 when Barry Goldwater responded to a challenge publicly presented by Dine elders Roberta Blackgoat and Violet Ashka during the culmination of AIM's longest walk in Washington, D.C. The same month. At their invitation, he traveled to Big Mountain to meet with the resistors, but used the occasion to try and confuse the issue by asserting that the Relo 157 Catian Act entailed no governmental policy that says that LTHE Dine have to move or what have to do. 91. Even the establishment press responded negatively to such clumsy distortion. 92 Finding FOR once that bold-faced lying wouldn't carry him through, Goldwater quietly signaled his colleagues that he would not oppose whatever token gestures might be proposed by congressional liberals to soften the appearance of what was happening. The main weight of this effort fell upon Dennis DeConcini in the Senate and Representative Morris Udall Amorman, who had already openly sided with the Sequequiptuous. In the House. 93 Both lawmakers tendered proposals that would amend PL 93 to 531 to provide life estates allowing limited numbers of Dine elders to remain on 90-acre parcels within the HPL until they died. No provisions were made to allow these selected elders to retain the familial community context which lent meaning to their lives, to have access to sufficient grazing HND to M. RRT. RRTHIRFLORH, or to PLSS leong their holdings to their heirs. In effect, they were simply granted the right to live out their lives in impoverished isolation. Not unreasonably, the Dine began in short order to refer to the idea as an offering of death estates. Nonetheless, a combination of the DeConcini and Udall initiatives were passed as PL 96-305 in 1980.94 touted as having corrected the worst of the problems inherent to PL 93-53-1. The new law immediately became a focus of resistance in its own right. It was generally viewed, as Dine activist Danny Blackgoat put it in 1985, as a way to divide the unity of the people, setting up struggles between relatives and neighbors over who should receive an estate, and causing those who were offered estates to abandon those who weren't. That way, the resistance would fall apart, and the government would be able to do whatever it wanted. But, as Blackgoat went on to observe, it didn't work. The people rejected the whole idea, and our struggle actually increased after the 1980 law was passed 95. As Dine resistance and outside support mounted with the approach of the government's relocation deadline, the Liberals adopted a different strategy. Udall first engineered a February 25, 1986, Memorandum of Understanding whereby the Relocation Commission, which was by that point openly admitting it could not meet its goals, would essentially dissolve itself and hand over responsibility for relocation to the BIA. He next secured an agreement from both Yvonne Sidney and Indian Commissioner Ross Swimmer to Rego Fork. 158. IBL relocation, pending further legislative remedy of the situation. He then teamed up with Arizona Representative John McCain to introduce compromise legislation, House Resolution 4281, which would have allowed an exchange of land between Dine and Hopi within the partitioned areas without disturbing the basic premises of PL 93-531 in any way at all. 96 The Udall-McCain bill was already in the process of being rejected by the resistance on the grounds that it accomplished nothing of substance when Goldwater began entering his own objections to the effect that it was time to stop coddling the resistors. H.R. 4281 thus died without being put to a vote. This provoked New Mexico Representative Bill Richardson to propose a bill requiring a formal moratorium on FORCED relocation until the matter might be sorted out. Udall quickly killed this initiative in his capacity as chair of the House Interior and Insular Affairs Committee. 97 A stalemate of sorts prevailed until 1987 when California Senator Alan Cranston introduced a bill more or less reiterating Richardson's by calling for an 18-month moratorium on relocation, pending further study and the devising of a resolution to which all parties might agree. This effort continued in altered form into the early 1990s, officially designated as S-481, and was co-sponsored by Illinois Senator Paul Simon and Colorado Senator Tim Wirth. A lower chamber version of the bill, H.R. 1235, was co-sponsored by 20 members of the House. 98 Meanwhile, with the help of Udall, McCain was able to push through still another different bill which became PL 100-666 in 1989. The statute contained elements of the earlier Udall/McCain land exchange contrivance while requiring that the Relocation Commission be reactivated and that relocation go forward, to be completed by the end of 1993.99. In the end, however, this measure proved no more effective in accomplishing the latter objective that had its predecessors. Finally, in October 1, 1996, Congress approved a so-called Accommodation Agreement, PL 104-301, which revamped the 1980 statute's provisions so as to reinstitute life estates in the FORM of long-term leases to much smaller parcels of land. 100A March 3, 1997, deadline was also stipulated, by which time all Dine remaining in the HPL were either to have signed FORMs acknowledging Hopi ownership of their property and agreeing to lease it, or indicating their intent to relocate within the near future. 159. The Hopi Trihe and the U.S. Department of Justice gave the Dine families remaining on the HPL until March 31 to sign the accommodation agreement in order to stay on what government entities recognize as Hopi land. By signing the agreement, the Dina families are acknowledging Hopi tribal jurisdiction on the land where they live. They will be sub-ject to provisions of the agreement as well as Hopi tribal ordinances. They may remove their names from the agreement at any point during a 3-year trial period. If they remove their names, they will be told to relocate or face eviction. LOL. On March 26, Farrell Sekakuku, who replaced Yvonne Sidney as Hopi chair, announced that his police, augmented by federal personnel as need be, would begin forcible removal of any holdouts on February 1, 2000.102. They have a choice, he said, to sign a lease to legally stay, or to return to the Navajo reservation or the new lands, through the relocation process, or to be considered a trespasser by not signing the agreement and, in the latter instance, they will be dealt with 103. The present situation. As things stand, it seems unlikely there will be many Dine resistors remaining by the time Sekakuku sends out his troops. The cynical federal straighthead, adopted in 1986, has succeeded all too well, worn down by the stress, both physical and psychological, attending decades of continuous pressure, and still with no positive outcome anywhere in sight. People had begun to lose hope in droves by 1989.104. Consequently, the relocation rate has risen sharply during the 90s. By the time the 1997 deadline rolled around, it was estimated that some 1,2,000 of the original HPL Dine population had already left the area. 105 of the 1,000 or so who remained, a number indicated they planned to leave within the year. 106 among those opting to stay, the heads of family at 82 of 96 homesites, including such long-time resistors as Maitso, signed the agreement, accepting Hopi ownership of NJ jurisdiction over their land. 107 the hardcore of 20 or so announcing their intention to continue to resist, no matter what, include Pauline Weitzinger and Roberta Blackgoat. But, like most of the holdouts, both women have reached an age where their ability to sustain such defiance seems doubtful. Indeed, most of their peers among the traditional resistors are already dead, a matter all but 160, precluding any meaningful resurgence of the resistance movement they once galvanized. LOS. As to the recent relocates, the bulk have ended up in instant communities like Nahtajil, which have been rapidly erected to cluster them on the new lands purchased by the Navajo Tribal Council along the 1-40 corridor in Arizona. There, they have been denied any possibility of reconstructing the way of life they led around Big Mountain. Instead, the old have been systematically marginalized and disemployed, while the younger members of their families have been channeled into low-wage menial occupations. As one area activist put it, the latter group now comprises an indigenous labor force en masse in order to provide cheap labor for industries such as coal, uranium, and coal-fired electricity. L09 by any reasonable estimation, then, those who spoke of genocide during the 1980s have been proven correct. The Big Mountain Dine, who comprised by FAR the largest remaining enclave of traditional native culture in the U.S. a scant quarter century ago, have at this point been systematically extinguished as a distinct society. 110 Theirs may have been a sugar-coated genocide in comparison to that which has been visited upon other peoples of late, the Ake Indians of Paraguay, for example, but it is genocide nonetheless. 111 Pretending otherwise simply ensures more of the same. 112 The principle applies equally to ecocide. In early 1989, Peabody Coal requested that the Federal Office of Surface Mining approve expansion of its mining activities on Black Mesa. Although Peabody had never obtained permits, required by law since 1985, to operate at its already existing mine sites, the OSM raised no objections to this new application. Instead, it referred the matter for review within the framework of an officially commissioned and supposedly objective environmental impact study released on June 2, the same year. LL3 The study is suspect on a number of grounds, not least of which is an assertion that post-extraction reclamation of the area to be strip mined will be 100% effective. Such a claim is contradicted by the available scientific evidence, although it is customarily advanced by representatives of Peabody Coal. 114 Other problems include inadequate assessments of the effects of water drawdown for increased slurry operations, selenium accumulation, atmospheric pollution, and sociocultural effects. Lack of available information is typically cited as a reason for these deficiencies, despite the facts that the missing data are known to exist, and that a number of regional 161 experts were never contacted for their opinions. Although the study allegedly took for years to complete, public response time was restricted by the OSM to 60 days, thus severely limiting the type and quantity of countervailing information submitted. LL5 Hence, while it is true that expanded mining operations in the northern HPL have not yet commenced, all indications are that an official go-ahead for such activity has already been given. This in turn establishes the prospect that the question of residual dine resistance within the area may ultimately be solved by neither the Hopi Rangers nor the resistors' eventual die-out, but by Peabody's simply digging the very ground from beneath their FEET. It follows that the whole of Black Mesa will shortly have been converted into what the National Academy of Science has termed a national sacrifice area in the interests of energy development, an outcome which must reclose the future of the Hopis as surely as it has the Dine RNLLNRLRIOMNLLNT in 116. As Roberta Blackgoat put it years ago, if they come and drag us all away from the land, it will destroy our way of life. That is genocide. If they leave me here, but take away my community, it is still genocide. If they wait until I die and then mine the land will still be destroyed. If there is no land and no community, I have nothing to leave my grandchildren. If I accept this, there can be no Dine, no Hopi, because there will be no land. That is why I will never accept it. I can never accept it. I will die fighting this law. 117. Beyond this, there seems nothing left to say. The struggle for New Sigabia. The Western Shoshone battle for their homeland. Of course our whole national history has been one of expansion. That the barbarians recede or are conquered, with the attendant fact that peace follows their retrogression or conquest, is due solely to the power of the mighty civilized races which have not lost their fighting instinct, and which by their expansion are gradually bringing peace into the red wastes where the barbarian peoples of the world hold sway. Theodore Roosevelt. The Strenuous Life, 1901. In 1863, the United States entered into the Treaty of Ruby Valley with the new nation, agreeing in exchange for Indian commitments of peace and friendship, willingness to provide right-of-way through their lands, and the granting of assorted trade licenses to recognize the boundaries encompassing the approximately 24.5 million acres of the traditional Western Shoshone homeland, known in their language as New Sigabia. The U.S. also agreed to pay the News $1,00,000 in restitution for environmental disruptions anticipated as a result of Euro-American commerce in the area. As concerns the ultimate disposition of territorial rights within the region, researcher Rudolph C. Reiser has observed that, nothing in the Treaty of Ruby Valley ever sold, traded, or gave away any part of the new country to the United States of America. Nothing in this treaty said that the United States could establish counties or smaller states within new country. Nothing in this treaty said the United States could establish settlements of U.S. citizens who would be engaged in any activity other than mining, agriculture, milling and ranching too. From the signing of the treaty until the mid-20th century, no accession was taken by either Congress or federal courts to extinguish native title to New Sigabia. 3 Essentially, the land was an area in which the United States took little interest. Still, relatively small but steadily growing numbers of non-Indians did move into new territory, a situation which was generally accommodated by the Indians so long as the newcomers did not become overly presumptuous. By the late 1920s, however, conflicts over land use had begun to sharpen. Things worsened after 1934, when the federal government installed a tribal council form of government desired by Washington but rejected by traditional news under provision of the Indian Reorganization Act. 4 It was to the IRA Council heading one of the Western Shoshone bands, the Timok, that attorney Ernest Wilkinson went with a proposal in early 1946. Anatomy of a Land Dispute Resolution. Wilkinson was a senior partner in the Washington-based law firm Wilkinson, Cragen, and Barker, commissioned by Congress toward the end of WORLDWAR2 to draft legislation creating the Indian Claims Commission. The idea he presented to the Timok Council was that his firm be retained. 174. To represent their interests before the Commission. Ostensibly, his objective was to secure the band's title to its portion of the 1863 treaty area. Much more likely, given subsequent events, is that his purpose was to secure title for non-Indian interests in Nevada and to collect the 10% attorneys he and his colleagues had written into the Claims Commission Act as pertaining to any compensation awarded to native clients. 6 In any event, the Timoks agreed, and a contract between Wilkinson and the council was approved by the Bureau of Indian Affairs in 1947.7. Wilkinson followed up in 1951 with a petition to the Claims Commission arguing that his representation of the Timoks should be construed as representing the interests of the entire new nation. The commission concurred, despite protests from the bulk of the people involved. 8 While such a ruling may seem contrary to popular notions of American justice, it is in fact entirely consistent with the form and function of the Commission, and of federal Indian law more generally. As Dan B. Omberry, head of the Seventh Generation Fund, has explained, when the U.S. succeeded in forcing the Indian Reorganization Act upon tribes, installing puppet governments, the ultimate U.S. aim was to make Indians a resource colony, like Africa was for Europe. Sometimes the issue is coal or uranium and sometimes it's just open land. The role of the Indian Claims Commission is to get the land of tribes who do not have puppet governments, or where the traditional people are leading a fight to keep land and refuse money. It follows that from the outset, Wilkinson's pleadings, advanced in court by his partner, Robert W. Barker, led directly away from new rights to the Ruby Valley Treaty territory. The Shoshone objectives in agreeing to go to court have been explained by tribal elder Saggy Williams, a resident of Battle Mountain. All we wanted was for the white men to honor the treaty. Believed the lawyers we hired were to work for the Indians and to do what the Indians asked. But they didn't. They did as they pleased and told us we didn't have any land. At the time, we didn't talk about selling our land with the lawyer because we had the treaty, which settled the land question. It protected land's law. As Glenn Hawley, a Timok leader of the contemporary land claims struggle, puts it, most of our people never understood that by filing with the Claims Commission, we'd be agreeing we lost our land. They thought we were just clarifying the title question. L1 However, Barker filed the claim in 1951, asserting that the Eastern Shoshones had lost not only their treaty 175 lands, but also their aboriginal land extending into Death Valley, California. He put the date of loss at 1872, and he included in the 24 million acre claim some 16 million acres that the Shoshones insist were not occupied by anyone but Indian bands, and that were never in question. But the U.S. Justice Department agreed with Barker's contention. Since opposing attorneys agreed, the Claims Commission did not investigate or seek other viewpoints. 12. Clarence Blossom, one of the NU elders who signed the original contract with Wilkinson, and who supported Barker for a time, points out that the land claim was never explained to the people. The old people do not even understand English. It was years later that I read that once you accept money, you lose your land. The government pulled the wool over our eyes. If I had known what was going on, I never would have accepted the attorney contract. 13. As Raymond Yowell, a member of the Timok Band Council and an other original signatory, laid it out in a 1978 issue of the native Nell Adon, a majority of the people present objected to the way Barker was giving up the remaining rights to our lands and walked out. Soon after, at meeting, about 80% of the people showed their opposition by walking out. It is important that at these meetings Barker insisted we had no choice as to whether to keep title to some lands or to give them up for claims money. The only choice was whether to approve or disapprove the, and if we disapproved we would get nothing. 14. Ultimately, the Wilkinson, Cragen, and Barker firm received a $2.5 million federal subsidy for services rendered in its resolution of the matter in a fashion which was plainly detrimental to the express interests of its ostensible clients. 1 Shawnee scholar and activist Glenn T. Morris has summarized the matter in what is probably the best article on the Western Shoshone land struggle to date. In 1962, the Commission conceded that it was unable to discover any formal extinguishment of Western Shoshone to lands in Nevada, and could not establish a date of taking, but nonetheless ruled that the lands were taken at some point in the past. It did rule that approximately 2 million acres of new land in California was taken on March 3, 1853, HUD without documenting what specific act of Congress extinguished the title. Without the consent of the Western Shoshone Nation, on 176. February 1, 1966, Wilkinson and the U.S. lawyers arbitrarily stipulated that the date of valuation for government extinguishment of Western Shoshone title to over 22 million acres of land in Nevada occurred on July 1, 1872. This lawyers' agreement, entered without the knowledge or consent of the Shoshone people, served as the ultimate loophole through which the U.S. would allege that the New had lost their land. By 1872 prices, the award of compensation to the New for the historic loss of their territory was calculated, in 1972, at $21,350,000, an amount revised upwards to $26,154,600 and certified on December 19, 1979. In the interim, by 1976, even the Timokes had joined the other new bands in maintaining that Wilkinson and Barker did not represent their interests. They fired them, but the BIA continued to renew the firm's contract on the Indians' behalf until the claims commission itself was dissolved in 1978.18. Meanwhile, the News retained other counsel and FU'd a motion to suspend commission proceedings with regard to their case. This was denied on August 1, 1977, appealed, but upheld by the U.S. Court of Claims on the basis that if the New desired to avert extinguishment of their land claims, they should go to Congress rather than the court's for redress. The amount of $26,189.89 was then placed in a trust account with the U.S. Treasury Department in order to absolve the U.S. of further responsibility in the matter. 19. One analyst of the case suggests that if the United States were honest in its valuation date of the taking of new land, the date would be December 1, 1979, the date of the ICC award, since the could point to no other extinguishment date. The U.S. should thus compensate the Shoshone in 1979 land values and not those of 1872. Consequently, the value of the land that would be more realistic, assuming the Western Shoshone were prepared to ignore violations of the Ruby-Villi Treaty, would be in the neighborhood of $40 billion. On a per capita basis of distribution, the United States would be paying each Shoshone roughly $20 million. The has already received billions of dollars in resources and use from new territory in the past 1 to 5 years. Despite this obvious benefit, the U.S. government is only prepared to pay the Shoshone less than a penny of actual value for each acre of NU territory. 20. The NUs as a whole have refused to accept payment for their land under the premise articulated by Yowell, now chair of the W. Eastern Shoshone Sacred Lands Association. We entered into the Treaty of Ruby. 177. VA as co-equal sovereign nations. The land to the traditional Shoshone is sacred. It is the basis of our lives. To take away the land is to take away the lives of the people. 21. Glenn Holly, concurs. Nothing happened in 1872, he says. No land was taken by the government. We never lost that land, we never left that land, and we're not selling it. In our religion, it's forbidden to take money for land. What's really happening is that the US government, through this Claims Commission, is stealing the land from us right now. 22. We should have listened to our old people. Yael sums up, He told us Barker was selling out our lands. It took me years to realize it. 23. The Dan case. Giving FORM to the sentiment, were the sisters Mary and Carrie INN, who not only refused eviction from their homes by the U.S. Bureau of Land Management, which claimed at that time to own property that had been 111 their Tour generations, but challenged all U.S. title contentions within the new treaty area when the Bureau attempted to enforce its position in court. In 1974, the Dan sisters were herding cattle near their home when a BLM ranger stopped them and demanded to see their grazing permit. The Dans replied that they did not need a permit since they were not on U.S. land, but the land of the Western Shoshone Nation. They were charged with trespassing. I have grazed my cattle and horses on that land all my life, says Carrie Dan, and my mother did before me and her mother before her. Our people have been on this land for thousands of years. We don't need a permit to graze here. 24. The trespassing case was filed in the U.S. District Court for Reno, where the sisters invoked Aboriginal land rights as a defense. The ensuing litigation has caused federal courts to flounder about in disarray ever since. As John O'Connell, an attorney retained by the News to replace Barker, and who has served as lead counsel in defending the Dans, has put it, we have asked the government over and over again in court to show evidence of how it obtained title to Shoshone land. They start groping around and can't find a damn thing. In FACT, the relevant documents show the United States never wanted the Nevada desert until recently. There's no doubt in my mind that the Eastern Shoshones still hold legal title to most of their aboriginal territory. The great majority of them still live there and they don't. 178. Want money for it? They love that desert. But if the Claims Commission has its way, the United States may succeed in finally stealing the land legally. 25. In 1977, the District Court ruled that the Dans were indeed trespassers, fining them $500 each, an amount they have steadfastly refused to pay because the Claims Commission had allegedly resolved all title cases. This decision was reversed on appeal to the Ninth Circuit Court in 1978 because, in the higher court's view, the question of land title had not been litigated, and has not been decided. 26. On remand, the District Court engaged in a conspicuous pattern of stalling, repeatedly delaying its hearing of the case for frivolous reasons. The judge never wanted trial, O'Connell recalls. At one point I accused the government of deliberately delaying the Dan case long enough to get the Indian claims check written, under the theory that once payment was received Indian title would have been extinguished and the Dans would have been prevented from asserting it. The JUDGE admitted on record that he was sympathetic with the government's strategy in this regard. 27. In the end, this is exactly what was done. In other words, a $26 million payment to Indians who never sought it, tried to stop it, and refused to accept it payment for lands that were alleged by the payer to have been taken in 1872, but which the courts have finally affirmed were never taken at all, is now being used as the instrument to extinguish Indian title. 28. The District Court, however, in attempting to reconcile its mutually contradictory determinations on the topic, observed that Western Shoshone Indians retained unextinguished title to their Aboriginal lands until December of 1979, when the Indian Claims Commission judgment became final. 29. This, of course, demolished the articulated basis that a title transfer had been effected more than a century earlier for the Commission's award amount. It also pointed to the fact that the Commission had comported itself illegally in the Western Shoshone case insofar as the Indian Claims Commission Act explicitly disallowed the Commissioners from extinguishing previously unextinguished land titles. Thus armed, the Dans went back to the Ninth Circuit and obtained another reversal of the lower court's ruling. 30 The government appealed to the Supreme Court and, entering yet another official estimation of when new Title 179 was supposed to have been extinguished, the justices reversed the Circuit Court's reversal of the District Court's last ruling. Having thus served the government's interest on appeal, the High Court declined in 1990 to hear an appeal from the Dans concerning the question of whether they might retain individual Aboriginal property rights based on continuous occupancy even if the collective rights of the new were denied. Ytom Lueben, another of the non-Indian attorneys involved in defending new rights, has assessed the methods of litigation employed by the U.S. It is clear that one of the main strategies the government uses in these cases is simply to wear out the Indians over decades of struggle, he observes. The government has unlimited resources to litigate. If the Indians win one victory in court, the government just loads up its legal guns, adds J. New, bigger crew of FRS lawyers, and comes back harder. It is the legal PAFFORDS them tangible rights to pursue their traditional livelihood. They hope, Mander notes, to carve a hole in the earlier me tell you one goddamn thing. There's no way we're ever letting any of the Indians have title to their lands. If they don't take the money, they'll get nothing. 39. 181. The accuracy of this anonymous assertion of federal policy is amply borne out by the fact that an ohair of compromise extended by a portion of the Shoshone resistance in 1977 that the News would drop their Major land claim in exchange for the establishment of a 3 million acre reservation, guarantee of perpetual access to specified sacred sites outside the reservation, and payment of cash compensation against the remaining 1 million acres was peremptorily rejected by then Secretary of Interior C. Sil Andrus. No explanation of this decision was ever offered by the government other than that the Secretary considered their being relegated to a landless condition to be in their best interests. For a Leo Kurlitz, an assistant to Andrus and the Interior Department's chief attorney at the time the compromise offer was rejected, admits that he didn't give the legal issues much thought. 41. Admitting that he was uncomfortable with the very idea that the Shoshones still seemed to possess title to their land, he acknowledges that under no circumstances was I going to recommend that we create a reservation. I saw my job as assessing the resource needs of the Shoshones, but I couldn't recommend that we establish a reservation. 42. Mander's unnamed source says much the same thing, observing that, these Indian cases make me so damned uncomfortable, I wish I didn't have to work on them at all. 43. He professes a certain bewilderment that at least some indigenous nations refuse to be bought off. I really can't understand what these people want. Their lawyers get them great settlements. The Shoshones were awarded $26 million, and the Sioux may get only the herbs but other medicines like the lizard in the south, which we use to heal the mentally sick and arthritis. There will also be electric fences, nerve gas, and security people all over our lands. It will affect the eagles and the hawks, the rock chuck, ground squirrel, rabbit, deer, sage grouse, and rattlesnake. If this MX goes through, it will mean the total destruction of the Shoshone people, our spiritual beliefs and our ways of life. 60. On this basis, overt new opposition to nuclear militarism became both pronounced and integral to assertion of their land claims. As the matter was framed in a resolution first published by the Sacred Lands Association during the early 1980s, the Western Shoshone Nation is calling upon citizens of the United States, as well as the world community of nations, to demand that the United States terminate its invasion of our lands for the evil purpose of testing nuclear bombs and other weapons of war. 61. 184. This stance, in turn, attracted attention and increasing support from various sectors of the non-Indian environmental, FREs and anti-war movements, all of which are prone to engaging in large-scale demonstrations against U.S. nuclear testing and related activities. Organizations such as SANE, clergy and laity concerned, Earth First, and the Sierra Club were represented at the 1979 mass meeting. Their loose relationship to the Shoshone land claim struggle has been solidified through the work of new activists like the late Joe Sanchez, and reinforced by the participation of groups like Friends of the Earth, the Environmental Defense Fund, the Great Basin Greens Alliance, the American Peace Trust, and the Global Anti-Nuclear Alliance. 6.2 As Mander puts it, there have been some positive developments. Many of the peace groups have belatedly recognized the Indian issue and now request permission from the Western Shoshone Nation to demonstrate on their land. The Indians, in turn, have been issuing the demonstrators safe passage permits and have agreed to speak at rallies. The Western Shoshone National Council has called the nuclear testing facility an absolute violation of the Treaty of Ruby Valley and the laws of the United States. Peace activists are instructed that if they are confronted or arrested by U.S. government officials while on Shoshone land, they should show their Shoshone permits and demand to continue their activities. Furthermore, in case of trial, the defendants should include in their defense that they had legal rights to be on the land, as granted by the landowners. 6.3. Looking forward. It is in this last connection that the greatest current potential may be found. Not only for the news in their struggle to retain their homeland, but for assertion of indigenous land rights more generally, and for the struggles of non-Indians who seek genuinely positive alternatives to the North American status quo. In the combination of forces presently coalescing in the Nevada desert lie the seeds of a new sort of communication, understanding, respect, and the growing promise of mutually beneficial joint action between native and non-native peoples in this hemisphere. For the Shoshones, the attraction of a broad and broadening base of popular support for their rights offers far and away the best possibility of bringing to bear the kind and degree of pressure necessary to compel the 185 federal government to restore all, or at least some sizable portion, of their territory. For the non-Indian individuals and organizations involved, the incipient unity they have achieved with the news represents both a conceptual breakthrough and a seminal practical experience of the fact that active support of native land rights can tangibly further their own interests and agendas. For many American Indians, particularly those of traditionalist persuasion, the emerging collaboration of non-Indian groups in the defense of Eastern Shoshone lands has come to symbolize the possibility that there are elements of the dominant population that have finally arrived at a position in which native rights are not automatically discounted as irrelevancies or presumed to be subordinate to their own. On such basis, bona fide alliances can be built. Herein lies what may be the most important lesson to be learned by those attempting to forge a truly American radical vision, and what may ultimately translate that vision into concrete reality. Native Americans cannot hope to achieve restoration of the lands and liberty which are legitimately theirs without the support and assistance of non-Indians, while non-Indian activists cannot hope to effect any transformation of the existing social order which is not fundamentally imperialistic, and thus doomed to replicate some of the most negative aspects of the present system, unless they accept the necessity of liberating indigenous land and lives as a matter of first priority. Both sides of the equation are at this point bound together in all but symbiotic affiliation by virtue of a shared continental habitat, a common oppressor, and an increasingly interactive history. There is thus no viable option but to go forward together, figuratively joining hands to ensure our collective well-being, and that of our children, and our children's children. It is perhaps ironic, but undoubtedly appropriate, that New Segovia, long thought by the invading culture to have been one of the most useless regions in all of North America, and therefore one of the last areas to be functionally incorporated into its domain, should be the locale in which this lesson is first realized in meaningful terms. Yet, in its way, because it so plainly emblemizes much that has been worst in the historical nature of Indian-white relations, the W. Eastern Shoshone resistance and the outside support it has come to attract offers us a veritable relief map of the road we must all traverse if we are to attain a future which separates itself finally and irrevocably from the colonialism, genocide, and ecocide which have come before. Last stand at Rubicon Lake. Genocide and ecocide in the Canadian North. We've been pushed as far as we can go. This is where we make our stand. Chief Bernard Armagnac, 1989. OFTE and the situation of even the smallest of peoples can provide considerable insight into the likely fate of much broader groups, the outcomes of their seemingly particularized circumstances becoming indicative. 0FFARL1J.org Control PR0BKLLL. Sud. DLDE, IDU. UUGOILG struggle of the Rubicon Lake Band of Cree in northern Alberta to preserve their ancestral land base, their way of life and their very identity as a people. The methods which have been and are being used by a consortium of Canadian governmental and corporate entities to deny such things to the people of Rubicon Lake, and the reasons underpinning this governmental corporate behavior, add up to a prospectus for all the indigenous peoples in the Anglo-dominated portion of this hemisphere. The whole thing began in 1899 when a delegation from the Canadian government travelled through northern Alberta to secure the signatures of representatives from various Aboriginal groups in the area upon an international document titled Treaty 8. The purpose of this instrument, as had been the case of each of the other Canadian Indian treaties, was to gain sealer title to as much native land as possible for the British Crown. In exchange, under provisions of Treaty 8, each Indian band was to retain a formally acknowledged area within its traditional domain for its own exclusive use and occupancy, as well as hunting, fishing, and trapping rights within much larger contiguous territories. Additionally, each band was to receive a small monetary settlement for lands lost, and each individual band member was to receive, in perpetuity, an annual cash stipend. One, it was well understood in Ottawa at the time that the treaty commissioners had failed to contact, or secure agreement to the terms and 190 conditions of Treaty 8, from many of the small bands scattered across the vast area affected by the document. The Canadian government nonetheless chose to view these bands as being equally bound by the treaty and relied upon the Indians' moccasin telegraph to eventually spread the word. An improvised arrangement was established wherein members of previously unnotified bands might simply show up at agencies serving the signatory groups in order to receive annual per capita payments. Little or no thought appears to have been devoted by the government to deciding how to keep such intermingling sorted out for record-keeping purposes, or how Canada might go about meeting its obligation to demarcate acceptable reserved areas for each late notice band as it was identified. Point 2. As it turned out, members of the Rubicon Lake Band did not receive word of Treaty 8 until sometime around 1910. At that point, nothing much changed for them other than that band members gradually began to make an annual trek to Whitefish Lake, the location of the agency serving another Cree group, in order to receive their annuities. The local Indian agent, following government guidelines, simply recorded their names on his pay list and went on about his business. For their part, the Rubicons continued to live where and how they had, very much unconcerned with what went on in Ottawa, or even at Whitefish Lake. The situation remained unchanged for about a quarter of a century. Point 3. At some point in 1935, however, the residents of Rubicon Lake were informed that, given the appearance of their names on the list of Whitefish Lake payees, they were considered by Canada to be part of that more southerly band. It was suggested that they were therefore living in a location well outside their reserved area and should accordingly relocate to a place nearer the Whitefish Lake Agency. Those at Rubicon Lake, of course, protested this misidentification and for the first time requested the establishment of a reserve of their own. Point 4. This led, in 1939, to a visit from C.P. Schmidt, the Alberta Inspector of Indian Agents, for purposes of investigating their claim. This resulted in a report by Schmidt to Ottawa stipulating that he had concluded the people at Rubicon Lake were in fact a band distinct from the people at Whitefish Lake, and that they were thus entitled to a reserve. 5 The government initially accepted Schmidt's recommendation, as well as his census fixing the Lubicon population at 127 persons. This number was multiplied by the 128 acres per person the government felt was a sufficient 191 domain for Indians, and it was thereby decided that the Lubicon Lake Reserve should be composed of some 25 square miles of territory. An aerial survey was conducted, and in 1940 the lines of the new reserve boundaries were tentatively drawn on the map. All seemed to be going quite well, with the only remaining formality being a ground survey by which to set the boundaries definitively. But Canada, enmeshed INWORLDWAR2 at this time and qualified surveyors being correspondingly scarce, decided to delay finalization of the process until hostilities had ceased. 6 Things began to get sticky during the summer of 1942 when a man named Malcolm McCrimmon was sent to Alberta to see that the Province annuity pay lists were in order. McCrimmon stated concern, as part of a broader desire to put all of Canada's resources behind the war effort, was to ensure that these Indians are not getting something for nothing. To this end, he arbitrarily rewrote the rules pertaining to eligibility for per capita P1YNLFNTSOTHLT111WHOH. J.D. been added to the treaty pay lists after 1912 were eliminated out of hand. He then went on to require that an individual must furnish acceptable proof that his male ancestors were of pure Indian blood. Given that only written birth records were posited as constituting such proof, and that Indians traditionally maintained no such records, the latter clause can be viewed as an attempt not only to limit the number of native people recognized as such, but to eliminate them altogether. In any event, McCrimmon quickly removed the names of more than 700 northern Alberta Indians, including 90 of the 154 then belonging to the Lubicon Lake Band, from the pay lists. He also specifically recommended against establishing the Lubicon Lake Reserve because there were no longer enough eligible Indians to warrant such action. Hence, the earlier postponement of the reserve's actualization assumed an aura of permanence. 7. Enter the oil seal pannies. On April 1, 1952, the director of the Technical Division of Provincial Lands and Forests Department wrote to the Federal Department of the Interior in Ottawa that, due to the fact that there are considerable inquiries regarding the minerals in the area, and also the fact that there is a request to establish a mission at this point, we are naturally 192. Anxious to clear our records of this provisional reserve if the land is not required by this band of Indians. Alberta followed up shortly thereafter by informing Ottawa that the Lubicon Lake site seemed too isolated to be effectively administered as a permanent reserve, and that it is recommended that the 24 sections of land set aside for a reserve at Lubicon Lake be exchanged for. No objections to the transfer, though there is no assurance that the mineral rights could be included had FROM time to time asked when our department reserve. There were so many inquirious from oil companies to explore the area that it was becoming embarrassing to state that it could not be entered. That situation existed when our branch was advised that unless the department gave a definite answer before the end of 1953, the provincial authorities were disposed to cancel the reservation and return it to Crown lands, which then could be explored. This was discussed when I was in Ottawa last October. I was of the opinion that our branch had taken no action and that the Block F land at Lubicon Lake would automatically return to Alberta. The supervisor then went on to explain that the federal government was very well aware of the implications of this line of action, instructing his agent to collaborate directly in effecting the expropriation of Lubicon Re. 193. Sources: in approaching the subject with the Indians, I think it would be well to keep in mind that the mineral rights may be very much more valuable than anything else. If this block was given up, then it is very unlikely that mineral rights would be made available with the surface rights QF any other reserve that might be picked up. 10. The minerals with which the government correspondence was primarily concerned at the time mostly consisted of oil and natural gas, rich deposits of which had earlier been determined by Petro-Canada, Ottawa's own energy corporation, to underlie the entire Peace River region. Petro-Canada had already enlisted a consortium of 10 transnational energy giants including Royal Dutch Shell, Shell Canada, Exxon, Gulf, and Standard Oil of California to become involved in exploration and development of the area. Both the federal and provincial governments stood to reap a considerable profit on the bargain, with only the rights of a FEW small ARF, L1M of TNO, MSST Noim in the wave. The obvious solution, under such conditions, was simply to deny native rights within the intended development zone, setting the stage for the removal of all Indians from the area. Even at that, there appears to have been substantial official resistance to the idea of providing any acreage with which to establish substitute or replacement reserves for those Indians targeted for coerced relocation. As concerns the Lubicons in particular, the focus of governmental discourse had shifted to the vernacular of outright liquidation by early 1955, a matter readily evidenced in an instruction issued by the federal superintendent of reserves and trusts to his staff. Consult the appropriate files and advise whether action was taken by the department to officially establish as a band, FOR. At that time any such action appears rather short-sighted, and if this group was not established as an official band, it will serve our purposes very well at the present time. 11. In another memo, the Alberta Regional Supervisor for Indian Affairs clarified the government's intent in denying the Lubicons' existence. He Whitefish Lake Band have no objection to RTHE Lubicon Lake people being transferred to their band, and I am suggesting contact those members who are at present residing at Whitefish Lake and Gruard and ascertain if they wish to file applications for transfer. If they all wish to transfer, it would reduce the Lubicon Lake Band membership to approximately 30-12. Elsewhere, the supervisor served that 194. It is quite possible that the 7 families will make application for enfranchisement in the near future. Should they do so, I would recommend that enfranchisement be granted. The FEW remaining members of the about 10 years ago the provincial government started construction of an all-weather road into our area. The purpose of the road is clearly to facilitate TVIP 1 length of our area. The road was completed about 5 years ago. Faced with the prospect of an influx of outsiders into our traditional area, we tried to file a caveat with the provincial government, the effect of which would have been to formally serve notice on all outsiders of our unextinguished Aboriginal claim to the area. 17. Alberta refused to accept the caveat, and the Lubicons attempted to force the matter in federal court. The provincial government asked the court to postpone hearing the case until another being tried in the Northwest Territories was decided. The case in the Territories went against the Indians. However, the decision read that the court there would have found for the Indians, had the law been written as it was in Alberta and Saskatchewan. The province then went back to court and asked for another postponement, during which they rewrote the relevant provincial legislation, illiking the changes retroactive to before the time we tried to file our caveat. In light of the rewritten, retroactive provincial legislation, the judge dismissed our case as no longer having any basis in law. It is noteworthy that the federal government chose to exercise its trust responsibility to the Indians during the caveat case by filing a brief in behalf of the PROLNCLC over Onliti. The Lubicons then petitioned Ottawa under conventional Canadian trust provisions to allocate them financial support with which to seek injunctive relief through the courts and to appoint a special land claims commissioner to attempt to resolve land title issues in the Peace River region. These ideas were rejected by the government in 1980. Instead, during 196, the summer of 1981, community to be a provincial hamlet, surveyed it, divided it up into little 2-acre plots, and tried to force our people to either lease these plots, or accept them as gifts from the province. People who supported the provincial government's hamlet and land tenure program were promised services and security. People who opposed the program said all kinds of consequences. 19. Fearing that acceptance of the provincial hamlet and land tenure program would jeopardize their land rights, The ban then asked the province to delay implementation of the program until its effect could be determined. They refused, stating that they had checked the legal implications of the program and had been assured that there was no relationship between land claims and land tenure. When we continued to question the effect implementation of their program would have on our land rights, they resorted to a legalistic form of deception. One old woman, who can neither read nor write, signed a program application form after being told that she was signing for free firewood. Another was told that she was signing for an Alberta housing trailer. A third was told she was signing a census form. 20. The real relationship between Alberta's hamlet and land tenure program on the one hand, and the Lubicons' Aboriginal rights on the other, was amply revealed the following year. When it became absolutely and unavoidably clear that we would not get anywhere with the provincial government, the Lubicons recounted in their 1983 presentation, we appealed to the federal minister. He responded by sending the province a telex requesting a 6-month delay in the implementation of the provincial land tenure program, during which time, he said, he hoped to resolve the question of our land rights. The provincial minister of municipal affairs responded to the federal minister's telex with a letter, questioning the very existence of our band, and stating that our community could not be part of a land claim anyway, since it was now a provincial hamlet, and was no longer classed as unoccupied Crown land. 21. Legal stalemate. The federal minister concerned, Davy Jim Fulton, appears to have been something of a maverick in governmental circles and was unconvinced by Alberta's argument. Further, he actually sat down and talked with the 197 Lubicon leadership, reaching the conclusion that the band's position was not unreasonable and could be accommodated in some fashion by both Ottawa and the province. He therefore convened a meeting between representatives of his own federal Indian Ministry and the provincial government of Alberta during January of 1982, intending to negotiate a resolution to the Lubicon land issue agreeable to all parties concerned. To the minister's undoubted astonishment, negotiations broke down almost immediately. During the meeting between federal and provincial officials, the province rejected out of hand most if not all of the points discussed between federal officials and officials of the band. Provincial officials refused to consider the question of land entitlement until they were satisfied as to the merits of that entitlement. They refused to agree to a timetable for determining the merits of that entitlement. They refused to consider the land which had been originally selected or which included our traditional equals C, colon, dot, Y, dot, it dot comma, 8F lit, colon, EU, pound, L, L lake. The T, F, et to include men as contractual agents of the province were sheltered under the same mantle of immunity. To its credit, the court ruled in favor of the Lubicons on this outrageous thesis. But it then closeted itself to consider a range of procedural issues raised by the province and corporations concerning why the injunctive matter should not be heard, even though the Indians were entitled to bring it before the bench. Ultimately, we beat back all of these procedural challenges, but not in time to stop much of the damage that we'd hoped to stop. Concluding arguments on the procedural points were heard on December 2, 1982. In Alberta, such procedural points are usually decided very fast. However, in this case, a decision was not brought down until March 2, 1983, exactly 3 months to the day from the time concluding arguments were heard. These 3 months coincided exactly with the oil company's winter season, which is of course the period of most intense development activity, since the ground at this time of year is frozen, allowing for the relatively easy transport of heavy equipment. 26. 199. Thus, the court was able to arrive at a judicially sound conclusion, avoiding the entry of a disastrously contaminating precedent into Canadian law, or risking being overturned upon review by a higher court, while simultaneously allowing those it was preparing to rule against to complete their objectionable activities prior to entry of its ruling. All the oil companies had to do was accelerate their exploration operations so as to be able to complete them in one winter rather than the 2 or 3 which had been remaining on their various schedules. The Lubicons were then presented with the opportunity to obtain an injunction suspending governmental and corporate operations which had already been completed. This was the limit of the Lubicons' legal success. With the most environmentally damaging aspects of the oil extraction process largely completed, the court was free to rule that pumping operations could proceed insofar as they in themselves presented no real threat to the Cree way of life. No attempt was made to determine whether the sheer infusion of outsiders into the formerly isolated Lubicon territory might not have precisely this effect. As a result of the court's de facto non-intervention in oil exploitation, the value of the petroleum being pumped from the immediate area of the Lubicon claim had exceeded $1 million in US dollars per day by mid-1987 and was rising rapidly. 27 Concerning the broader issues of land rights and jurisdiction, the THIRD held that it could not resolve the issues because, as Bill McKnight, Fulton's replacement as federal Indian minister, would later put it, the band attempted to follow two mutually exclusive processes: a settlement under Treaty 8 and a settlement in Aboriginal title. The court made no lent at all on the fact that it had been the government itself which had barred exercise of Lubicon rights under the treaty while simultaneously holding that they were covered by the document, at least for purposes of extinguishing their Aboriginal title. Further, no hint was offered as to what in the court's view might be a correct course for the band to pursue in effecting a settlement under Crown law. The Lubicons, of course, took the matter to the Alberta Court of Appeal, which upheld the lower, Queen's Court in January 1, 1985. In March, and again in May of the same year, the Supreme Court of Canada refused to hear the case. 28 Although the Lubicons have continued to pursue legal remedies in Canadian courts since then, the weight of their efforts to achieve a real solution has shifted heavily into other areas of endeavour. 200. Assertion of Lubicon sovereignty. In 1982, under the leadership of Chief Bernard Armagnac, the people of Lubicon Lake, defining themselves at this point as being some 250 individuals, began to express ever more strongly their traditional rights as a wholly sovereign people. 29 Following this logic, they increasingly de-emphasized their entitlement, always resisted by the Alberta government, to the 25 4 square mile reserve provisionally demarcated in 1940. Instead, reasoning that since they'd never signed a treaty of cession they'd ceded no land at all, the Lubicons began to articulate their land rights in terms of the territory historically used by their ancestors for purposes of hunting, fishing, trapping, occupancy and trading purposes. In total, this amounts to about 1,000 times the area involved in the reserve Alberta had so resolutely attempted to cheat them of. The 25,000 square mile tract of land claimed by Aboriginal right comprises about a quarter of the entire province of Alberta. In addition, the Lubicons stipulated that they were due some $900 million in US dollars for damages done to their territory during the period of illegal Canadian occupancy. 30 The official response was initially to scoff at such presumptuousness. The Lubicons, meanwhile, rather than continuing to argue their case in the courts, launched a public outreach and education campaign to secure popular support. To the government's surprise and consternation, the response to this effort was so generally favorable that steps were necessary to contain the situation. This assumed the form of an independent investigation undertaken in 1984 by the Reverend Drive Randall Ivani, Ombudsman of Alberta, who dutifully went through the motions of examining the Lubicon claims before releasing a report entitled Complaints if the Lubicon Lake Band if Indians. Predictably, the document concluded that there was no substance to the Lubicons' allegations and no fatal basis to their charge that various layers of Canadian government were engaged in committing cultural genocide against them. 3-1 While Ivani's report was intended to undercut the rising tide of public sentiment favoring the Lubicons, its very transparency generated an altogether opposite dynamic. Capitalizing on this PR windfall, Chief Armagnac and other Lubicon leaders shortly began to issue statements to the effect that 201. They were considering conducting a boycott, large-scale demonstrations, and other disruptions of the 1988 Winter Olympics, scheduled for Calgary, Alberta. In something of a panic, both Alberta and Ottawa quickly resorted to what each must have felt were extraordinary measures in a mutual effort to avert an international embarrassment and scrutiny of what they had been doing to Indigenous peoples under the guise of domestic affairs. Ivani's sham investigation was quickly supplanted by another, this one functioning under auspices of McKnight's Department of Indian and Northern Affairs but chaired by the minister's predecessor, Jim Fulton. 32. The first tangible result of this official change in attitude was an offer, made on December 1, 1985, and recommended by Fulton, of the 1940 Reserve Area, complete with the mineral rights which had appeared so problematic to Canadian policymakers only a year before. This overture was rejected on the same day by the Lubicans, with Chief Armagnac pointing out that it was the government's own greed and deviousness which had blocked establishment of the reserve for nearly half a century, forcing the Indians to pursue the full extent of their aboriginal rights in the first place. The Lubicans, he said, would be prepared to enter into any serious negotiations concerning Canadian recognition of their sovereignty and the real scope of their territory. 34 After a quick huddle, Ottawa officials returned in January 1, 1986 with the offer of an ex gratia award which they'd previously refused to do on two separate occasions of $1.5 million in Canadian dollars to cover the cost of Lubican litigation for reserved land rights. To date, the J.Ubicans accepted the payment and then filed suit in April for that amount pills an additional $750,000 Canadian dollars to cover future costs of litigation. In November of 1986, the suit was amended to encompass $1.4 million in past litigation costs and $2 million in projected legal fees. 35 In the latter month, the Lubicans also stepped up their campaign to organize actions around the Olympics, undertaking their first truly mass mailing on the sub-JECT and sending a delegation to Europe to rally support. 36 Meanwhile, in June, Fulton was replaced again, this time by Roger Tass, a former Minister of Justice, who was charged with pushing through a negotiated settlement in which the band might drop its protest plans and 202. Assertion of broader land rights in exchange for clear title to attract approximately the size of the 1940 reserve. Chief Armagnac agreed to meet with federal officials, but only on condition that the government of Alberta would be completely excluded from the proceedings. In July, after preliminary discussions, the Lubicans broke off negotiations when it became clear that Ottawa was not yet prepared to take up the matter of their Aboriginal land rights in any meaningful way. 37 This was followed in January 1, 1987 by an announcement by the Lubicans that they had determined in council that the band was now comprised of 458 individuals, some 250 of whom did not appear on federal Indian registration lists, and that they were prepared to accept a 90-square-mile reserve centering on the community of Little Buffalo, over which they would exercise full control. Additionally, they asserted undisturbed hunting, fishing, and trapping rights over an area of approximately 4,000 square miles and insisted that, in order for these rights to have meaning, the Lubican band would require a voice equal to those of other governments in determining corporate licensing and the development policy impacting their region. Chief Armagnac also stated that the band would henceforth begin, by force if necessary, to evict corporate work crews within the reserve proper and elsewhere as need be. In March, the size of reserve area was amended to read 92 square miles/236 square kilometers in a motion filed with the Court of Queen's Bench in Alberta. 38 May of 1987 saw delegations of Lubicans in both the United States and Europe explaining the band's position, mustering support for the proposed Olympic boycott, and preparing an intervention on their case. For submission in July to the United Nations WO Working Group on Indigenous Populations. 39 Another item on the delegates' agenda was a partially successful effort to convince various museums not to lend objects to the Spirit Sings, a government-sponsored exhibition of native artifacts scheduled for display in conjunction with the Olympics in Calgary. 40 Such outreach efforts continued to achieve very positive results. 41 In the face of mounting international pressure, both Ottawa and Alberta appointed formal negotiators Brian Malone for the federal government, Jim Horseman for the province in October 1. 987. The federal government simultaneously released the Fulton Report, a plan prepared by 203. The former Indian minister calling for tripartite meetings between Ottawa, Alberta, and the Lubicons to resolve the land rights and sovereignty issues equitably and permanently. 42. The Lubicon leadership rejected the idea, pointing to the outcome of a similar tripartite negotiating arrangement signed on December 23, 1986, between Ottawa, Alberta and the 1,000-member Fort Chipewyan Band of Cree, in which the Indians' traditional territory had been reduced into a mere 20-square-mile reserve divided into 9 separate parcels. Chief Amaniak stated that his people hardly considered this to be the productive result of negotiations touted by Alberta, at least not from the indigenous perspective. He followed up on January 23, 1988, by releasing through the Calgary Herald the information that the Lubicons had entered into a formal alliance with other bands and many whites in the North Country, and that these Indians and non-Indians in Alberta, Saskatchewan, and Quebec have agreed to set up a resident army on Lubicon territory. Provincial fish and wildlife officials would be subject to arrest and trial, he said, in the event they attempted to interfere with the exercise of Lubicon sovereignty anywhere within the unceded area. 43 Such warnings carried a tangible ring of authority. As analyst John Goddard has observed, it is hard to imagine an Indian band better prepared to pursue its national rights than the Lubicon Lake Band of early 1988. By the time the Olympic Games opened in Calgary, the Lubicon people commanded international support and the means to convert that support into political power. They had prevailed in disputes with Union Oil and all the other dozens of other oil companies that had gone from posting no trespassing signs to asking the band's permission to work in Lubicon territory. Band members controlled the 90 square miles they had identified as reserve. Plans for a new community were ready for tender. Essentially, the Lubicon Lake Cree remained a cohesive Indian society led by purposeful elders and a gifted chief. 44. Faced with the prospect of an outright armed confrontation, Alberta Premier Don Getty at last began to give bits of ground, offering in March to immediately place the 1940-acre reserve area claimed by Alberta under Lubicon control, and to align with the Indians in negotiating for additional acreage from Ottawa. Chief Amaniak declined the transfer, but accepted the latter proposal, joining with Getty in calling for establishment of a 3-member tribunal to hear and effect a binding resolution upon the 204 Lubicon claims against both the province and the central government. 45 McKnight, however, stonewalled the idea, countering that if Alberta wishes to be bound by a tribunal in providing Alberta land to the Lubicons, that is Alberta's right, and that he expected the province to provide a 45-square-mile parcel in full satisfaction of all Lubicon claims, thus exempting Ottawa from any responsibility in the situation whatsoever. 46 On May 1, 7, he filed suit to compel Getty to accede to his demands. Confrontation. There followed several months of legal maneuvering in which McKnight thwarted all efforts to achieve a reasonable compromise. Finally, on October 6, 1988, James O'Reilly, the Lubicon's head litigator, appeared before the Alberta Court of Appeal at Calgary to read a statement prepared by his clients suspending their involvement in the Canadian judicial process. His effort has been in vain, it stated. From this day, we will no longer participate in any court proceedings in which the Lubicons are presently a party, whether in this court, the Court of Queen's Bench of Alberta, the Federal Court of Appeal or the Federal Court of Canada. Instead, it continued, by October 1, 5, the Lubicon Nation intends to assert and enforce its aboriginal rights and its sovereign jurisdiction as an independent nation, with its own law enforcement and court systems. 47. The plan was to erect checkpoints on the FO or main roads into Lubicon territory. As of October 1, 1988, band members would stop all vehicles. Anybody wishing to work in the area would have to buy permits from the band office at the same rates as those paid to the Alberta government. All payments would be due in advance. Companies would have to submit copies of existing provincial authorizations to the band and post copies of approved Lubicon permits at all work sites. Oil company employees refusing to acknowledge the band's authority would be turned back at the checkpoints. Officially, band members would be unarmed. But they had prepared spiked boards to throw across the road in an emergency, and some members hinted broadly that guns would also be at hand. 48. "We don't have any choice," Chief Omanayak informed reporters shortly after O'Reilly had read the Lubicon statement. "It's time we protect what is ours." As of 1:00 p.m. on October 1, "Anybody who wants to come on our land will have to deal with us and recognize this land is ours." 49. After 50 years of trying to get their own home recognized as their home, and their own land, an AFAIR deal, O'Reilly observed as the roadblocks went. 205. Up, and being thrown from Fe Darrell broken promise to Fe Darrell broken promise and nothing happening, and nothing on the horizon, and their way of life being destroyed, and the United Nations having reproached Canada to do something about it and Canada saying basically, "We don't care what you say," and flouting international law. Enough is enough. The Lubicons intend to make this literally their last stand. 50. By the afternoon of the 15th, all oil company activity on Lubicon land had ceased, a matter which was variously estimated to cost the corporations from $260,000 to $430,000 per day. 51. By then, Getty had upped the provincial settlement offer from 25.4 to 79 square miles. 52. The Lubicons responded that recent births had expanded their population to a total of 478 people, using the standard multiplier of 1 to 8 acres per Indian which pertained across Canada. They therefore computed their minimum entitlement as being 9.56 square miles. They also asserted a claim to a 10% royalty applicable to all resources illegally extracted from their territory during the previous half-century. 53. On October 2, the Royal Canadian Mounted Police staged a raid to dismantle the Lubicon checkpoints. They were met with 110 resistance, given that Getty was already promising that such law enforcement would be mostly symbolic, that the 27 Lubicons arrested would be immediately released, and that the gesture would inaugurate a new round of negotiations designed to resolve the Alberta/Lubicon conflict once and for all. 54. Chief Omanayak stipulated that, should the province deviate from this script, the roadblocks would be instantly reinstated and maintained indefinitely. In He received pledges of physical support from the Treaty 8 chief who vowed to replace, on a body-for-body basis, anyone hauled away by the RCMP. 55. Eugene Steinhauer of Saddle Lake, a former president of the Indian Association and one of Alberta's best-known Indian leaders, left a hospital bed to be there. Chia-trom other bands around Alberta could be seen, including Lawrence Court O'Reilly, Vice President for Alberta of the Assembly of First Nations, and leaders such as Mohawk Chief Billy T.W. Rivers of Conwake near Montreal. Members of the Comité Against Racism from Calgary held placards saying "Support the Lubicon." News reporters and photographers were out in FORCE, representing the national television networks, the radio networks, the Southam and Canadian Press News Services, an Italian wire service and dozens of Alberta print and broadcast outlets. A group of clergy led by Peter Hamill of the Anglican Church of Canada joined the ranks. 206. Dutch member of the European Parliament, Herman V. Verbeek, arrived separately, telling reporters, "It is important that Canadians be aware that people in Europe and all over the world know what is happening here." Radio talk shows focused on the issue. Do you recognize the Lubicon nation as sovereign? Asked the moderator of CBC Edmonton's phone forum. Responses ran 80% in the band's favor. 5. In terms of more direct actions, the protests spread to other parts of the country. In Montreal, the Mohawks of Conway slowed traffic on the Mercier Bridge to distribute 10000 Lubicon support flyers. In Brantford, Ontario, 15 members of the Six Nations Mohawk Reserve blocked highway traffic briefly in a similar show of solidarity. In Labrador, partly emboldened by the Lubicon move, a community of Innu Indians camped at the end of a military runway at Goose Bay to protest low-level military flights over their caribou lands. More than 150 people were arrested, then released. 57. Under these conditions, Getty flew to the town of Grimshaw, near the Lubicon land, to meet with Chief Armagnac on October 22. By nightfall, an agreement had been hammered out wherein 95 square miles of land would be transferred to the Lubicons. Of this, Alberta committed to providing 79 square miles outright, with FULL subsurface rights. The remaining 16 square miles were to be purchased from the province for the Indians by Otitawa, with Alberta retaining subsurface rights sub-JECT to Lubicon veto power over any provincial development scheme. 58 Both sides agreed to begin negotiations concerning cooperative administration of entities devoted to environmental oversight and wildlife management, and to jointly propose a more complete resolution package, including financial compensation and economic development. Support for the Lubicons, to the central government. 59. What an enormous victory the Grimshaw Agreement was. More had been accomplished in a week of confrontation than in a decade of official meetings and court appearances. Getty had developed an appreciation of how badly the Lubicon people had been treated over the years, telling Armagnac privately that he felt ashamed to have been part of the earlier government. For band members, the agreement vindicated a long-term strategy to build power and use it. The victory seemed to show that even the smallest and most remote of Canadian Native societies, by holding together and working hard, could develop enough muscle to prevail over legal and political inequities. 60. As Chief Armagnac put it the same evening, we've done something today that could have been done years ago in a very short time compared with the 48 years we've been waiting. I hope we have shown. 207. Today that if we put up a united front, there is not too much they can do to stop us. And with that, I thank all the community members, and say, federal government, the Lubicons are coming at you. 61. Federal subversion. For its part, Ottawa reacted to the changed situation with a certain initial confusion when negotiations began on November 29, 1988. The immediate response of McKnight and his aides was to retreat, conceding that the Lubicon band membership should total 506 people, and that the land agreement worked out at Grimshaw was therefore quite reasonable. By the end of the second week of talks, the government had committed itself to providing $34 million to construct housing, roads, sewers, electrification, and public buildings on the reserve. A $5 million trust from which the Lubicons could draw annual interest to use as a lever to engage in economic development was also offered. This left only the issue of compensation for prior resource exploitation hanging when the talks were recessed for the Christmas/New Year holidays. Things appeared to be going very well. 62 When negotiations resumed, however, it seemed the federal team had utilized the break to regroup itself in order to adopt an entirely different posture. The change was capped on January 24, 1989, when Ottawa spokesperson Brian Malone tabled what he called a final, take-it-or-leave-it settlement offer. The terms of the proposal included only $30 million in infrastructural development ending. It accepted the Lubicon membership roles as a working figure only, leaving actual band membership subject to approval of low-level functionaries. This obviously held implications as to the quantity of land which would ultimately end up in Lubicon possession. Finally, it sought to void both the Lubicans' rights to compensation and their international efforts to secure support. Nothing in the written offer suggests that the band free to sue the federal government for compensation. The current wording obliges the band to cede, release and surrender all Aboriginal claims and rights to current and future legal actions related to Aboriginal rights. Under the provisions, the band must also agree to withdraw its complaints from the United Nations Human Rights Committee, to acknowledge settlement of its grievance against Canada, before the compensation issue is settled. Nothing in the offer is binding, unlike the original treaties. 208. Which are guaranteed in the Canadian Constitution. Any agreement arising out of this offer will be subject to parliamentary appropriations during the applicable fiscal year, the text of the Lubican offer states. If Parliament failed for any reason to advance enough money to fulfill the agreement from year to year, implementation would be suspended. 63. The reason for Ottawa's reassertion of a hard line, rejected categorically by the Lubicans the day it was tabled, quickly became apparent. In February 1, 1989, Pierre Cadieux, bearing with him a whole new strategy with which to undermine and destroy the Lubicans, replaced William McKnight as head of Aboriginal Affairs. 64. Cadieux's concept was drawn from the classic vernacular of divide and conquer. First, the federal unit tried to identify a dissident faction within the Lubican ranks that might be used to overthrow Ornanayak. When such a faction proved non-existent, federal players tried to create one, aiming to overthrow Ornanayak or, alternatively, split the band. When that attempt also failed, federal players recruited native people from all over northern Alberta to create a new band designed to lay claim to Lubican territory and accept the federal offer. The idea was cynical and brutal, but it provided the mechanism by which federal authorities could impose a settlement, ward off the United Nations Human Rights Committee, scotch the Grimshaw Agreement, and divide native people in the interior against each other so that the Lubican people could never again mount an effective Aboriginal rights challenge. 65. A part of the maneuver was to convince individual Indians who were not Lubicans, or who had no desire to live in Lubican territory, to enroll in the band and then accept land in Severalteri elsewhere. 66. In this faction, both the sense of unity evidenced by the band, and the basis of its assertion of collectivity in its land claims might be severely undercut. The tactic, of course, placed the government, which had been actively seeking to diminish or eliminate Lubican membership altogether for nearly a century, in the position of suddenly and completely reversing itself, expanding the roles willy-nilly over the protests of the Indians. Within weeks, Cadieux claimed to have received a petition submitted by 182 people who are unhappy with the leadership of B. Renard Amanayak, and who wish to receive their own 160-acre parcels of land in Severalteri. 67. Cadieux's representatives, while adamantly refusing to provide copies of the document, contended that 60 or 70 of the people signing the petition were names familiar to those who are familiar with the band list. 68. Cadieux promptly offered federal resources for the signatories whom he dubbed he disenfranchised Lubicans to retain an attorney. 209. Bob Wyoung, while pursuing registration as status Indians and attending land claims, each award of which was to be deducted from the 95 square mile Lubican settlement offer. 69. In the end, the petition turned out to be forged, and to have contained the names of no enrolled Lubicans at all. By then, however, the effort to depose Amanayak, who had himself called for an election when rumors of factionalism had first surfaced, had failed when he was unanimously continued in office by a band poll conducted in late May. The government, meanwhile, had shifted gears. On August 28, 1989, 8 months after the Ottawa talks, Pierre Cadieux constituted the newly registered Indians as an official band. The Woodland Cree Band, he called it, using a generic term for the Cree of the Northern Woodlands. Not since the early treaty days had a band been formalized so quickly. Within 12 weeks of Wyoung's application, and ahead of about 70 Aboriginal societies across the country who had been waiting up to 50 years for band status. Woodland members Regis, several children had joined. The others had not. 74. Like the Lubicons' legal offensive of the early 1980s, their diplomatic initiatives had clearly undered by 1991. Chief Armagnac and the rest of the Lubicon leadership, badly fried by years of continuous effort, were thus placed in the position of needing to come up with a fresh approach while convincing their equally weary people to pick up and start anew amidst an increasingly confused situation. Nor was this the end of their problems. The day show a connection. On February 8, 1988, Premier Getty and his forestry minister, Leroy F. J. Ordbotton, announced that the government of Alberta had entered into an agreement with the Japanese Forestry Corporation, Daishowa, to construct a pulp mill and launch a timbering operation approximately 65 miles south of Little Buffalo. 75. The new pulp mill will be the largest hardwood pulp mill in Canada. It will employ about 600 people, 300 to take down and transport trees to the new mill, 300 to turn the trees into pulp. It will produce 1,000 metric tons of pulp per day, 340,000 metric tons per year. It will consume trees at the rate of about 4 million per year. The trees will come from a timber lease which covers an area of over 29,000 square kilometers. 211. The Daishowa deal. Herald. More than 11,000 square miles. The timber lease to supply the Lu pulp mill Pletley. 7. The move was astute, insofar as it forced a certain reconciliation of the Ottawa and Alberta positions. The new pulp mill will cost more than $1 million, including $75 million in federal and provincial government grants. $9.5 million of the government subsidy is being provided by Federal Indian Affairs Minister Bill McKnight, in his capacity as minister responsible for the so-called Western Diversification Program. The Western Diversification Program is a political slush fund set up by the federal government to try and prop up its faltering political efforts in Western Canada. In his capacity as Indian Affairs Minister, Mr. McKnight is of course also supposedly responsible for ensuring that the constitutionally recognized rights of Aboriginal people in Canada are respected. 77. In addition, as F. J. Ordbotton put it, the Alberta government will be 212. Building rail and road access and other infrastructure to cost $65. $2 million over the next 5 years, a necessary requirement to proceed in this relatively remote location. Lack of such access has long been an impediment to development of the forest industry in northern Alberta. 78. In other words, the province intended to go for the Lubicon jugular. The announcements led Assembly of First Nations National Chief George Erasmus to demand that Prime Minister Brian Mulroney fire McKnight for conflict of interest. 79. For his part, Chief Armagnac went on the Canadian Broadcasting Corporation radio station in Edmonton on February 9 to warn that we're not going to allow anybody to come in and cut down our trees within our traditional lands. When asked by talk show hostess Ruth Anderson how far he would go to prevent the logging, he replied that it just depends on how hard the other side is going to push. We basically decided that we're going to start asserting our own jurisdiction. Now they announce this pulp mill and also that they're going to be leasing all the timber rights on trees that are going to be needed for the pulp mill that we have on our traditional lands. The exchange continued, with Anderson asking whether the Lubicons would resort to violence to stop this latest assault on what you claim is your land. Chief Armagnac replied that our preference would be to not get into violence. But again, it all depends on how forceful the other side wants to be. But whatever it takes, that's what we're going to do. Elsewhere, the chief observed that the Lubicons are preparing to make a last stand on their land, and on their rights. We're not threatening, we're not bluffing. And we would like to keep it as peaceful as possible. I just don't know how much longer we can go on like this. 80. A breakthrough appeared to be in the offing when, on March 2, 1988, Daishowa's Vice President FOR North American Operations, Koichi Kitagawa, phoned Chief Almanac, stating that the corporation had not fully understood the extent of Lubicon claims when it entered into its arrangement with the Alberta government. Kitagawa asked for a meeting with Almanac in Peace River, Little Buffalo, or any place else. 81. This occurred 5 days later at the corporation's main offices in Vancouver, with the result that senior Daishowa officials including Mr. Kitagawa agreed to stay out of the entire traditional Lubicon territory until there was a settlement of Lubicon land rights and an agreement negotiated with the Lubicon people respecting environmental concerns. 82. Although the Lubicons responded by suspending nationwide protests. 213. Against it, Daishowa officials started dissembling and backtracking on the March 7 agreement almost immediately after the meeting was over. 83. As early as March 2, 5, for example, Kitagawa committed to writing an understanding that environmental safeguards rather than land rights were the crux of the issue and that the logging would commence as soon as a forest management agreement could be hammered out with the provincial government. 84. But a prompt written reply by Chief Almanac correcting Kitagawa's misimpression, the corporation persisted. Starting in the FALL of 1990, Daishowa officials have variously misrepresented March 7 agreement, saying first that it didn't cover Daishowa subcontractors and a wholly owned Daishowa subsidiary named Brewster Construction. Then saying that it covered only a proposed reserve area, then saying that it pertained only to so-called new areas not previously logged, and finally denying that there had ever been any agreement or commitment by Daishowa to stay out of THPNNRPT1.T1TN Huron-T territory. 85. On March 26, 1990, the United Nations Committee on Human Rights wrapped up a 6-year investigation of the situation at Lubicon Lake with a report finding that Canada was violating Lubicon rights under Article 27 of the International Covenant on Civil and Political Rights. Historical and more recent developments threaten the way of life and culture of the Lubicon Lake Band, the committee concluded, and constitute a violation of Article 27 so long as they continue. 86. Nonetheless, on August 3, Daishowa spokesperson Wayne Krause announced that Brewster Construction and 3 subcontractors would be logging in the area that is claimed to be the traditional hunting and trapping areas this winter. During a September 24 meeting requested by the Lubicons to clarify the corporation's intentions, Brewster Construction representative Doug Atikat contended that although his company was owned outright by Daishowa, it constituted a separate body and was therefore not bound by any agreement between its parent and the Lubicons. Daishowa officials Wayne Thorpe and Stu Dornbreer not only concurred but went further, arguing in effect that no entity other than Daishowa itself, / they claimed was respecting the agreement, was bound to comply with it. 87. This was followed, in late October 1990, by the establishment of logging camps in the unceded territory by Brewster and 2 of the 3. 214. Subcontractors. The Lubicons responded on November 8 by issuing a warning that all such facilities would henceforth be subject to immediate removal without notice. 88. When it became clear the admonition would not be heeded, direct action was called FOR, and on November 24 equipment belonging to one of the subcontractors, Buchanan Logging Company, was torched. Although nobody was injured in the incident, 13 Lubicons now face charges which could net them as much as 50 years apiece in Canadian prisons. 89. Despite its potentially high cost to the individuals allegedly involved, and consequently to the band as a whole, the raid accomplished its short-term objective. On December 7, even as other Daishowa representatives were publicly denying the existence of any agreement with the Lubicons, the corporation's Woodlands operations manager Barry Heinen announced that the agreement still stands. We won't log within until the dispute is settled. 90. At about the same time, corporate spokesperson Alan Wallstrom conceded FOR the first time that Daishowa actually did control the operations of Brewster, Buchanan, and its other subordinates. It followed that Heinen's we might be understood as encompassing them as well as the parent corporation. 91. Over the longer haul, however, things looked far less promising. On April 1, 1991, responding to a letter of inquiry concerning Daishowa's ultimate intentions on Lubicon land, corporate official Jim Morrison wrote that Daishowa ca not indefinitely postpone the timber harvest to which it is entitled. After all, Daishowa's $580 million investment in the Peace River pulp mill was premised on having a secure supply, and eventually it will be needed. In the same missive, Morrison also restored the corporation to its posture of denying the terms of the March 7, 1988 agreement. Daishowa at no time made a commitment to the Lubicon Band that involved their traditional territory 92. Friends of the Lubicon. Casting about for a nonviolent alternative with which to counter the threat posed by Daishowa, the Lubicon settled during the summer of 1991 on a strategy of organizing a comprehensive boycott of the corporation's pauper products. Their hope was that lost sales revenues might offset or surpass whatever profits Daishowa anticipated in clear-cutting the unceded land, and 21.5. That this, in turn, might compel the corporation to honor the 1988 agreement. The vehicle selected for accomplishing the task was Friends of the Lubicon, a Toronto-based non-Indian organization nominally headed by Kevin Tholuas, Ed Bianchi, and Stephen Kenda. 93. Meanwhile, Morrison telegraphed Daishowa's next move in an August 27 letter to a Lubicon supporter in Quebec named Vilhelmo Villa N. Lenho. In it, Morrison asserted that Daishowa Canada, Peace River Pulp Division, has purchased and is legally obligated to purchase salvage aspen from independent sawmillers, farmers and loggers. Within would be restarted, further DLEs are no longer possible. In FFECT, Morrison had announced the corporation's intent to engage in full-scale logging operations on Lubicon land over the winter of 1991-92.94. Hence, with a sense of extreme urgency, Friends of the Lubicon launched the boycott on November 6, 1991, sending letters to officials of several major restaurant chains Holy Chow, Cultures, and Pizza Pizza, each of which relied primarily on Daishowa for paper bags, napkins and similar products. A letter was also sent to the Nectals chain of FOOD stores, another major outlet for the corporation. The missives began as FOLOs. As soon as the ground freezes in northern Alberta, Daishowa will begin clear-cutting Lubicon land. This, as well as previous destruction of their land by government-sponsored oil and gas development, will result in the cultural genocide of the Lubicojl people. Each executive was then asked to suspend his/her firm's purchase of Daishowa paper products until the corporation publicly agreed not to acquire pulp taken from Lubicon territory. The request was punctuated by a press release issued on November 1 under the heading Stop the Genocide. It read in part, the Lubicon see the impending destruction of their forest as the final stage of a genocidal process that began with government-backed oil and gas development in the late 70s. 96. 3 days later, a demonstration was conducted outside Daishowa's Bay Street offices in Toronto, during which a leaflet was handed out explaining that the Lubicon see as an act of genocide against their nation. 97. By November 20, having garnered significant press attention, the FOL 216 was prepared to send a second letter to the target companies, this one pointing out that hanging paper suppliers is little to ask when the alternative involves the genocide of an Aboriginal community. 98. This was FOLO'd, on November 26, with another press release, captioned Stop the Genocide, Boycott Daishowa. 99. On November 28, in conjunction with demonstrations outside Daishowa's world headquarters in Tokyo, the FOL began picketing Pizza Pizza restaurants, the only one of the FOR firms originally approached which had not already changed suppliers in Toronto. 100. Their efforts were endorsed by the National Association of Japanese Canadians the same day. This position reflects the grave concern that the NAJC has over the environmental consequences that Daishowa's clear-cutting operations represent. But of even greater importance is the concern of the NAJC about the long-term destructive effects that such action will have on the Lubicons themselves, and their very existence as a people. Todd. Undoubtedly surprised at the degree of success attained so quickly by the boycotters, Daishowa, which appears to have simply ignored a warning letter sent by Kevin Thomas on November 6, shortly began to backpedal. 011 Its plans to begin clear-cutting. 102 These were soon to be postponed indefinitely, as the FOL gained momentum. The results of the Friends campaign against Daishowa from 1991 to 1994 were, in a word, stunning. Approximately 50 companies using paper products from Daishowa were approached by the Friends. The list of these companies reads like a who's who of the retail and fast food industries in Ontario: Pizza, the Liquor Control Board of Ontario, Cultures, Country Style Donuts, Mr. Submarine, 13 Oetlager, A&W, Kentucky Fried Chicken, W.O. Woolworths, Roots, Club Monaco, Movenpick Restaurants, and Holt Renfrew, to name but a few. Every one of the companies approached by the Friends joined the boycott of Daishowa products. All but two did so before their stores were picketed. Pizza was subjected to picketing outside its store on 2 occasions. W.O. Woolworths had a single store picketed on 2 occasions. Both Pizza and W.O. Woolworths joined the boycott. T03. Although the corporation's in-house spin doctors tried their best to offset the FOL information blitz, they were plainly losing ground at a steady rate. 104 Finally, on January 1, 1995, Daishowa filed a SLAPP suit against Thomas, Bianchi, and Kenda, as well as John Doe, Jane Doe, and persons unknown in the Ontario Court of Justice. Citing millions of dollars in lost sales and an increasing erosion of its client base, Daishowa alleged that the 217 FOL leaders and their co-conspirators had engaged in unlawful interference with Daishowa's contractual and economic relationships through the use of unlawful means such as threats, intimidation and coercion, misinformation and defamatory statements, and the threat of secondary picketing and secondary boycott of Daishowa's customers. Before Thomas and his colleagues even had an opportunity to file their joint statement of defense, an interim injunction was issued to restrain them from engaging in boycott activities of any sort for a period of 90 days. 106 On May 1, 9, just as the temporary restraining order expired, Daishowa's attorneys requested an interlocutory injunction which would last for the duration of legal proceedings. The matter was heard by Judge Francis Kitely, who substantially dismissed the motion, restraining the defendants only from referencing the March 7, 1988 agreement until such time as its nature was judicially clarified, and from employing the word genocide in their organizing materials until a judicial determination had been made as to whether such usage was defamatory. 7 Daishowa immediately appealed this ruling to the Ontario Divisional Court, where it was overturned in a split decision. All of the corporation's requests were thereupon granted and eventually expanded to include a prohibition against the defendants, their attorney, and even an expert witness. University of Victoria law professor Chris T. Olefson, a leading authority on SLAPP suits, from publicly discussing the case. 109 Both the Ontario Court of Appeal and Canada Supreme Court subsequently declined without explanation to review the lower court's decision. In the end, after a 28-day trial marked by an extended recess to decide whether Daishowa was bound to disclose relevant financial records to the defendants, the apparency of 28 witnesses and submission of 82 exhibits containing more than 1,000 documents. 111 The court produced a verdict which essentially reinstated Judge Kitely's earlier ruling, purportedly resolving the issues she'd left hanging and thereby rendering its effects permanent. In his opinion, released on April 1, 1998, the presiding judge, C. McPherson, rejected Daishowa's argument that Thomas, Bianchi, and Kenda had organized illegal secondary picketing insofar as the whole concept, nebulous at best, relates to labor disputes rather than consumer boycotts, especially those imbued with a broader educational purpose. LL2 The question which must be considered in this trial, the judge observed, is whether 218 The reasons in favor of the prohibition against secondary picketing in a labor relations context support a prohibition against picketing in a consumer boycott context. In my view, they do not. 113. He then went on to elaborate his reasoning in considerable detail. The fact that freedom of expression is protected in the Charter of Rights and Freedoms, coupled with the absence of any economic rights, except for mobility to pursue the gaining of a livelihood, is a clear indication that free speech is near the top of the values that Canadians hold dear. The plight of the Lubicon is precisely the type of issue that should generate widespread public discussion. Moreover, there is not one penny of economic self-interest in the Friends campaign. Rather, the economic component of the Friends message is anchored in the same foundation as all its activities, namely to focus public attention on a public issue, the plight of the Lubicon. And Daishowa's alleged connection to that issue. An important part of the Friends message, and certainly the most effective part, is the attempt through speech in a picketing context to enlist consumers in a boycott of Daishowa products. Why? Is there anything unlawful about such a consumer boycott? McPherson queried in his finding on the issue. And do those who conceive and organize it violate any law? I think not. 115. On the contrary, he concluded that the manner in which the Friends have performed their picketing and boycott activities is a model of how such activities should be conducted in a democratic society. 116. From there, it was a relatively easy matter for the judge to dispense with Daishowa's various torts. With respect to the corporation's allegation that the FOL had unlawfully interfered with its economic interests, he observed that since he had already decided that none of the means used by the Friends in their campaign, including picketing, was unlawful, it follows that the plaintiff cannot succeed in its claim against the defendants. 117. Much the same language was used in rejecting allegations that Thomas, Bianchi, Kenda, or anyone else associated with the FOL had induced breach of contract, relied upon intimidation or conspired to injure the corporation. 1L8. That little matter of genocide. Having thus replicated Judge Kitely's substantial dismissal of Daishowa's case, McPherson concomitantly entered a glowingly categorical affirmation of the FOL's formal right to utilize the tactics of boycott and picketing in pursuit of its goals. From this noble-sounding position, however, he then proceeded to finalize the temporary restraints she'd imposed upon 219. The defendants in her interlocutory order, thereby gutting their practical ability to exercise that right. The first such maneuver came with McPherson's assessment of the validity of the 1988 no-logging agreement. Completely disregarding the obvious, that is, Chief Ornanayak's testimony that we would never have agreed to call off the growing nationwide protest if Daishowa had not agreed to stay out of our unceded traditional territory until there was a settlement of Lubicon land rights. 119. The judge announced that there was simply no credible evidence suggesting such an agreement had ever been reached. Even the earlier quoted statements of Daishowa's senior management and other relatively low-level employees were summarily discounted as mistaken whenever they conflicted with what the JUDGE described as his own common-sense interpretation of events. 120. Such findings of fact allowed the court to conclude that the statements by the Friends to the effect that Daishowa made, and then broke, an agreement with the Lubicon on March 7, 1988 are false and to permanently njo in not only the defendants but the public at large from asserting that Daishowa and the Lubicon Cree reached an agreement concerning Daishowa's exercise of its logging rights within unceded Lubicon territory. 121. This was because, as McPherson himself noted, without question, the publication of statements in letters and leaflets would tend to lower Daishowa's reputation in the community and therefore comprise one of the FOL's more effective means of organizing its boycott. 122. More egregious still was the court's handling of the FOL's employment of the terms genocide and genocidal in describing the anticipated impact of Daishowa's activities upon the Lubicons. This, McPherson pronounced not only to be defamatory but bordering on the grotesque, before enjoining both the defendants and everyone else from characterizing the corporation's conduct, past, present or projected, in such fashion. 123. In order to arrive at this assessment, however, it was necessary for him to advance what is, for a jurist, a rather interesting definition of the term. In my view, the plain and ordinary meaning of the word genocide is the intentional killing of a group of people. Genocide is defined by serious mental harm, or serious bodily harm for that matter, is left unstated. Equally mysterious is the reasoning he employs in deciding that preventing births or transferring children are somehow the same as mass killing. Conversely, he offers no advice as to how, if we were to accept his supposedly reasonable definition, we might avoid citing all incidents of mass murder, the St. Valentine's Day Massacre, for instance, as genocide. Even when he broadens his horizons a bit to hold that the essence of the meaning of the word genocide is the physical destruction of a group identified on a racial, political, ethnic, or cultural basis, 130 the JUDGE provides no explanation. 136. On same page, another passage, completely unmentioned by Macpherson, reads: Genocide has two phases, one, destruction of the national pattern of the oppressed group, the other, imposition of the national pattern of the oppressor. This imposition, in turn, may be made upon the oppressed population which is allowed to remain, or upon the territory alone, after removal of the population and colonization of the area by the oppressor's own nationals. 137. Killing the members of an oppressed group is certainly one method of removing it from its territory. But it is, as Lemkin observed, an extreme and historically exceptional one. Correspondingly, well over half the proliferation of examples he deployed as illustrations of genocidal policies and processes do not involve killing, either directly or indirectly. 138 The core of Lemkin's idea, as Canadian analysts Robert Davis and Mark Zanis pointed out a quarter-century hence, has to do with the creation of conditions which lead to the dissolution/extinguishment of identifiable human groups as such, even if every individual member were to survive. 139 It follows that when he was retained by the United Nations Secretariat 223 to produce a draft genocide convention in 1947, Lemkin placed the greatest weight upon the article in which he delineated what is referred to as cultural genocide. 40. Even in the article devoted to physical genocide, a greater emphasis was accorded, not to direct killing but to what he called slow death measures. These include deprivation of the means of livelihood by confiscation of property, looting, curtailment of work, and the denial of proper housing, clothing, food, hygiene, and medical care. 4. In substance, Lemkin's conception of genocide encompasses not only the destruction of a group but actions or policies preventing its preservation and development. 142. Moreover, to borrow from the Saudi delegate who helped in preparing the final draft instrument in 1948, it involves not only the planned disintegration of the political, social, or economic structure of a group or nation but the systematic debasement of a group, people, or nation. 43. Such is the definitional background against which the Genocide Convention must be read if it is to be understood. If it does not provide an accurate and appropriate description of the overall pattern of historical relations between Canada and the Lubicons, a context in which Shoah is now very much an integral part, then nothing does. Indeed, Macpherson himself comes very close to saying this at one point. The essential subject matter of everything the Friends say and do is the plight of the Lubicon Cree. There can be little doubt that their plight, especially in recent years, is a tragic, indeed a desperate one. The compelling testimony of Chief Bernard Armagnac painted a vivid picture of the disintegration of a proud people who had lived successfully and prospered, on their own terms, for centuries. The loss of a traditional economy of hunting, trapping and gathering, the negative effect of industrial development on a people spiritually anchored in nature. The disintegration of a social structure grounded in families led by successful hunters and trappers, alcoholism, serious community health problems such as tuberculosis, and poor relations with governments and corporations engaged in oil and gas and forest operations on land. The Lubicon regard as theirs. All of these have contributed to a current state of affairs for the Lubicon Cree, which deserves the adjectives tragic, desperate, and intolerable. J.E.144. It may well be that the judge, in common with most domestic jurists, lacked the competence in international human rights law to appreciate that what he was describing is a process of genocide, both cultural and physical. It is also likely that, his pretensions to having attained a sort of instant expertise notwithstanding, he lacked an inclination to delve very deeply into the 224 relevant body of theory during the trial itself. The fact is, however, that he needed neither the specific competence nor the desire to attain it in order to arrive at something resembling an appropriate conclusion. Connecting the dots in such respects is, after all, the purpose of expert witnesses. Here, an ample base was laid by the FOL, while none was offered by Dei Shoa. Among the authorities cited was the late Dr. James J.E. Smith, curator of North American Ethnography for the Museum of the American Indian/High Foundation, who, after 8 years of studying the situation, concluded in 1990 that the Canadian government, in concert with corporations such as Dei Shoa, was engaged in activities which are leading to the social and cultural genocide of the Lubicon Lake. 145. Another was the McGill University Law Faculty, who, in their publication Quid Novi, described the Lubicon situation as modern genocide, and explained although it is difficult for the average Canadian to believe that genocide still exists in our country, it does and is not done by conventional military methods, but by legislation and corporate power. 146. I myself provided additional testimony at trial, both written and oral, with regard to the legal, sociological, and other definitions of genocide. 147. Both written and oral testimony was also provided by Dr. Joan Ryan, Professor Emeritus in Anthropology at the University of Calgary, who, having studied conditions on the ground since 1980, concluded that if Dei Shoa is permitted to proceed with cutting before settlement of the land claim, the Lubicon people will cease to exist as a viable band. The genocidal destruction of Lubicon Cree society will be completed. 148. Dr. Ryan went on to observe that the term genocide is not used lightly here, and it predictably evokes strong aversive reactions. However, it is important to use the term because it is accurate, and the reactions to it are important to deal with. I use the term genocide as defined by Webster, that is, deliberate and systematic destruction of a racial, political, or cultural group. I have tried to document the nature of the destruction of the Lubicon people, their way of life and their culture over the past 15 years in which, I show it to violate, he ignored altogether every inconvenient submission on the matter of genocide. Not one word of expert witness testimony is so much as mentioned in the verdict. Having thus carefully distorted and trimmed the available evidence into seeming conformity with his own logically, factually untenable viewpoint, Macpherson positioned himself to denounce as an enormous injustice, cavalier and grossly unfair to Dei Shoa the FOL's entirely accurate characterization of the corporation's plans, attitudes, and activities vis-a-vis the Lubicons. 15. Then, not content merely to brand the defendant's word usage as defamatory, he went on to reject on the merits their contention that it was nonetheless fair comment on an important political and social issue. 151. The future. The preceding synopsis begs the question as to why a jurist of J.C. Macpherson's undeniable stature height have opted to comport himself in such an utterly squalid fashion. The answer is as fundamental as it is structural. The JUDGE is part, and an elite part at that, of the very system he was called upon in this case to oppose. His position, its attendant comfort, privileges, and whatever prestige he enjoys all depend upon that system's continuing to function in the smoothest possible manner. At base, then, systemic requirements and Macpherson's or any judge's perceptions of self-interest must inevitably coincide. The result is that the judicial function, irrespective of the judiciary's sanctimony about its role being to administer and dispense justice, amounts to little more than the rationalizing of business as usual. 152 When confronted with the issues and evidence in the FOL case, there were really only three hypothetical options Macpherson might have exercised by way of response. First, he could have concurred that the Lubicons are in fact suffering genocide by any reasonable definition and that the FOL's use of the term was therefore justified. In this instance, he might also have entered an emergency decree and inning Dei Shoa FROM their activities pending judicial review in a more appropriate FORUM. 153. 226. Second, he might have entered an opinion holding that although the FOL's usage of the term genocide conforms to a wide range definitions, including those found in international law, it failed to mesh with the much narrower definition embodied in Canadian law. On that basis he might have enjoined them from employing such characterizations of Deus Haua in the FU2.1s for third. There was the option he selected, to deny that anything remotely approximating genocide was occurring and then to wax indignant that the FOL had been so irresponsible as to suggest otherwise. In actuality, the first two choices were reclosed before the trial began. Leaving aside the fact that his verdict would have been instantly overruled by a higher court, had Macpherson accepted the international legal definition of genocide as binding and responded accordingly, the precedent would have opened the door to a virtually total destabilization and eventual collapse of the Canadian system. Dei Shoa, after all, is not unique. Consider the bevy of oil corporations already operating on and systematically degrading unceded Lubicon land. The reality is that, without exception, every corporation doing developmental business in Canada does so at the direct expense of and often with comparable impacts upon the ability of Indigenous peoples to sustain themselves. 1ss The Canadian state itself exists on the basis of the expropriation of native land and resources, the subordination of native polities. 156 And then there are such nutters as whether the residential school system imposed for so long and with such catastrophic effects didn't constitute a forced transfer of children within the meaning of the Genocide Convention. 1s7 One need not be Einstein to see how the dominoes would fall on this one. Reliance upon the second option would have been in many ways as bad. To openly admit not only that a genocide is occurring but that it is permissible for it to occur under the domestic laws of one's own country is something not even the most unabashed of Nazi officials were prepared to do. Public response to the FOL's rather less than official argument to the same effect being what it was, one can only imagine the popular reaction to an official verdict first pronouncing them correct in their assessment and then ordering them to shut up about it. TOCALL The likely result destabilizing is to wildly understate the possibilities. Again, one need not be Einstein. 227. This leaves denial. And so began Macpherson's contorted semantic odyssey, AJO Ernie leaving him no doubt uncomfortably, a matter accounting perhaps for the peculiar belligerence with which his rhetoric on the topic is laced, sharing intellectual space with the likes of James Keegstra, Ernst Zundel, Stephen Katz, and other such deniers of genocides past. Is as for the government he represents, the JUDGE's performance places it firmly in league with those of Paraguay and Brazil, the judiciaries of which employed similar stratagems when rejoining allegations that native peoples within their borders were being subjected to genocide. IS-9 Genocide denied, however, remains genocide, no matter how out of the sight and mind of polite society it may be rendered in the denial. How is it that the Lubicons are expected to respond now that their best hope of a peaceful resolution, the boycott, has been rendered ineffectual by Macpherson's subtextual pronouncement that the economic interests of the CC ult JDLLYLL 0 lit VV lie there II, LLRVTITVC as a pecpal, 160 Obviously, they cannot be expected to, as they put it, lie down in a ditch and die 161. On the contrary, the Lubicons are obliged to defend themselves by what Malcolm X called any means necessary, and, to paraphrase Dr. Martin Luther King, Jr., those, like J.C. Macpherson, who would make the success full employment of peaceful methods impossible, simply make reliance upon violent methods inevitable. 162. 228. Part 3, Other Fronts. Industrial slave capitalist and communist imperialists smiling with faces beckoning us with their lies about progress, wanting us to enjoy the rape of the earth and our minds. Industrial slave forked tongue legalistic contract chains turning our visions into technological dreams, national security war makers desecrating the natural world, and God still trying to get over what you done to his boy. Industrial slave material bound law and order religious salvation individually alone industrial slave. Jon Trudel from living in reality. Geographies of sacrifice. The radioactive colonization of native North America. Our defeat was always implicit in the history of others, our wealth has always generated our poverty by nourishing the prosperity of others, the empires and their native overseers. In the colonial and neocolonial alchemy, gold changes to scrap metal and food into poison, have become painfully aware of the mortality of wealth which nature bestows and imperialism appropriates. Eduardo Galeano, Op. CII Veins of Latin America. T. He unstated rationales guiding the federal governments of both the United States and Canada in their contemporary handling of native peoples and territories are straightforward. It is not considered geopolitically expedient to allow a scattering of small, mostly landlocked nations to exercise anything resembling real sovereignty within their own borders. Moreover, it has been discovered that, perhaps ironically, the barren, residual land base left to Indians in the 20th century is extremely rich in resources, some 60% of all known U.S. domestic uranium reserves and a quarter of its low-sulfur coal lie under Indian land. In addition, as much as a fifth of the oil and natural gas are in reservation areas. Substantial assets of commercial and strategic minerals such as gold, silver, copper, bauxite, molybdenum, and zeolites are at issue, as are water in the arid West and other renewable resources like timber. 1. The pattern of resource distribution in Canada is comparable. 2. With such holdings, it would seem logical that the several million people indigenous to North America, a population officially acknowledged as consisting of approximately 1.9 million in the United States and perhaps as many more in Canada, should be among the continent's wealthiest residents. 3. As even the government's own figures reveal, however, we receive the 239 lowest per capita income of any population group and evidence every standard indicator of dire poverty, the highest rates of malnutrition, plague disease, death by exposure, infant mortality, teen suicide, and so on. 4. The U.S. government in particular has found that by keeping native assets pooled in reserved areas under its trust authority, it is able to channel them at very low rates to preferred corporations, using a tribal administrative apparatus it established during the late 1930s. As a medium for leasing purposes. 5. Thus, as of 1984, stateside Indians were receiving only an average of 3.4% of the market value for uranium extracted from their land, 1.6% for oil, 1.3% for natural gas, and a little under 2% for coal. These figures run as much as 85% below the royalty rates paid to non-Indians for the same returns. 6. The spoon to the US and Canadian economies has been enhanced by the government's utilization of a self-proclaimed plenary power over Indians and Indian land to relax or dispense with environmental protection standards and job safety regulations, further lowering extraction and production costs while allowing certain of the more odious forms of production and waste disposal associated with advanced industrial technologies to be conveniently located out of sight and mind of the mainstream public in areas occupied primarily by native people. 7. In substance, we have been consigned to a status of expendability by federal, state and corporate economic planners in both Canada and the United States. 8. From the perspective of North America's social, political and economic elites, The advantages of maintaining discrete Indian territories under trust control thus greatly outweigh any potential benefit accruing from final absorption of these residual areas. 9 The history of conquest, militarily or otherwise, which has always marked the U.S./Canadian relationship to native North America, has correspondingly transformed itself into a process of colonization, albeit of an internal variety peculiar to highly evolved settler states. 10 The impacts of this system on American Indian environments and the people who inhabit them are in many ways best demonstrated through examination of the effects engendered by the uranium industry since 1950. Four Corners Area. Energy exploitation. Although only about 2/3 of U.S. uranium deposits lie within reservation boundaries, over 90% of the country's mining and milling have been undertaken on or immediately adjacent to Indian land since the mineral became a profitable commodity during the early 1950s. 11 The bulk of this activity has occurred in the Grants uranium belt of the Colorado Plateau, the so-called Four Corners region, where the boundaries of Utah, Arizona, Colorado, and New Mexico intersect. The Four Corners is home to the greatest concentration of land-based indigenous population remaining in North America, the Dine, Southern Ute, Ute Mountain, Zuni, Laguna, Acoma, and several other Puebloan nations all reside there. Since by far the most extensive activity has occurred on the Navajo and Laguna reservations, it will be useful to consider the situation of each in turn. 241. The Navajo Nation. In 1952, the U.S. Interior Department's Bureau of Indian Affairs awarded the Kerr-McGee Corporation the first contract duly rubber-stamped. Paid by the federally created and supported Navajo Tribal Council to mine uranium on Dine land, employing about 100 Indian miners at 2/3 the off-reservation pay scale. T2 In the same year, a federal inspector at the corporation's mine near the reservation town of Shiprock, New Mexico, found the ventilation fans in the facility's main shaft were not functioning. When the same inspector returned in 1955, the fans ran out of fuel during his visit. By 1959, radiation levels in the Shiprock mine were estimated as being 90 to 100 times the maximum permissible for worker safety. 14 Nothing was done about the situation before the uranium deposit played out and the Shiprock operation was closed in 1970. 15 At that point Kerr-McGee, EESLL and PLY abandoned the site, leaving the local community to contend with 70 acres of uranium tailings containing about 85% of the original radioactivity found in raw uranium ore, much of it continuously emitted in clouds of radon and thoron gas. The huge mounds of waste, which will remain virulently mutagenic and carcinogenic for thousands of years, begin less than 60 feet from the only significant surface water in the Shiprock area, the San Juan River. 16 It was shortly discovered that the BIA had overlooked inclusion of a clause requiring the corporation to engage in any sort of post-operational cleanup. 17 Richard Zero. Clemmer has explained the problem quite succinctly. Radon and thoron gases, while themselves inert, readily combine with the molecular structure of human cells and decay into radioactive thorium and radon and thoron gases, if inhaled, irradiate cells in the lining of the respiratory tract, causing cancer. The millions of gallons of radioactive water claimed that it did not possess information about the health problems of uranium miners. Unions and the Public Health Service physicians disagreed. Dr. Victor Archer at NIOSH claimed that European physicians had noted a high incidence of lung cancer in uranium miners prior to 1940. The National Commission on Radiation Protection and the International Commission on Radiation Protection were aware of the potential hazards from radon gas by the early 1905. Given that it had known that some cancers develop only 10 to 20 years after initial exposure, it is inexcusable that the AEC had not analyzed the literature on radiation-related deaths in the mining industry. As far back as the 1950s, it was widely known that 70% of German and Czech pitchblende and uranium miners who worked in the industries from the 1920s and earlier had died of lung cancer. 23. Dr. Joseph W. A. Goner, Director of Epidemiological Research at NIOSH, stated that both the cancer deaths and apparent mutagenic effects of Kerr-McGee's operations at Shiprock and Red Rock present serious medical and ethical questions about the responsibility of the federal government, which was the sole purchaser of uranium during the early uranium period. 24. In 1979, 11 Red Rock miners suffering FROM lung cancer and or fibrosis of the lungs, their families and the families of 15 miners who had already died of the respiratory maladies filed what was to be an unsuccessful damage suit against the AEC and Kerr-McGee. 25. Several Navajos who worked in the uranium mills in the 1950s and 1960s also affected with lung cancer or pulmonary diseases. Joined the uranium miners in suing the federal government and uranium companies for compensation. Conditions in the mills were deplorable. An abandoned Shiprock mill was found to have $1,00,000 worth of yellow cake between two layers of 243 roofing, while workers tell of stirring yellow cake in open, steam-heated floor pans. 26. The evidence continued to mount. Yet, by 1982 amidst ongoing federal assurances that there was really no particular health hazard, and that resulting revenues would lead eventually to economic self-sufficiency and jobs galore for the impoverished 42 more major mines and 7 NEW mills were operating on Navajo land, while another 15 major uranium projects were on the drawing board. 27 A substantial part of the Dine economy, both existing and projected, was being quite deliberately distorted to conform to the demands of the uranium industry, regardless of the effects on the Indians. The degree of confluence between governmental and corporate interests, as well as the intensity with which uranium development at Navajo was being pursued during this period, is indicated in a 1977 article in Bizzle 1's FIC. Currently, 3.200 miners work underground and 900 more are in open pit operations. By 1990, the industry will need 18,400 underground miners JND 4,0 above ground. Once on the job, Kerr-McGee estimates that it costs $80,000 per miner in training, salary, and benefits, as well as the costs for the trainees who quit. Kerr-McGee is now operating a training program at the Church Rock mine on the Navajo reservation. The $2 million program is financed by the U.S. Labor Department. Labor Department sponsors hope the program will help alleviate the tribe's chronic unemployment. 28. Kerr-McGee remained the major corporate player but had been joined by United Nuclear Corporation and Exxon. The rate of exploitation had grown frenzied. Kerr-McGee's Church Rock No. 1 mine went into production early in 1976, analyst W.D. Armstrong observed the same year, and it is estimated that production of uranium ore will reach nearly 1 million tons per year by 1978. If Church Rock No. 2 and No. 3 mines come on stream in 1980 and 1983 respectively, annual production would approach 3 million tons per year. 29. As the pace of such activities accelerated, so too did the environmental and human costs. On July 16, 1979, the United Nuclear Uranium Mill at Church Rock, New Mexico, was the site of the largest radioactive spill in U.S. history. A mill pond dam broke under pressure and released more than 100 million gallons of highly contaminated water into the Rio Luirco. As has been observed elsewhere, despite the greater publicity surrounding the 3 Mile Island nuclear plant accident in March 1979, Church Rock resulted in the nation's worst release of radioactivity. A decade later, the residents still could not use local water supplies, partly because of the spill and partly because of several mines in the area. 31 About 1,700 Navajo were immediately affected, their single source of water irradiated beyond any conceivable limit. Sheep and other livestock were also found to be heavily contaminated from drinking river water in the aftermath, yet United Nuclear refused to supply adequate emergency water and FOOD supplies. A corporate official was quoted as saying in response to local Dine requests for assistance that this is not a FRE lunch. 32. Rather than trying to offset the damage, the corporation stonewalled FOR nearly 5 years before agreeing to pay a minimal $525,000 out-of-court settlement to its victims. 33 United Nuclear was greatly aided in achieving this, a favorable outcome by an official finding that downstream Dyne had suffered little or no damage as a result of the spill. 34 Government officials at both the federal and state levels were later shown to have actively colluded with the corporation, both before and after the disaster. According to the Southwest Research and Information Center, an Albuquerque-based environmental organization, the whole thing was readily avoidable. United Nuclear, the group demonstrated, had known about cracks in the dam structure at least 2 months before the break. No costly repairs were made, however, because political pressure was brought to bear. 35. Even more striking, given the magnitude of what had so recently occurred, New Mexico Governor Bruce King in 1981 told the New Mexico Environmental Improvement Agency to allow to continue an illegal water discharge, which the staff had been attempting to control for over a year. 36. Similarly, the Kerr-McGee mine at Church Rock was allowed, quite illegally, to continue discharging upwards of 80,000 gallons of contaminated fluid per day, dewatering its primary shaft into the local supply of surface water. 37 In 245. Actuality, this steady emission of effluents by the United Nuclear and Kerr-McGee mines has caused far more serious contamination of the Church Rock area than the 1979 spill. P.S. Such circumstances are hardly unique. When the Navajo Ranchers Association around Crown Point, seeking to prevent what had occurred at Church Rock from happening to them, filed suit in federal court in 1978 to block Mobil Oil from launching a pilot uranium project in the Dalton Pass area, the judge ruled that the corporation's activities would have insufficient impact to necessitate so much as an environmental impact study. 39 In 1979, he refused to allow the plaintiffs to cancel Mobil's leases to their land, which the BIA had approved over their objections. 40 When the Dyne plaintiffs argued in 1980 that their pastoral way of life would be destroyed by the plans of Mobil, Gulf, Kerr-McGee, Exxon, and a dozen other energy corporations that had by then queued up to mine uranium near Dalton Pass, the judge responded that he could not understand why they would want to continue it anyway, given the opportunity for them to become miners and millers. 41 Such thinking was upheld by the 9th U.S. Circuit Court, and this matter, too, was eventually settled on terms entirely acceptable to the corporations. 42 Things are no better with regard to cleanup. Despite passage of the much-touted Uranium Mine Links Radiation Control Act in 1978, 43 the first attempt to address the question of radioactive wastes on Navajo land tailings abandoned around the Foot Mineral Company mill near Shiprock in 1968 was not completed until 1986. This project was finished in such timely fashion only because Harold Tso, head of the Navajo Environmental Protection Administration, had himself convinced the tribal government to begin expending royalty monies on the effort as early as 1973. 44 The next 3 such operations affecting the Navajo clearing tailings piles at long-abandoned mill sites in Monument Valley and Tuba City, Arizona, and Mexican Hat, Utah are all under exclusive federal control. Scheduled for completion in late 199, none were finished by mid-decade. 45 Virtually nothing has been done with mill tailings around Church Rock or at several other comparable locations on the reservation. 46 Or is this the end of it? A 1983 study by the Federal Environmental Protection Agency concluded there were nearly 1,000 additional significant nuclear waste sites surrounding the proliferation of abandoned 246 mines, large and small, scattered about Dyne territory. Cleanup of these locations was and is not required by any law, and they were designated by the EPA as too remote to be of sufficient national concern to warrant the expense of attempting their rehabilitation. 47 And so there remain, from White Mesa in the east to Tuba City in the west, hundreds upon hundreds of radioactive sand piles still played upon by Dyne youngsters and swept by the wind across the land. 48 Such is the fate of the largest indigenous nation in terms of both land base and population in the United States. Laguna Pueblo. At the neighboring Laguna Pueblo in New Mexico, the situation is perhaps worse. In 1952, the Anaconda Copper Company, a subsidiary of the Atlantic Richfield Corporation, was issued a lease by the BIA to 7,500 acres of Laguna land on which to undertake open-pit uranium mining and an adjoining milling operation. By 1980, the resulting Jackpile Pagwit mine was the largest in the world, encompassing some 2,800 acres. It has been estimated that it would take 400 million tons of earth, enough to cover the entire District of Columbia 45 feet deep, to fill it in. 0.49 of the earth removed, approximately 80 million tons, were good-grade uranium ore. 50 by the time the facility closed in 1982, Anaconda had realized about $600 million in profits from its operation at Laguna. 51 in the process, the corporation, in collaboration with federal development officers, virtually wrecked the traditional Laguna economy, recruiting hundreds of the small community's young people into wage jobs even as their environment was being gobbled up and contaminated. 52. El Anaconda SJ mining techniques require dewatering, i.e., the pumping of water contaminated by radioactive materials to facilitate ore extraction. Since 1972, the Jackpile mine has wasted more than 119 gallons per minute through this dewatering procedure. Altogether, more than 500 million gallons of radioactive water have been discharged. This water, already radioactive from contact with uranium ore underground, is pumped over the 260-acre tailings pile comprised of overburden and processed ore sitting on soft, porous rock. From the tailings pond, this radioactive water either sinks back into the aquifer, evaporates, or seeps out of the tailings pond into the arroyos and drainage channels of the tiny Rio Micano stream that is fed by a natural spring near the tailings dam. 53. Concerning milling. At the Blue Water Mill, 18 miles west of the Laguna Reservation, suggested that small doses of radiation exposure may actually promote more disease than larger doses because cells are damaged, rather than destroyed outright. Irradiated sex cells in parents can result in birth defects. 62. Negotiations continued, nonetheless. From the Laguna side, this was obviously because of the environmental devastation with which they had been left. After 1983, the federal government began to actually encourage this, as the extent of the damage began to attract public attention and generate pressure in nearby Albuquerque and among non-Indian environmental organizations. Meanwhile, the Indian position was simple enough. The Lagunas did not consider it an Indian site and therefore ranked it as a high priority for cleanup. 91 The government's idea, vociferously rejected by Wind River's Arapahoes and Shoshones, was to move the waste few miles, onto reservation land proper. Only when the state of Wyoming sided with the Indians in 1986, insisting that it wanted the material dumped nowhere within its borders, did the DOE alter its position. 92 As in the Edgemont example, however, most of the tailings remain on or near their original location at present. 93 In the end, all that appears to have so far averted uranium development in and around the Black Hills of the scope evident along the Grants Belt was the same set of factors which interrupted its continuation in the 4 Corners. Reaction to the 3 Mile Island nuclear accident of March 1, 1979, in combination with the ABCs having met by 1981 the ore buying quotas established for it in the 1950s, brought about a precipitous decline in uranium prices. 9 for a pound of yellow cake, which had brought $43 in the former year, garnered only $1.05 by 255. The latter. 95 by 1982, virtually all U.S. uranium production had been suspended in favor of importing cheaper material from abroad. The spectacular boom cycle in the U.S. domestic uranium market therefore entered a continuing bust phase. Other U.S. locations. Although the Four Corners and Black Hills regions were the scenes of by far the most intensive uranium development during the boom period, they were not alone. In 1964, on the Spokane Reservation in Washington State, the BIA arranged a mining/milling lease on behalf of the Don Mining Company, partly owned by the much larger NUL 110 NT Mining Corporation. The Bureau's post-operational land reclamation clause to the contract specifically exempted the company from responsibility for any environmental damage resulting from ordinary wear and tear and unavoidable accidents in their normal use. DON was required to post only a $1.5000 bond to ensure cleanup whenever it completed its business on Spokane land. This occurred in 1981 and 1982 for the mining and milling operations respectively. 96 By then, the contours of disaster were emerging. In 1977 BIA geologist Jim L. E. Brett, a Spokane tribal member, discovered dangerous toxic wastes trickling from the mine at Blue Creek, a favorite camping and picnic spot for tribal members before uranium mining had begun. He was accompanied by his father and uncle, who had discovered uranium on the reservation and previously owned interests in DON mining. They left in tears after seeing the canary yellow trickle of wastewater and the destruction it had caused. 97. The BIA's only response was to order on to build a dam, which contained the toxic wastes for several years. 98 The stopgap was obviously inadequate to address the problem. Even more serious contamination occurred after mining had stopped and the trickle had grown to a 75 to 400 gallons per minute stream of wastes. The Indian Health Service said in 1983 that the heavy metal and acid contamination was appalling and recommended the BIA prevent livestock and humans from consuming the water in question by whatever means necessary. When the EPA tested the seepage, the radiological chemist in Las Vegas said he had never seen such radioactive line wastewater before. 256. What Anaconda had threatened to do with regard to the Jackpile-Pagwit mine DON actually did at Spokane, filing suit against the Department of the Interior in 1982 as a defense against being compelled to underwrite any part of restoring the Blue Creek environment, an effort estimated to require a minimum of $1.0 million. Despite DAWNs having gleaned about $45 million in profits from the Spokane operation over the years, the company's president, Marcel Deguire, pled poverty, claiming his firm's only assets were the abandoned mill and mine. He also asserted, but could not substantiate, that DON had already spent $4 million restoring the environment. 100 It was not until 1987 that the EPA forced the company to stop the discharge, one analyst noted. This was 6 years after the mining stopped and 10 years after the Le Bretts noticed the discharge. By then it was too late. The reservation stream, Blue Creek, which previously had provided habitat for about 13,000 rainbow trout. In the spring of 1988 only 5 or 6 adults returned to spawn. EPA admitted that if the mine had not been on Indian land, it would probably have come to someone's attention sooner. LOL. As of mid-1998, virtually nothing has been done to repair the damage to Blue Creek, and cleanup of the tailings piles surrounding DON's mill site have not even been scheduled. Federal action. L02 A somewhat better result has been obtained with regard to the Western Nuclear Corporation's Sherwood Mine and Mill, also on the Spokane Reservation. Not built until 1978, neither facility had time to cause great environmental impact before being closed in 1982. In 1989, largely for public relations and tax reasons, the corporation transferred ownership of both facilities to the Spokane people and provided $4 million in reclamation funds. L03 cleanup at these sites is nearly complete. L04 Nor are mining and milling the only activities involved in the radioactive colonization of native North America. Just east of the Four Corners area, near Santa Fe, New Mexico, is the Los Alamos Scientific Laboratory, author of a portion of the National Sacrifice Thesis and birthplace of the atomic bomb. Between 1944 and 1952, the University of California's Los Alamos Scientific Laboratory, now operated on contract by the dumped liquid and solid wastes from its bomb manufacturing projects into 3 nearby canyons. Since 1952, solid and liquid radioactive wastes have been treated at 257. One of two ion exchange plants. Solid, radioactive waste is buried in 0-foot DCCP, asphalt-lined shafts, or in 5-5-gallon drums at several sites. Within the 56 acres encompassed by LASL's boundaries, there are about 300,000 tons of solid wastes, including 20 pounds of plutonium. About 25,000 gallons of liquid radioactive wastes are pumped daily into nearby canyons. The canyon streams feed into the Rio Grande 6 miles southeast at Otoe Bridge. A 1978 report assured the public that no migration of radioactive contaminants away from disposal sites has been observed by the continuing monitoring program. But officials now admit the inaccuracy of the report. Sediments on San Ildefonso sacred lands have revealed plutonium levels 10 times higher than concentration attributed to fallout, although LASL maintains that these concentrations are well below guides established to protect human health. Low 5. In addition to plutonium, tritium, a radioactive gas or water vapor that is virtually impossible to control because it combines readily with oxygen and can be incorporated into the organic molecules in the human body and in nature, has been found in concentrations 2 to 5 times normal levels in area mule deer, ravens, and other birds in the area. Cesium-137 has been found in mule deer at levels up to 35 times the norm. 106 Public opposition to such contamination has been constrained by the fact that north-central New Mexico is part of one of the country's more chronically depressed areas, and LASL provides some 8,650 jobs, more than $1.50 million in income to area residents. L07 Although the San Ildefonso Governing Council has passed several resolutions of concern about pollution from LASL, it has, under the circumstances, often professed an abiding sense of helplessness to attempt anything more. What can we do? One council member has been quoted as asking. We have no say up there. Low 8. A similar, though more extravagant, example is that of the Hanford Nuclear Weapons Manufacturing facility, located in Washington State, about 30 miles upstream from the Yakima Reservation and operated by the ABC on behalf of the military from 1944 until its closure in 1989. Officials at the plant consistently utilized a top-secret classification covering their procedures. Much of what was really done at Hanford is still classified and may remain so. Plus or minus, about 7,800 curies of radioactive iodine-131 were deliberately released in an experiment designed to detect military reactors in the Soviet Union. Of thyroid tumors and cancers have been observed in populations living downwind from Hanford. Strontium-90, cesium-137, and plutonium-239 have been released in large quantities, as was, between 1952 and 1967, ruthenium-106. People in adjacent neighborhoods were kept uninformed about these releases before, during, and after, and none were warned that they were at risk for subsequent development of cancer. 115. Another indicator of extensive contamination is that, following the pattern it established at Gamont, the government began in 1984 to pursue a vigorous initiative to situate a major nuclear waste dump on or very close to Yakima land. 116 The plan was narrowly averted in 1988, mainly because of a sustained intertribal/intercultural opposition organized and spearheaded by Yakima leader Russell Jim. LL7 Under provision of the 1982 Nuclear Waste Policy Act, the Yakimas have also been able to secure $1.28 million in federal funding. The state of Washington has received another $1.12 million to study the degree and effects of nuclear contamination already present in their environment. 118. J #Stern Shoshone and Mescalero. AFEW 100 miles south-southeast of Hanford, deep in the Nevada desert, lies the Nellis Air Force Test Range. Consisting entirely of territory appropriated from the Western Shoshone people in contravention of the 1863 Treaty of Ruby Valley. Nellis contains the Nevada test site. Also, like the U.S. scenario, the Canadian government created a 265 mechanism through which to co-opt or confuse the resistance of the indigenous people on whose land the mining would be done. This assumed the FORM of what is called the Saskatchewan Indian Nations Corporation, which ensures that a native preference will be exercised when hiring is done for such menial occupations as driving trucks and guarding mining and milling facilities. 144 Throughout the 1970s, the provincial government busily utilized tax revenues to create an infrastructure necessary only to the uranium industry, including thousands of kilometers of roadways connecting projected mining sites in the north to the planned distribution center in Saskatoon, located far to the south. 145 The private beneficiaries of this massive expenditure of public funds were, of course, always intended to be such private concerns as the U.S. owned Gulf Minerals Corporation and the Japanese utility, Kyushu Limited, to which Saskatchewan Mining and El Dorado Nuclear jointly pledged delivery of 2.7 million kilograms of low-cost uranium concentrate over a 13-year period beginning 1LL1987.146. The constellation of transnational resource corporations now active in northern Saskatchewan includes French, German, American, and Japanese interests. 147. Development. In truth, governmental mining and milling of good to high-grade uranium has been going on in northwestern Saskatchewan at a relatively moderate pace since 1952, beginning with the TLRST of what were eventually to be 25 open-pit and underground mines around an ersatz town called Uranium City. Before the greater profitability of higher-grade mines elsewhere caused it to be phased out in 1982, El Dorado Nuclear had spent FULLY 30 years keeping overhead down at the Uranium City complex by dumping both liquid and solid wastes directly into Lake Athabasca, FROM, whence considerable contamination continues to flow down the Slave River to the Mackenzie and then into the Arctic Ocean. 148 The town itself existed solely to serve the uranium industry, Goldstick observes. Before the mines, no one lived there. After the mines, the population sank from its high of more than 4,000 in 1979 to fewer than 200 in 1983. A good thing, too, because, as in the Anaconda/Laguna example, it was FOUND that the corporation had cut costs, this time by building everything from the street to the hospital from uranium tailings. In 1977, for instance, it was discovered that classrooms in the local Kandu High School, governmentally named to commemorate Canada's first online nuclear reactor, evidenced radon levels 60 times higher than the allowable limit. The school was nonetheless used for another 5 years. 149. By the mid-70s, what became a government-sponsored boom was beginning to materialize. In 1975, El Dorado opened the Rabbit Lake Mine, in the northeastern portion of Saskatchewan, digging into an ore deposit ranging from 0.3 to 3% impurity. An open pit about 550 yards wide and 150 deep was created before the most profitable ore played out, and the mine was closed in 1984. El Dorado, in collaboration with Gulf Minerals, had built the largest uranium mill in northern Canada, producing some $100 million per year in yellowcake to service its Rabbit Lake endeavor, but it was not closed when the mine shut down. 1 So instead, beginning in 1982, the mill was expanded to accommodate the even greater volume of ore of a much higher grade expected from a new mine the corporation was opening at nearby Collins Bay on Wollaston Lake. LSI The Collins Bay open pit mine is especially dangerous because the uranium is actually under the bottom of Wollaston Lake, says Goldstick. In order to get at the uranium, part of the lake was diked off and drained in 1984. Mining below the bottom of the lake began in the spring of 1985. The pit is separated from the rest of the lake by a thin dike of steel that extends only about 1 meter above the water level, and may not be all to withstand strong waves which are a common occurrence on the lake. After the projected 6 years of mining, the dike will be destroyed, allowing the further spread of contamination. LS2 Such activity is unquestionably intended to continue in the Wollaston Lake area until some point well into the 21st century, given a 19R5 statement by El Dorado, when the Collins Bay deposit is eventually depleted, or will he mine from several deposits within a 12-kilometer distance? S3WOLASTON is, however, hardly the only place in northern Saskatchewan afflicted in this FAtion. At Clough Lake, southward across Lake Athabasca FROM Uranium City, preparation FOR mining and milling of extremely high-grade ore began in 1978. Although the Sea-Luff Lake Mining Corporation proudly announced when it began operations in 1980 that it was employing new technology, actually only huge concrete containers for storing liquid wastes, the first L110R spill had 268 occurred by 1982. This involved 2 tons of radium and raised the radiation level of a nearby stream to an incredible 600,000 times the maximum limit. 154 by 1986, it was discovered that at least 200 containers had cracked. They were being stacked too deep for reasons of economy and convenience and had leaked another 2.5 tons of comparable contamination into the environment. 155 The Corporation then announced it would accept a subsidy from Saskatchewan Mining to solve the problem by building yet another facility in 1987. This one to refine the radium waste is in collaboration with a French consortium, AMUC. 156. The Key Lake Mine in central Saskatchewan is the most southerly of all such operations in the province. It is now the largest open pit in the world. The mine, opened in 1983 by an international consortium including Saskatchewan Mining, Eldorado Nuclear and Urane, and calling itself the Key Lake Mining Corporation, is estimated to contain more than 84 million kilograms of uranium in an average ore grade of 2.5%. The attendant mill capacity of 5 million kilos per year makes up about 12% of free WORLD yellowcake output. 157. Much to the embarrassment of there was at least localized impact in Hidden Bay in the vicinity of the effluent creek mouth. 166. In terms of impact on fish, the study documents that toxicity tests of the Rabbit Lake waste discharge on several occasions found the tailings effluent acutely lethal to rainbow trout. Laboratory tests from March 1, 1977 to January 1, 1979 putting rainbow trout in precipitation pond effluent, FOUND, that all fish died in 96 hours, even when the 271 effluent concentration was only 10%. In July 1978 tests were conducted putting sucker FRY collected from Collins Bay into plastic containers submerged for 56 hours in Effluent Creek, the inlet to Horseshoe Lake. DND precipitation pond effluent. The water was FOUND to be acutely lethal in all but the Effluent Creek sample 67. Downstream from the Ubina mine, 3 aquatic plants water lily, milfoil and sedge were studied. Water lily consistently revealed concentrations of radium 11000 times greater than normal, milfoil showed an average 14000 times the normal level of uranium, sedge collected 13000 times the normal level of lead 210. 168. In 1983 a researcher from the Department of Biology at the University of Saskatchewan determined quantities of vegetation at 2 sites in the Rabbit Lake area, Collins Creek and Hidden Bay, and for comparison purposes, 2 sites near the Churchill River, Birch Hill and Otter Rapids. The Rabbit Lake sites showed significantly greater accumulation in FOR of the 10 species analyzed: blueberry, Labrador tea, green alder and black spruce. Collins Creek was FOUND to a hotspot for all species except dryland cranberry. A different study in another area, looking at uranium levels in trees, found the greatest amount in the growing tips of twigs, followed by the bark, leaves and wood. 69. The study, conducted by Dr. Stella M. Swanson, concluded that radionuclides are collected by plant life in the following descending order: lichen, moss, shrubs, and trees. Lichens and moss accumulate radioactivity at a rate 5 to 10 times greater than shrubs and trees, respectively. Moss and lichens absorb contamination from the atonosphere, while higher plant forms tend to take it in through the roots, making their contamination a somewhat more localized phenomenon than with lower forms. 170. Humans, of course, directly consume some of these plants and thereby ingest contaminants. Blueberry, for instance, is the greatest radionuclide collector among shrubs and is an integral part of the northern native diet at certain times of the year. Moreover, vegetation composes the whole diet of virtually every bird and mammal which, along with fish, comprise more than two-thirds of the traditional Indian larder in the upper reaches of Saskatchewan. Caribou, to name one example, subsist primarily on moss and lichens. Moose and deer consider the young tips of shrubs and trees to be a high delicacy. FOWL consume shoots from each of the three aquatic plants studied. 171. In the Canadian context, only AFEW studies examine accumulation of radioactivity in mammals. This area warrants NLOR attention as there have been 2 reports of ECO/Li. 272. Moose carrying a 2-headed Fe tusk being shot near Wollaston Lake. Further, Wollaston residents have often shot moose from the Rabbit Creek area, and people have seen moose drinking from the tailings ponds Y2. Even FEWER investigations have been conducted with regard to contamination of the indigenous people affected. Probably the closest was a study conducted from 1965 to 1969 with regard to the effects of mining and milling much lower grade ore in Ontario upon 25 relatively proximate Inuit communities in the Northwest Territories. The results showed levels of soft tissue and bone irradiation as much as 100 times normal, at times exceeding even the maximum limits established by the notoriously lax International Commission on Radiation Protection. 173 To date, neither the Government of Canada nor of Saskatchewan has offered any sort of realistic plan to dispose of the rapidly proliferating wastes being generated. Nor have the array of transnational corporations with which the two governments are involved. Rather, they have combined to offer what are, at best, utterly cosmetic remedies such as revegetating tailings piles. While prettying up thousands of acres of lethal waste, turning it all into nice moose pastures, as one El Dorado official has put it, cannot be said to accomplish anything at all to combat the pollution, it might possibly make the effects even worse. 174. It is important to realize that plant growth on top of a tailings area does not mean the spread of contamination is stopped. Limited plant growth has been achieved with massive fertilizer application and natural plants have regrown along the edges. But plant growth can actually increase the quantity of radon gas escaping from wastes. This is because radium travels up through the roots and is distributed in the leaves. Thus the surface area available for radon release is greatly increased. In addition, root penetration allows water to seep through protective soil cover and into tailings, allowing groundwater to be polluted. As well, the plants themselves become contaminated through uptake of toxic materials, which pose a danger to animals eating them. 175. And one of this can be new or especially mysterious information to the governments and corporations pursuing such rehabilitation schemes, given that the Los Alamos Scientific Laboratory reached precisely the same conclusions concerning the disutility of revegetation 20 or more years ago. 176 Overall, then, paranoid assessments by Indians and allied non-Indian radicals that northern Saskatchewan is being quietly but steadily written off as a gigantic national sacrifice area take on considerable sub. 273. Stance. 177 And, as with similar plans in the United States, the people of the land will necessarily be sacrificed along with the land itself. Back in the USA, during the 1970s, it was a standard slogan among environmental activists, a truth apparently now forgotten, that our radioactive contamination is forever. Today, it has become something of a commonplace among North American progressives, including important sectors of the environmental movement, to consider nuclear issues passé, a thing of the past, as if they had or could have gone away. 178 Some, like Barry Commoner, have taken things so far as to adopt a smug and self-congratulatory tone, pointing to an imagined collapse of the nuclear industry as evidence of a grassroots victory over big business and big government. In Oric.1 Ilajor died. Lip PR0 do TI0 IL Nikoldi PUVVI Pulilknilshan 11C1:/Eli CDJ had a powerful effect. In the United States it has brought the industry to an ignominious halt. The nuclear power industry is paralyzed because intense public opposition has made the industry pay its environmental bill, most dramatically by forcing the abandonment of the $5.3 billion plant at Shoreham, Long Island. 7. While much of the creditor temporarily consolidating public sentiment against the nuclear industry must go to the spectacular nature of the 1986 Chernobyl disaster rather than to organizing, it is true that the anti-nuke movement posted some impressive tactical wins. 180 popular opposition did have much to do with what happened at Shoreham, as well as the canceling of reactor construction at other locations such as Seabrook, New Hampshire, and Point Conception and Diablo Canyon in California, well before Chernobyl. 181 Similarly, well-focused activism played a role in bringing about the closure of existing reactors like that at Fort St. Vrain, Colorado, and several military-use facilities. 182. As of, reactors at Hanford, Washington, and at Savannah River, SC, are out of commission. The uranium production plant at Fernald, O, is closed permanently. Uranium enrichment facilities at Portsmouth, OH, and Paducah, Kentucky, are halted temporarily, and production at Rocky Flats has ended. T8L. Hopeful as these achievements are, however, what is occurring? 3. Northern Saskatchewan should be enough to disabuse anyone of the notion. 274. That the nuclear industry is somehow resultingly DEAD. Even Commoner admits that, in 1982, there were only 72 operational nuclear reactors in the United States, whereas there are now 110. 184. These figures undoubtedly represent a slowing in the pace of reactor construction. 95 facilities were under construction in the United States in 1980, less than a dozen today but hardly a stoppage. 185. Careful observers will also have noticed a marked upsurge in the propaganda of the U.S. nuclear industries Big Four: the Westinghouse, Babcock and Wilcox, Bechtel, and Combustion Engineering Corporations and their subsidiaries, reintroducing the alleged benefits of the peaceful atom during the early 90s. 186. Perhaps even more to the point, the energy policy announced by George Bush in 1991 was about as diametrically opposed to Commoner's pleasant script as it is possible to be. The president's plan called for the building of several hundred more reactors within 20 years, at a cost of between $390 billion and $1.3 trillion. 187. Only the 1992 election of Bill Clinton and Al Gore appears to have staved off implementation, however temporary. 188. Other signs of an impending resurgence in the U.S. nuclear industry also exist. Anaconda, for example, has indicated an interest in reopening its Jackpile-Pagwit mine at Laguna at some point early in the next century. 189. Ma Jane Ambler, a leading apologist for this sort of activity on Indian land, has predicted that mining and milling will not only resume at Navajo, Spokane, and Wind River, but on the Ute Mountain Reservation in Colorado, the Canoncito Reservation and Zuni, Acoma, Zia, and Jemez Pueblos in New Mexico, and the Hualapai Reservation in Arizona. 19. Unmentioned in her scenario are significant uranium deposits under the Crow and Northern Cheyenne Reservations in Montana and the Gunnery Range. Deposit at Pine Ridge. 191. Such wholesale development would, of course, dwarf the degree of radioactive colonization evident in Indian country between 1950 and 1980. The mechanism through which this can be accomplished is also present in a much more coherent form than was the case 30 years ago. Beginning in 1977, at the very height of the last U.S. uranium boom, the Federal Energy Administration provided $250,000 in seed money, an amount increased to $24 million annually in 1979 by the DOE to create an entity capable of both coordinating and creating a more plausible facade of Indian consent to such exploitation. 19. Dubbed the Sea Council of Energy. 275. Resource Tribes. The new organization was composed of the chairs of the federally created and maintained tribal councils on what were already known to be the 25 most mineral-rich reservations in the country. 193 The first task assigned CERT was to assemble a comprehensive inventory of energy assets in U.S. Indian country as a whole. Called a Sears and Roebuck Catalog of Reservation Resources by critics. 194 Its second task was to assist in conceiving and implementing a plan by which more efficient corporate penetration might be accomplished. 195 This last placed CERT over strong objections by a majority of those whose interests it supposedly represented in a position of serving as central broker and liaison in virtually all Indian energy resource transactions, a matter which quickly attracted millions in ongoing corporate FU. Ending. 196 Although the uranium bust of the 1980s affected CERT as it did sponsoring companies, the org 3.Nisltio, L simply devoted more 3.Tensio, L to fossil fuel extraction and to smoothing the way for the placement of nuclear waste dumps on Indian land, such as those approved at Mescalero and Skull Valley. 197 It has also moved itself into a position to reconcile environmental conflicts in Indian country more generally. By 1984 the number of tribal requests for CERT's environmental technical assistance had mushroomed. In that year the EPA awarded CERT $125,000 to study wastes on 25 pilot reservations. Later, the EPA provided $90,000 to establish an environmental information base and provided other, relatively small contracts for regional meetings. To increase tribal support, the CERT board created the CERT Technical Services Corporation, which was designed to market technical assistance. 08. In sum, CERT is now ideally situated to facilitate a full-scale resumption of uranium mining and milling in Indian country. Further, it is well placed to bring about construction of many, perhaps all, of the reactors called FOR in the 1991 Bush Plan in the same locale. Not only would such a strategy represent a genuine consummation of the national sacrifice area concept of the 1970s with all the implied advantages of subsequent unrestricted use of sacrificed areas this entails, it would carry the added attraction of going virtually unnoticed by the general public until well after the fact. When questioned on the matter, governmental and corporate spokespersons could simply deny that the facilities themselves were being constructed. After all, they had no particular difficulty in masking the reality of what was going on. 276. In Indian country the first time around, at least until the process was almost completed. Even in a non-Indian setting like Cincinnati, the DOE, in collaboration with the Department of Defense, was able to pass off its Fernald, Ohio, uranium mill as a pet FOODFA for 37 years, during which time it quietly dumped at least 167,000 pounds of radionuclides into the Great Miami River, another 298,000 pounds into the atmosphere, and still another 1.27 million pounds into leaking earthen pits. 199 The same combination of players was able to hide the release of more than 2 million pounds of radioactive mercury from its Oak Ridge, Kentucky plant until 1988.200. Until the same year, they were able to deny that the Rockwell International's operation of the Rocky Flats weapons facility just west of Denver, Colorado had resulted in extensive plutonium contamination of both water and landscape in a broad arc extending from Broomfield in the north to Golden in the south. 201 How much more easily and effectively might the government, businesses, and a cooperating agency like CERT be able to disguise what was underway in the Great American outback where only a relative handful of Indians reside? Fighting back. The question points in important ways to what has been a crucial defect in the U.S. anti-nuclear movement and the broader environmental movement of which it was and is mostly a part all along. From the clamshell and abalone alliances of the 1970s to the freeze movement of the 1985, non-Indian activists have focused all but exclusively on the very final stages of the nuclear cycle. 202 In other words, they have inevitably concentrated on the reactors and weapons composed of byproducts eventually refined from the yellowcake uranium mined and milled at the front end of the cycle, on Indian land. Hence, Their victories, however satisfying in an immediate sense, have always been tactical, never strategic. Put another way, whenever they have been successful in closing or preventing a reactor in one place, their opponents have simply built another somewhere else. Whenever they have caused weaponry to be removed from one location, it has merely been shifted to another. 203 If the specter of rampant nuclearism is ever to be truly abolished, such approaches must be changed, and drastically so. The key to a strategic vision. 277. FOR anti-nuclear activism is and has always been in finding ways to sever nuclear weapons and reactors from their roots. This means, first and foremost, that non-Indians cast off the blinders which have led them to the sort of narrow not in my backyard sensibility voiced by Barry Commoner and his erstwhile vice presidential running mate, LaDonna Harris. 24. Rather than endlessly combating the end products of the nuclear industry, the movement as a whole must shift its emphasis to preventing uranium from being taken out of the ground in the first place. This, in turn, means focusing everyone's primary energy and attention, not on places like Seabrook and Diablo Canyon, inhabited as they may be by important population sectors, but upon places peopled by mere Indians, Key Lake and Cigar Lake in Canada, for example, or Navajo, Laguna, and other reservations in the United States. 20s Ultimately, stopping the processes of uranium extraction in Indian country and consequent nuclear proliferation elsewhere will be impossible so long as the structure of colonial domination on the reservations is maintained. This means that coordinative and brokering organizations like CERT and the prevailing system of tribal governance must be opposed right along with the non-Indian governments and corporations which invented and sustain them. A top priority, probably the first priority for the anti-nuclear movement, the broader environmental movement, and FOR North American progressivism in general, must be the decolonization of native North America. To accomplish this, those representing indigenous liberty and struggles must be accorded a central role in setting the agenda FOR and defining the priorities of radical social change on this continent. 206 The alternative, if it may be called that, is at best only the prospect of what the French commentator André Gortz, in examining his own country's nuclear industry, once termed electric schism. 207. More likely, in North America, the radioactive colonization of Indian country will go on, until like some proverbial Meniere's canary sent first into shafts to detect with their lungs the presence of lethal gas, Indians die of the contaminants to which their betters have forcibly subjected them. 20s Unlike the canary, however, Indians can by their deaths provide no early warning of an avoidable fate about to befall those who sacrifice them in this fashion. This is true because, unlike miners who rely upon canaries, those who sacrifice Indians have no place to turn for safe haven once their victims have died. 278. The ecological effects of radioactive colonization know no boundaries. Radon gas and windblown radioactive particles do not know they are intended to stop when they reach non-Indian territory. Contaminated water does not know it is supposed to pool itself only under Indian wells. Irradiated flora and fauna are unaware they are meant only for consumption by indigenous expendables. The effects of such things are just as fatal to non-Indians as they are to Indians. The longevity of radionuclides is still just as forever now as it was 20 years ago. Nothing has really changed in these respects since John Goffman and Arthur Tamplin first published Poisoned Power in 1971. 209 Neither genocide nor ecocide can be contained when accomplished by nuclear means. The radioactive colonization of native North America therefore threatens not only Indians, but the survival of the human species itself. The tools for fighting back against any threat begin, it is said, with a precise understanding of the danger and, the best means by which to counter it. In this instance, the situation is simple enough. Like it or not, we are all Indian and non-Indian alike finally in the same boat. At last there is no more room for non-Indians to maneuver, to evade, to find more significant issues with which to preoccupy themselves. Either the saving of indigenous lives becomes a matter of preeminent concern, or no lives will be saved. Either native North America will be liberated, or liberation will be reclosed for everyone, once and for all. The fight will either be waged on Indian land, for Indian lives, or it will be lost before it really begins. We must take our stand together. And we are all running out of time in which to finally come to grips with this fact. The water plot. Hydrological rope in northern Canada. There are strange things done in the midnight sun by the men who toil toward gold. The Arctic trails have their secret tales that would make your blood run cold. Robert Service. In northern Canada, a water diversion scheme far larger than anything yet undertaken in the United States has been planned, piloted, and awaits only the right climate of public opinion. Point 1. The idea is to divert Canada's hydroelectricity and clean, fresh waters to support the growing demand of the lower 48 U.S. states. According to proponents of the plan, Canada would earn a great deal of rain exchange, and would profit considerably from the employment created by construction of the required dams, dikes, canals, tunnels and pumping stations. Little is said about what will happen once these works are built. As will be seen, what little benefit might actually accrue to the citizens of Canada will be vastly outweighed by the costs of adverse economic, human, and environmental consequences. Land that supports its people. In the Canadian Northlands, the indigenous Dene, Cree, Inuit, and Ojibwe populations live primarily high time-honored methods of hunting, trapping and fishing, at lording these occupations not only practical but central spiritual significance. Point 2. Those who hold wage jobs do so mainly in the three industries which support the resident non-Indian population, mining, forestry and tourism. Point 3. Each of these economies must be considered in any assessment of the overall impacts attending the projected hydrological rape of the subarctic. 292. As developments in northern Quebec over the past quarter century have amply demonstrated, massive water diversion is utterly devastating to the ecosystems upon which indigenous economies depend. The habitat of fur-bearing animals, without which there can be no trapping, is flooded out when effluent waters are dammed. Point 4. Similarly, much of the bottomland on which large mammals graze becomes submerged, killing or driving the animals away and destroying the basis for commercial or even subsistence hunting. Aquatic life is also disrupted by damming. Many of the varieties of fish native to northern Canada require a current in which to thrive. They disappear quickly once their rivers and streams have been converted into relatively motionless reservoirs. The flooding caused by dams also tends to cause mercury contamination and other forms of water pollution which renders poisonous to consume even those types of fish which are able to adapt. Point 6. If the grand plan for water diversion in the subarctic is consummated, the impact upon indigenous peoples there will be catastrophic. It is certain to destroy their present economic self-sufficiency and, as will be seen below, will reclose on every economic alternative supposedly available to them. The net result may well be their rapid disappearance as peoples. In this sense, the effect of the water plot carries implications of genocide as well as ecocide. 7. Permanent deforestation. Although northern Canada is abundantly wooded, it takes more dollars worth of equipment to generate a penny's worth of profit from the pulp and paper industry than nearly any other business in the world. Because trees in the subarctic grow comparatively slowly, each paper mill must draw on a broad forest area in order to ensure that the large capital investment involved receives a perpetual supply of raw materials. Point 8. In northwestern Ontario, for example, timber limits are now almost fully allocated throughout the harvesting area south of Highway 11 and north of Lake Nipigon. Reservoirs already cover tens of thousands of square miles of former woodlands in the region, and it is easy to see that further hydrological improvements can only be accomplished through destabilization of the forestry industry. Point 9. If the THIRD plot were to achieve fruition, forests and forestry, not only in Ontario, but elsewhere in the north, would become relics of the past. Reduction of forestry would deny the indigenous. 293. people of the area not only a primary source of what limited cash they now receive, but also one of the major alternatives to their traditional economy that the dominant culture has always espoused. Point 10. The mining industry. There is an estimated $1 billion worth of nickel in the new Inco mine on Shabandowan Lake, in Ontario. The entrance to the mine shaft is barely 20 feet above the natural level of the lake. Shabandowan is but one of many similar sites, all of them yielding rich mineral ores, including not only nickel, but copper, bauxite, manganese, uranium, iron, silver and, of course, gold. Each of the mines is similarly located, at or very near lake level. Projected areas of flooding if the water plot is consummated show that all of these will disappear beneath the waves, as will a number of Indian and non-Indian communities. Planners explain that construction of an elaborate system of cofferdams, causeways, and pumping facilities will be sufficient to save many existing mine sites. They are silent, however, concerning the expense involved. There are no estimates of the increase in costs of Canadian ORES needed to pay the tab. In all likelihood, mining in much of northern Canada will be priced out of the market and correspondingly gutted. Further, planners have little to say about how their scheme would affect exploration and mining of presently undiscovered mineral deposits which will be buried not tens, but often hundreds of feet underwater. 12. A THIRD diversion of the sort now envisioned would thus demolish the second supposed alternative to traditional native economies. Tourism. Tourism, the third and final basis for an indigenous cash economy in the Northlands, is also threatened. For more than 40 years, a solid business of sport fishing and hunting, camping, and the like has developed and provides a cash supplement to the subsistence activities of many native people. 13. This will be completely ruined if fast-moving pike streams, as well as pickerel lakes, are converted into huge, largely stagnant inland seas in which only carp can live, and upon which one can barely cast a line without snagging the rotting remains of once proud pine forests. As is readily demonstrated behind the sprawling Bennett Dam in British Columbia, even where water still flows, navigation will be severely impaired by floating timber and land. 294. Ings will have to be made on mudflats, amidst the skeletal remains of miles upon miles of drowned trees. 1. For the tourist industry in most of northern Canada will be obliterated if the THIRD plot is realized. And with it would go the last hope of survival for the region's indigenous peoples. Genocide as national sacrifice. Once the dams and attendant paraphernalia are put in place, the entire developed area will quite literally be gone, leaving nothing by which a population, indigenous or otherwise, can support itself. Northern Canada will have become what in the United States has been described as a national sacrifice area. It follows that the human beings who reside there will have been simultaneously converted into what American Indian Movement leader Russell Means has termed national sacrifice peoples. 15. As the dimension of this incipient disaster has dawned on people throughout Canada, and to a lesser extent in the United States, questions have been raised. The response of the Canadian government and of various provincial governments has been to become increasingly secretive about their water diversion and hydroelectric projects. Large-scale, detailed maps of the targeted locales, on which it might be possible to decipher the likely extent of flooding, have been withdrawn from circulation. Even general information and small-scale maps have become quite difficult to obtain in many instances. 16. Apparently, the government intends to deny the public's right to know what is being done to them and their resources until the dams have been erected and the damage done. 17. But, contrary to Ottawa's wishes, or the wishes of the cliques inhabiting a number of corporate boardrooms and provincial capitals, such information is the property of the people, and not just of North America. Genocide is, after all, a crime against all humanity. 1. The same is true of ecocide. As will be shown, existing and planned projects in the Canadian Northlands entail significant negative implications for the biosphere of the entire planet. The Jollies Bay projects. It all began early in the 20th century, when the first hydroelectric plants were built at those rare sites where large amounts of electric power could be generated, and where there were nearby cities to which it 295 could be shipped, or the power so abundant and cheap that electricity-consuming industries could be enticed to build new plants near where it was generated. 19. Such endeavors were not especially disruptive of the environment, and remained concentrated in the heavily populated southeastern corridor of Canada. By the late 1930s, however, English-speaking capitalists and engineers built the first major powerhouses in, harnessing the St. Lawrence River at rapids near Montreal, as well as tributaries of the St. Lawrence where they tumbled off the central plateau of the Quebec-Labrador Peninsula. Montreal Light, Heat, and Power Consolidated, for instance, supplied the large and growing market of Montreal with power generated nearby. It grew into one of the largest privately owned electrical utilities in the world and made Irish-born financier Henry Holt exceedingly wealthy. Shawnigan Water and Power Company, launched high American entrepreneurs, generated cheap and abundant electricity at Shawnigan Falls on the St. Maurice River, a tributary of the St. Lawrence. The company attracted aluminum refineries, pulp and paper mills, and other electricity-hungry industries to locate in what had been wilderness, and the surplus power plowed through NORTHA Mencas TJRST long-distance high-voltage Transl 11 SSL online to Montreal, on the Sanguena River, another tributary of the St. Lawrence, a subsidiary of the Aluminum Company of America. A subsidiary which later became the multinational firm Alcan built its own hydroelectric plants to power its aluminum refineries. 20. Toward the end of World War I, in April 1, 1944, the provincial government began to lay the groundwork for a vast expansion of Quebec's hydroelectrical generation by nationalizing Montreal Light, Heat, and Power. The resulting public utility, dubbed Hydro-Quebec, began a rapid program of building ever bigger hydro-projects on rivers ever farther from the centrace of population and industry, running transmission lines at ever higher voltages over ever greater distances too. 1. The new utility doubled in size, and then doubled again. By 1963, it had become the largest employer in Quebec, and a source of pride among the province's large nationalist population. It had also begun to export a considerable portion of its electrical output to the United States and was eyeing schemes of development which transcended provincial boundaries altogether. It was in this context that the Liberal administration of Jean Lesage had swept into power, quickly increasing Quebec's debt by $600 million in order to absorb all private utilities remaining within its borders. 22 by 1967. 296. Quebecois watched with pride army of workers and fleets of trucks a dam, giant, graceful structure of arched concrete on the Manicouagan River, some 700 kilometers away. Technology usually advances in small steps, but to transmit power from the distant Manic hydroelectric complex, Hydro-Quebec made a large extrapolation. It more than doubled the standard voltage used for high-voltage distance power transmission, and developed the first 735 kV transmission line. 2-3. Next came the majestic falls of the Churchill River, more than 1,000 kilometers distant. Hydro-Quebec did not develop Churchill Falls, which is in Labrador, the mainland portion of the province of Newfoundland and Labrador. But Hydro-Quebec was its only potential customer. After marathon negotiations, Hydro-Quebec signed a deal with Brinco, the company developing the hydroelectric project. In return for securing the loans which paid for construction of the Churchill Falls hydroelectric plant, Hydro-Quebec, for 65 years, got almost all its enormous output at what turns out to be extremely low rates, about 1/50th of those it charged when it sold POWER in the United States. 24. With the election of Robert Bourassa as Premier of Quebec in April 1, 1970, the pace of development increased exponentially. Having campaigned on a promise of delivering 100,000 new jobs in short order, The new premier demanded an immediate start-up of a massive pro-JECT to dam three major rivers, the Nottoway, Broadback, and Rupert, all of them draining into James Bay, and at JUNCT at the southern extreme of Hudson Bay. 25 Hydro-Quebec initially resisted the idea, which it had been exploring since at least as early as 1965, on the basis that anticipated expenses would be too great and that demand for the quantity of power generation which would result did not yet exist. 26 Bourassa, however, quickly overcame the financial objection by arranging an initial $300 million loan through David Rockefeller of the Chase Manhattan Bank. Consumption concerns were then partially addressed via assurances from the banker's brother, New York Governor Nelson Rockefeller. The good governor, it should be noted, was in an excellent position to give such guarantees since he served simultaneously as president of Consolidated Edison, which supplies power to New York City. As a result of these maneuverings, a new subsidiary of Hydro-Quebec, the Société 297 d'Énergie de la Baie James Bay Energy Corporation, was established in 1971 to move things along. 28 James Bay I. By the time construction actually began in 1972, the scope of the pro-JECT had been expanded to include a complex on the La Grande River. It was there that Canadian Bechtel, a subsidiary of the huge Bechtel International Construction Corporation, was contracted to engage in Phase 1 building, ultimately moving enough earth to recreate the Great Pyramid of Cheops 80 times over. 29 In the process, Bechtel also pushed through a network of roads where none had previously existed, installed airports and housing to accommodate 5,000 workers, and began generally to open up the previously pristine James Bay wilderness to the ravages of civilization. 30. And, as analyst Sean McCutcheon has pointed out, after such a dynamic is set in motion, it becomes almost impossible to stop. Once having paid a royalty fixed sum termed restructure, then the more dams Hydro-Quebec builds, the lower the cost per kilowatt generated tends to be. Thus economies of scale encourage building on a large scale. 31. The developers, however, encountered intense and unexpectedly effective opposition early on from the Mistassini Cree people indigenous to the area, a group the Bourassa administration had casually dismissed as squalid savages. 32. Beginning in February 1, 1972, a pair of young men, Philippa Washish and Billy Diamond, alerted by newspaper articles summarizing the government's plans, began a village-by-village campaign to organize a cohesive Indian resistance to the James Bay pro-JECT. By April, they had retained James O'Reilly, a specialist in environmental and Canadian Indian law, and filed a motion with the Superior Court of Quebec to NJO in all building pending the outcome of an independent environmental impact study they themselves had commissioned. 33 After a number of site visits, a team of 15 scientists were prepared to take the stand in October and November of the same year and testify that not only would the proposed dams, roads and transmission lines precipitate an environmental catastrophe of the first magnitude, but its impact upon the Cree and more northerly Inuits would be culturally genocidal. 34. Einar 298. Skinnerland, who had been a ranking engineer in the Churchill Falls endeavor, testified that he was having second thoughts about such projects, especially wholesale river diversions, which he described as being the most disastrous decisions we can make. He termed the economic and energy rationales underlying construction baloney. 35. More than 60 native people also took the stand, once their attorney had convinced the court that even under Canadian law they held a range of rights with regard to their lives and land. 36. Carefully coached by O'Reilly, speaking for the most part through translators, they explained themselves to the urban world which many of them had never before visited. They talked about fishing, hunting, and trapping, about their reverence for the land, about their reliance upon it for what they call country food, for bear, beaver, caribou, moose, rabbit, seal, and whale, for geese and ptarmigan, for Arctic char, pike, salmon, sturgeon, trout, walleye, and whitefishy. The defendants named in the action Hydro-Quebec, the James Bay Development Corporation and the James Bay Energy Corporation could not find a scientist in Canada to testify on their behalf and were astounded by the emotional fervor of the opponents of the project. In the end, they were reduced to countering that, a. the Indians and Inuits had no right to oppose destruction of their cultures by the dams because their cultures would inevitably be destroyed anyway, b. that the threat to both people and environment was being greatly overstated because the initial phases of the project would flood only 3% of the affected portion of the province, and c. halting the project would be inconvenient to the non-native majority of Quebec's population. 38 The court was plainly unconvinced by such arguments. In November 1973, Superior Court Judge Albert Malouf, who had spent the summer and fall crafting his opinion, ruled in favor of the plaintiffs, holding in effect that Bechtel and other developers were trespassing on native land. He then ordered all construction to be halted until a hearing on a permanent injunction could be held. 39 A week later, the Quebec Court of Appeal overturned Malouf's decision, not on the basis of law, but because, it said, the interests of the greater society compelled it to do so. The appeals court, however, stipulated that the Crees and Inuits held a right to sue for damages, a circumstance which contained the prospect of dramatically increasing the costs of doing developmental business in the James Bay area, fearing a legal impasse, which in turn might give investors in the 299 hydroelectric project cold feet. Bourassa had to settle with the natives. He offered a treaty, the terms of which included, among other things, payment of $100 million. In March 1974, Cree hunting families were flown out of bush camps to vote on this offer and flatly rejected it. The Indian lands are not for sale, not for millions and millions of dollars, said Billy Diamond. 41 Ottawa then entered the fray, providing funding with which to form an entity called the Grand Council of the Crees of Quebec, composed largely of representatives deemed acceptable to the government. Billy Diamond himself was co-opted into becoming Grand Chief. 42 A comparable group, the Northern Inuit Association of Quebec, headed by Charlie Watts, was created to represent that people. 43. The purpose was to negotiate an out-of-court settlement of some sort which would clear the way for a project completion unhampered by extensive litigation or other obstructionist acts by the natives. After 8 months of intensive negotiation, what was called the James Bay and Northern Quebec Agreement, strongly opposed by the bulk of grassroots Crees and Inuits, was signed in November 1975. 44. The agreement divided just over 1 million square kilometers of land, not JLLT the James Bay Territory, but all of Quebec north of the 49th parallel, that is, 2/3 of the whole province, into 3 categories. About 1% of the land, in blocks around villages, is essentially native-owned. The only resource of interest in this land is wildlife. Before the natives could select land in this category, the provincial government subtracted those areas with known hydroelectric or mineral potential, as well as land it would need for roads and power lines. About 14% is shared land. Only natives can hunt, trap, and fish here, but Quebec can develop mines, hydroelectric projects, and the like. The remaining 5% of the land is public, though certain species of wildlife are reserved for the natives. 45. Indian control over schools, health, and social services and other government-funded programs was conceded, and members of the Cree Grand Council/Northern Inuit Association were placed on a range of environmental oversight boards. In addition, the Cree communities were awarded a total of $135 million, to be paid over 20 years, as compensation. Inuit communities were awarded $90 million. A minimum annual income was guaranteed to the hunters of both groups, and additional funds were committed to underwrite the relocation of any village or band forced to move because of flooding or related factors. Altogether, the package came to some $500 mil. 300 lion in payments and guarantees. In exchange, the native people had only to formally relinquish Aboriginal rights to their homeland and, for the first time, accept ultimate federal and provincial authority over their affairs. 4.6. The government could well afford its generosity in the deal. In attaining native sanction, or an appearance of it, for its consolidation of power over indigenous territory, Canada and Quebec had finally placed themselves in a lawful position to renege on any portion of the agreement. All that was juridically required was that one or the other resort to such domestic or internal expedients as the exercise of eminent domain over native property. 47. Meanwhile, construction was proceeding full at not one, but four sites along the La Grande. At its peak, during 1978–79, the pro-JECT employed more than 22,000 people working nearly around the clock. By the time it was completed in 1984, it had cost approximately $20 billion, 15 times the per capita expenditure of U.S. citizens in sending the Apollo spacecraft to the Moon, more than 3 times what the Bourassa administration had originally predicted. 48. The La Grande, third largest river in Quebec, as well as 2 of its main tributaries, the East Main and the Kaniapesca, had been effectively killed, transformed free-flowing currents into a series of stagnant lakes and ponds incapable of supporting most life forms. 49. Ironically, the huge cost overruns associated with James Bay were in part responsible for Bourassa's defeat in the 1976 provincial election and René Lévesque's rise to power as leader of the Parti Québécois Just as the pro-JECT began to show a return. 50. In 1978, Hydro-Québec completed its first interconnection with the New York Power Authority and, by October 1, 1979, was exporting electrical current equivalent to that which could be produced by burning 150,000 barrels of oil per day. By 1985, with James Bay complete, the utility's aggregate production had outstripped total provincial usage even during the peak midwinter months of consumption by at least 7,000 kilowatts. 51. The grid capacity for exporting overages of such magnitude to the United States not yet being available, Hydro-Québec began aggressively pursuing the development of electrically intensive and environmentally devastating industries such as aluminum refining in the southern portion of the province itself. Electrical charges strong enough to erase credit cards, stop digital watches or pull a wrench from someone's hands are what separate pure aluminum from its ore. An aluminum smelter uses as much power as a small city. So much electricity is used in 301. Making it that aluminum can be thought of as congealed electricity. The multinational firms who produce aluminum build their billion-dollar smelters not where the ore is mined, but where they can be assured of getting abundant, cheap electricity. Hydro-Québec offered rates low enough to induce several of these firms, notably Reynolds and Pecheny, to build or expand smelters in the St. Lawrence Valley, and to induce other firms to build a magnesium smelter as well as pulp and paper mills. All these plants use enormous quantities of electricity and, since their products are mainly exported, they are, in effect, exporting Quebec's electricity. 52. Even as this was occurring, however, the grid problem was being resolved. In March of 1982, Hydro-Québec had entered into another long-term contract to provide greatly increased power to the New York Power Authority and, in 1984, the conduit was completed through which to fulfill its commitment. In 1983, the utility also signed the first of a 2-part package with the New England Power Pool, an arrangement which committed it to providing a direct line to New Hampshire. The second part of the Agree LLC LGILCJIU 1985, called for erecting a 2,500-kilometer line, directly from the La Grande generating facility to a point just outside Boston. A separate deal was negotiated in 1984 through which Hydro-Québec would supply year-round power to Vermont. 53. By the early 90s, James Bay was supplying approximately 10% of the electricity consumed in the northeastern U.S. states. 54. None of this, of course, was sufficient to offset the huge debt incurred in the process of constructing James Bay, much less render it profitable for the taxpayers who, in the final analysis, were its real investors. 55 On the other hand, it proved the viability of pro-JECTS on the scale conceived by Bourassa and his colleagues, and appealed to nationalist sensibilities of those who revelled in the idea, pushed hard by provincial and utility propagandists alike, that by becoming the sole provider of a crucial commodity to Canada's powerful southerly neighbour they had accomplished something independent of the Anglo-centric government in Ottawa on behalf of Quebecois culture. 56 As Ojibwe activist Winona Laduke, who spent several years at James Bay, puts it, these things take on a life of their own. Once you've gone in debt to start one, the only way to stay abreast of the debt service is to go even if you're ill debt, borrowing more and more so you can build more and more and more, no matter what the consequences to land and people. You lose control of your destiny. In this sense, Canada is no different than most third world countries. It owes its soul to U.S. corporate and financial elites, and so it must sacrifice everything it has, everything it is or claims to be. 302. To satisfying the demands of those elites. For the power structure of Canada, especially in Quebec, there is no longer a way out of the trap it laid for itself 30 years ago. Canada is now little more than a U.S. satellite, an energy colony. 57. Hence, even before James Bay I was finished, the groundwork was laid for undertaking James Bay II, a far more ambitious, and therefore more destructive, project. James Bay II. In 198-6, Robert Bourassa returned to power in Quebec, bringing with him a plan to generate 12000 megawatts of power to the northeastern United States by the turn of the century. 58 To this end, he almost immediately oversaw a revision of provincial legal codes in such a way that restrictions limiting sales of electricity to short-term contracts were eliminated. This allowed negotiation of contracts for firm provision of large blocks of hydroelectric current over periods ranging from 15 to 30 years rather than the 1 to 5 year packages previously offered. As a result, by early 1988 Hydro-Quebec had signed agreements with Central Maine Power and Vermont Joint Owners, a utilities consortium in those states. A year later, the largest export contract ever, a deal to sell another 1,000 megawatts to the new York Power Authority every year for 21 years, was finalized. 59 Bourassa announced at about the same time that, in order to meet the requirements of these new contracts, as well as to accommodate burgeoning industrialization in the St. Lawrence Valley, Quebec would need to possess a generating capacity of some 12,000 megawatts by 1998.60. The amount was nearly triple the total Hydro-Quebec could muster, even considering its portion of Labrador's generation at Churchill Falls. To acquire the necessary generating capacity, Bourassa stated, it would be necessary to move forward with a new three-stage project which made James Bay I seem tiny by comparison. The first stage, to begin immediately, was to construct 2 additional generating facilities in the existing La Grande River complex. The second stage, to begin in 1991, would be to build a new complex involving 5 major dams along the Great Whale River about 160 kilometers north of the La Grande. Another 400 square kilometers would be flooded at a projected construction cost of $2.6 billion. The third stage, by far the most extravagant, was set to begin not later than 1993. It was a return to the original. 303. Hudson Bay. 11. Concept of diverting the Nottoway and Rupert rivers into the Broadback through construction of at least 11 major dams. No predictions were offered as to how much territory would be flooded in this, but construction costs were projected at $44 billion. 61 Together, the 3 complexes which would be in place when James Bay II was complete would effect a replumbing of virtually all of northern Quebec. For funding, Bourassa had already returned to New York in 1985, meeting with John Dyson, former president of the New York Power Authority, and James Schlesinger, U.S. Energy Secretary under Jimmy Carter and at the time a vice president in the Lehman Brothers investment banking firm. The latter, in exchange for a 1.7% commission, organized the 304 underwriting by an array of U.S. investment firms of an estimated $50 billion in bond issues over 10 years in order to guarantee Hydro-Quebec's solvency during construction of the megapro JECT 62 in 1989, Bourassa informed his public of these astronomical figures through resort to the usual nostrums of progress. Such expenditures would, he claimed, create 40,000 new jobs for Quebec and generate $40 billion in annual revenues by the year 2063. By then, however, both the degree of error embodied in the government's earlier cost, profit and employment estimates, and the actual environmental and cultural consequences of James Bay were becoming well known. 64 The environmental portrait is indeed bleak, the La Grande complex having ultimately inundated about 12,000 square kilometers of forest land, including some 83,000 linear kilometers of shoreline. 65 As at Bennett Dam, the rims of reservoirs do not, and cannot, replace any of the lost wetland habitat. They are broad, lifeless banks of mud, rock, and dead trees. 66. In substance, the populations of aquatic mammals along the La Grande, East Main, and Ca Neapisca beaver, muskrat, snowshoe hare, mink and otter, among others, all of which had still been abundant during the mid-70s, had been exterminated. 67 Submerged wood and floating debris, as well as silt, have destroyed the water's capacity to oxygenate and have clogged spawning grounds, decimating most varieties of fish. 68. Millions of plants, mainly the pioneering, colonizing species, jack pine, willow, and alder, have been planted in an effort to reforest zones stripped by construction, as well as to reduce erosion on sections of the banks of desiccated rivers. This has been done, however, in only a fraction of damaged areas, those along the most well-used roads and around the most visited installations. It will take a long time before the scattered plants reseed the barren spaces between them. 69. Many Crees assert unequivocally that the damage has been terrible, much worse than anything they were led to expect. There are FEWER and FEWER ducks and geese each year. The climate is changing, animals are confused because their migration routes have been disrupted. 7. 0. The last claim was amply borne out by a spectacular instance in late September 1, 1984, when an estimated 10,000 caribou drowned during a single attempt by a large herd to cross the newly transformed Kaniapiska. 71. Among the native people themselves, the permanent neurological damage caused by eating mercury-contaminated fish has become a substantial problem. 7. To fear of this, along with a steady diminishment in available 305 game animals, has led to a marked alteration in diet, an increase in the sugars and starches indicative of civilized consumption, compounded by the increasingly sedentary way of life imposed upon them by the disappearance of traplines and decreased hunting and fishing, all of which kept them physically active. This has led to a sudden appearance of diabetes, heart disease, and obesity, maladies unknown in Cree communities until the 1980s. As traditional life has quickly disintegrated along the La Grande, social decay has come to be manifested in spiraling rates of alcoholism, glue-sniffing among young people, and other forms of substance abuse. Concomitantly, domestic violence, child abandonment and suicide, all of them virtually unheard of among the Cree until recently, have made their ugly appearances. 73 Like the Habitat itself, the indigenous society impacted by James Bay is plainly dying. Moreover, the sort of native participation in environmental oversight guaranteed in the James Bay and Northern Quebec Agreement of 1975, participation which might HL1CO2F, JVOR, JHLY alter such an outcome, has proven illusory. Native leaders complain that they have not been able to exercise any significant control over decisions affecting their region. The mechanisms, such as joint committees, which were to give them power to participate actively in economic development of their land not just as beneficiaries, but as controllers, do not work. For instance, the Crees have not been able to stop the loggers who, with Quebec's permission, are now clear-cutting most of the harvestable timber in the southern portion of the Cree homeland. 74. Under these conditions, Cree opposition to James Bay II was instantaneous and far more profound than was the case with the James Bay I proposals of the early 70s. In 1987, they decided to put the Grand Council, originally designed by the government to serve as a vehicle of co-optation, to work in forging a unified resistance to what was planned along the Great Whale and in the Tri-River area. 7 A young mysticini named Matthew Cooncombe was elected to head this effort, and even Billy Diamond resumed his radical stance long enough to describe the agreement he himself had signed a dozen years earlier as a trail of broken pre-Arnisas. 76. The bulk of the Inuits north of the project zone also renounced representation by the Northern Inuit Association and the leadership of Charlie Watts, by then a member of the Canadian Senate and called Megawatts by 306. His ostensible constituents, and in the Crees in opposing all further construction. 77 Both peoples flatly refused to negotiate with Hydro-Quebec about James Bay II, despite a $1 billion offer introduced by the utility in 1989 if they would endorse an updated version of the 1975 understanding. 78 This time they were not alone, a matter reflecting increased sophistication on the part of Cooncombe and others in the ways of attracting non-Indian support in both Canada and the United States, as well as heightened sensitivity among many non-Indians with regard to native and environmental issues. In Montreal, longtime environmental activist Helene Lejam and Gordon Edwards, head of the Canadian Coalition for Nuclear Responsibility, utilized the 1989 conference of the Canadian Greens to establish what may have been the first anti-James Bay II organization outside of Indian country. 79 This was soon followed by demands for a moratorium on construction by the coalition for Public Debate on Energy, an organization in Quebec City claiming membership of 1/6 of the provincial population. The Arctic Resources Committee and Cultural Survival, both based in Ottawa, and Lee, as did a new entity in Quebec, Prudent residents opposed electrical cable transmission. 80 Things developed similarly south of the border. In Vermont, for example, Jim Higgins, a social worker who has canoed in the James Bay area, helped found the New England Energy Efficiency Coalition. In New York City, Jeff Woollick of the Solidarity Foundation, which puts royalties earned by the Irish rock group U2 to work in defense of native peoples, helped found the James Bay Defense Coalition, which comprises some 20 organizations, and began lobbying to cancel the New York Power Authority contracts. Major international environmental organizations became involved. In July 1989, the New York-based National Audubon Society publicized, in Quebec, its concerns that water resource developments would harm the large numbers of migratory birds that use the James Bay coast, and called for public environmental hearings. The Sierra Club created an umbrella organization, the James Bay and Northern Quebec Task Force, and channeled funds through a think tank founded by Helene Lejam, the Centre d'Analyse de Politiques Energetiques, to establish an office in Montreal. The large organizations have not swallowed up the grassroots movement. There are at least 30 anti-James Bay II groups on college campuses throughout New York State, and more elsewhere in the Northeast. The building of such a serious, multi-ethnic, and multinational opposite. 307. Shin movement had almost immediate effect. In January 1, 1989, a group calling itself No Thank You Hydro-Quebec was successful in convincing the Maine Public Utilities Commission to deny approval of the Central Maine Power Contract. 82 In New York, the Sierra Club, Protect, the Cree Grand Council and other groups joined in a suit against the New York Power Authority, arguing that it is required to ensure that all electricity it imports is generated under conditions conforming to the state's own environmental protection standards. Although the legal action was unsuccessful, it was helpful in bringing pressure to bear on Governor Mario Cuomo and New York City Mayor David Dinkins. Consequently, in June of 1999, the state announced it was delaying ratification of its 1000 megawatt contract with Hydro-Quebec for 1 year while the environmental implications of James Bay 2 were studied by New York's own experts. 83 In Vermont, the most recalcitrant of new air GHRRDTTF, RRNFNT, J1M score a partial victory in October. The State Utilities Board voted to approve 340 of the 450 megawatts called for in the Vermont joint owners contract with Hydro-Quebec, but only if the latter could guarantee that none of the electricity imported was generated at James Bay 2 facilities. 84 Under these circumstances, Bourassa had little alternative but to postpone the beginning of construction for a year, until the summer of 1992. In April of that year, however, New York cancelled its major contract altogether and announced it was reviewing its previous arrangements with Hydro-Quebec as well. Left seriously in the lurch, the province was already guaranteeing $30 billion in long-term debt for its utility, which necessitated another $500 million in short-term funds to stay solvent. Bourassa was forced to announce a second year's postponement. 85 Meanwhile, public opinion polls showed that support in Quebec for further development had plummeted for the first time. 86 Kuncum and other Cree leaders reinforced this decline in support by stating that they would meet any attempt to get building underway with physical resistance. The credibility of their warning was dramatically underscored by an armed confrontation between Mohawks, provincial police, and the Canadian Army at the town of Oka, near Montreal, in 1990. 87 In April 1, 990, responding to rumblings from Bourassa and his energy minister, Lisa Bacon, concerning use of the power of eminent domain to force the issue. O'Reilly and other attorneys T.C.J. the Crees filed suit in the 308 Queen's Court challenging the Provost of the James Bay and Northern Quebec Agreement, whereby their clients allegedly relinquished Aboriginal rights to their land both north and south of the La Grande. After much governmental maneuvering, including repeated motions by Quebec that the case be dismissed, it was finally docketed for April 1, 992.88. Even as these actions were unfolding, in June 1, 991, Crees prevented an Inuit delegation aligned with Charlie Watt's from leaving the Great Whale Airport to participate in a provincially sponsored environmental impact hearing intended to secure some measure of native ratification for the James Bay 2 plan. Instead, the Grand Council filed another suit in Queen's Court, this one to compel the federal review process stipulated in the 1975 agreement, but never actualized. Judge Paul Rouleau upheld the Crees position in August and, although Quebec filed an appeal, federal oversight hearings were again ordered, a process which would have taken as long as 2 years once it began. 89 By 1996, the province had had enough, and Premier Jacques Parizeau shelved James Bay 2 indefinitely. 90. Other WA diversion sketnies. Despite this major victory against the WA plot, 3 Northern Quebec, the balance of Canada remains in many ways up for grabs. This is readily evidenced by the damming of the St. John River in New Brunswick, despite serious and sustained protests by local residents that the benefits of this development were vastly overrated, and that irreparable environmental damage was being done. 91. There are other illustrations, but the extent of the situation is nowhere better revealed than in an official document of the Ottawa government entitled V. Lichter Diversion Proposals if North America. 92 Summarized therein are 8 major scenarios the James Bay projects account for only 2 in which Canada's water and or hydroelectricity are to be exported to the United States. The most grandiose of these, the Great Recycling and Northern Development Project and the North American Water and Power Alliance, if combined would turn literally the whole subarctic west of Quebec into a single, interconnected plumbing system. The purpose of this would be primarily to provide truly gargantuan quantities of fresh water to the arid and semi-arid western plains and southwestern desert regions of the United States. These plans can be traced back to the 309 Canada-U.S. Free Trade Agreement of 1989, the subsequent North American Free Trade Agreement, which includes Mexico, means that the water will likely reach areas as far south as that country, after the creation of agribusiness zones in Sonora and Chihuahua. Secondarily, planners suggest a deadjustment of water levels in the Great Lakes system as a means of flushing industrial pollutants into the Atlantic Ocean, hydroelectric generation and provision of emergency water during droughts to the U.S. Midwestern corn and industrial belts. Each of these gigantic projects is worthy of being examined in turn. The Grand Project. The Grand Project, which is concentrated in northern Ontario, calls for construction of some 160 kilometers of dikes across James Bay to create a fresh water reservoir the size of Lake Superior. The water would be drawn off through the major rivers west of the bay: the Moose, Ogochee, Albany, Kenogami, Ramscaw, Attawapiskat and Skvab, each of which would be extensively dammed in order to control water flow and afford a fringe benefit of allowing hydroelectric generation. To the north, along Ontario's portion of Hudson Bay's western shore, a comparable damming of major rivers the Wynask, Severn, Sachigo and Duck would occur. Canals would jo in the northern complex to its southern counterpart by traversing the distance between Trout Lake and the Attawapiskat. From there, the joint flow would be diverted into Lake Nipigon and thence into Lake Superior. The scope of the hydrological engineering involved encompasses all of northern Ontario. A minimum of 50 major dams, including at least 3 megadams, are called FOR if the scheme is to work. More than 250 kilometers of lined canal will be needed, not to mention thousands of kilometers of all-weather road, airports, housing FOR as many as 100,000 workers, scores of pumping facilities, hydroelectric plants, and so on. No cost estimates of what would be required to complete the Grand Project have been released, but a conservative projection might be twice the aggregate expenditure calculated for both James Bay Projects, or about $1.50 billion. Moreover, little has been said with regard to what the environmental consequences of such an extravagant rearrangement of the natural order might be, although, where James Bay destroyed the ecology of an area approximately the size of West Germany, the Grand Project would. 310. The WATER plot in northern Ontario. Flood about 3 times as much territory. The implications for the area's indigenous Ojibwe, Wa Swanipi Cree and Inuit populations are stark. 93. Actually, the grand concept is not new. To the contrary, its origins may be discovered in some of the earliest large-scale water projects in Canada. North of Lake Superior, 2 diversions from the James Bay watershed into the Great Lakes were carried out during WORLDWAR2. The headwaters of the Ogochee River were converted into a lake and now flow into Ambabika Bay on Lake Nipigon. The Long Lake watershed, which formerly drained north via the Kenogami River, was diverted into Lake Superior through the Aquasabon River at T'Respe. The Ogochee diversion was implemented in 1940 to permit Ontario Hydro to increase the capacity of its Niagara River generating plants to meet wartime demand. The purpose of the Long Lake diversion was to supply power to the U.S.-owned Kimberly-Clark paper mill at T'Respe. At the time of these diversions, 31-1. The United States was not yet at war and refused to reduce the quantity of hydropower Ottawa had committed to supply, or to allow Canada to withdraw more than its pre-war share of Niagara River water. 94. Serious planning for realization of something along the lines of the present Grand Project can be traced back at least a quarter century, to October 1, 1965, when, the Prime Minister of Canada and the Premier of Ontario announced that the governments of Canada and Ontario had agreed to undertake a series of coordinated studies on Ontario's northern water resources and related economic developments. Most of the work is being done in 5 river basins draining to Hudson Bay and James Bay. These are the Severn, Wynask, Attawapiskat, Albany, and Moose River basins. 95. A coordinating committee was then formed for purposes of liaison and oversight of investigations to be carried out by agencies of the 2 governments with respect to waters draining into James Bay and Hudson Bay in Ontario, to assess the quantity and quality of water resources for all purposes, to determine present and future requirements for such waters, and to assess alternative possibilities for utilization of such waters locally or elsewhere through diversion. 96. Thereafter, the Federal Surveys and Mapping Branch completed preliminary mapping of a possible diversion route between the Ittawapiskat and Albany rivers. A potential diversion route between Wynosk Lake and the Ittawapiskat River were W. Livy, D. Mollard, and Ripley, Clone, and Leonoff. 99 The U.S. Army Corps of Engineers has also been directly involved at least once, conducting an ice survey during the period 1967 to 69. 100. These agencies, particularly the branches of the WA Resources CO Mission and Energy, Mines, and Resources Department, have steadily collected data on stream flow, snow course, rainfall, water levels, chemical analyses of water, bathymetric contours of lakes and geological mapping. They have also conducted considerable core inspection and hydraulic testing of boreholes drilled along the Albany River, have leveled large areas, and have conducted feasibility studies of alternative diversion routes to those mentioned in the government documents quoted above, and have even gone to the lengths of making anthropological/sociological studies of the likely effects of development upon the region's native peoples. The initial field work in Ontario appears to have begun in 1966, and to have accelerated steadily after 1969. Construction itself had actually begun somewhat earlier, and with predictable results. In 1958, hydro dams flooded almost 1,600 hectares of the White Dog Reserve, damaging trap lines at White Dog and the nearby Grassy Narrows Reserve in northern Ontario. Then, from 1962 to 1970, a pulp mill pumped 9,000 kilograms of mercury into the English Wabigoon River system, poisoning the fish. Dozens of Ojibways at Grassy Narrows who relied on fish as their staple diet, ended up with dangerous levels of mercury in their blood and symptoms of mercury poisoning such as tremors, tunnel vision, impaired hearing, and slow reflexes. For years, politicians assured the Indians that their FERs were exaggerated. The provincial government suppressed the results of the mercury tests. Warning signs were pulled down. But the Indians were eventually forced to stop fishing, and their commercial fishery was wiped out. 102. Alcoholism and crime, which had been minor problems at Grassy Narrows in the early 1960s, soon reached epidemic proportions, observes 313. Analyst Jeffrey York. By the late 1970s, a survey found that 2/3 of the adults on the reserve were heavy drinkers, and half of the children in grade 2 and grade 3 were sniffing gasoline regularly. The suicide rate soared, and 3/4 of all deaths were caused by violence. Not until 1985 were the Ojibways compensated for the destruction of their way of life. The owners of the pulp mill agreed to pay $1.75 million in, while the federal and provincial governments provided $4.92 million, and Ontario Hydro gave $1.5 million to the White Dog Band to compensate for the flooding. 103 But by then it was far too late. NAWAPA. Nawapa, once described by Newsweek magazine as the greatest, most colossal, stupendous, supersplendificent public works project in history, 104 was conceived by the Ralph M. Parsons engineering firm during the 1960s to divert 36 trillion gallons of water from Yukon River in Alaska to 33 states, several Canadian provinces, and northern Mexico. I-05. Under its provisions, the Yukon River, Rocky Mountain Trench, Peace River, Great Bear, Great Slave and Lesser Slave Lakes, Athabasca River, North Saskatchewan River, Fraser River, Nelson River, Qu'Appelle River, Columbia River and Lake Winnipeg, as well as many tributaries, would all be tied together. From Lake Winnipeg, a portion of the proceeds would be channeled into the western end of Lake Superior, the remainder into the dry zone of the United States west of the Mississippi River. As with the Grand Project, there are signs that motions are being made toward fulfillment of the NAWAPA vision. Nawapa takes as its focus the western provinces of British Columbia, Saskatchewan, Alberta, Manitoba, the Yukon, and the Northwest Territories. Beginning in British Columbia, where horror stories concerning the effects of the W.A.C. Bennett Dam and its attendant Columbia River Treaty are well known, a Canadian Broadcasting Corporation television program aired on the night of January 1, 1972, revealed plans to dam the Fraser River. 106 Nothing further was heard on the matter, and it was all but forgotten. This was a mistake. A second dam, completed at Moran Canyon on the Fraser River in 1976, backed up water into a 170-mile lake. Since then, another score of dams have been built along the Columbia River, and 25 more along the Fraser. Another 13 have 314 N.A. VV-.AP.A. been built along the Thompson River, and as many as 30 more are either in progress or planned in the immediate future. 107. The consequences for native people were nothing less than catastrophic, replicating in all essential respects the experience of the Sekani in northern BC when a dozen of their villages were submerged under 80 meters of water behind the Bennett Dam. The federal government transferred the Sekani Reserve to the province. Although the province made arrangements to help the white farmers who would be affected by the flooding, it ignored the 125 families of the Sekani band. The Sekani houses were burned down, the villages bulldozed, and most of the Sekani were dumped onto the territory of another Indian band. In the late 1960s, after several years of misery, they migrated back to Inganaki Point, the only remaining habitable corner of their homeland. Because they did not officially have a reserve, the federal government gave them virtually nothing. They lived in one-room shacks made of logs salvaged. 31.5. From the hydro reservoir and carried buckets of water up a steep hill from the reservoir. The water soon became contaminated with salmonella. 108. It was not until 1987 that, under pressure from the media, a provincial cabinet minister finally consented to even visit Inganika Point. Forced to admit that the living conditions there were and had been for 20 years the worst he'd ever seen in British Columbia, he arranged a morsel of compensation. The province underwrote repairs on the makeshift houses and paid for the drilling of a deep water well. I-09to the east, in the Prairie Provinces, the WINNIPEG Free Press has reported that Manitoba Hydro intends to regulate water levels in Lake Winnipeg as part of its Nelson River Power Development Project, before going ahead with a planned diversion of South Indian Lake. According to CBC filmmaker Dick Bocking, some water will be diverted directly to the United States, and the Kettle Lake Dam and South Indian Lake Hydro Plant will, in combination, produce far more electricity than can possibly be used by Winnipeg. Barring construction of environmentally devastating industries such as the aluminium smelters installed in Quebec, and no such plans have been announced, the excess hydroelectric output is plainly slated for export southward. Because of the expense of the Manitoba endeavour, comparable diversions in Alberta and Saskatchewan, part of the so-called Prime Project, have been postponed, but not abandoned. LLO as in Ontario and Quebec, the impacts of such developments upon native people are already starkly apparent in Manitoba. At Moose Lake and Chemawawin, in the lush Saskatchewan River Delta, once considered to be among the most peaceful and self-sufficient reserves in Canada, Manitoba Hydro's massive Grand Rapids Dam, it required 80 million kilos of concrete, stands 20 meters high and includes dikes extending a dozen kilometers in each direction to create the Earth's largest lake in the entire province, has wrought havoc. At Moose Lake, whose residents received a total of only $1.0,000 compensation, cattle and muskrat ranches were wiped out, the crops and gardens were destroyed, and the supply of moose fell sharp. Y112. Crime and alcoholism, both of which had been virtually non-existent on the reserve in 1960, began to rise dramatically after the flooding occurred in 1964. Elias Martin, a drug and alcoholism counselor for the band, estimated that upwards of 90% of all adults were addicted to one or both by 197R, a symptom of their compulsion to anesthetize themselves against the stress. 316. Anxiety and fear attending the loss of their way of life and consequent destitution. 113. The impact of the flooding was even worse among the Cree people at Keemwaun, who lived nearby on the shores of Cedar Lake. OB serves Jeffrey York.114. Before the Grand Rapids Hydro Dam was built, they enjoyed the same abundant resources as the Moose Lake Band and had a prosperous economy of hunting, trapping and fishing. Alcohol abuse was rare and crime was virtually unknown. There are no apparent community problems, a provincial official reported in 1963. Another official said that the thriving economy was the most striking aspect of the reserve at Cedar Lake. But all that was radically altered by the Grand Rapids Hydro Project and flooding. In the end, nearly the whole reserve disappeared underwater, and the Cree were forced to relocate to a vastly interior site about 60 kilometers southeast, on the opposite shore of Cedar Lake. The federal government made no effort to help the band. Using its powers under the Indian Act, the government simply expropriated the Chemawawin Reserve and transferred the land to the province YS. As a result of the flooding, Cedar Lake was shortly choked with logs and debris, and the water level often fluctuated so that it became dangerous to fish on the lake. The result was a 93% reduction in the Chemawawin's annual fish harvest, while even the remnant was rendered dubious by mercury CO contamination. Their hunting and trapping economies also collapsed as moose and fur-bearing animals disappeared. To top things off, it was shortly discovered that untreated sewage at Easterville had seriously contaminated the band's supply of potable water. 116 by 1966. Even as Manitoba Hydro publicly described the relocation as a huge success, a federal study quietly concluded that it constituted a social disaster, noting that the Crees were desperate, alcohol abuse was spreading rapidly, vandalism had become commonplace, and that children were often neglected. For the first time in the band's history. A decade and a half later, it was reported that some 90% of all Chemawawins were subsisting on welfare and that mental depression had become an endemic condition on the reserve. In 1986, E. Hobbs and Associates, a consulting firm retained to assess the impact of the Grand Rapids project upon the Indians, concluded that there was certainly no evidence that the Keemwaun recovered from the trauma of their move, the loss of their treaty lands and their resource base. 117. Whatever the wider benefits the Grand Rapids Hydro Project may have brought for Manitoba, for the Chemawawin Cree, it has meant the destruction of their way of life. 317. Today, the band has no viable economic base. FEW prospects for the future, a wide range of accelerating social problems and a diminished level of confidence and self-esteem, the inevitable consequence of the decline in the band's efforts since the flooding. 11.8. Sometimes, the results have been even more drastic. In the 1980s, the Cree bands at Cross Lake and Norway House in northern Manitoba, for example, were hit by suicide epidemics after their traditional economy of hunting and fishing was severely damaged by hydro flooding. Because of the hydro projects, water levels in some northern Manitoba lakes and rivers have fluctuated wildly, dropping by as much as 2.5 meters every sol 11. Mare. Weeds, rocks, and mud flats made it almost impossible for the Cree to continue fishing. Hunting and trapping became difficult because thousands of animals were drowned. 119. Pride and self-reliance stripped away. From 1985 to 1987, there were killed in one 8-month period. At the same time, there were as many as 15 suicide attempts each month by the Cree at Norway House. Loss for the first time in centuries, band members realized there is no point in teaching their children the traditions of hunting and fishing. I cannot pass on what was passed on to me, I can't pass it on to my kids, and they won't be able to pass it on to their kids, one band member said. T20. There can be no question that not only corporate but governmental officials were fully aware of the genocidal implications of the hydroprojects before undertaking them. In 1960, it was predicted in a study made by Indian Affairs Canada that construction of the Grand Rapids I.M. would precipitate the economic collapse of the Chemawawin and Moose Lake bands almost as fast as it was completed. Provincial officials were also predicting that the dam's impact on the indigenous economy would, no doubt, be greater than any compensation 121. Later, a senior provincial official admitted that he had seen a tragedy brewing as early as 1962, 2 years before the flooding. An environmental impact study, commissioned by the Manitoba government, confirmed that the flooding would cause serious damage, but its results were kept secret. In a confidential memo, a federal official warned Ottawa that many of the resources from which the people derived a livelihood will be lost or seriously depleted for a number of years, and in some cases, possibly forever. 122. No recommendations were forthcoming in any of these documents as to how such culturally destructive and potentially lethal impacts might be 318. Offset or even significantly mitigated. Moreover, even as Ottawa was transferring title to the reserves for purposes of moving the project forward, all parties sought to restore controversy by directly and deliberately misleading the incipient victims as to the anticipated results. In a letter written in 1964, for instance, Manitoba Premier Duff Roblin assured the anxious Crees that they would in fact be able to earn as good a living as before and, we hope, a better living 123. Small wonder, given the nature and magnitude of such betrayals, that the suicide epidemics at Cross Lake and Norway House were just two examples of the tending trend towards self-annihilation in Native communities. A study of Manitoba suicides from 1971 to 1982 found that the suicide rate for Native teenagers was 11 times higher than the rate among white teenagers. According to the study, Native males were by far the highest risk group in Manitoba 124. For Canada as a whole, the suicide rate for Indians under the age of 25 is about 6 times higher than the rate for non-natives in the same age group. 1/3 of all suicides. Each year, Indians lose almost 5,000 potential years of life because of suicide. As shocking as these figures are, they may be underestimates. Violent deaths account for 36% of all Indian deaths, and a large portion of these are believed to be unreported suicides. Often an apparent suicide is officially recorded as an accident because the victim was intoxicated and the coroner is reluctant to record that the victim took his own life. Many drownings and car crashes may also be hidden suicides. Researchers believe the true rate of Indian suicides may be 12 times the national average. 125. In fact, experts like University of Lethbridge sociologist Menno Bold contend that the suicide rate among Canadian Indians may well be the highest of any group in the world. Bold is joined by University of Manitoba professor Michael Moffat, who argues that the destruction of their traditional culture combines with the absence of any viable replacement induces an endemic sense of despair among Aboriginal youth. 126. It's one thing to say they should find meaning in their lives by struggling to reclaim their homelands and traditions, observes veteran Ojibwe activist Terrence Nelson, but how are they supposed to do that when the homeland itself is under 80 meters of water? What we're talking about here is permanent destruction, both of the environment and of ways of life that go with it, a combination of ecocide and genocide. 127. It is true that, to date, no major water diversion projects have been 319 carried out in either the Yukon or the Northwest Territories, home to traditional Inuits and Dene, who together comprise one of the largest remaining traditional indigenous groups on the planet. It is nonetheless noteworthy that feasibility studies on damming the headwaters of the Yukon River, and assembly of a canal system which would carry its fluids into first the Great Slave and then the Great Bear Lakes, have been conducted by the government and assorted contractors. 128. As with the Grand Project, it seems that only the arrival of an appropriate climate of public opinion in Canada is necessary for NAWAPA to begin this final phase of its transition from drawing board to reality. The future of the North is ours. In 1966, General A.G.L. MacNaughton warned that if plans such as Thames BAF, Grand and NAWAPA were actually effected, jurisdiction and control, although nominally international, would in reality be dominated by RTHE United States, which would thereby acquire a formidable vested interest in the national waters of Canada. It is obvious that if we make a bargain to divert water to the United States, we cannot ever discontinue, or we shall force to compel compliance. He therefore concluded that ideas like those underlying each of the megaprojects represented a monstrous concept, a diabolical thesis. 129. Indeed, even without use of its military power, the United States has proven itself increasingly able to impose its will upon Canada as water diversion has increased since 1970. As has been noted, Quebec has been forced to saddle itself with an astronomical debt load, much of it secretively assumed and virtually all of it held by Wall Street firms, since beginning its pursuit of economic independence at James Bay. This, in turn, has compelled provincial authorities to solicit an influx of productive facilities on terms favorable to the foreign corporations holding the reins rather than to Canada. By such deals, Quebec is locking itself into an almost third-world condition as a supplier of subsidized energy to an enormous, global, extractive industry. 13. During the same year that General MacNaughton issued his warning, the Parsons Company of Los Angeles, author of the NAWAPA Plan, announced that Canada would need to invest a minimum of $40 billion as its part in ending the project. It was noted that it would be necessary to bore 320 row virtually all of this sum in the United States at a nominal interest rate of 8%, or $3.2 billion per year in debt service. The latter figure should be compared to the $4 billion per year Parsons estimated Canada might realize from export of hydroelectricity if NAWAPA were completed. L3L and, of course, inflation and other factors have conspired to drive the figure up by at least 400% over the subsequent quarter century. The minimum price tag which could now be associated with just the Canadian portion of NAWAPA is somewhere around $1.60 billion, with annual debt service of about $1.4 billion. 132 Between James Bay, the Grand Project and NAWAPA, an array of development interests are moving along with plans which would encumber the Canadian public with about a third of $1 trillion in debt, nearly $30 billion yearly in interest alone. This, in the context of a seriously deteriorating world economy and with the bulk of the profits flowing, one way or the other, to points south of the U.S./Canadian border. 133 Yet both Ottawa and the provincial regimes appear to be proceeding, full speed ahead, despite a range of consequences which should long since have become obvious to anyone who cared to examine the matter. History has yet to offer a single instance in which the patterns of debt assumption and external investment which have emerged in Canada turned out to have benefited the host country, either economically or in terms of socio-political self-determination. 134 Environmentally, the prospects are even worse. Jan B. of the Audubon Society has compared James Bay to the Brazilian rainforest in terms of its importance to the ecological equilibrium of the world, placing the James Bay projects in a perspective never hinted at by developers. 135. Quebec is not alone in disturbing this maritime ecosystem. Manitoba and Ontario, the provinces which share the western coasts of James Bay and Hudson Bay, are planning hydroelectric projects which will amplify the impacts of James Bay too. When the dams are built, far more fresh water will flow into James Bay in the winter than it did before, and far less in the spring. How will this affect the algae that grow under ice in the winter and bloom in the spring, and that form one of the bottom layers of a FOOD pyramid whose upper layers include birds, seals, beluga, and in the United States they and their advisors are challenging current energy and economic policies, and are proposing alternatives. 138. In effect, by struggling to defend themselves against the ravages of genocide and ecocide, the indigenous peoples of the Northlands have taken a position which could ultimately save their neighboring colonizers from themselves being colonized by a more powerful neighbor. In doing so, they have taken the sole position which stands to save the vital subarctic ecology for all humanity. Theirs is thus a truly human position, perhaps the only genuinely human position to have emerged from the whole context of controversy and contention surrounding the WA plot, and others are slowly but steadily waking up to the fact. Non-Indians are at last discovering the truth Indians have known, insights about the relationship of humans and nature that native people have been trying to share all along. 139 This is why the Crees and others have gained many supporters, on both sides of the border and around the world. The fundamental difference between the current dispute and that of 20 years ago is the extent to which thoughts and feelings that were dismissed a generation ago as the motley notions of counterculture cranks are now credible. Environmental concerns have moved from the margin towards the mainstream of politics. So, too, has sympathy with native peoples 14-0. In this new and evolving confluence of interest and understanding between Indian 322 and non-Indian lie the seeds, not only of the demise of the water plot itself, but of many comparable enterprises underway in this postmodern age. Herein, perhaps, lies the silver lining to the WA plot's menacing cloud. In catalyzing an apprehension of the natural order antithetical to its own existence, it may well transcend itself, laying the groundwork for a widespread negation of the beliefs, attitudes, and outlooks which ushered it into being in the first place. If so, it will have turned out to be a blessing rather than a curse, the cornerstone of a sustainable and radically better future not only for ourselves, but for all who come after us. Like sand in the wind. The making of an American Indian diaspora in the United States. They are going away. With a visible reluctance which nothing has overcome but the stern necessity they feel impelling them, they have looked their last upon the graves of their sires, the scenes of their youth, and have taken up the slow toilsome march with their household goods among them to their new homes in a strange land. They leave names to many of our rivers, towns, and counties, and so long as our state remains, the Choctaws who once owned most of her soil will be remembered. We told them that we would rather die than leave our lands, but we could not help ourselves. They took us down. Many died on the road. 2 of my children died. After we reached the new land, all my horses died. The water was very bad. All our cattle died, not one was left. I stayed till 158 of my people had died. Then I ran away. Standing Bear, January 1, 1876. In the arena of diaspora studies, the question of whether the field's analytical techniques might be usefully applied to the indigenous population of the United States is seldom raised. In large part, this appears to be due to an unstated presumption on the part of diaspora scholars that because the vast bulk of the native people of the U.S. remain inside the borders of that nation-state, no population dispersal comparable to that experienced by Afro-Americans, Asian Americans, Latinos or, for that matter, Euro-Americans is at issue. Upon even minimal reflection, however, the fallacy embedded at the core of any such premise is quickly revealed. To say that a Cherokee remains essentially at home so long as he resides within the continental territoriality claimed by the U.S. is equivalent to arguing that a Swede displaced to Italy, or a Vietnamese refugee in Korea, would be at home simply because they remain in Europe or Asia. Native Americans, no less than other peoples, can and should be understood as identified with the specific geographical settings by which they came to. 330. Identify themselves as peoples. Mohawks are native to the upstate New York/southern Quebec region, not Florida or California. Chiricahua Apaches are indigenous to southern Arizona and northern Sonora, not Oklahoma or Oregon. The matter is not only cultural, although the dimension of culture is crucially important, but political and economic as well. Struggles by native peoples to retain use and occupancy rights over their traditional territories, and Euro-American efforts to supplant them, comprise the virtual entirety of U.S/Indian relations since the inception of the Republic. All FORUDI of the so-called Indian Wars recorded by the federal government were FOUGHIT over land. 1 On more than 370 separate occasions between 1778 and 1871, the Senate of the United States ratified treaties with one or more indigenous peoples by which the latter ceded portions of its land base to the U.S. In every instance, a fundamental quid pro quo was arrived at. Each indigenous nation formally recognized as such through a treaty ratification was simultaneously acknowledged as retaining a clearly demarcated national homeland within which it might maintain its socio-political cohesion and from which it could draw perpetual sustenance, both spiritually and materially. 2 At least 5 succeeding generations of American Indians FOUGHIT, read and died to preserve their peoples' residency in the portions of North America which had been theirs since time immemorial. In this sense, the fundamental importance they attached to continuing their linkages to these areas seems unquestionable. By the same token, the extent to which their descendants have been dislocated from these defined, or definable, land bases is the extent to which it can be observed that the conditions of diaspora have been imposed upon the population of native North America. In this respect, the situation is so unequivocal that a mere sample of statistics deriving from recent census data will be sufficient to tell the tale. By 1980, nearly half of all federally recognized American Indians lived in off-reservation locales, mostly cities. The largest concentration of indigenous people in the country, 90,689, was in the Los Angeles metro area. 3 By 1990, the proportion of urban-based Indians is estimated to have swelled to approximately 55%. 4. All federally unrecognized Indians, a figure which may run several times that of the approximately 1.9 million the U.S. officially admits still exist within its borders, are effectively landless and scattered everywhere across the country. 5. 331. Texas, the coast of which was once one of the more populous locales for indigenous people, reported a reservation-based Native American population of 859 in 1980.6. The total Indian population of Texas was reported as being 39,740.7. Even if this number included only members of peoples native to the area, it would still represent a reduction from about 1.5 million at the point of first contact with Europeans. A veritable vacuum in terms of American Indian reservations and population is now evidenced in most of the area east of the Mississippi River, another region once densely populated by indigenous people. Delaware, Illinois, Indiana, Kentucky, Maryland, New Hampshire, New Jersey, Ohio, Pennsylvania, Rhode Island, Tennessee, Vermont, Virginia, West Virginia show no reservations at all. 9 The total Indian population reported in Vermont in 1980 was 968. In New Hampshire, the figure is that a greater number of persons indigenous to the North American continent now live in Hawaii, far out in the Pacific Ocean, than in any of these easterly states. To the ways in which such deformities in the distribution of indigenous population in the U.S. have come to pass were anything but natural. To the contrary, the major causative factors have consistently derived from a series of official policies implemented over more than 2 centuries by the federal government of the United States. These have ranged from forced removal during the 1830s, to concentration and compulsory assimilation during the 1880s, to coerced relocation beginning in the late 1940s. Interspersed through it all have been periods of outright liquidation and dissolution, continuing into the present moment. The purpose of this essay is to explore these policies and their effects on the peoples targeted for such exercises in social engineering. The post-revolutionary period. During the period immediately following the American War of Independence, the newly formed United States was in a desperate financial plight. Saw its salvation in the sale to settlers and land companies of western lands lying outside the original 13 colonies. Indeed, the revolution had been forced in significant part in order to negate George Ill's 332. Proclamation of 1763, an edict restricting land acquisition by British sub-JECTS to the area east of the Appalachian Mountains and thereby voiding certain speculative real estate interests held by the U.S. Founding Fathers. During the war, loyalty of rank-and-file soldiers, as well as major creditors, had been maintained through warrants advanced by the Continental Congress with the promise that rebel debts would be retired through issuance of deeds to parcels of Indian land once the decolonization was achieved. 12 A substantial problem for the fledgling republic was that in the immediate aftermath, it possessed neither the legal nor the physical means to carry through on such commitments. In the Treaty of Paris, signed on September 3, 1783, England quit-claimed its rights to all present U.S. territory east of the Mississippi. Contrary to subsequent Americana, this action conveyed no bona fide title to any of the Indian lands lying within the area. 13 Rather, it opened the way for the United States to replace Great Britain as the sole entity entitled under prevailing international law to acquire Indian land in the region through negotiation and purchase. 14 The U.S. already an outlaw state by virtue of its armed rejection of lawful crown authority appears to have been emotionally prepared to seize native property through main force, thereby continuing its initial posture of gross illegality while confronted by the incipient indigenous alliance espoused by Tecumseh in the Ohio River Valley and to the south by the powerful Creek and Cherokee confederations. However, the U.S. FOUND itself militarily stalemated all along its western frontier. 16 The Indian position was considerably reinforced when England went back on certain provisions of the Treaty of Paris, refusing to abandon a line of military installations along the Ohio until the U.S. showed itself willing to comply with minimum standards of international legalism, acknowledging the Indian right in the soil long since recognized under the doctrine of discovery. 17 To the south, Spanish Florida also aligned itself with native nations as a means of holding the rapacious settler population of neighboring Georgia in check. Frustrated, federal authorities had to content themselves with the final dispossession and banishment of such peoples as the Abenaki and Delaware, whose homelands fell within the original colonies, and who had been much weakened by more than a century of warfare to points beyond the 1763 demarcation line. There, these early elements of a U.S. precipitated indigenous diaspora were taken in by stronger 333 nations such as the Ottawa and Shawnee. 19 Meanwhile, George W. Washington's initial vision of a rapid and wholesale expulsion of all Indians east of the Mississippi, expressed in June 1, 1783, was tempered to reflect a more sophisticated process of gradual encroachment explained by General Philip Schuyler of New York in a letter to Congress the following month. As our settlements approach their country, RTHE Indians must, from the scarcity of game, which that approach will induce, retire farther back, and dispose of their lands, unless they dwindle to nothing, as all savages have done. When compelled to live in the vicinity of civilized people, and thus leave us the country without the expense of purchase, trifling as that will probably be. 2. As Washington himself was to put it a short time later, policy and economy point very strongly to the expediency of being on good terms with the Indians, and the propriety of purchasing their lands in preference to attempting to drive, codifying a formal renunciation of what it had been calling its rights of conquest with respect to native peoples. The utmost good faith shall always be observed towards the Indian, their land shall never be taken from them without their consent, and in their property, rights, and liberty, they shall never be invaded or disturbed, but laws founded in justice and humanity shall from time to time be made, for wrongs done to them, and for preserving peace and friendship with them. 23. The era of renouveau. By the early years of the 19th century, the balance of power in North America had begun to shift. To a certain extent, this was due to a burgeoning of the Anglo-American population, a circumstance actively stirred by government policy. In other respects, it was because of an increasing consolidation of the U.S. state and a generation-long erosion of indigenous strength resulting from the factors delineated in Schuyler's policy of gradual expansion. 24 by 1810, the government was ready to resume what Congress 334 described as the speedy provision of the extension of the territories of the United States through means of outright force. 25 already, in 1803, provision had been made through the Louisiana Purchase for the massive displacement of all eastern Indian nations into what was perceived as the vast wasteland west of the Mississippi. 26 The juridical groundwork was laid by the Supreme Court with Chief Justice John Marshall's opinion in Fletcher v. Peck, a decision holding that the title of U.S. citizens to parcels of Indian property might be considered valid even though no Indian consent to cede the land had been obtained. 27 With the defeat of Great Britain in the War of 1812, the subsequent defeat of Tecumseh's Confederation in 1813, and General Andrew Jackson's defeat of the Creek Red Sticks in 1814, the clearing of the East began in earnest. 28 By 1819, the U.S. had wrested eastern Florida from Spain, consummating a process begun in 1810 with assaults upon the western portion of the territory. 29 Simultaneously, the first of a pair of Seminole wars was begun on the Florida Peninsula to subdue an amalgamation of resident Miccosukes, recalcitrant Creek refugees, and runaway chattel slaves naturalized as free citizens of the indigenous nations. 30 In 1823, Joe H. N. Marshall reinforced the embryonic position articulated in Peck with Johnson 1. McIntosh 543, an opinion inverting conventional understandings of indigenous status in international law by holding that U.S. sovereignty superseded that of native nations, even within their own territories. During the same year, President James Monroe promulgated his doctrine professing a unilateral U.S. right to circumscribe the sovereignty all other nations in the hemisphere. 31 In this environment, a tentative policy of Indian removal was already underway by 1824, although not codified as law until the Indian Removal Act was passed in 1830. This was followed by John Marshall's opinions, rendered in Cherokee v. Georgia 1, and Mike J. Ercester v. Georgia 551, that Indians comprised domestic dependent nations, the sovereignty of which was subject to the HR authority of the F. E. Darrell government. 32 At that point, the F. E. Darrell program of physically relocating entire nations of people from their eastern homelands to what was then called the Permanent Indian Territory of Oklahoma west of the Mississippi became full-fledged and enforceable. 33 The primary targets were the prosperous F5 civilized tribes of the Southeast, the Cherokee, Creek, Chickasaw, Choctaw, and Seminole nations. 335. They were rounded up and interned by troops, concentrated in camps until their numbers were sufficient to make efficient their being force marched at bayonet point, typically without adequate food, shelter, or medical attention, often in the dead of winter, as much as 500 miles to their newh lands. 34 There were, of course, still those who attempted to mount a military resistance to what was happening. Some, like the Sauk and Fox nations of Illinois, who toughed what has come to be known as the Black Hawk War against those dispossessing them in 1832, were simply slaughtered en masse. 35 Others, such as the hardcore of Seminoles who mounted the Second War bearing their name in 1835, were forced from the terrain associated with their normal way of life. Once ensconced in forbidding locales like the Everglades, they became for all practical intents and purposes invincible. One group refused to make peace with the U.S. until the early 1960s, but relatively smaller and more diffuse in their demography. 36 In any event, by 1840 removal had been mostly accomplished, with only the smallest, least offensive, and most thoroughly integrated tribes escaping the pressure to clear the eastern half of the continent of its original inhabitants. 37. The results of the policy were always catastrophic for the victims. For instance, of the approximately 17,000 Cherokees subjected to the removal process, about 8,000 died of disease, exposure, and malnutrition along what they called the Trail of Tears 38. In addition, the Choctaws are said to have lost 15% of their population, 6,000 out of 40,000, and the Chickasaw surely suffered severe losses as well. By contrast, the Creeks and Seminoles are said to have suffered about 50% mortality. For the Creeks, this came primarily in the period immediately after Re-11 OVTL, FOR example, of the 100,000 or more who were resettled in 1836–37. An incredible 3,500 died of bilious fever 39. Nor was this the only cost. Like the Seminoles, portions of each of the targeted peoples managed through various means to avoid removal, remaining in their original territories until their existence was once aged and recognized by the U.S. during the 20th century. One consequence was a permanent socio-cultural and geographic fragmentation of formerly cohesive groups, while the bulk of the identified populations of these nations now live in and around Oklahoma. Smaller segments reside on the tiny Eastern Cherokee Reservation in North Carolina, Mississippi Choctaw Reservation in Mississippi, the Miccosukee and Big Cypress, Hollywood and Brighton Seminole Reservations in Florida. An unknown but significant number of Cherokees also went beyond Oklahoma, following their leader, Sequoyah, into Mexico in order to escape the reach of the U.S. Altogether, why this established something of a precedent for other peoples such as the Kickapoos, a small Mexican colony of whom persists to this day. 42 Such dispersal was compounded by the fact that throughout the removal process varying numbers of Indians escaped at various points along the route of march, blending into the surrounding territory and later intermarrying with the incoming settler population. By and large, these people have simply slipped from the historical record, their descendants today inhabiting a long arc of mixed-blood communities extending to northern Georgia and Alabama, through Tennessee and Kentucky, and into the southernmost reaches of Illinois and Missouri. 43 Worse was yet to come. At the outset of the removal era proper, Andrew Jackson, a leading proponent of the policy who had ridden into the White House on the public acclaim deriving from his role as commander of the 1814 massacre of the Red Sticks at Horseshoe Bend and a subsequent slaughter of noncombatants during the First Seminole War, offered a carrot as well as the stick he used to compel tribal cooperation. 44. In 1829, he promised the Creeks that your father has provided a country large enough for all of you, and he advises you to remove to it. There your white brothers will not trouble you, they will have no claim to the land, and you can live upon it, you and all your children, as long as the grass grows or the water runs, in peace and plenty. It will be yours forever. 45. Jackson was, to put it bluntly, lying through his teeth. Even as he spoke, he was aware that the Mississippi, that ostensible border between the U.S. and permanent Indian territory proclaimed by Thomas Jefferson and others, had already been breached by the rapidly consolidating states of Louisiana, Arkansas and Missouri in the south, Iowa, Wisconsin, and Minnesota in the north. 46 Nor could Jackson have been unknowing that his close friend, Senator Thomas Hart Benton of Missouri, had stipulated as early as 1825 that the Rocky Mountains rather than the Mississippi should serve as an everlasting boundary of the U.S. 47 By the time the bulk of removal was completed a decade later, Anglo-American settlement was reaching well into 337. Kansas. Their cousins who had infiltrated the Mexican province of Texas had revolted, proclaimed themselves an independent republic, and were negotiating for statehood. The eyes of empire had also settled on all of Mexico north of the Rio Grande, and the British portion of Oregon as well. 48 Peoples such as the Shawnee and Potawatomi, Lenni Lenape and Wyandotte, Peoria, Sac, Fox, and Kickapoo, already removed from their eastern homelands, were again compulsorily relocated as the Western Indian Territory was steadily reduced in size. 49 This time, they were mostly shifted southward into an area eventually conforming to the boundaries of the present state of Oklahoma. Ultimately, 67 separate nations, only 6 of them in truly indigenous to the land at issue, were forced into this relatively small dumping ground. 50 when Oklahoma, too, became a state in 1907, most of the territorial compartments reserved for the various Indian groups were simply dissolved. Today, although Oklahoma continentis to FFPNRT that TRNRL lar, est native population of ANV state, only the Osage retain a reserved land base which is nominally their own. 51. Subjugation in the West. The U.S. winning of the West, which began around 1850, that is, immediately after the northern half of Mexico was taken in a brief war of conquest, was, if anything, more brutal than the clearing of the East. 52 Most of the U.S. wars against native people were waged during the following 35 years under what has been termed an official rhetoric of extermination. 53. The means employed in militarily subjugating the indigenous nations of California and southern Oregon, the Great Plains, Great Basin, and northern region of the Sonora Desert devolved upon a lengthy series of wholesale massacres. Representative of these are the slaughter of about 150 Lakotas at Blue River in 1854, some 500 Shoshones at Bear River in 1863, as many as 250 Cheyennes and Arapahoes at Sand Creek in 1864, P.E. Raps 300 Cheyennes on the Washita River in 1868, 175 Piegan non-combatants at the Marias River in 1870, and at least 100 Cheyennes at Camp Robinson in 1878. The parade of official atrocities was capped off by the butchery of another 300 unarmed Lakotas at Wounded Knee in 1890.54 Other means employed by the government to reduce its native oppo. 338. To a state of what it hoped would be object subordination included the four-year internment of the entire Navajo Nation in a concentration camp at the Bosque Redondo, outside Fort Sumner, New Mexico, beginning in 1864. The Dine, who had been force marched in what they called the Long Walk, a 300-mile trek from their Arizona homeland. They were then held under abysmal conditions, with neither adequate food nor shelter, and died like flies. Approximately half had perished before their release in 1868.55. Similarly, if less dramatically, food supplies were cut off to the Lakota Nation in 1877. Militarily defeated the year before, the Lakotas were being held under army guard at the time until starvation compelled its leaders to cede the Black Hills area to the U.S. 56 The assassination of resistance leaders such as the Lakotas Crazy Horse and Sitting Bull was also a commonly used technique. 57 Other recalcitrant figures like Geronimo and Satanta were separated from their people by being imprisoned in remote facilities like Fort Marion, Florida. 58 In addition to these official actions, which the U.S. Census Bureau acknowledged in an 1894 summary as having caused a minimum of 45,000 native deaths, there was an even greater attrition resulting from what were described as individual affairs. 59. These took the form of Anglo-American citizens at large killing Indians, often systematically, under a variety of quasi-official circumstances. In Dakota Territory, for example, a $200 bounty for Indian scalps was paid in the territorial capital of Yankton during the 1860s. The local military commander, General Alfred Sully, is known to have privately contracted for a pair of Lakota skulls with which to adorn the city. 60 In Texas, first as a republic and then as a state, authorities also placed a bounty upon the scalp of any Indian brought into a government office, man, woman, or child, no matter what tribe. No questions asked. 61. In California and Oregon, the enormous decrease from about 250,000 to less than 20,000 due chiefly to the cruelties and wholesale massacres perpetrated by the miners and early settlers. 62. Much of the killing in California and southern Oregon Territory resulted, directly and indirectly, from the discovery of gold in 1848 and the subsequent influx of miners and settlers. Newspaper accounts document the atrocities, as do oral histories of the California Indians today. It was not uncommon for small groups or villages to be attacked by immigrants and virtually wiped out overnight. 63. It has been estimated that Indian deaths resulting from this sort of did 339. Rate violence may have run as high as 500,000 by 1890.64. All told, the indigenous population of the continental United States, which may still have been as great as 2 million when the country was founded, had been reduced to well under 250,000 by 1900.65. As the noted demographer Sherburne F. Cook has observed, the record speaks for itself. No further commentary is necessary. 66. Under these conditions, the U.S. was able to shoo native peoples around at will. The northern Cheyennes and closely allied Arapahoes, for instance, were shipped from their traditional territory in Montana's Powder River watershed to the reservation of their southern cousins in Oklahoma in 1877. After the Cheyenne remnants, more than a third of whom had died in barely a year of malaria and other diseases endemic to this alien environment, made a desperate attempt to return home in 1878, they were granted a reservation in the North Country. But not before the bulk of them had HFFN kill FCL High Army troops. Moreover, they were permanently separated from the Arapahoes, who were temporarily assigned to the Wind River Reservation of their hereditary enemies, the Shoshone, in Wyoming. 67. A faction of the Chiricahua Apaches who showed signs of continued hostility to U.S. domination by the 1880s were yanked from their habitat in southern Arizona and resettled around Fort Sill, Oklahoma. 68. Hinmatan Yalatkit of the Nez Perce and other leaders of that people's legendary attempt to escape the army and flee to Canada were also deposed in Oklahoma. From the Idaho Valley they'd height to retain. 69. Most of the Santee Dakotas of Minnesota's woodlands ended up on the wind-swept plains of Nebraska, while a handful of their relatives remained behind on tiny plots which are now called the Upper and Lower Sioux Reservations. 70. A portion of the Oneidas, who had height on the side of the rebels during the Revolution, were moved to a small reservation near Green Bay, Wisconsin. 71. An even smaller reserve was provided in the same area for residual elements of Connecticut's Mohegans, and other peoples, all of them lumped together under the heading Stockbridge-Muncie Indy. Answer 72. On and on it went. Allotment and assimilation. With the native ability to militarily resist U.S. territorial ambitions finally quelled, the government moved first to structurally negate any meaningful residue of national status on the part of indigenous peoples, and then 340. To dissolve them altogether. The opening round of this drive came in 1871, with the attachment of a rider to the annual Congressional Appropriations Act suspending any further treaty making with Indians. This was followed, in 1885, with passage of the Major Crimes Act, extending U.S.J jurisdiction directly over reserved Indian territories for the first time. Beginning with 7 felonies delineated in the initial statutory language, and combined with the Supreme Court's opinion in U.S. v. Kama that Congress possessed a unilateral and incontrovertible right to exercise its authority over Indians as it saw fit, the 1885 Act opened the door to subsequent passage of the more than 5,000 federal laws presently regulating every aspect of reservation life and affairs. 73. In 1887, Congress passed the General Allotment Act, a measure designed expressly to destroy what was left of basic indigenous socio-economic cohesion by eradicating traditional systems of collective landholding. Under provision of the statute, each Indian identified as such by demonstrating 1/2 or more degree of Indian blood was to be issued an individual deed to a specific parcel of land. 160 acres per family head, 80 acres per orphan or single person over 18 years of age, and 40 acres per dependent child within existing reservation boundaries. Each Indian was required to accept U.S. citizenship in order to receive his or her allotment. Those who refused, such as a substantial segment of the Cherokee full-blood population, were left landless. 74. Generally speaking, those of mixed ancestry whose blood quantum fell below the required level were summarily excluded from receiving allotments. In most cases, the requirement was construed by officials as meaning that an applicant's blood had to have accrued from a single people, persons whose cumulative blood quantum derived from intermarriage between several native peoples were thus often excluded as well. In other instances, arbitrary geographic criteria were also employed. All Cherokees, Creeks, and Choctaws, living in Arkansas, for example, were not only excluded from allotment, but permanently denied recognition as members of their respective nations as well. 75 Once all eligible Indians had been assigned their allotments within a given reservation, all of them from the worst land available therein, the remainder of the reserved territory was declared surplus and open to non-Indian homesteaders, corporate acquisition and conversion into federal or state parks and forests. 76. 341. Under the various allotment programs, the most valuable land was the first to go. Settlers went after the rich grasslands of Kansas, Nebraska, and the Dakotas, the dense black soil forests of Minnesota and Wisconsin, and the wealthy oil and gas lands of Oklahoma. In 1887, for example, the Sisseton Sioux of South Dakota owned 918,000 acres of rich virgin land on their reservation. But since there were only 2,000 of them, allotment left more than 600,000 acres for European American settlers. The Chippewas of Minnesota lost their rich timber lands. Once each member had claimed land, the government leased the rest to timber corporations. The Colvilles of northeastern Washington lost their lands to cattlemen, who fraudulently claimed mineral rights there. In Montana and Wyoming the Crows lost more than 2 million acres, and the Nez Perces had to cede communal grazing ranges in Idaho. All 67 of the tribes in Indian Territory underwent allotment. On the Flathead Reservation, which included Flatheads, Pend Oriles, Kootenays, and Spokanes, the federal government opened 1 million acres to settlers. A similar story prevailed throughout the country. 77. By the time the allotment process had run its course in 1930, the RPI-SIL 1P of land holdings in the U.S. had been reduced from approximately 150 million acres to a little over 50 million. 78 of this, more than two-thirds consisted of arid or semi-arid terrain deemed useless for agriculture, grazing, or other productive purposes. The remaining one-third had been leased at extraordinarily low rates to non-Indian farmers and ranchers by local Indian agents exercising almost dictatorial powers over remaining reservation property. 79 Indians across the country were left in a state of extreme destitution as a result of allotment and attendant leasing practices. WORSE, the situation was guaranteed to be exacerbated over succeeding generations insofar as what was left of the reservation land base, already insufficient to support its occupants at a level of mere subsistence, could be seen to become steadily more so as the native population recovered from the genocide perpetrated against it during the 19th century. 80 A concomitant of allotment was thus an absolute certainty that ever-increasing numbers of Indians would be forced from what remained nominally their own land during the 20th century, dispersed into the vastly more numerous American society at large. There, it was predictable that they would be digested, disappearing once and for all as anything distinctly Indian in terms of socio-cultural, political, or even racial identity. The record shows that such outcomes were anything but unintentional. The purpose of all this was assimilation, as federal policymakers described their purpose, or to put the matter more unabashedly, to bring about the destruction and 342. Disappearance of American Indian peoples as such. In the words of Francis E. Loop, Commissioner of Indian Affairs from 1905 through 1909, the Allotment Act in particular should be viewed as a mighty pulverizing engine for breaking up the tribal mass which stood in the way of complete Euro-American hegemony in North America. Or, to quote Indian Commissioner Charles Burke a decade later, T is not desirable or consistent with the general welfare to promote tribal characteristics and organization. 81. The official stance was consecrated in the Supreme Court's determination in its 1903 Lone Wolf v. Hitchcock opinion extended from John Marshall's domestic dependent nation thesis of the early 1830s that the U.S. possessed plenary power over all matters involving Indian affairs. In part, This meant the federal government was unilaterally assigning itself perpetual trust prerogatives to administer or dispose of native assets, whether these were vested in land, minerals, cash, or any other FROM, regardless of Indian needs or desires. 82 Congress then consolidated its position with passage of the 1906 Burke Act, designating the Secretary of Interior as permanent trustee over Indian country. In 1924, a number of loose ends were cleaned up with passage of the Indian Citizenship Act imposing U.S. citizenship upon all native people who had not otherwise been naturalized. The law was applied across the board to all Indians, whether they desired citizenship or not, and thus included those who had foregone allotments rather than accepted. 83 Meanwhile, the more physical dimensions of assimilationist policy were coupled to a process of ideological conditioning designed to render native children susceptible to dislocation and absorption by the dominant society. In the main, this assumed the FORM of a compulsory boarding school system administered by the Interior Department's Bureau of Indian Affairs, wherein large numbers of indigenous children were taken, often forcibly, to facilities remote from their families and communities. Once there, the youngsters were prevented from speaking their languages, practicing their religions, wearing their customary clothing or wearing their hair in traditional fashion, or in any other way overtly associating themselves with their own cultures and traditions. Instead, they were indoctrinated typically for a decade or more in Christian dogma and European values such as the work ethic. During the summers, they were frequently farmed out to Euro-American foster homes where they were further steeped in the dominant society's views of their peoples and themselves. 83. 343. Attendance was made compulsory. The agent was made responsible for keeping the schools filled, by persuasion if possible, by withholding rations and annuities from the parents, and by other means if necessary. Who were guilty of misbehavior might either receive corporal punishment or be imprisoned in the guardhouse. A sincere effort was made to develop the type of school that would destroy tribal ways. 84. The intention of this was, according to the perpetrators and many of their victims alike, to create generations of American Indian youth who functioned intellectually as little white people, facilitating the rapid dissolution of traditional native cultures desired by federal policymakers. 85 In combination with a program in which native children were put out for wholesale adoption by Euro-American families, the effect upon indigenous peoples was devastating. 86 The systematic transfer of children not only served to accelerate the outflow of Indians from reservation and reservation jade CCLLT 5 Tl 1 GS. But the Chuflo one of IL1 individuals 111 dolly condition to conduct themselves as non-Indians escalated the rate at which many native societies unraveled within the reservation contexts themselves. 87 The effects of the government's allotment and assimilation programs are reflected in the demographic shifts evidenced throughout Indian country FROM 1910 through 1950. In the FORM year, only 0.4% of all identified Indians lived in urban locales. By 1930, the total had grown to 9%. As of 1950, the total had grown to 1.34%. Simultaneously, the displacement of native people FROM reservations to off-reservation rural areas was continuing apace. 88 In 1900, this involved only about 3.5% of all Indians. By 1930, the total had swelled to around 1.25% and, by 1950, it had reached nearly 18%. 89 Hence, in the latter year, nearly one-third of the federally recognized Indians in the United States had been dispersed to locales other than those the government had defined as being theirs. Reorganization and colonization. It is likely, all things being equal, that the Indian policies with which the United States ushered in the 20th century would have led inexorably to a complete eradication of the reservation system and corresponding disappearance of American Indians as distinct peoples by some point around 1950. There can be no question but that such a final consolidation of its 344 Internal land base would have complemented the phase of transoceanic expansionism into which the US entered quite unabashedly during the 1890s. That things did not follow this course seems mainly due to a pair of ironies, one geological and the other unwittingly embedded in the bizarre status of quasi sovereignty increasingly imposed upon native nations by federal jurists and policy makers over the preceding 100 years. As regards the first of these twin twists off a TE, authorities were becoming increasingly aware by the late 1920s that the worthless residue of territory to which indigenous people were consigned was turning out to be extraordinarily endowed with mineral wealth. Already, in 1921, an exploratory team from Standard Oil had come upon what it took to be substantial fossil fuel deposits on the Navajo Reservation. 91 During the next 3 decades, it would be discovered that just how great a proportion of U.S. domestic resources lay within American Indian reservations. Western reservations in particular possess vast amounts of coal, oil, shale oil, natural gas, timber, and uranium. More than 40% of the national reserves of low-sulfur, strippable coal, 80% of the nation's uranium reserves, and billions of barrels of shale oil exist on reservation land. On the 1 million-acre Navajo Reservation, there are approximately 100 million barrels of oil, 25 trillion cubic feet of natural gas, 80 million pounds of uranium, and 50 billion tons of coal. The 440,000-acre Northern Cheyenne Reservation in Montana sits atop a 62-thick layer of coal. In New Mexico, geologists estimate that the Jicarilla Apache Reservation possesses 2 trillion cubic feet of natural gas and as much as 154 million barrels of oil. 92. This led directly to the second quirk. The more sophisticated federal officials, even then experiencing the results of opening up Oklahoma's lush oil fields to unrestrained corporate competition, realized the extent of the disequilibriums and inefficiencies involved in this line of action when weighed against the longer-term needs of U.S. industrial development. 93 Only by retaining its trust authority over reservation assets would the government be in a continuing position to dictate which resources would be exploited, in what quantities, by whom, at what cost, and for what purpose, allowing the North American political economy to evolve in ways preferred by the country's financial elite. 94 Consequently, it was quickly perceived as necessary that both Indians and Indian country be preserved, at least to some extent, as a facade behind which the socialistic process of central economic planning might occur. For the scenario to work in practice, it was vital that the reservations 345 be made to appear self-governing enough to exempt themselves from the usual requirements of the U.S. free market system whenever this might be convenient to their federal guardians. On the other hand, they could never become independent or autonomous enough to assume control over their own economic destinies, asserting demands that equitable royalty rates be paid for the extraction of its ores, for example, or that profiting corporations underwrite the expense of environmental cleanup once mining operations had been concluded. 95 In effect, the idea was that many indigenous nations should be maintained as outright internal colonies of the United States rather than being liquidated out of hand. 96 All that was needed to accomplish this was the creation of a mechanism through which the illusion of limited on self-rule might be extended. The vehicle for this purpose materialized in 1934, with passage of the Indian Reorganization Act, or IRA, as it is commonly known. Under provision of this statute, the traditional governing bodies of most indigenous nations were supplanted by tribal councils, the structure of which were devised in Washington, N.C. Functioning within parameters of formal constitutions written by BIA officials. 97 A democratic veneer was maintained by staging a referendum on each reservation prior to its being reorganized, but federal authorities simply manipulated the outcomes to achieve the desired results. 98 The newly installed IRA councils were patterned much more closely upon the model of corporate boards than of governments, and possessed little power other than to sign off on business agreements. Even at that, they were completely and voluntarily subordinated to U.S. interests, all decisions of any consequence rendered by these tribal councils were made sub-ject to the approval of the Secretary of Interior or his delegate, the Commissioner of Indian Affairs 99. One entirely predictable result of this arrangement has been that an inordinate amount of mining, particularly that related to energy development, has occurred on Indian reservations since the late mid to late 1940s. Virtually all uranium mining and milling during the life of the U.S. Atomic Energy Commission's ore buying program occurred on reservation land. Anaconda's Jackpile Mine, located at the Laguna Pueblo in New Mexico, was the largest open-pit uranium extraction operation in the world until it was phased out in 1979. 100 every year, enough power is generated by Arizona's Four Corners power plant alone, every bit of it. 346. FROM coal mined at Black Mesa, on the Navajo Reservation to light the lights of Tucson and Phoenix for 2 decades, and present plans include a four-fold expansion of Navajo coal production. LOL. Throughout the West, the story is the same. On the face of it, the sheer volume of resource development in Indian country over the past half-century should, even under disadvantageous terms, have translated into some sort of material improvement in the lot of indigenous people. Yet the mining leases offered to selected corporations by the BIA in behalf of their native wards and duly endorsed by the IRA councils have consistently paid such a meager fraction of prevailing market royalty rates that no such advancement has been discernible. Probably the best terms were those obtained by the Navajo Nation in 1976, a contract paying a royalty of 55 cents per ton FOR coal. This amounted to 8% of market price at a time when Interior Secretary Cecil Andrus admitted the minimum rate paid FOR coal mined in off-reservation settings was 1 to 5%. 102 simultaneously, a 1.75 cents per ton royalty was being paid FOR coal on the Crow Reservation in Montana, a figure which was raised to 40 cents, less than half the market rate, only after years of haggling. Low 3 What are at issue here are not profits, but the sort of super profits usually associated with U.S. domination of economies in Latin America. Low 4 Nor has the federally coordinated corporate exploitation of the reservations translated into wage income for Indians. As of 1989, the government's own data indicated that reservation unemployment nationwide still hovered in the mid-60th percentile, with some locales persistently running in the 90th. LOS most steady jobs involved administering or enforcing the federal order, reservation by reservation. Such business-related employment as existed tended to be temporary, menial, and paid the minimum wage, a matter quite reflective of the sort of transient, extractive industry which brings its cadre of permanent, skilled labor with it. The BIA had encouraged to set up shop in Indian country. I06 edition Ally, the impact of extensive mining and associated activities had done much to disrupt the basis for possible continuation of traditional self-sufficiency occupations, destroying considerable acreage which held potential as grazing or subsistence garden plots. 107 In this sense, U.S. governmental and corporate activities have underdeveloped native North America in classic fashion. LOS overall, according to a federal study completed in 1988, reservation 347 based Indians experienced every indice of extreme impoverishment, by FAR the lowest annual and lifetime incomes of any North American population group, highest rate of infant mortality, highest rates of death from plague disease, malnutrition and exposure, highest rate of teen suicide, and so on. The average life expectancy of a reservation-based native American males is 44.6 years, that of females about 3 years 10 Enger. 109 The situation is much more indicative of a third world context than of rural areas in a country that claims to be the world's most advanced industrial state. Indeed, the poignant observation of many Latinos regarding their relationship to the U.S., that your wealth is our poverty, is as appropriate to the archipelago of Indian reservations in North America itself as it is to the South American continent. By any estimation, The open veins of Native America created by the IRA have been an incalculable boon to the maturation of the U.S. economy, while Indians continue to pay the price by living in the most grinding sort of poverty and their is worse. One of the means used by the government to maximize corporate profits in Indian country over the years, again rubber stamped by the IRA councils, has been to omit clauses requiring corporate reclamation of mined lands from leasing instruments. Similarly, the cost of doing business on reservations has been pared to the bone by simply waiving environmental protection standards in most instances, while such practices have spawned ecological catastrophe in many locales. As the impact of the Four Corners plant, one of a dozen coal-fired electrical generation facilities currently online on the Navajo reservation, has been described elsewhere. The 5 units of the 2,075 megawatt power plant has been churning out city-bound electricity and local pollution since 1969. The plant burns 10 tons of coal per minute, 5 million tons per year, spewing 300 tons of fly ash and other waste particulates into the air each day. The black cloud hangs over 10,000 acres of the once pristine San Juan River Valley. The deadly plume was the only visible evidence of human enterprise as seen from the Gemini 1-2 satellite, which photographed the Earth from ISO miles in space. Less visible, but equally devastating, is the fact that since 1968 the coal mining operations and power plant requirements have been extracting 2,700 gallons from the Black Mesa water table each minute, 6 million gallons per year, causing extreme desertification of the area, and even the sinking of some ground by as much as 12 FECTL-12. Corporations engaged in uranium mining and milling on the Navajo Reservation and At Laguna were also absolved by the BIAOF responsibility for cleaning up upon completion of their endeavors, with the result that 348 hundreds of tailings piles were simply abandoned during the 1970s and 80s. 1L3A fine sand retaining about 75% of the radioactive content of the original ore. The tailings constitute a massive source of windblown carcinogenic/mutagenic contaminants affecting all persons and livestock residing within a wide radius of each pile. 114 Both ground and surface water has also been heavily contaminated with radioactive byproducts throughout the Four Corners region. 115 In the Black Hills region, the situation is much the same. 116 At its Hanford Nuclear Weapons facility, located near the Yakima Reservation in Washington state, the AEC itself secretly discharged some 440 billion gallons of plutonium, strontium, cesium, tritium and other high-level radioactive contaminants into the local aquifer between 1955 and 1989. 117 Given that the half-life of the substances involved is as long as 250,000 years, the magnitude of the disaster inflicted upon native North America by IRA colonialism should not be underestimated. The Los Alamos National Scientific Laboratory observed in its February 1, 1978 mini-report that the only solution its staff could conceive to the problems presented by windblown radioactive contaminants would be to ozone the land into uranium mining and milling districts so as to forbid human habitation. Similarly, a National Academy of Science report states bluntly that cannot be done in areas with less than 10 inches of rainfall a year. The rainfall over most of the Navajo Nation involved were the comparatively large and wealthy Menominee of Wisconsin and the Klamath of Oregon, both owners of extensive timber resources. Also passed were acts to terminate the Indians of Western Oregon, small Paiute bands. 350 in Utah, and the mixed bloods of the Uinta and Ouray reservations. Approved, too, was legislation to transfer administrative responsibility for the Alabama and Coushatta Indians to the state of Texas. Early in the first session of the 84th Congress, bills were submitted to Wyandotte, Ottawa, and Peoria of Oklahoma. These were enacted early in August of 1956, a month after passage of legislation directing the Colville Confederated Tribes of Washington to come up with a termination plan of their own. During the second administration of President Dwight D. Eisenhower, Congress enacted 3 termination bills relating to the Choctaw of Oklahoma, for whom the termination process was never completed, the Catawba of South Carolina, and the Indians of the Southern California Rancherias. 124. It is instructive that the man chosen to implement the policy was Dillon S. Meyer, an Indian commissioner whose only apparent job qualification was in having headed up the internment program targeting Japanese Americans during the Second WORLDWAR. 125 in total, 109 indigenous nations encompassing more than 35,000 people were terminated before the liquidation process had run its course during the early 1960s. 126 only a handful, like the Menominee and the Siletz of Oregon, were ever reinstated. 127 suddenly landless, mostly poor and largely unemployed, those who were not mostly scattered like sand in the wind. 128 even as they went, they were joined by a rapidly swelling exodus of people from unterminated reservations, a circumstance stirred by yet another federal program. Passed in 1956, the Relocation Act was extended in the face of a steady diminishment throughout the first half of the decade in federal allocations to provide assistance to people living on reservations. The statute provided funding to underwrite the expenses of any Indian agreeing to move to an urban area, establish a residence, and undergo a brief period of job training. The quid pro quo was that each person applying for such relocation was required to sign an agreement that he would never return to his or her reservation to live. It was also specified that all federal support would be withdrawn after relocates had spent a short period, often no more than 6 weeks, adjusting to city life. 129 Under the conditions of near starvation on many reservations, there were many takers, nearly 3,500 people signed up to move to places like Los Angeles, Minneapolis, San Francisco, Chicago, Denver, Phoenix, Seattle, and Boston during the period 1957-1959 alone, although there was ample early indication that relocation was bearing disastrous fruit. Those who underwent it, all that was happening was that relocates were exchanging the familiar squalor of reservation life for that of 351. The alien Indian ghettos that shortly emerged in most major cities. The government accelerated the program during the 1960s. Under the impact of termination and relocation during the 50s, the proportion of native people who had been urbanized rose dramatically, from 13.5% at the beginning of the decade to 27.9% at the end. During the 60s, relocation alone drove the figure upwards to 44.5%. During the 1970s, as the program began to be phased out, the rate of Indian urbanization decreased sharply, with the result that the proportion had risen to only 9% by 1980. 131 Even without a formal federal relocation effort on a national scale, the momentum of what had been set in motion over an entire generation carried the number into the mid-50th percentile by 1990, and there is no firm indication the trend is abating. 132 Despite much protestation to the contrary, those who migrated to the cities under the auspices of termination and relocation have already begun to join in the legions of others. No longer recognized as Indians even by other Indians, who were previously discarded and forgotten along the Tortuous route from 1776 to the present. 133 Cut off irrevocably from the centers of their socio-cultural existence, they have increasingly adopted arbitrary and abstract methods to signify their Indianness. Federally sanctioned certificates of tribal enrollment have come to replace tangible participation in the political life of their nations as emblems of membership. Federally issued certificates of degree of Indian blood have replaced discernible commitment to Indian interests as the ultimate determinant of identity. 134 In the end, by embracing such standards, Indians are left knowing no more of being Indian than do non-Indians. The process is a cultural form of what, in the physical arena, has been termed a Genocide. 135. Looking ahead. The Indian policies undertaken by the United States during the 2 centuries since its inception appear on the surface to have been varied, even at times contradictory. Openly genocidal at times, they have more often been garbed, however thinly, in the attire of humanitarianism. In FACT, as the matter was put by Alexis de Tocqueville, the great French commentator on the early American experience, it would occasionally have been impossible to destroy men with more respect to the laws of humanity. 136. Always, however, there was an underlying consistency in the sentiments which begot. 352. Policy, to bring about the total dispossession and disappearance of North America's indigenous population. It was this fundamental coherency in U.S. aims, invariably denied by responsible scholars and officials alike, which caused Adolf Hitler to ground his own notions of Lebensraumpolitik in the U.S. Example. 137. Neither Spain nor Britain should be the models of German expansion, but the Nordics of North America, who had ruthlessly pushed aside an inferior race to win for themselves soil and territory. For the future to undertake this essential task, sometimes difficult, always cruel. This was Heider's version of the white man's burden. 138. As early as 1784, a British observer remarked that the intent of the fledgling United States with regard to American Indians was that of extirpating them totally from the face of the earth, men, women, and children. 139. In 1825, Secretary of State Henry Clay opined that U.S. Indian policy should be predicated in a presumption that the Indian race was destined to extinction in the face of persistent expansion by superior Anglo-Saxon civilization. 14. 0. During the 1870s, General of the Army Phil Sheridan is known to have called repeatedly the FOR complete extermination of targeted native groups as a means of making the West safe FOR repopulation by Euro-Americans. 141. Subsequent assimilationists demanded the disappearance of any survivors through cultural and genetic absorption by their conquerors. 142. Well into the 20th century, Euro-America as a whole typically referred often hopefully to indigenous people as the vanishing race, decimated and ultimately subsumed by the far greater number of invaders who had moved in upon their land. 143. Many of the worst U.S. practices associated with these sensibilities have long since been suspended. Yet, large-scale and deliberate dislocation of native people from their land is anything but an historical relic. Probably the most prominent current example is that of the Big Mountain Dine, perhaps the largest remaining enclave of traditionally oriented Indians in the United States. Situated astride an estimated 24 billion tons of the most accessible low-sulfur coal in North America, the entire 13,000 person population of the Big Mountain area is even now being forcibly expelled to make way for the Peabody Coal Company's massive shovels. There being no place left on the remainder of the Navajo reservation in which to accommodate their sheep-herding way of life, the refugees, many of them elderly, are being settled in off-reservation towns like Flagstaff, Arizona. 144. Some have been sent to Phoenix. 353. Denver, and Los Angeles. All suffer extreme trauma and other maladies resulting from the destruction of their community and consequent transition. 145. Another salient illustration is that of the Eastern Shoshone. Mostly resident to a vast expanse of the Nevada desert secured by the ancestors in the 1863 Treaty of Ruby Valley, the Shoshones have suffered the fate of becoming the most bombed nation on Earth by virtue of the U.S. having located the majority of its nuclear weapons testing facilities in the southern portion of their homeland since 1950. During the late 70s, despite its being unable to demonstrate that it had ever acquired valid title to the territory the Shoshones call New Segovia, the government began to move into the northern area as well, stating an intent to construct the MX missile system there. While the MX plan has by now been dropped, the Shoshones are still being pushed off their land, freeing it for use in such endeavors as NLLCLELRW Saint CLLLMPS like THEONE recently open Eclat Yul CCLM Altland 146 in Alaska, where nearly 200 indigenous peoples were instantly converted into village corporations by the 1971 Alaska Native Claims Settlement Act. There is a distinct possibility that the entire native population of about 22,000 will be displaced by the demands of tourism, North Slope oil development, and other developmental enterprises by some point early in the 21st century. Already, their land base has been constricted to a complex of tiny townships and their traditional economy mostly eradicated by the impacts of commercial fishing, whaling, and sealing, as well as the effects of increasing Arctic industrialization on regional caribou herds and other game animals. 147 Moreover, there is a plan apparently conceived in all seriousness to divert the waterflow of the Yukon River southward all the way to the Rio Grande, an expedient to supporting continued non-Indian population growth in the arid regions of the lower F-Rudiate states and creating the agribusiness complex in the northern Mexican provinces of Sonora and Chihuahua envisioned in NAFTA. 148 It seems certain that no traditional indigenous society can be expected to stand up against such an environmental onslaught. Eventually, if such processes are allowed to run their course, the probability is that a final solution of the Indian question will be achieved. The key to this will rest, not in an official return to the pattern of 19th century massacres or emergence of some Auschwitz-style extermination center, but in the erosion of socio-cultural integrity and confusion of 354. Identity affecting any people subjected to conditions of diaspora. Like water flowing from a leaking bucket, the last self-consciously Indian people will pass into oblivion silently, unnoticed and unremarked. The deaths of cultures destroyed by such means usually occurs in this fashion, with a faint whimper rather than resistance and screams of agony. Part 4, An Alternative. This time I almost wanted to believe you when you said it would be alright. You wanted to end the suffering, and the deliberateness of the wrongs were only in my imagination. This time I almost wanted to believe you when you implied the times of sorrow were buried in the past. Never would we have to worry about shadows and memories clinging and draining. This time I almost wanted to believe you when you spoke of peace and love and caring and duty and God and destiny, but somehow the death in your eyes. From our souls. And your bombs and your taxes and your greed told me this time I cannot afford to believe you. The strength. John Trudell from Living in Reality. I am indigenist. Notes on the ideology of the Fourth World. The growth of ethnic consciousness and the consequent mobilization of Indian communities in the Western Hemisphere since the early 1960s have been welcomed neither by government forces nor by opposition parties and revolutionary movements. The Indian question has been an almost forbidden subject of debate throughout the entire political spectrum, although racism, discrimination, and exploitation are roundly denounced on all sides. Roxanne Dunbar Ortiz Indians QFTHE Americas. V. Very often in my writings and lectures, I have identified myself as being indigenist in outlook. By this, I mean that I am one who not only takes the rights of indigenous peoples as the highest priority of my political life, but who draws upon the traditions, the bodies of knowledge and corresponding codes of value evolved over many thousands of years by native peoples the world over. This is the basis upon which I not only advance critiques of, but conceptualize alternatives to the present social, political, economic, and philosophical status quo. In turn, this gives shape not only to the sorts of goals and objectives I pursue, but the kinds of strategy and tactics I advocate, the variety of struggles I tend to support, the nature of the alliances I am inclined to enter into, and so on. Let me say, before I go any further, that I am hardly unique or alone in adopting this perspective. It is a complex of ideas, sentiments, and understandings which motivates the whole of the American Indian movement, broadly defined, here in North America. This is true whether you call it AIM, or Indians of all tribes, the W.A. Ryers Society, W.O.Men of all red nations, or whatever one. It is the spirit of resistance that shapes the struggles of traditional Indian people on the land, whether the struggle is down at Big Mountain, in the Black Hills, or up at James Bay, in the Nevada desert, or out along the 367 Columbia River in what is NOW called Washington State. Point 2 In the sense that I use the term, indigenism is also, I think, the outlook that guided our great leaders of the past, King Philip and Pontiac Tecumseh and Creek Mary and Osceola, Black Hawk, Nancy Ward and Satanta, Lone Wolf and Red Cloud, Satank and Quanah Parker, Left Hand and Crazy Horse, Dull Knife and Chief Joseph, Sitting Bull, Roman Nose and Captain Jack, Louis Rial and Poundmaker and Geronimo, Cochise and Man TLS. Victorio, Chief Seattle, and on. Point 3 in my view, those, Indian and non-Indian alike, who do not recognize these names and what they represent have no sense of the true history, the reality of North America. They have no sense of where they've come from or where they are, and thus can have no genuine sense of who or what they are. By not looking at where they've come from, they cannot know where they are going or where it is they should go. It follows that they cannot understand what it is they are to do, how to do it, or why. In their confusion, they identify with the wrong people, the wrong things, the wrong tradition. They therefore inevitably pursue the wrong goals and objectives, putting last things first and often forgetting the first things altogether, perpetuating the very structures of oppression and degradation they think they oppose. Obviously, if things are to be changed for the better in this world, then this particular problem must itself be changed as a matter of first priority. In any event, all of this is not to say that I think I am one of the significant people I have named, or the host of others, equally worthy, who've gone unnamed. I have no new conception of myself as the reincarnation of someone who has come before. But it is to say that I take these ancestors as my inspiration, as the only historical examples of proper attitude and comportment on this continent, this place, this land on which I live and of which I am a part. I embrace them as my heritage, my role models, the standard by which I must measure myself. I try always to be worthy of the battles they fought, the sacrifices they made. For the record, I have always found myself wanting in this regard, but I subscribe to the notion that all is obligated to speak the truth, even if one cannot live up to or fully practice it. As Chief Dan George once put it, I endeavor to persevere, and I suppose this is a circumstance which is shared more or less equally by everyone presently involved in what I refer to as indigenism. Others whose writings and speeches and actions may be familiar, and who fit the definition of indigenous or fourth worlder, as we are SOLC. 368. Times called include Winona LaDuke and John Trudell, Simon Ortiz, Russell Means and Leonard Peltier, Glenn Morris and Leslie Silko, Jimmy Durham, John Mohawk and Orrin Lyons, Bob Robideau and Dino Butler, Ingrid Washenawatoke and Dagmar Thorpe. There are scholars and attorneys like Vine Deloria, Don Grind, Pam Colorado, Sharon V.E. Northeast, George Tinker, Bob Thomas, Jack Forbes, Rob Williams, and Hank Adams. There are poets like W.E.N.D. Rose, Adrian Lewis, Dion Million, Christos, Elizabeth Woody and Barna Bush. There are also many grassroots warriors in the contemporary world, people like the Dance Sisters, Bernard Almanac, Art Montour and Buddy Lamont, Madonna Thunderhawk, Anna Mae Aquash, Kenny Kane and Joe Stunts, Minnie Garrow and Bobby Garcia, Dallas Thundershe 1D, Phyllis Young, Andrea Smith and Richard Oakes, Margot Thunderbird, Tina Trudell and Roque Duenas. And, of course, there are the elders, those who have given, and continue to give, continuity and direction to indigenous Praise Zion. I am referring to people like Chief Fools Crow and Matthew King, Henry Crow Dog and Grandpa David Sahapa, David Monongai and Janet McLeod and Thomas Banyasaya, Roberta Blackgoat and Catherine Smith and Pauline Weitzinger, Marie Lego and Philip Deere and Ellen Moves Camp, Raymond Dowell and Nellie Redow 1.4. Like the historical figures I mentioned earlier, these are names representing positions, struggles, and aspirations which should be well known to every socially conscious person in North America. They embody the absolute antithesis of the order represented by the four Georges: George Washington, George Custer, George Patton, and George Bush, emblemizing the sweep of American history as it is conventionally taught in that system of indoctrination the United States passes on as education. They also stand as the negation of that long stream of Vichy Indians five-spawned and deemed respectable by the process of predation, colonialism, and genocide the four Georges signify. The names I have listed cannot be associated with the legacy of the hang around the fort Indians, broken, disempowered, and intimidated by their conquerors, or with the sellouts who undermine the integrity of their own cultures, appointed by the United States to sign away their people's homelands in exchange for trinkets, sugar, and alcohol. They are not the figurative descendants of those who participated in the assassination of people like Crazy Horse and Sitting Bull, and who filled the ranks of the 369 colonial police to enforce an illegitimate and alien order against their own. They are not among those who have queued up to roster the regimes installed by the U.S. to administer Indian country from the 1930s onward, the craven puppets who to this day cling to and promote the lawful authority of federal force as a means of protecting their positions of petty privilege, imagined prestige, and often their very identities as native people. No, indigenists and indigenism have nothing to do with the sorts of quisling impulses driving the Ross Swinnunners, Dickie Wilson's W. Eebster T.W.O. Hawks, Peter MacDonald's Vernon B. E. LaCourts and David Bradley's of this world. 6 Instead, indigenism offers an antidote, a vision of how things might be that is based in how things have been since time immemorial, and how things must be once again if the human species, and perhaps the planet itself, is to survive much longer. Predicated on a synthesis of the wisdom attained over thousands of years by indigenous, land-based peoples around the globe, the Fourth World, or, as Winona LaDuke puts it, the host world upon which the first, second, and third worlds all sit at the present time. Indigenism stands in diametrical opposition to the totality of what might be termed Eurocentric business as usual. 7. Indigenism. The manifestation of indigenism in North America has much in common with the articulation of what in Latin America is called indigalismo. One of the major proponents of this, the Mexican anthropologist/activist Guillermo Bonfil Badilla, has framed its precepts this way: in America there exists only one unitary Indian civilization. All the Indian peoples participate in this civilization. The diversity of cultures and languages is not an obstacle to affirmation of the unity of the civilization. It is a fact that all civilizations, including Western civilization, have these sorts of internal differences. But the level of unity the civilization is more profound than the level of specificity. The civilizing dimension transcends the concrete diversity g. The differences between the diverse peoples have been accentuated by the colonizers as part of the strategy of domination. There have been attempts by some to fragment the Indian peoples. By establishing frontiers, deepening differences, and provoking rivalries. This strategy follows a principal objective, domination, to which end it is attempted ideologically to demonstrate that in America, Western civilization is confronted by a magnitude of atomized peoples, differing from 1. 370. Another. Thus, in consequence, such peoples are believed incapable of forging a future of their own. In contrast to this, the Indian thinking affirms the existence of a unique and different Indian civilization, which extend as particular expressions the cultures of diverse peoples. Thus, the identification and solidarity among Indians. Their Indianness is not a simple tactic postulated, but rather the necessary expression of an historical unity, based in common civilization, which the colonizer has wanted to hide. Their Indianness, furthermore, is reinforced by the common experience of almost 5 centuries of domination. The past is also unifying, Bonfil Badilla continues. The achievements of the classic Mayas, for instance, can be reclaimed as part of the Quechua foundation, much the same as the French affirm their Greek past. And even beyond the remote past which is shared, and beyond the colonial experience that makes all Indians similar, Indian peoples also have a common historic project for the future. The legitimacy of that project rests precisely in the existence of an Indian civilization, within which work it could be realized, once the chapter of colonialism ends. One's own civilization signifies the right and the possibility to create one's own future, a different future, not Western law. As has been noted elsewhere, the new indigenist movement Bonfile B. Tala equates colonialism imperialism with the West, in opposing the West. View themselves as anti-imperialist. Socialism, or Marxism, is viewed as just another Eastern manifestation LL. A query is thus posed. What, then, distinguishes Indian from Western civilization? Fundamentally, the difference can be summed up in terms of relationship with the natural world. For the West, the concept of nature is that of an enemy to be overcome, with man as boss on a cosmic scale. Man in the West believes he must dominate everything, including other. The converse is true in Indian civilization, where part of an indivisible cosmos and fully aware of harmonious relationship with the universal order of nature. He neither dominates nor tries to dominate. On the contrary, she exists within nature as a moment of it. Traditionalism thus constitutes a potent weapon in the civilization's struggle for survival against colonial domination. Bonfile Batala contends that the nature of the indigenist impulse is essentially socialist, insofar as socialism, or what Karl Marx described as primitive communism, was and remains the primary mode of indigenous social organization in the Americas. 1-3 Within this framework, he remarks. 371. That there are 6 fundamental demands identified with the Indian movement, all of them associated with socio-political, cultural, and economic autonomy and self-determination. First, there is land. There are demands for occupied ancestral territories. Demands for control of the use of the land and subsoil, and struggles against the invasion of commercial interests. Defense of land held and recuperation of land lost are the central demands. Second, the demand for recognition of the ethnic and cultural specificity of the Indian is identified. All organizations reaffirm the right to be distinct in culture, language and institutions, and to increase the value of their own technological, social, and ideological practices. Third is the demand for political rights in relation to the state. Fourth, there is a call for the end of repression and violence, particularly that against the leaders, activists, and followers of the Indians' new political organizations. Fifth, Indians demand the end of family planning programs which have brought widespread sterilization of Indian women and men. Finally, tourism and folklore are rejected, and there is a demand for true Indian cultural expression to be respected. The commercialization of Indian music and dance are often L11-inchant. Analfleer I a particular JJ like CUI die explodlio UCLL CLHDT 11 DVL. Sacred content and purpose for Indians. An end to the exploitation of Indian culture in general is why. In North America, these Index C11ista demands have been adopted virtu ally intact and have been conceived as encompassing basic needs of native peoples wherever they have been subsumed by the sweep of Western expansionism. This is THC idea of the fourth WORLD explained by Cree author George Manuel, FO Undying president of the WORLD Council of Indigenous Peoples. The Fourth World is the name given to indigenous peoples descended from a country, aboriginal population, and who today are completely or partly deprived of their own territory and its riches. The peoples of the Fourth World have only limited influence or none at all in the nation-state. The peoples to whom we refer are the Indians of North and South America, the Inuit, the Sami people are of northern Scandinavia, the Australian Aborigines, as well as the various indigenous populations of Africa, Asia, and Oceania. Manuel might well have included segments of the European population itself, as is evidenced by the ongoing struggles of the Irish, Welsh, Basques, and others to free themselves from the yoke of settler state oppression imposed upon them as long as 800 years ago. 16 In such areas of Europe, as well as in the Americas and large portions of Africa, the goal is not the creation of a state, but the expulsion of elite rule and the reconstruction of societies. 17. 372. That such efforts are entirely serious is readily evidenced in the fact that, in a global survey conducted by University of California Cultural Geographic Rafer Bernard Nietschmann FROM 1985-1987, it was discovered that of the more than 100 armed conflicts then underway, some 85% were being waged by indigenous peoples against the state or states which had laid claim to and occupied their territories. ISS Theo van Boven, FOR Director of the United Nations Division FOR Human Rights, put it in 1981, the circumstances precipitating armed struggle may be seen with particular poignancy in relation to the indigenous peoples of the world, who have been described somewhat imaginatively and perhaps not without justification as representing the FO Earth world, the world on the margin, on the periphery. 19. The issue of land in North America. What must be understood about the context of the Americas north of the Rio Grande is that neither of the nation-states, the United States and Canada, which claim sovereignty over the territory involved, has any legitimate basis at all in which to anchor its absorption of huge portions of that territory. I am going to restrict my remarks in this connection mostly to the United States, mainly because that is what I know best, but also because both the United States and Canada have evolved on the basis of the Anglo-Saxon common law tradition. 20. So, think much of what can be said about the United States bears a certain utility in terms of understanding the situation in Canada. Certain of the principles, of course, also extend to the situation in Latin America, but there you have an evolution of nation-states based on the Iberian legal tradition, so a greater transposition in terms is required. 21. The shape of things down south was summarized eloquently enough by the Peruvian freedom fighter Hugo Blanco with his slogan, "Land or Death." 22. The United States, during the first 90-odd years of its existence, entered into and ratified more than 370 separate treaties with the peoples indigenous to the area now known as the 48 contiguous states. 23. There are a number of important dimensions to this, but two aspects will do for our purposes here. First, by customary international law and provision of the U.S. Constitution itself, each treaty ratification represented a formal recognition by the federal government that the other parties to the treaties, the N.A. 373 peoples involved were FULLY sovereign nations in their own right. 24. Second, the purpose of the treaties, from the U.S. point of view, was to serve as real estate documents through which the United States acquired legal title to specified portions of North America. From the indigenous nations it was thereby acknowledging already owned it. From the viewpoint of the indigenous nations, of course, these treaties served other purposes, the securing of permanently guaranteed borders to what remained of their national territories, assurance of the continuation of their ongoing self-governance, trade, and military alliances, and so forth. The treaty relationships were invariably reciprocal in nature. Indians ceded certain portions of their land to the United States, and the United States incurred certain obligations in exchange. 25. Even at that, there were seldom any outright sales of land by Indian nations to the United States. Rather, the federal obligations incurred were usually couched in terms of perpetuity. The arrangements were set up by the Indians so that, as long as the United States honored its end of the bargains, it would have the right to occupy and use defined portions of Indian land. In this sense, the treaties more nearly resemble rental or leasing instruments than actual deeds. And what happens under Anglo-Saxon common law when a tenant violates the provisions of a rental agreement? The point here is that the United States has long since defaulted on its responsibilities under every single treaty obligation it ever incurred with regard to Indians. There is really no dispute about this. In FACT, there is even a Supreme Court opinion, the 1903 Lone Wolf case, in which the good Justices held that the United States enjoyed a right to disregard any treaty obligation to Indians it found inconvenient, but that the remaining treaty provisions continued to be binding upon the Indians. This was, the High Court said, because the United States was the stronger of the nations involved and thus wielded plenary power. This simply means full power over the affairs of the weaker indigenous nations. Therefore, the court felt itself free to unilaterally interpret each treaty as a bill of sale rather than a rental agreement. 26 Stripped of its fancy legal language, the Supreme Court's position was astonishingly crude. There is an old adage that possession is 9/10 of the law. Well, in this case the court went a bit further, arguing that possession was all of the law. Further, the highest court in the land went on record boldly arguing that, where Indian property rights are coil. 374. Served, might, and might alone, makes right. The United States held the power to simply take Indian land, they said, and therefore it had the right to do so. This is precisely what the Nazis argued only 30 years later, and the United States had the unmitigated audacity to profess outrage and shock that Germany was so blatantly transgressing against elementary standards of international law and the most basic requirements of human decency. 27 For that matter, this is all that Saddam Hussein stood for when he took Kuwait. Indeed, Iraq had a far stronger claim to rights over Kuwait than the United States has ever had with regard to Indian country. With the result that George Bush began to babble about fighting a just war to roll back naked aggression, free occupied territory, and reinstate a legitimate government. If he were in any way serious about that proposition, he would have had to call airstrikes in on himself instead of ordering the bombing of Baghdad. 28 Be that as it may, there are a couple of other significant problems with the treaty constructions by which the United States allegedly assumed title over its land base. On the one hand, a number of the ratified treaties can be shown to be fraudulent or coerced, and thus invalid. The nature of the coercion is fairly well known. Perhaps a third of the ratified treaties involved direct coercion. Now comes the matter of fraud, which assumes the form of everything from the deliberate misinterpretation of proposed treaty provisions to the Senate's alteration of treaty language after the fact and without the knowledge of the Indian signatories. On a number of occasions, the United States appointed its own pre-FERRED Indian leaders to represent their nations in treaty negotiations. 29 In at least one instance, the 1861 Treaty of Fort Wise, U.S. negotiators appear to have forged the signatures of various Cheyenne and Arapaho leaders. 30 Additionally, there are about 400 treaties which were never ratified by the Senate and were therefore never legally binding, but upon which the United States now asserts its claims concerning lawful use and occupancy rights to, and jurisdiction over, appreciable portions of North America. 31 When all is said and done, however, even these extremely dubious bases for U.S. title are insufficient to cover the gross territoriality at issue. The federal government itself tacitly admitted as much during the 1970s in the findings of the so-called Indian Claims Commission, an entity created in 1946 to make quiet title to all illegally taken Indian land within the lower 48 states. 32 What the Commission did over the ensuing 35 years was 375. In significant part to research the ostensible documentary basis for U.S. title to literally every square foot of its claimed territory. It found, among other things, that the United States had no legal basis whatsoever, no treaty, no agreement, not even an arbitrary act of Congress to fully 1/3 of the area within its boundaries. 33 At the same time, the data revealed that the reserved areas still nominally possessed by Indians had been reduced to about 2.5% of the same area. 34 What this means in plain English is that the United States cannot pretend to have even a shred of legitimacy in its occupancy and control of upwards of 30% of its home territory. And, just such matters he totally lost in the shuffle. I should note that it has even less legal basis for its claims to the land in Alaska and Hawaii. 35 Beyond that, its right to assert dominion over Puerto Rico, the U.S. Virgin Islands, American Samoa, Guam, and the Marshall Islands tends to speak for itself. Indian land recovery in the United States. Leaving aside questions concerning the validity of various treaties, the beginning point for any indigenous endeavor in the United States centers, logically enough, in efforts to restore direct Indian control over the huge portion of the continental United States that was plainly never ceded by native nations. Upon the bedrock of this foundation, a number of other problems integral to the present configuration of power and privilege in North American society can be resolved, not just for Indians, but for everyone else as well. It is probably impossible to solve, or even to begin meaningfully addressing, certain of these problems in any other way. But still, it is, as they say, no easy sell to convince anyone outside the more conscious sectors of the American Indian population itself of the truth of this very simple fact. In part, uncomfortable as it may be to admit, this is because even the most progressive elements of the North American immigrant population share a perceived commonality of interest with the more reactionary segments. This takes the form of a mutual insistence upon an imagined right to possess native property, merely because they are here, and because they desire it. The great fear is, within any settler state, that if indigenous land rights are ever openly acknowledged, and native people therefore begin to recover some significant portion of their land, the immigrants will correspondingly be dispossessed of that which they have come to consider. 376. T. Ayres. Tellingly, every major Indian land recovery initiative in the United States during the second half of the 20th century, the Eastern Shoshone, those in Maine, the Black Hills, the Oneida claims in New York State are prime examples, has been met by a propaganda barrage from right-wing organizations ranging from the Ku Klux Klan to the John Birch Society to the Republican Party, warning individual non-Indian property holders of exactly this peril. 36. I will debunk some of this nonsense in a moment, but first I want to take up the posture of self-proclaimed leftist radicals in the same connection. And I will do so on the basis of principle, because justice is supposed to matter more to progressives than to rightist hacks. Let me say that the pervasive and near total silence of the left in this connection has been quite illuminating. Non-Indian activists, with only a handful of exceptions, persistently plead that they cannot really take a coherent position on the matter of Indian land rights because, unfortunately, they are not really conversant with the issues. Meanwhile, they do virtually nothing, generation after generation, to inform themselves on the topic of who actually owns the ground they are standing on. The record can be played only so many times before it wears out and becomes just another variation of hear no evil, see no evil. At this point, it does not take Einstein to figure out that the left does not know much about such things because it has never wanted to know, or that this is so because it has always had its own plans for utilizing land it has no more right to than does the status quo it claims to oppose. The usual technique for explaining this away has always been a sort of pro-forma acknowledgement that Indian land rights are really important stuff, but that one really does not have a lot of time to get into it. Reason. One is just overwhelmingly preoccupied with working on other important issues. Typically enumerated are sexism, racism, homophobia, class inequities, militarism, the environment, or some combination. It is a pretty good evasion, all in all. Certainly, there is no denying any of these issues their due, they are all important, obviously so. But more important than the question of land rights? There are some serious problems of primacy and priority embedded in the orthodox script. 377. To aim things clearly in this regard, let us hypothesize for a moment that all of the various non-Indian movements concentrating on each of these issues were suddenly successful in accomplishing their objectives. Let us imagine that the United States as a whole were somehow transformed into an entity defined by the parity of its race, class, and gender relations, its embrace of unrestricted sexual preference, its rejection of militarism in all forms, and its abiding concern with environmental protection. When all is said and done, the society resulting from this scenario is still, first and foremost, a colonialist society, an imperialist society in the most fundamental sense and with all that this implies. This is true because the scenario does nothing at all to address the fact that whatever happens is on someone else's land, not only without their consent, but with an adamant disregard for their rights to the land. Hence, all it means is that the immigrant or invading population has rearranged its affairs in such a way as to make itself more comfortable at the continuing expense of indigenous people. The colonial equation remains intact and may even be reinforced by a greater degree of participation and vested interest in maintenance of the colonial order among the settler population at large. 37 The dynamic here is not very different from that evident in the American Revolution of the late 18th century, is it? And we all know very well where that led. Should we therefore begin to refer to socialist imperialism, feminist imperialism, gay and lesbian imperialism, environmentalist imperialism, Afro-American and La Raza imperialism? I would hope not. 38 I would hope this is all just a matter of confusion, of muddled priorities among people who really do mean well and who would like to do better. If so, then all that is necessary to correct the situation is a basic rethinking of what it is that must be done, and in what order. Here, I would advance the straightforward premise that the land rights of first Americans should be a priority for anyone seriously committed to accomplishing positive change in North America. But before I suggest everyone jump up and adopt this priority, I suppose it is only fair that I investigate the converse of the proposition. If making things like class inequity and sexism the preeminent focus of progressive action in North America inevitably perpetuates the internal colonial structure of the United States, does the reverse hold true? I will state unequivocally that it does not. 378. There is no indication whatsoever that a restoration of indigenous sovereignty in Indian country would foster class stratification anywhere, least of all in Indian country. In fact, all indications are that when left to their own devices, indigenous peoples have consistently organized their societies in the most class-free manner. Look to the Haudenosaunee for an example. Look to the Muskogee Confederacy. Look to the confederations of the Yaqui and the Lakota, and those pursued and nearly defeated by Pontiac and Tecumseh. They represent the very essence of enlightened egalitarianism and democracy. Every imagined example to the contrary brought forth by even the most arcane anthropologist can be readily offset by a couple of dozen other illustrations along the lines of those I just mentioned. 39 Would sexism be perpetuated? Ask the Haudenosaunee clan mothers, who continue to assert political leadership in their societies through the present day. Ask Wilma Mankiller, recent head of the Cherokee Nation, a people who were traditionally led by what were called beloved WO men. Ask a Lakota woman or man, for that matter, about who owned all real property in traditional society, and what that meant in terms of parity in gender relations. Ask a traditional Navajo grandmother about her social and political role among her people. WO men in most traditional native societies not only enjoyed political, social, and economic parity with men, but they also often held a preponderance of power in one or more of these spheres. Homophobia. Homosexuals of both genders were, and in many settings still are, deeply revered as special or extraordinary, and therefore spiritually significant, within most indigenous North American cultures. The extent to which these realities do not now pertain in native societies is exactly the extent to which Indians have been subordinated to the mores of the invading, dominating culture. Insofar as restoration of Indian land rights is tied directly to the reconstitution of traditional indigenous social, political, and economic modes, one can see where this leads. The Indian arrangements of sex and sexuality accord rather well with the aspirations of feminism and gay rights activism. 40 How about a restoration of native land rights precipitating some sort of environmental holocaust? Let us get at least a little bit realistic here. If one is not addicted to the fabrications of Smithsonian anthropologists about how Indians lived 41 or George Werthner's Euro-supremacist Earth First fantasies about how we beat all the woolly mammoths and mastodons and 379 saber-toothed cats to death with sticks 42 then this question is not even on the board. I know it has become fashionable among Washington Post editorialists to make snide references to native people strewing refuse in their wake as they wandered nomadically about the prehistoric North American landscape. 43 What is this supposed to imply? That we, who were mostly sedentary agriculturalists in any event, were dropping plastic and aluminum cans as we went? As I said, let us get real. Read the accounts of early European invaders about what they encountered. North America was invariably described as being a pristine wilderness at the point of European arrival, despite the fact that it had been occupied by 15 or 20 million people enjoying a remarkably high standard of living for nobody knows how long. 40,000 years? 50,000 years, 44 longer? Now contrast that reality to what has been done to this continent over the past couple of hundred years by the culture /LLERTH, LER, the Smith.me MLNCLTHPPMTRPRRPPNT, MOU tell flu about environmental devastation, that leaves militarism and racism. Taking the last first, there really is no indication of racism in traditional indigenous societies. To the contrary, the record reveals that Indians habitually intermarried between groups and frequently adopted both children and adults from other groups. This occurred in pre-contact times between Indians, and the practice was broadened to include those of both African and European origin, and ultimately Asian origin as well, once contact occurred. Those who were naturalized by marriage or adoption were considered members of the group, pure and simple. This was always the native viewpoint. 46 The Europeans and subsequent Euro-American settlers viewed things rather differently, however, and foist off the notion that Indian identity should be determined primarily by blood quantum, an outright eugenics code similar to those developed in places like Nazi Germany and apartheid South Africa. Now, that is a racist construction if there ever was one. Unfortunately, a lot of Indians have been conned into buying into this anti-Indian absurdity, and that is something to be overcome. But there is also solid indication that quite a number of native people continue to strongly resist such things as the quantum system. 7 As to militarism, no one will deny that Indians fought height wars among themselves both before and after the European invasion began. Probably half of all indigenous peoples in North America maintained permanent warrior. 380. Societies. This could perhaps be reasonably construed as militarism. But not, I think, with the sense the term conveys within the European/Euro-American tradition. There were never, so far as anyone can tell one on straight, wars of annihilation fought in this hemisphere prior to the Columbian arrival. None. In fact, it seems that it was a more or less firm principle of indigenous warfare not to kill, the object being to demonstrate personal bravery, something that could be done only against a live opponent. There is no honor to be had in killing another person, because a dead person cannot hurt you. There is no risk. This is not to say that nobody ever died or was seriously injured in the fighting. They were, just as they are in full contact contemporary sports like football and boxing. Actually, these kinds of Euro-American games are what I would take to be the closest modern parallels to traditional Indian warfare. For us, it was a way of burning excess testosterone out of young males and not much more. So, militarism in the way the term is used today is as alien to native tradition as smallpox and atomic bombs. 48 Not only is it perfectly reasonable to assert that a restoration of native control over unceded lands within the United States would do nothing to perpetuate such problems as sexism and classism, but the reconstitution of indigenous social standards that this would entail stands to free the affected portions of North America from such maladies altogether. Moreover, it can be said that the process should have a tangible impact in terms of diminishing such things elsewhere. The principle is this: sexism, racism, and all the rest arose here as a concomitant to the emergence and consolidation of the Eurocentric nation-state form of socio-political and economic organization. Everything the state does, everything it can do, is entirely contingent upon its maintaining internal cohesion, a cohesion signified above all by its pretended territorial integrity, its ongoing domination of Indian country. Given this, it seems obvious that the literal dismemberment of the nation-state necessary for Indian land recovery correspondingly reduces the ability of the state to sustain the imposition of objectionable policies within itself. It follows that realization of indigenous land rights serves to undermine or destroy the ability of the status quo to continue imposing a racist, sexist, classist, homophobic, militaristic order upon non-Indians. A brief aside, anyone with doubts as to whether it is possible to bring about the dismemberment from within of a superpower state in this day and age, ought to sit down and have a long talk with a guy named Mikhail. 381. Gorbachev. It would be better yet if one could chew the fat with Leonid Brezhnev, a man who we can be sure would have replied in all sincerity, only 20 years ago, that this was the most outlandish idea he'd ever heard. Well, look on a map today, and see if you can find the Union of Soviet Socialist Republics. It ain't there, folks. Instead, you are seeing, and you will see it more and more, the re-emergence of the very nations Leon Trotsky and his colleagues consigned to the dustbin of history clear back at the beginning of the century. These megastates are not immutable. They can be taken apart. They can be destroyed. But first we have to decide that we can do it and that we will do it. So, all things considered, when indigenous movements like AIM advance slogans like US out of North America, non-Indian radicals should not react defensively. They should cheer. They should see what they might do to help. When they respond defensively to sentiments like those XPRCS, CDBY,IL1/HJT they 1 Realton 13. Telly defending is the very govern 1L1PNT, the very order they claim to oppose so resolutely. And if they manifest this contradiction often enough, consistently enough, pathologically enough, then we have no alternative but to take them at their word, that they really are at some deep level or another aligned, all protestations to the contrary notwithstanding, with the mentality that endorses our permanent dispossession and disenfranchisement, our continuing oppression, our ultimate genocidal obliteration as self-defining and self-determining peoples. In other words, they make themselves part of the problem rather than becoming part of the solution. Toward a North All-American Union of Indigenous Nations. There are certain implications to Indian control over Indian land that need to be clarified, beginning with a debunking of the G-Reed fear, the reactionary myth that any substantive native land recovery would automatically lead to the mass dispossession and eviction of individual non-Indian homeowners. Maybe in the process I can reassure a couple of radicals that it is okay to be on the right side of this issue, that they will not have to give something up in order to part company with Pat Buchanan on this. It is hard, frankly, to take this up without giggling, because of some of the images it inspires. I mean, what are people worried about here? Do all of you really see Indians standing out on the piers of Boston and New York City, issue 382. Ing sets of water wings to long lines of non-Indians so they can all swim back to the old world? Gimme a break. Seriously, one can search high and low, and never find an instance in which Indians have advocated that small property owners be pushed off the land in order to satisfy land claims. The thrust in every single case has been to recover land within national and state parks and forests, grasslands, military reservations and the like. In some instances, major corporate holdings have also been targeted. A couple of times, as in the Black Hills, a sort of joint jurisdiction between Indians and the existing non-Indian government has been discussed with regard to an entire treaty area. 49 But even in the most hardline of the indigenous positions concerning the Black Hills that advanced by Russell Means in his treaty program, where resumption of exclusively Lakota jurisdiction is demanded, there is no mention of dispossessing or evicting non-Indians. 50 Instead, other alternatives, which I will take up later, were carefully spelled out. In the meantime, though, I would like to share with you something the right-wing propagandists never mention when they are busily whipping up non-Indian sentiment against Indian rights. Recall that I said that the quantity of unceded land within the continental United States makes up about 1/3 of the land mass. Let's just round this off to 30%, because there is the matter of 5% of the overall land base still set aside as Indian reservations. Now juxtapose that 30% to the approximately 35% of the same land mass the federal government presently holds in various kinds of trust status. Add the 10 or 12% of the land the individual states hold in trust. That adds up to a 30% Indian claim against a 45 to 47% governmental holding. S1 Never mind the percentage of the land held by major corporations. Conclusion. It is, and always has been, quite possible to accomplish the return of every square inch of unceded Indian country in the United States without tossing a single non-Indian homeowner off the land on which they live. Critics, that is the amazingly charitable self-description employed by those who ultimately oppose the assertion of indigenous rights in any form and as a matter of principle, are always quick to point out that the problem with this arithmetic is that the boundaries of the government trust areas do not necessarily conform in all cases to the boundaries of unceded areas. That is true enough, although I would just as quickly point out that more often than not they do correspond. This problem is nowhere near as big as it is 383 made out to be. And there is nothing intrinsic to the boundary question which could not be negotiated once non-Indian America acknowledges that Indians have an absolute moral and legal right to the quantity of territory which was never ceded. Boundaries can be adjusted, often in ways which can be beneficial to both sides involved in the negotiation. 52. Let me give you an example. Along about 1980, two Rutgers University Ecocide professors, Frank and Deborah Popper, undertook a comprehensive study of land use patterns and economy in the Great Plains region. What they discovered is that 110 counties, 1/4 of all the counties in the entire Plains region, falling within the western portions of the states of North and South Dakota, Nebraska, Kansas, Oklahoma, and Texas, as well as eastern Montana, Wyoming, Colorado, and New Mexico, have been fiscally insolvent since the moment they were taken from native people a century or more ago. TIMOLRFOL of ALHO 11T140,0001 MRF miles, inhabited by a widely dispersed non-Indian population of only around 400,000, attempting to maintain school districts, police and fire departments, road beds and all the other basic accoutrements of modern life on the negligible incomes which can be eked from cattle grazing and wheat farming on land which is patently unsuited for both enterprises. The Poppers found that without considerable federal subsidy each and every year none of these counties would ever have been viable. Nor 011. The face of it, will any of them ever he? Bluntly put, the pretense of bringing Euro-American civilization to the plains represents nothing more than a massive economic burden on the rest of the United States. What the Poppers proposed on the basis of these findings is that the government cut its perpetual losses by buying out the individual land holdings within the target counties and converting them into open space wildlife sanctuaries known as Buffalo Commons. The whole area would in effect be turned back to the bison, which were very nearly exterminated by Phil Sheridan's buffalo hunters back in the 19th century as a means of starving recalcitrant Indians into submission. The result would, they argue, be both environmentally and economically beneficial to the nation as a whole. It is instructive that such thinking has gained increasing credibility and support from Indians and non-Indians alike, beginning in the second half of the 1980s. Another chuckle here, Indians have been trying to tell non-Indi and Matthews, where the buffalo roam. 385. ANS that this would be the outcome of fencing in the plains ever since 1850 or so, but some folks have a real hard time catching on. Anyway, it is entirely possible that we will see some actual motion in this direction over the next few years. 53. So, let us take the Popper's idea to its next logical step. There are another 100 or so economically marginal counties adjoining the perpetual red ink counties already identified. These do not represent an actual drain on the U.S. economy, but they do not contribute much either. They could be written off and lumped into the Buffalo Commons with no one feeling any ill effects whatsoever. Now add in adjacent areas like the National Grasslands in Wyoming, the National Forest and Parklands in the Black Hills, extraneous military reservations like Ellsworth Air Force Base, and existing Indian reservations. This would be a huge territory lying east of Denver, west of Lawrence, Kansas, and extending from the Canadian border to so. Harold T. Esass, all of it outside the lawn NFUS Beeman 11111L1. The bulk of this area is unceded territory owned by the Lakota, Pawnee, Arikara, Hidatsa, Crow, Shoshone, Assiniboine, Cheyenne, Arapaho, Kiowa, Comanche, Jicarilla and Mescalero Apache nations. There would be little cost to the United States, and virtually no arbitrary dispossession or dislocation of non-Indians if the entire commons were restored to these peoples. Further, it would establish a concrete basis from which genuine expressions of indigenous self-determination could begin to re-emerge on this continent, allowing the indigenous nations involved to begin the process of reconstituting themselves socially and politically and to recreate their traditional economies in ways that make contemporary sense. This would provide alternative socio-economic models for possible adaptation by non-Indians and alleviate a range of considerable costs to the public treasury incurred by keeping the Indians in question in a state of abject and permanent dependency. Critics will undoubtedly pounce upon the fact that an appreciable portion of the Buffalo Sea Omens area I have sketched out, perhaps a million acres or so, lies outside the boundaries of unceded territory. That is the basis for the sorts of multilateral negotiations between the United States and indigenous nations I mentioned earlier. This land will need to be charged off in some fashion against unceded land elsewhere and in such a way as to bring other native peoples into the mix. The Poncas, Omahas, and Osages, whose traditional territories fall within the area in question, come immediately. 386. 8ly to mind, but this would extend as well to all native peoples willing to exchange land claims somewhere else for actual acreage in this locale. The idea is to consolidate a distinct indigenous territory while providing a definable land base to as many different Indian nations as possible in the process. From there, the principle of the Buffalo Commons cum Indian Territory could be extended westward into areas that adjoin or are at least immediately proximate to the Commons area itself. The fact is that vast areas of the Great Basin and Sonoran Desert regions of the United States are even more sparsely populated and economically insolvent than the plains. A great deal of the area is also held in federal trust. Hence, it is reasonable, in my view at least, to expand the Commons territory to include most of Utah and Nevada, northern Montana and Idaho, quite a lot of eastern Washington and Oregon, most of the rest of New Mexico, and the lion's share of Arizona. This would encompass the unceded lands of the Blackfeet and Gros Ventre, Salish, Kootenai, Nez Perce, Yakima, Eastern Shoshone, Goshutes and Utes, Paiutes, Navajo, Hopi and other Pueblos, Mescalero and Chiricahua Apache, Havasupai, Yavapai and Zero-ODM. It would also set the stage for further exchange negotiations to consolidate this additional territory in order to establish a land base for a number of other indigenous nations. At this point, we have arrived at an area comprising roughly one-third of the continental United States, a territory that, regardless of the internal political and geographical subdivisions affected by the array of native peoples within it, could be defined as a sort of North American Union of indigenous nations. Such an entity would be in a position to assist other indigenous nations outside its borders but still within the remaining territorial corpus of the United States to resolve land claim issues accruing from fraudulent or coerced treaties of cession. It would also be in a position to facilitate an accommodation of the needs of untreated peoples within the United States, the Abenaki of Vermont, for example, and the Hawaiian and Alaskan natives. Similarly, it would be able to help secure the self-determination of U.S. colonies like Puerto Rico. One can see the direction the dominoes would begin to fall. Nor does this end with the United States. Any sort of indigenous union of the kind I have described would be as eligible for admission as a fully participating member of the United Nations as, say, Croatia and the 387. Possible boundaries. North American Union of Indigenous Nations. 1992, War Churchill. Ukraine have recently shown themselves to he. This would set a very important precedent, insofar as there has never been an American Indian entity of any sort accorded such political status on the world stage. The precedent could serve to pave the way for comparable recognition and attainments by other Native American nations, notably the Confederation of Incan peoples of the Andean highlands and the Mayans of present-day Guatemala and southern Mexico, and from there, other indigenous nations elsewhere around the world. Again, one can see the direction the dominoes would fall. If we are going to have a new world order, let us 388. Make it something just a bit different from what George Bush and his FREs had in mind. Right? Sharing the land. There are several closely related matters that should be touched upon before wrapping this up. One has to do with the idea of self-determination, or what is meant when indigenists demand the unrestricted right for native peoples. Most non-Indians, and even a lot of unceded Indian territory / stolen in 1877, the Missouri River water and much of the aquifer remained within Lakota holdings. The U.S. was interested in gold in those days. Water was not an issue for it, and so water was left in Indian hands. But during the period of the Allotment and Homestead Acts, when so much of what was then called the Great Sioux Reservation was taken, water became a major issue. The Wasatchus became interested in farming and ranching as well as mining, and suddenly, as if by magic, the west bank of the Missouri River became the eastern boundary of our remaining lands. Overnight, with no authorization from the Lakota people at all, the federal government decided that the water in the Missouri River did not belong to us. And, while the size of our reserved territories have been steadily diminished since passage of the IRA in 1934, our right to aquifer water is said to have passed along with the land. 407. Lands of the Sioux Nation acknowledged by IHEUS in 1805. Today, almost nothing remains of the water rights our ancestors fight so hard to preserve for us. Oahe and other major dams along the Missouri divert massive amounts of water to exclusively non-Indian use. What little groundwater remains available is being increasingly contaminated by mining and other industrial processes. Plans are on the board right now to drain the entire aquifer through ETSI and other corporate projects. If such plans succeed, the very basis for life itself will be gone from the whole Black Hills region. Given the situation, the administration of U.S. President Jimmy Carter was correct in designating the Black Hills a national sacrifice area. And you can be sure that the official outlook has not changed for the better now that it is to be voiced by the Reagan administration's Interior Secretary, James Watt. Such realities were clearly seen by our ancestors in the terms of the treaty they established for protection of their unborn. It is our responsibility to conduct ourselves in the same manner, extending similar protection over our unborn. If we do not offer water to our future generations, we offer nothing at all. Sovereignty. Within the understandings of international law, it is the right of all sovereign nations to enter into treaty relationships with other sovereign nations. Conversely, only sovereign nations are entitled to enter into such relationships. Individuals and other entities imbued with a standing subordinate to nations such as states or provinces, cities, counties, and the like do not have the legal right to make treaties. Article 1 of the United States Constitution reflects this fact. The article states unambiguously that subordinate entities may not enter into treaties. It follows that the federal government can enter into treaties only with other sovereign nations. For the government to conduct itself otherwise would be an illegal act under both U.S. and international law. The United States government, which we can only presume was and is aware of its own laws, chose to enter into treaties with the Lakota Nation in 1805, 1847, 1851 and 1868. Not once, but 4 times did the United States, by definition of its own constitution, acknowledge what our ancestors already knew, that the Lakota people were, and therefore are, sovereign in the 41-0. Precisely same sense as the United States itself. This principle has been recognized in legal doctrine from before the time of Chief Justice John Marshall in the early 19th century. A nation which enters into a treaty relationship with another has both a moral and a legal obligation to carry out its responsibilities under the terms and provisions enshrined in the treaty document. The Lakota Nation has always done so, not only with respect to the United States but with all other nations. The United States, on the other hand, as was shown in the sections on land and water, and as will be shown in the sections which FOLO has patently failed to do so with respect to the Lakota. The immoral and illegal actions of the United States in this regard thus represent a clear infringement upon Lakota sovereignty. By international legal definition, this amounts to acts of war continuing to this very day. In effect, the United States, which proposed and ratified 4 separate treaties of peace and friendship with the Lakota Nation, has never stopped waging what amounts to an undeclared war against us. There is a definition of this sort of behavior by nations, a definition advanced by the US itself in describing the illegal conduct of the Nazi regime during its prosecution at Nuremberg after World War II. The definition is this: a nation which willingly and intentionally violates the sovereignty of another for purposes of territorial or other gain is guilty of the crime of waging aggressive war. The US assumed a leading role in trying and executing or imprisoning the Nazi leaders deemed responsible for waging aggressive war during the 1930s and 40s, yet it is equally guilty, where the Lakota Nation is concerned, of waging exactly the same kind of war. And there is more. The reason treaties are so important in international affairs is that they are the primary mechanism through which major understandings between nations can be reached short of war, or to end existing wars. They are voluntary arrangements entered into by all parties expressly as a means to prevent violence. The violation of any treaty is therefore an inherently violent act. Similarly, the blocking of treaty agreements is an inherently violent act, as it prevents peaceful solutions to international problems. Since treaties are voluntary, any sovereign nation has a right to decline to be involved in one. The United States exercised this right in 1871, when it declined to become involved in any further treaties within 411 indigenous nations, including the Lakotas. There was a snag, however. The U.S. had earlier reached an understanding with these same nations wherein it had reserved unto itself the exclusive prerogative of making treaties with them. The matter cannot be had both ways. A nation cannot monopolize the right to treat with other nations and then refuse to negotiate treaties with them. Not only does this serve to undermine the sovereignty of these other nations, it destabilizes the whole delicate structure by which nonviolent international problem solving is meant to be accomplished. Hence, it is fair to say that aggressive war and violent usurpation of sovereignty have been built into the U.S. relationship to the Lakota and other indigenous nations since at least 1871. Such a situation obviously cannot be allowed to continue. Either the United States must end its aggressive war against the Lakota Nation by honoring its existing treaties with us, and by indicating its willingness to ODENEW treaties which are mutually acceptable, or the Lakota Nation must enter, by treaty, into new international relationships designed to guarantee Lakota sovereignty both now and in the future. To be sure, our ancestors would expect no less. Self-determination. According to the United Nations Charter and other elements of international law, all peoples possess an inherent right to self-determination. That is, we have an absolute right to our own form of government, our own legal system, our own methods of organizing our communities, control over our economy, our own means of defining who is not a citizen, our own manner to defining our relationship to other peoples, and so on. In substance, it is recognized in black letter law that we are inalienably a nation and entitled to determine for ourselves the form of our socio-economic and political life. Unquestionably, the United States, in cynical disregard of this fundamental standard of international comportment and legality, has acted to systematically deny the right of self-determination to the Lakota people. This is true not only where land, water, and treaties are concerned, but in other important ways as well. 412. Government. The Lakota Nation has, and has always had, its own form of government. Traditionally, this has been constituted in the councils of elders. The United States unequivocally recognized the validity of our traditional government when it entered into its treaty relationship with us. Indeed, the right of our government to continue its functioning is permanently guaranteed in the 1868 Fort Laramie Treaty and elsewhere. Nonetheless, in 1936, on the basis of the IRA, the U.S. intervened massively in our internal affairs. Central to this externally dictated reorganization of our national life was the imposition of a thoroughly alien type of government. This took the form of an elected president and tribal council operating on the basis of a written constitution formulated not by Lakotas, but by BIA officials in Washington, D.C. It should be self-evident that any people subjected to such a process by another nation has been denied the right of self-determination at the most basic level. Denial of the right of self-determination with respect to the form of one's government is to be denied the right of participation in the genuine political life of one's country. It's that simple. Jurisdiction. The key to any legal system is the question of where it holds jurisdiction. Our ancestors reserved the authority of the Lakota legal system over our territory through the 1868 Treaty. The U.S. agreed, guaranteeing us this right forever. Yet, in 1885 the United States unilaterally extended its own jurisdiction over our territory through what it called the Seven Major Crimes Act. After that, the scope of U.S. jurisdictional usurpation was broadened, year after year, law after law. With each expansion of U.S. jurisdiction, Lakota authority suffered a corresponding loss. The process is one in which the alien legal system quite literally shoved the Lakota legal system aside. Today, Lakota jurisdiction, and thus the Lakota legal system itself, has been reduced to sheer meaninglessness. It holds no real power over either Lakotas or non-Lakotas living within our reservations. Instead, the U.S. government wields absolute police and judicial power over Lakota territory, as is readily evidenced by the manner in which the FBI and Federal Marshal Service have recently conducted themselves on 413. Our reservations and the number of Lakotas currently serving time in federal prisons (FORC) crimes committed on Lakota land. The true magnitude of this violation of our self-determining rights may be fully appreciated only if one considers the implications of the United States authorizing itself to assert a comparable authority over Canada, France, or Japan. While the latter prospect is instantly perceived as being not only absurd but criminal, such U.S. conduct vis-a-vis the Lakota Nation is, legally speaking, no less so. THIRD-WORLDISM. The Lakota people have, and have always had, the means by which to organize ourselves into communities. A number of such FORMs have been traditionally NJOYed, and have long since proven themselves effective, whether organization wasleys along family/clan lines, around seasonal needs, or in pertin NF specific tasks/responsibilities undertaken by the group. Living as a community. Another aspect of traditional Lakota community organization has always been the direct interaction of the various THIRD-WORLDisms in comprising a multifaceted, multilevel national governing structure. In effect, Lakota society has always been organized in a manner sometimes described by Euro-American political theorists as a participatory democracy. Yet, despite the fact that the traditional THIRD-WORLDism of social organization amply met the needs of the Lakota people, the United States intervened to impair or nullify it. This was accomplished mainly through the BIA's exercise of a federally self-assigned trust authority, beginning in the late 1880s, to manipulate Lakota land holdings, cash, and other assets in such ways as to make it impossible for traditional Lakota communities to retain their cohesion. In doing this, the BIA has not simply engaged in a policy of inducing severe social disruption, but has acted to reduce and redefine Lakota governance mechanisms to a single dimension. Where there was once a functioning interpenetration of an array of community forms, there is now the single governmental edifice allowed by the IRA. Participation of the entire people in the governing process, even to the extent evident in the surrounding non-Indian society of South Dakota, is thereby prevented within the Lakota Nation. Once again, this is a clear violation of our self-determining rights. 414. Economics. Since time immemorial, the Lakota people have demonstrated complete economic self-sufficiency. At the same time, we have been able to live in harmony with our environment, demonstrating respect for all natural relations, human and non-human alike. In sum, it is accurate to observe that not only have we always possessed our own mode of economy, but one which has proven itself to be remarkably efficient and durable in terms of meeting the full range of our material and other needs for sustenance. The Lakota economy, of course, has always been synonymous with our land base and attendant sources of water. As the United States has steadily stolen Lakota land and usurped our water rights, it has consciously acted to destroy our traditional economy. Further, the U.S. has moved quite deliberately to replace the Lakota economy with its own. In the process, the U.S. has sought to convert what remains of Lakota territory, as well as our supplies of water, into mere resources. Those who have imposed this situation, which the BIA refers to as resource development, have promised that the Lakota people would benefit by being equally developed, thus becoming resources themselves as workers profitably employed in various corporate enterprises. Plainly, there are some very serious questions that need to be asked about the wisdom of entering into a process by which all people and places are commodified and thereby converted into mere things. But, leaving such issues aside, the fact is that the promise has been a total lie. Today, real unemployment and corresponding poverty among Lakotas is over 90%. The level of self-sufficiency evidenced among even those who have somehow managed to cling to AFEW acres of land is nearly zero. This among a people who have always been productively occupied in the past, and who have never been truly impoverished. Meanwhile, the wealth of our land, our water, our very habitat itself is being stripped away, inch by inch, pound by pound, all for the use and profit of others. And the price we pay for this progress? It cannot be measured only in the depths of our destitution. Besides the obvious costs, there is the radioactive and chemical contamination of what little water remains to us, a matter which has led to spiraling rates of cancer, stillbirth and genetic mutations like cleft palate. Every new strip mine, uranium mill, power generating plant, 41.5. and production facility serves to up the ante of the consequences we endure. The situation is already bad, and it promises to become much worse in coming years. Lakota territory is extraordinarily rich in minerals, and both the federal government and its corporate partners are once again offering jobs, income, and prosperity to those foolish enough to grant them easy access. What happens when the resources are gone? Look around you. The conditions currently prevailing at Pine Ridge are but a small taste of what is to come. The example of Laguna Pueblo, which placed its faith in uranium mining, is very much to the point. Only AFEW years ago, Laguna had the highest per capita income and lowest unemployment of any reservation in North America. Then the uranium played out, and with it went the jobs and royalties which had made Laguna prosper. Now the corporate sugar daddy is gone. The water is radioactively contaminated, and so are the foundations of homes and community buildings, the roadbeds, and the Reamland. The old economy of Laguna cannot be reconstructed, the new economy is bust, and the chances are that the people will not even be able to remain on their homeland because of the contamination. The people of Laguna are rapidly being reduced to absolute dependence upon unemployment compensation, welfare, ADC, commoditized distribution, the Indian Health Service and Christian charity. So are the Lakota people. The only difference between them and us is that their situation is likely permanent, and ours doesn't have to be. But it could be. If we follow their lead, if we allow the trend of industrial progress to continue, our present situation will not be temporary. It will be permanent. There will be no way to regain self-sufficiency in terms acceptable to our own Lakota tradition. Insofar as the United States and its corporate allies are presently seeking to leave us no alternative but to accept such a fate, they are guilty of denying Lakota's self-determination in the most egregious manner imaginable. Defining citizens. All sovereign nations hold the right to determine for themselves, according to their own perceptions of need and interest, the composition of their own citizenry. Consequently, every country in the world has methods. 416. By which it defines the basis of citizenship. The United States certainly does. The Lakota Nation has the same right. Traditionally, the Lakota people have always had ways through which /VEVE established the parameters of our membership, including criteria allowing for the acceptance of non-Lakotas into our society. Similarly, we've always possessed understandings of when and to what extent it was appropriate to enter into alliances and other relationships which in certain instances led to forms of joint or mutual citizenship. Today, the situation is rather different. The United States has taken it upon itself to decide for us who is and is not Lakota. The basis upon which the U.S. determines such matters? Through a system of blood quantum as crude and vicious as the race codes by which the Nazis determined who was Jewish, Gypsy, etc. This, and the place of birth. Membership/citizenship in the Lakota Nation, which is rightly decided upon a whole range of factors including knowledge of/allegiance to Lakota tradition, has thereby been reduced to an essentially racial proposition by outsiders. Further, by unilaterally imposing its own citizenship upon all Lakotas, the United States has presumed to decide for us that we are to be permanently allied with it in the most intimate sort of way. We never had a choice as to whether we would be permanent allies with and citizens of the United States. This was simply forced down our throats as a people. Of course there are those who will say that dual citizenship, i.e., holding both Lakota and U.S. citizenship at the same time, is a good thing, or at least that it does us no harm. To them, the following question must be asked: if dual citizenship does no harm, why does the federal government actively prevent us from making anyone we wish a Lakota citizen? To put it another way, if dual citizenship is so good, why isn't our naturalization of new citizens considered to be in everybody's interest? The answer is that dual citizenship, as it is used by the U.S., is and always has been a means of confusing and diluting the socio-political integrity of the Lakota Nation. By insisting that a people which is suffering a war of aggression at the hands of a given nation are simultaneously citizens of the aggressor nation, the aggressor can keep its victims psychologically off balance, their spirit of resistance radically diminished. This renders the victims vulnerable, a much softer target than would otherwise be the case. Conversely, the last thing any aggressor power would want or allow to 41-7 happen is for any appreciable part of its own population to come to view itself as citizens of the victim nation, with all the feelings of kinship, empathy, and solidarity this entails. Also, in addition to confusing all too many Lakota people about where their real interests and loyalties should lie, the dual citizenship policy employed by the United States serves to dilute the Lakota Nation physically. By combining dual citizenship with blood quantum, the U.S. government has actually been able to create new citizens for itself at the direct expense of the Lakotas. In other words, the child of any dual citizen whose blood quantum falls below the U.S. approved minimum automatically becomes only a U.S. citizen, never a Lakota citizen. By defining Lakota identity in terms of genetic standards, the U.S. government is able to effectively regulate the size of the Lakota population in accordance with its own rather than our perception of needs and interests. All in all, the assumption of U.S. control over the definition of Lakota citizenship, and the imposition of its own citizenship upon all Lakotas, are two more blatant denials of the Lakota right to self-determination. U.S. internal colonialism, a crime against humanity. The result of all this, and the list could have been made much longer, is a feeling of total powerlessness among most Lakota people at the present time. This is entirely natural in a situation where the average citizen possesses no influence or control over his/her community affairs, day-to-day personal affairs, employment situation, and the like, never mind regional and national policies and politics. This is especially true when the terms of one's life are defined by an outside force strictly on the basis of race, rather than by oneself on the basis of outlook and interest. In sum, the combination of all these factors points directly to a certain harsh reality: the Lakota Nation exists today as a colony of the United States. And, since the Lakota Nation is landlocked, surrounded by the United States, it may be said to constitute an internal U.S. colony. The symptoms of disempowerment and lack of influence over those situations which most affect us are shared by the Lakota people with colonized peoples the world over. The Lakotas, and American Indian peoples in general, also suffer a 41/8 number of other things in common with colonized peoples everywhere. Our lack of power and influence over our own affairs is real, not imagined, and this is borne out in certain physical proofs. For example, because of the fact that colonized peoples are deprived by their colonizers, for profit, of the self-determining ability to act in their own interests, they may be expected to be markedly poorer than citizens of the colonizing powers. Sure enough, American Indians, overall, have, by a decided margin, the lowest per capita income of any sector of the North American population. Colonized people, because of our enforced poverty, may be expected to be hungry more often than others. Sure enough, American Indians evidence the highest rates of malnutrition of any population group in both the US and Canada. Colonized people should, in light of this, suffer diseases at rates far higher than our colonizers. True to FORM, American Indians suffer the highest per capita incidence of all manner of readily preventable/curable diseases. We are also burdened with the highest rates of infant mortality, teen suicide, death by exposure, and by far the shortest lifespan of any group in North America. These are some of the human consequences of the colonial relationship imposed by the United States upon the Lakota Nation. When the Nazis adopted similar policies against the peoples of Eastern Europe during the Second World War, the US stood at the forefront in charging the German leadership with crimes against humanity. At Nuremberg in 1946, the United States took a leading role in convicting and either executing or imprisoning the Nazi potentates guilty of such crimes just as it did concerning charges that the Germans had waged an aggressive war against their neighbors. Obviously, as the defendants argued during the Nuremberg trials, the United States neither practices the lofty form of enlightened humanitarianism it preaches, nor does it adhere to the standards of legal comportment it so sanctimoniously imposes on others. It didn't then, and it doesn't now. Indeed, it never has. 41-9. Alcoholism and substance abuse. Before proceeding to lay out the treaty program for changing things, it seems appropriate that we stop and examine in some depth another of the more virulent byproducts of the ubiquitous sense of powerlessness and despair induced by U.S. colonialism among Lakotas. What we will look at is alcoholism, because it is a truly devastating disease, unknown to our ancestors, which now pervades every nook, cranny and dimension of our society. Moreover, we will look at alcoholism in particular because, of all the maladies with which we are presently afflicted, it demonstrates most clearly how two different aspects of colonization, the mental and the physical, interact in their impact upon the colonized as individuals, and how this serves to destroy our families, our communities and, ultimately, our society as a whole. It is a bitter fact that alcoholism is rampant on Pine Ridge. There are no communities, and very few homes, in which it is not a problem. More deaths on the highway and from exposure, more cases of child abuse and domestic violence, and more cases of the dereliction of basic human decency are caused by alcohol than all other reasons combined. Money which is desperately needed to offset malnutrition and other horrible conditions, especially among children, goes to drinking alcohol, day in and day out. Psychologically, this is in large part an understandable situation. People who feel powerless to affect their lives and living conditions, and who find such feelings reinforced at every turn, lose hope. People who lose hope begin to look for ways to escape the realities which make them feel hopeless. Alcohol, which is always available in off-reservation towns like Scenic and White Clay, offers a way to gain this escape through sheer oblivion. It works so well that it has become a potential money maker on the reservation, and there are therefore those who advocate that Pine Ridge be opened up to liquor sales. In any event, the psychological motivation to drink alcohol created by colonial domination is more than sufficient to provide the basis for chronic alcoholism on the reservation. That in itself would warrant serious concern and action on the part of anyone, or any group, committed to the well-being of the Lakota people. But there is more to the problem than just psychology. With Lakotas, there is also a problem aiding the mental compulsion to drink with a more 420 tangible physical craving. This has nothing to do with genetics, a supposedly innate Indian disposition towards alcoholism, but with day-to-day reality of another sort, the very food we are forced to eat. This is not meant as a joke. The typical Lakota diet today consists of starches, potatoes, white flour, white rice, beans, grits, etc. Such foods are both relatively cheap when bought on the market and constitute the great bulk of what the federal government provides as commodity provisions. They thereby comprise our basic staples. Obviously, a high-starch diet is not balanced as it should be, and, when consumed over a sustained period, this has significant consequences. The first thing any competent dietitian will tell you is that a diet which is unbalanced towards starches will cause an abnormal blood sugar content in the body, and certain critical vitamin and mineral deficiencies as well. This last means that a person subsisting on a high-starch diet is suffering from malnutrition even though he is eating large amounts of food. It may sound strange, but basing a diet on starch means, among other things, that a person can be very overweight and literally starving to death at the same time. The blood sugar problem caused by the typical Lakota high-starch diet is even trickier. In simplest terms, what it means is that the body chemistry is tuned in such a way that when a person takes a drink of alcohol, very likely for the psychological reasons mentioned above, the alcohol reacts in the person's imbalanced blood to create a physical craving. In other words, if you've subsisted on a high-starch for a while and then drink some alcohol, you will experience addiction to alcohol. The longer you've been on such a diet, the more you drink, the stronger your addiction. It's not heroin, but it's the same principle. Thus, most Lakotas who drink not only need alcohol for psychological reasons, because they feel beaten and depressed and wish to mentally escape these feelings, but, once they've begun drinking, because of a very real physical addiction as well. The mental and the physical go hand in hand. So the problem must be dealt with on both levels if it is to be dealt with at all. This is all the more true when one considers that a major byproduct of the combination of poor diet and alcohol consumption we are discussing is diabetes, a leading killer of adult Lakotas and perhaps the single most prominent disease in the inventory of what ails us as a people. 421. Plainly, there is plenty of reason to deal with the problem, a conclusion based simply in the fact that so many Lakotas now suffer from alcoholism and related maladies. Worse, it is equally plain that the problem affects not only our present generation, but our future generations as well. An unborn child carried in the womb of his/her mother is totally dependent on the diet of the mother for the nutrients he takes in. If the mother is subsisting on a high-starch diet, and especially if the mother is drinking as well, the child will be born with a chemical predisposition to become an alcoholic, or will actually be an alcohol from the first moment. If the child is born with its body already addicted to alcohol, it will have to go through withdrawal-DTs and all from the instant of birth. If the child is born with a predisposition towards alcoholism rather than alcoholism per se, he or she will retain this predisposition so long as he is forced to remain on a high-starch diet. At still another level, when the mother engages in heavy and/or extended drinking during pregnancy, the unborn are impacted in other ways as well. This is through the so-called fatal alcohol syndrome, in which the quantity of alcohol toxicity transmitted through the mother's blood to her unborn child is sufficient to cause mental retardation, physical deformity, or both. Such effects are irreversible and are evident in increasing numbers of Lakota children today. In the traditional Lakota way, it is our responsibility to protect the unborn as a matter of highest priority. And, with something like alcoholism, the only means of providing such protection is by eliminating the condition of colonialism which produces both the physical and psychological circumstances underlying the disease. It cannot really be questioned that colonialism is at the root of the alcoholism problem among our people. We never used alcohol in any form before the United States forced its trust authority upon us. It is from such an understanding of our situation and what is necessary to change it the better that the treaty program came into being. 422. The treaty program. Since the treaty views U.S. colonialism as the source of the kinds of problems experienced on Pine Ridge and throughout the rest of the Lakota Nation for all the reasons stated above and many more, it views a comprehensive anti-colonialist program as the only reasonable plan to offer. What follows is an overview of the ways and means by which the treaty intends to begin turning its program into reality, its positions into a policy of self-sufficiency for the Oglala Lakota people. It must be understood that this overview is not an in-depth articulation of our plan. Far too much space would be required for us to go into all the details and complexities involved. Instead, our intention is merely to give people a clear idea of the direction in which we are headed, and some of the major methods we will use in accomplishing our goals. Government. Upon election, the treaty will immediately alter the structure of the Oglala Lakota government in the following ways. First, legislative power. The power to determine policy for the Oglala people will be returned to the councils of elders, traditional chiefs, and other traditional Lakota governmental bodies. Second, the elected governing body, the tribal president and council, will serve primarily as a buffer between the traditionals and the federal bureaucracy. It will also hold the responsibility of implementing the policy decisions of the traditionals. From its first moment, the treaty will thus serve merely the executive branch of government, a branch which, in contrast to the mutation which has occurred in the U.S. government, is rightly subordinate to the traditional, legislative branch. Over the longer term, even this function of the tribal president/council should be viewed as temporary and transitional, since the ultimate intention of the treaty is to dissolve this IRA-FORM of governance as rapidly as the traditional Lakota FORM can be fully reconstituted. This means that the current IRA-imposed constitution must be revised to serve as a provisional document reflecting the new legislative/executive arrangement and mandating a complete revitalization of traditional Lakota government at the earliest possible date. 423. Teospace. As one means of accomplishing this, the treaty administration will work under direction of the traditionals to establish functioning local governments in every community on the reservation within the first 6 months to 1 year of its tenure. Further, the treaty administration will work under direction of both the traditionals and the newly constituted local governments during its second year to establish functioning regional governments representing several communities simultaneously, on whatever basis the people decide. In this way, the overall traditional Lakota form of governance, multifaceted and multileveled, can be rebuilt to its fullest natural extent in the most rapid possible fashion. A portion of the treaty position in this connection will be the immediate reversal of current policies using housing and development funds to restructure existing communals. Funds will be channeled directly to community members where they are, or where they choose to be. In cases such as cluster housing programs, where people have already been coerced into physical relocation, funds will be devoted to undoing the damage done. People will be supported in moving back to their original communities if they so desire. In substance, existing and naturally rather than efficiently formed Lakota communities will be nurtured at all costs. While this transitional program of physical readjustment is being carried out, the treaty will also conduct one study to determine what sorts of structures, residences, community buildings, schools, etc. are most appropriate in terms of meeting the stated needs of each reservation community. Additional tribal development monies will then go directly to meeting these real needs rather than the needs of some planning agency in Washington, D.C. Jurisdiction. The treaty will immediately redefine and reconfigure the roles and functions of the tribal police and courts. First, the tribal courts will be dissolved in the form they have been constituted under the IRA. Judicial authority will be handed over immediately to the traditionals who comprise the proper authorities. 424. Among our people, the prevailing code of criminal laws and penalties will be suspended and or phased out, replaced as quickly as possible by that of the traditional Lakota. Second, the tribal police will be viewed as a transitional agency operating under traditional Lakota law and answering, through the tribal president, to the traditionals. This situation will be maintained until such time as the traditional Ecocide can be effectively reconstituted. The Ecocide will then replace the current BIA/IRA imposed police apparatus as the enforcement mechanism of governance within Oglala territory. Current members of the tribal police may or may not ultimately become members of the Ecocide, depending on the decision of the traditional government in each individual instance. In the interim, the tribal police will be instructed to enforce Oglala jurisdiction over Oglala territory. Their authority will encompass both Lakota and non-Lakota individuals within this area. Non-Lakotas who do not wish to live under sovereign Lakota jurisdiction, and in accordance with the traditional Lakota Code of Legality, will be free to leave the reservation immediately. Similarly, attempts by non-Lakota law enforcement agencies to assert jurisdiction within Oglala territory will be considered as criminal acts under both Lakota and international law. Offenders will be dealt with in ways deemed appropriate by the traditional government, whether this be a matter of simple expulsion from Lakota territory, expulsion accompanied by impoundment of weapons and vehicles, or by some other means. The arrest of a Lakota national by representatives of non-Lakota police agencies will be treated as kidnapping in the event it occurs within Oglala territory. Tribal police personnel unprepared to implement such a policy will be free to resign immediately. In the alternative, they will be fired. In either event, they will be replaced with individuals prepared to act in behalf of the people rather than on behalf of outside interests such as the FBI, State of South Dakota and the U.S. government. The treaty administration will also establish, as a matter of Lakota national priority, a CENTER-FOR international law staffed by Lakota and allied legal experts, the sole purpose of which will be to utilize all interna. 425. Legal means to recover every square inch of Lakota treaty territory. As land is recovered, it will be placed under Lakota jurisdiction in the manner described above. Sovereignty. Each of the preceding three categories of activity has obviously been aimed at the exercise of Lakota sovereignty within the internationally understood and accepted meaning of that term. A primary responsibility of the treaty administration will be to work with the CENTER-FOR International Law, Lakota Treaty Council, International Indian Treaty Council and other appropriate bodies to attain renewed international recognition of the sovereign Lakota Nation. Success in this area will be signaled by a formal declaration of recognition coming from a United Nations member state other than the United States. This is both extremely important and entirely possible to achieve. By being formally recognized by other governments around the world, the Lakota Nation immediately gains access to the UN and other international agencies capable of applying considerable pressure upon the U.S. government to end its war against the Lakota and honor its treaty commitments. We will also gain entree to the International Court of Justice located in The Hague. This will allow us to take the U.S. to court before the other nations of the world rather than merely in the rigged/closed system of the United States itself. The advantages of this in terms of our ability to effectively sue for restoration of our property and other rights should be obvious. Plainly, it is high time that the judges determining the legitimacy of our claims were not representatives of the opposing party. Finally, through such recognition the Lakota Nation would be able once again to exercise its rights to enter into treaties and other international agreements with governments other than that of the U.S. If the United States does not wish to enter into such relationships with us, fine. That is its right. But, this in no way prevents an internationally recognized Lakota government from entering into relationships with other countries, including other indigenous nations within the United States itself. 426. Given all this, you can bet that international recognition will bring about a rapid and positive change in U.S.L Lakota intergovernmental relations, especially in terms of the U.S. honoring its existing treaty obligations. Economics. The treaty economic program is tied directly to the land and to the traditional Lakota view of the people's relationship to our overall environment. From this, certain things automatically follow. First of all mining and other corporate leases within Lakota territory will be immediately cancelled. As the experience of the Lagunas, Navajos, and others have abundantly shown, temporary jobs and royalties from mining are of no benefit when the environment is destroyed as a result. This rule will apply to all treaty lands recovered as well as to the current reservation area. Second, agricultural and grazing leases let by the BIA to non-Lakotas within Lakota territory will be suspended pending a comprehensive investigation of the manner in which they were negotiated, as well as the terms and conditions they entail. All leases found to have been processed by the BRA without consent of the Lakota landowners will be cancelled outright. In the event the true landowners wish to utilize their property and they will be encouraged to do so either directly or through tribal enterprises, they will assume immediate control over their land. In the event they do not, a consenting and equitable leasing arrangement will be constructed, either by the individuals concerned or by the Lakota Nation itself. In the event that leases were entered into in a basically consenting fashion, but were negotiated at inordinately low rates by the BIA in its self-assigned trust capacity, the Lakota landowner will have the option either to recover their land by canceling the lease or to renegotiate the lease to reflect equitable terms. The treaty administration will also establish a CENTER-FOR individual land recovery which will be devoted to research and the filing of forced fee patents and other actions designed to recover off-reservation lands illegally taken from the Lakota people in areas such as Bennett County. Meanwhile, all fences serving as boundary markers and the like shall be 427. Removed within the entire Oglala Lakota territory at the earliest possible date. The open range that results will be consigned to the establishment of herds of buffalo, antelope, sheep, certain varieties of cattle and other animals naturally adaptable to the region's semi-arid climate. Tribal income will be committed to developing this resource base as rapidly as is feasible within the natural constraints of the land base, and to extending it to dairy operations at the earliest possible date. Fencing will be restricted to agricultural purposes, to keep livestock living on the open range from destroying gardens and small fields. Crop selection will be determined by the types of plant most naturally compatible with the climate and soil conditions natural to the area. Location of agricultural plots will be determined by the natural availability of water from place to place. Hence, it seems likely that relatively FEW areas will be FENCED under the treaty program. Realization of the treaty economic program is of course contingent upon several major factors discussed below. Land. Implementation of a full-fledged economic program is based upon our previously mentioned plan to recover treaty land. The 1868 treaty territory is more than sufficient to allow the Lakota Nation to rebuild a viable economy around the traditional forms of animal hunting, raising and limited agriculture. This traditional economic mode can be recreated without our engaging in the transitory and environmentally devastating processes of mining and industrialization. The key is to force the restoration of a national land base sufficient to support our economy. Water. Recovery of our land base will bring with it control over the water reserved for our use by our ancestors. The best agricultural and grazing lands within the 1868 treaty territory, that is to say, the lands with the best water sourcing, now lie outside of reservation boundaries. We must recover it. In the meantime, we must demand the fullest application of our right to water with the current reservation land base, because it is the springboard upon which both our economic recovery and broader land recovery initiatives must be launched. As a means of actualizing our water rights, the Treaty Administra. 428. Shin will immediately establish a center for water rights litigation similar to the above-mentioned centers for international law and individual land recovery. In terms of water, land recovery will eventually mean that locales which have come under U.S. Bureau of Reclamation and Army Corps of Engineers development will have to be considered. This is true especially within the western Missouri, Niobrara, and North Platte watershed areas. Such water control construction will have to be investigated on a case-by-case basis to determine its overall environmental impact. Structures found to be destructive of the environment, such as those which deplete our aquifer faster than it replenishes itself, will be dismantled. Those found to yield no irreparable damage will be retained. All water coming under Lakota control will be assigned a first-use priority of meeting the needs of Lakota citizens. Water surpluses, if any, will go to development of a revitalized Lakota economy. Electrification. One of the benefits of technology to which most Lakotas have become accustomed during the 20th century is electricity. A return to our traditional economy does not mean the elimination of electrical power. It does, however, draw into question the sources of such power and the sorts of technology used to generate it. The treaty is committed not only to maintain electrical power within Lakota territory, but to improve its availability, dependability, and method of generation. An immediate priority for the treaty administration will be to establish an Oglala Lakota Electrical Power Commission. The purpose of this commission will be to disentangle Pine Ridge from its current sources of electrical power, making the Oglala people completely self-administering in this regard. Second, the treaty administration will initiate a program to construct alternative electrical generation units, ultimately to be built by a tribal manufacturing facility, to replace the sorts of technology presently used to generate our electrical power. We live with an all but unused and non-depletable natural resource, the wind. It is possible to construct generators relying entirely on the 429 wind to generate electricity. Total reliance upon wind power in meeting Lakota electrical needs is a firm goal of the treaty, a goal it is entirely possible to meet over a very short period of time. This plan will encompass each sector of the 1868 treaty territory as it is recovered. Eventually, there will be no coal-fired or nuclear power plants within the entire Black Hills region. Wind power, which is essentially cost-free beyond construction outlays, is more than ample to meet the needs of the entire Lakota Nation. Electrical rates within the Lakota Nation can therefore be projected to the extent that they are charged at all, resulting funds will go into equipment maintenance and investment in the overall economic development of the Lakota Nation. In sum, electrical power may well be the first area in which the Lakota Nation becomes THIRD-WORLDISM livelifield. Additionally, there is every probability that the output of the Lakota National Wind Generation System, when complete, will be greater than needed by the people. Surplus electricity may then be sold at equitable rates to areas adjoining the Lakota Nation. All profits realized from such sales will be invested in economic development and other programs benefiting the people as a whole. Lakota/US relations. The treaty is committed to the position that not 1 square inch of Lakota territory is for sale. It is thus clearly not part of the treaty economic program that revenues will be generated by land sales or settlements. As part of its land recovery program, however, the treaty intends to conduct in-depth studies concerning the type and extent of damage inflicted upon the Lakota land base and the scale of profits accruing to the U.S. economy by virtue of the illegal and protracted U.S. occupation of the 1868 Treaty Territory. The Homestake Mining Company, to take but one prominent example, has extracted an estimated $1.4 to 16 billion in gold from the Black Hills over the past century. Homestake itself will of course be nationalized once the land it occupies has been recovered. It will also be closed immediately. 430. 8ly, thereby ending its cyanide contamination of water as far downstream as the Gulf of Mexico. But the gold already stolen still belongs to the Lakota Nation. The same principle holds true with respect to other mining enterprises. The uranium extracted from pits near the town of Gamont, for instance, as well as timbering and other corporate activities. Use FES must be retroactively charged against federal installations such as Ellsworth Air Force Base, Fort Meade, the Hot Springs VA Hospital, Igloo Army Ordnance Depot, and so forth, even though each such facility will be immediately shut down upon recovery of our land base. Then there are charges which must be levied in connection with environmental destruction and the costs of repairing it. The permanent defacing of Mount Rushmore is a case in point, as is the destruction of another entire mountain for purposes of creating what is ostensibly a gigantic sculptural likeness of Crazy Horse for the edification of non-Indian tourists. In some ways more important, however, are the expenses which can be readily projected with respect to dismantling Bureau of Reclamation and Army Corps of Engineers projects, reclaiming mined or otherwise devastate areas, cleaning up uranium tailings and other nuclear wastes, and similar matters. Reparations are due across the board. A block payment of indemnity is also due the Lakota people as a whole for the pain, suffering and material/spiritual degradation we have collectively experienced by being denied the benefit of our land base over an extended period. And, finally, the United States has a legal obligation to make direct payment to the Lakota Nation for its continued use of all lands outside the 1868 treaty area which still belong by both unrelinquished Aboriginal right as well as by treaty right to the Lakota people. Of particular interest in this regard are those areas encompassed by the terms of the 1851 Treaty of Fort Laramie. Here, a fair rent, plus interest, accruing from the date of illegal taking seem an appropriate remedy, at least until such time as a new international compact can be hammered out. It is of course difficult at this point to calculate with any degree of precision the aggregate amount owed by the United States to the Lakota Nation. A final tally must therefore be deferred until such time as the above-mentioned studies have been completed. The following very conservative 431 estimates will thus serve as preliminary figures. 1. Expropriated profits, plus interest. $1.00 billion. 2. Use FES. $25 billion. 3. Environmental damage. $250 billion. 4. Back rent, plus interest. $5.00 billion. 5. Block indemnity. $1.00 billion total $525 billion. The Lakota Nation, unlike its imperialist counterpart, the United States, is not economically unreasonable. We are therefore prepared to waive punitive damages and to negotiate a long-term payment plan through which the U.S. can begin to reintegrate itself among the ranks of civilized nations by retiring its debt in compensatory damages to the Lakota people in a relatively painless manner. The treaty suggests that discussions begin with the idea of a $50 billion initial lump payment, the balance to be paid over a 50-year period. We believe that an interest rate of 10%, compounded annually, should be considered quite reasonable in view of the rate set by the U.S.-controlled World Bank and comparable institutions. In addition, the U.S. should be prepared to pay $2.5 billion annually in rent for its extended leases of unceded Lakota land within the 1851 Treaty Territory and other such areas. This arrangement will continue until final disposition of these matters is negotiated through an appropriate international instrument. The treaty further recommends that the Lakota Nation waive any further financial or trust obligations on the part of the United States, whether real or self-assigned, within the 1868 Treaty Territory. This waiver should be considered effective so long as the above described annual payments by the U.S. are made in a regular and timely fashion. It seems self-evident that anything resembling the financial base sketched herein would allow all phases of the treaty program to be implemented. 432. Moreover, it is to be anticipated that long before the 50-year payment schedule has run its course, the Lakota Nation will have fully regained its rightful position as a sovereign, self-determining, self-sufficient, and self-perpetuating relative within the family of nations. Other international relations. It should be expected that the United States, given its lengthy history of international misconduct, may prove reluctant either to return stolen Lakota land or to provide appropriate compensation for its presently ongoing expropriation of Lakota resources. In the event that such expectations are borne out, the treaty program calls for the solicitation of non-U.S. developmental aid with which to undertake the necessary legal and other actions necessary to eventually compel U.S. compliance with the rule of law, to initiate service programs critically needed by the people, and to establish an increasingly viable economic base for the Lakota Nation despite U.S. preferences. The negotiation of relevant international agreements will be conducted by the traditional government with the treaty administration serving as a diplomatic/executive arm. Other initiatives. Clearly, the main thrust of the treaty program as outlined above is to reassert Lakota sovereignty, self-determination and economic self-sufficiency. Our goal is to bring about the complete decolonization of the Lakota Nation. Put another way, this means booting the U.S. out of Lakota territory, all Lakota territory. This will in itself solve our problems over the long run. But conditions on the reservation today are such that other, shorter-run initiatives must be undertaken immediately. Things like economic development are very far along. Some of the major areas in which this is true are the following. Nutrition. It is an immediate objective of the treaty to begin a nutrition program designed to replace the current federal commodity program. The treaty nutrition program will be focused primarily on providing a 433 balanced diet directly to Lakota youth, but it will also include the entire reservation population. The treaty firmly maintains that until the pervasive condition of malnutrition so evident among Lakotas is corrected, nothing else can be truly accomplished. Consequently, as a transitional program on the way to self-sufficiency, the treaty administration will negotiate with a wide array of non-governmental agencies, both in the U.S. and elsewhere in the international arena, to secure meat, poultry, and dairy products, produce whole grain products and vitamin supplements sufficient to provide an adequate diet to all Oglala Lakotas. Commitments will be sought from the sponsoring agencies to continue their support for a period of 10 years, if need be. Health. The great majority of diseases chronically suffered by Lakotas are directly related to PO or nutrition. In providing a balanced diet to the people, the treaty will have taken a significant step towards solving our problem of ill health. Nonetheless, more than a nutrition program is necessary. The treaty plans to construct, as a matter of national priority, at least FO or solar-powered water purification facilities on Pine Ridge. These facilities will provide pure drinking water to all reservation residents within 2 years. This pure water, distribution of which will constitute a tribal enterprise, will replace the contaminated water supplies which spread all manner of disease now available. The treaty is also committed to the thoroughgoing reorganization of existing healthcare facilities, bringing in competent staff, opening fixed and/or mobile community clinics, and the initiation of a general inoculation program during the first year of our administration. It is a fundamental goal of the treaty to institute free comprehensive and continuous healthcare for all Oglalas within the first 2 years. Alcoholism. As was noted earlier, alcoholism is a special problem among Lakotas today. The treaty therefore has a special program with which to counteract it. The first step is to permanently ban liquor sales on the reservation, and 434. To undertake suits and other actions to end its sale in adjoining localities. The second step, which begins at the same time as the first, is to balance the Lakota diet, thereby eliminating the physical basis for continuing alcohol addiction among our people. From that point, the treaty will undertake a substantial psychological intervention program designed to combat alcohol dependency. This of course includes appropriate modes of counseling, but is geared more towards providing a concrete sense of empowerment among those who presently feel themselves to be disempowered. The treaty proceeds with an understanding that the reintroduction of pride and self-respect among the people is the only sure means of ending our rampaging alcoholism crisis. Thus, the longer-term treaty programs for bringing about a restoration of our sovereignty, self-determination, and self-sufficiency should be seen as the ultimate method of curing both mental and physical dependency upon alcohol and other such substances. Education. The current BIA-run school system on Pine Ridge is plainly a total failure, at least if the education of our youth is or ever was its intention. In response, the treaty calls for the assumption of community control over each local school district within the first year of its administration. Curricula will then be redesigned to provide accurate and comprehensive instruction in Lakota history and language, foreign languages such as English and Spanish, U.S. history and international affairs, economics, traditional indigenous science and the THRs. Our children will learn to read in our schools, something that cannot be said of the BIA system. Also integral to the Lakota educational model will be solid instruction in our traditional values and spirituality, practical skills such as animal husbandry and carpentry, as well as oratory. This last is perfectly in keeping with our oral tradition and lends itself as much to the modern world as to the world of our ancestors. Further, the treaty intends to designate each local school campus as a community center in order to facilitate the rapid integration of the educational system with day-to-day community life and to bring our youth into more direct and regularized interaction with elders. 435. Naturalization. It is not, and has never been, the desire of the Lakota nation to usurp individual non-Lakota landholders within our treaty territory. We are instead concerned mainly with occupying and using foreign governmental and corporate holdings within the boundaries of our nation. Hence, unless guilty of specific crimes against Lakotas or other indigenous peoples, individual homeowners, ranchers, and the like who happen to be non-Lakota will be welcome to remain in the sovereign Lakota nation. Nor is there any reason why, in doing so, they cannot retain their personal property up to, say, a limit of 160 acres. There is of course a quid pro quo. Non-Lakotas opting to reside permanently in the Lakota nation will be subject to all laws, rules, and regulations prevailing within Lakota jurisdiction. Individuals unwilling to accept this arrangement will be free to leave Lakota territory in precisely the same manner they would leave any other country with which they are unsatisfied. In other words, they will be entitled to take with them all personal effects other than land title. Lakota citizenship will obviously prevail within the Lakota Nation. Individuals of non-Lakota origin who wish to reside permanently in our country will therefore be encouraged to apply to become Lakota citizens. If accepted, they will enjoy all the same rights and privileges, and incur the same responsibilities, as an other Lakota. So-called dual citizenship, the holding of U.S. and Lakota citizenship simultaneously, will not be acceptable, however. A choice must be made to be either a U.S. citizen or a Lakota citizen. Becoming a Lakota citizen will thus entail the formal renunciation of U.S. citizenship. Those of non-Lakota origin who wish remain in Lakota territory, under Lakota jurisdiction, but without relinquishing their U.S. citizenship, will be free to apply FOR status as landed immigrants. If accepted, they will be able to stay on, retaining their land holdings. Immigrant status, which is envisioned as being renewable, will be reviewed at 5-year intervals. Violation of Lakota law, however, will result in immediate deportation, the conditions of which will be determined by the nature of the crime. Inheritance of any sort will not apply to immigrants. Ownership of 436. Land and improvements will pass with the death or departure of each immigrant to the Lakota Nation. Conclusion. This has been a summary of the major points of the treaty program. Although less than exhaustive in both scope and depth, it should prove sufficient to provide a sound sense of the direction pursued by Russell Means and all other candidates currently campaigning FOR election under the treaty banner. Watch FOR supplemental documents examining various aspects of the treaty agenda in greater detail.